I declare open this hearing of the Senate Legal and Constitutional Affairs Legislation Committee for the supplementary budget estimates. The Senate has referred to the committee the particulars of proposed expenditure for 21-22 for the portfolios of Home Affairs and the Attorney-General and other related documents. These are supplementary budget estimates proceedings, and the outcomes to be heard during today's estimates are from the Home Affairs portfolio. The committee has set Friday the 10th of December 2021 as the date by which answers to questions on notice are to be returned. The committee has also decided that written questions on notice should be provided to the Secretariat by 5 p.m. on Friday the 5th of November 2021. Under Standing Order 26, the committee must take all evidence in public session. This includes answers to questions on notice. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence to a committee. Officers and senators are familiar with the rules of the Senate governing estimates hearings. If you need assistance, the Secretariat has copies of the rules. The Senate, by resolution in 1999, endorsed the following test of relevance of questions at estimates hearings. Any questions going to the operations or financial positions of the departments and agencies which are seeking funds in the estimates are relevant questions for the purpose of estimates hearings. I remind officers that the Senate has resolved that there are no areas in connection with the expenditure of public funds where any person has a discretion to withhold details or explanations from the Parliament or its committees unless the Parliament has expressly provided otherwise. The Senate has also resolved that an officer of a department of the Commonwealth shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. I particularly draw the attention of witnesses to an order of the Senate of the 13th of May 2009 specifying the process by which a claim of public interest immunity should be raised. Witnesses are specifically reminded that a statement that information or a document is confidential or consists of advice to government is not a statement which meets the requirements of the 2009 order. Instead, witnesses are required to provide some specific indication of the harm to the public interest which could result from the disclosure of the information or the document. Mobile phones should be switched off or turned to silent mode. Senators, departments and agencies have been provided with advice on the arrangements in place to ensure the budget estimates hearings are conducted in a COVID-safe environment. This guidance is also available from the Secretariat. The committee appreciates the cooperation of all attendees in adhering to these arrangements. In order to comply with social distancing requirements, senators and the Secretariat may use their electronic devices to communicate with one another during the hearing. We ask witnesses forbearance to do so and apologise in advance for any discourtesy. Officers called upon for the first time to answer a question should state their full name and position for the Hansard record, and witnesses should speak clearly into the microphones. I'd like to welcome Senator the Honourable Amanda Stoker, representing the Minister for Home Affairs, Minister for Emergency Management and National Recovery and Resilience, and Minister for Immigration, Citizenship, Migrant Services and Multicultural Affairs. Minister, good morning. Would you like to make an opening statement?
Good morning. No, thank you.
I'd now like to call officers from the Australian Federal Police. Commissioner, welcome and good morning to you. Would you like to make an opening statement?
Good morning, Chair. I would like to.
Thank you.
Good morning, Chair and Committee. When I first started as the Australian Federal Police Commissioner, this time 2 years ago, I pledged to be transparent and as open with the Australian public as possible. As a law enforcement agency, the AFP is accountable to the Parliament and the community we serve, and it is imperative the AFP explains how we use taxpayer money and why and how we use laws that keep Australians and Australia's interests safe. The information I'll place on the record today is the most open the AFP has been in a public forum about the threat of terrorism. As we all know, the best type of law enforcement is prevention, and this applies in the counter-terrorism space. As lockdowns end and borders reopen, Australians need to remain vigilant. The threat of terrorism remains probable, but there have been some significant shifts in the diversity and complexity of the environment and since the pandemic started almost a year and a half ago. The threat of terrorism has not dissipated. In fact, the pandemic extended lockdowns and more time spent online has in some cases made it easier for extremists to recruit. Increased anti-government sentiment, proliferation of conspiracy theories, physical isolation and more time spent online have increased the threat, facilitating local and transnational links between individuals and groups and sharing of ideas among extremist communities. Across the world, including in Australia, we have individuals who are now preloaded with extremist ideology, and the end of the restrictions on movement will make it harder for law enforcement. However, the community can be reassured that the joint counter-terrorism teams comprising of the AFP, ASIO, State and Territory Police, including the New South Wales Crime Commission, have maintained our efforts to ensure public safety, particularly through the COVID period, and will continue as we move to a post-COVID world. Religiously motivated violent extremism remains the biggest threat. 85% of investigations relate to RMVE, while the remaining 15% relate to ideologically motivated violent extremism. Last week, a UK MP was stabbed by an individual who reportedly had been in a government anti-terrorism scheme. Norway's security service believes an individual accused of killing 5 people with a bow and arrow last week had been radicalised. And closer to home, New Zealand police shot dead an ISIL supporter who stabbed 6 people in an Auckland supermarket. This has all happened within the past 8 weeks. The AFP and our partners are protecting Australians from terrorism on a number of fronts, including the concerning trend of young children occupying the attention of law enforcement agencies. Children as young as 13 years old, not even old enough to get their learner's driver's licence, are planning and negotiating with others online to carry out catastrophic terror attacks. Some of these youth feel isolated or do not feel like they belong, and so they retreat to the online world, looking to connect with someone, including RMVE and IMVE individuals. Research on how vulnerable children, including those with learning difficulties or developmental conditions, are being recruited is underway right now. The AFP will work with those stakeholders in relation to this issue because the AFP is dedicated to helping those vulnerable to radicalisation. We need parents and carers to understand who their children are communicating with online. And I implore parents to call the AFP if they are worried their child is being targeted by individuals with extremist views. Early intervention can divert children from this path, and where possible, we want to keep youth out of the criminal justice system. As I said, RMVE remains our biggest terrorism threat. However, the growth in IMVE is providing challenges, and that's because of its rural and regional presence, its influence over young people, the high levels of security consciousness and access to firearms amongst others. The IMVE cohort is extremely interconnected, especially online. Their views are diverse and include supports for nationalist, white supremacy and neo-Nazism. The AFP has detected a number of threats and concentrated investigative efforts on individuals or small networks of 3 to 4 individuals who are not aligned to members of a specific nationalist or racist group. Law enforcement is also cognizant of global instability, including the resurgence of the Taliban in Afghanistan, and the Australian Islamist cohort is influenced by both the ISIL and AQ ideology However, there is a greater number aligned to the ISIL ideology. We expect that ISIL will transform and re-establish transnational links to increase their ability to direct or influence terrorism in other parts of the globe. And other significant threats are the terrorist offenders released from Australian jails. Our global partners such as the UK and New Zealand are experiencing similar challenges. 18 terrorist offenders are scheduled for release from prison before 2026 and 54 are due for release by 2060. Since February 2019, the AFP has applied for and obtained more control orders than in the 15 years prior. 7 individuals have been arrested and charged for breaching the conditions of their control orders since July 2020. That is 70% of individuals on control orders. The community safety risks posed by the reintegration of convicted terrorist offenders into the community will be an ongoing challenge. I won't go into the numbers of police and cost involved to monitor these offenders. However, this is a significant investment of police resources. I will provide some details about a person recently released from prison who was assessed to be a potential domestic threat. Significant resourcing was required just for this one offender. The resources applied for this individual is replicated for almost every terror offender released. Another offender who was recently released almost immediately went online to access information about executions, beheadings and torture. And the AFP has established a dedicated high-risk terrorist offender capability to manage the risk of terrorist offenders. And the government has provided the AFP additional resources to address the requirements of HARTO management, and we acknowledge the ESO legislation that we hope will soon or has been passed by the Parliament to assist to manage the public safety risks presented by these offenders, as well as rehabilitate and reintegrate these individuals into the community. The online environment should not be a safe haven for terrorists or for criminal syndicates or child abusers. It is legislation that recently passed, the Surveillance Legislation Amendment Identify and Disrupt Act 2021, that will help keep Australians safe. The 3 new powers in this Act will significantly enhance how the AFP investigates serious cyber-enabled crime, and our investigators are already strategising on how they will use the new powers in active investigations to identify, target and disrupt offenders, including those relating to terrorism, large drug importations and distribution of child abuse material. We look forward to applying for and utilising these powers and working with our oversight bodies once all the administrative arrangements are settled. And encrypted communication platforms are in many cases a significant barrier for the AFP. Transnational serious and organised crime offenders rely on encrypted platforms to carry out their criminality. Today is the first time I've appeared before you since Operation Ironside was revealed. And Operation Ironside was enabled by a unique global law enforcement partnership, particularly with the US Federal Bureau of Investigation. And the FBI secretly operated a dedicated encrypted platform named Anom that was released into the criminal underworld. The AFP provided the FBI with the technical ability to decrypt and read these encrypted communications in real time. And the AFP and FBI dedicated 3 years to this operation, and as a result, in Australia alone, the latest operation statistics has led to Operation Stats reveals 711 search warrants executed, 302 offenders charged with 806 individual charges, 29 threats to kill identified, 6 clandestine labs shut down, 139 weapons, firearms seized, almost 49 million seized, and 5,055 kilograms of drugs seized by Australian agencies. Today, I reiterate that more significant action is in train and planned. I expect a significant number of alleged criminals to be arrested over the coming months. And law enforcement agencies around the world are investigating more effort against cyber-enabled crime. These are the crimes of the 21st century. Instead of a burglar breaking into your home or business, these cyber criminals, often tens of thousands of kilometres away, are taking money out of Australians' wallets and nest eggs and holding businesses to ransom and stealing the intellectual property of academia. This is the next frontier of crime, And the AFP and our partners will work with governments and global law enforcement networks to ensure the long arm of the AFP reaches criminals no matter where they are in the world. On that note, I'd like to acknowledge the work of our officers around Australia and offshore in posts around the world who continue to navigate the challenges of the COVID-19 pandemic, and we continue to achieve operational success through these challenges. And finally, I do want to comment briefly on the alleged sexual assault at Parliament House in 2019, simply to say that I'll be limited in what I can say today. This matter is now before the court in the ACT, and any public commentary has the potential to impact the outcomes of that trial. In particular, ACT law prevents the use of a victim's name in a public forum while court proceedings are ongoing. Thank you, Chair. I now welcome questions.
Thank you very much, Commissioner. I'm going to start by giving the call to Senator Keneally.
Thank you, Senator
We're starting
Henderson.
very informally already. Thanks, Senator.
Thank you. Thank you, Commissioner, and to your team for being here today. As I begin, I want to thank you for your comments about the High-Risk Terrorist Offenders Bill and acknowledge that the PJCIS has supported that legislation, and I join you in looking forward to it passing the Parliament so that the extended supervision orders may become a tool that are available to law enforcement. I want to pick up on something in your opening statement in relation to the Identify and Disrupt Bill. And again, thank you and the AFP for the support you gave to the PJCIS in terms of Operation Ironside and and Slade, the bill. You mentioned there that you look forward to being able to use those 3 warrants, and you mentioned that there were some additional actions that needed to be completed before those warrants would become available to you. Could you just explain that a bit further and also explain when you anticipate those 3 warrants becoming available to law enforcement?
Thanks, Senator. Appreciate the question. My brief is, and I'll have the Deputy McCartney answer this one, but my information is it's just an administrative process, and then that legislation becomes live, and then we're good to apply to a court for those warrants.
Senator, Deputy Commissioner Ian McCartney, the situation is under the Act in terms of 3 warrants. They need to be authorised by either a magistrate, an AAT member or a judge. As part of the process, they need to have that authorisation to be able to issue those warrants. And as we speak, the Attorney General's Department are working through that process. We believe in the next couple of weeks that will be resolved. And as the Commissioner has noted, we're very keen and ready to use the legislation.
Okay, thank you very much.
I'm sorry, Senator Keneally, before you ask your next question, could we just ask that your opening statement be tabled to Commissioner?
Sorry, Chair.
We would just like a copy of your opening statement so that can be tabled. Thank you. Thanks, Senator Keneally.
Thank you. I also acknowledge in your opening statement you mentioned the murder of Sir David Ames in the United Kingdom, and I would like to acknowledge that the Australian Federal Police have been very good in my personal experience and the circumstances of other MPs at responding to individual situations where MPs or senators have been the target of either fixated persons or extremist groups. In the lead up to the federal election and in the light of the Sir David Ames murder, are there any additional steps the AFP are considering to improve the safety of MPs and senators and candidates as they are campaigning?
Sadly, there are, yes, given our current threat environment and noting that recently an individual was arrested even in Western Australia by our joint counter-terrorism team who had access to firearms and made certain threats, and that I think was reported in the public domain. We've taken this issue very seriously, and last year I did bring out the UK Anti-Terrorism Command from the UK Met to have a look at our overall protection for MPs and high office holders. And part of that included looking at the threat assessments and a whole range of initiatives. So we are looking at a new model for us around what services we could be able to provide protection, whether that's physical protection, liaison, other solutions that perhaps in the past we haven't had a look at those kind of different layers. Our model tends to be sort of almost an all-in or nothing kind of model. So we're looking at how could we service all of the parliamentarians in a better way and provide that level of reassurance. What do you do when you've got these threats coming in, and not to take them lightly, because I know a lot of the electorates receive lots of threats and concerning letters and other things. So we do have to work with the state police as well. Often that's their jurisdiction, but I might just hand to Deputy Commissioner Operations, who has the remit.
Thank you, Commissioner. Good morning, Chair. Brad Pointing, Deputy Commissioner Operations. Yes, Commissioner's 100% right. In fact, the Commissioner has tasked me to conduct an urgent review to see what additional strategies could be employed to enhance the safety of members of Parliament. I think what happened in the UK was a stark reminder of the unpredictability of this environment. Our members of Parliament are often at public events. There's often people there who have different views, sometimes extreme views, and it's extremely important for us to work with members of Parliament and the broader intelligence community to make sure we have up-to-date intelligence, and that intelligence is converted into a security overlay that provides the best possible security for our members of Parliament. So we look forward to doing that piece of work as a matter of urgency, Senator.
Thank you. On the timing, just noting we could be in an election campaign in a matter of weeks or a matter of months. Do you have a sense of what that urgency looks like?
Yes, we're working through that now, Senator, and I've got to report back to the Commissioner by the 11th of November.
Thank you.
Thanks, Senator.
Thank you. Commissioner, if I could go on to the terrorist threat that we face, and thank you for that breakdown of the policing operations. I do note that the Australian Federal Police is quoted as telling an SBS News investigation that right-wing extremism caseload has increased 750% over the last 18 months. So while the proportion of your counter-terrorism work, it remains at 15%, there's been a massive increase in the last 18 months. Can you provide an update on AFP involvement in investigations or arrests in this space?
Yes. So I think my stat was in relation to the criminal offending. I think
Right.
workload-wise, as far as
Okay.
priority goes, I think the Deputy has those latest figures.
Oh, thank you. That's a helpful clarification. Thank you.
But you are correct, Senator, it has increased significantly.
So, Senator, like the Commissioner stated, our number one threat still is religiously motivated violent extremism, but there has been an increase. We now estimate 15% of our caseload is focused on this particular issue. In terms of the 21 major attacks that we've prevented working with our intelligence partners and our state and territory partners, 2 of those were attacks related to IMVE.
In what time frame?
So there was one in the last 2 years, Senator, and there was
So
one...
that 21, what time frame is
the
that?
21 is since 2014.
Oh, okay. So since 2014, you've prevented 21 attacks. 2 of those are related to ideologically motivated
Correct.
extremism. Okay. Are you able to tell us, are there any particular groups or organisations that are connected to this rise in caseload?
Oh, listen, I think there's a range of groups that are involved in this space, not one single group that stands out, Senator. And as we've briefed you on this issue many times, these groups change, disband and reconstitute into other groups that continue, from our perspective, we continue to focus on that issue.
Australians would have been alarmed by the reporting on 60 Minutes and in the 9 newspapers in relation to the National Socialist Network, and indeed the ASIO Director General was interviewed as part of that program. Are you able to tell us if that group you've seen a change in that group's membership or activities over the past 2 years?
So I think the stats I give you at the start was in terms of disruptions, in terms of people we've charged with terrorism offences that hold that ideology. Outside of that, there's a significant body of work that's undertaken with our state partners, with our intelligence partners, and a significant body of work in terms of disruptive activities, in terms of disrupting these groups. And I can say we've had a positive impact in terms of how those groups have been disrupted, Senator.
Okay, we'll leave it at that for the moment. Thank you. In terms of prevention, intervention and de-radicalisation programs, Commissioner, I note and welcome your comment to parents to know who your children are communicating with online and to contact the AFP. And I acknowledge that over the past 20 years, Australia has developed some very good de-radicalisation programs when it comes to religiously motivated violent extremism. If parents are concerned about their children interacting with ideologically motivated violent extremism, and specifically with right-wing extremist groups, if they contact the AFP, what types of de-radicalisation or intervention programs are available?
It does tend to be state-specific, what state you're occupying, and so the Joint Counter-Terrorism teams obviously work with the state services, and then it's trying to tailor those. What we found, without me, because I've got to be careful what I can say about children, with the cases that we've dealt with, really complex matters where we're really concerned some of those children with learning difficulties, it's going to be a long road to de-radicalise them. So there's almost, it's almost new territory for us, and the de-radicalisation of those young people who we've shown a real propensity for violence, and we've even had it in the backyard here in Canberra. So I guess the jury's out on the longer term aspect of this, but there is not a shortage of us to be able to refer those individuals to different programs, and I think the more they're tailored for those individuals, the better. And I think we haven't seen I guess the longitudinal study on the success or not success of these programs. We do know that some of our adult offenders have pretended to be de-radicalised, and then we've picked up other intelligence, as I've just said, when they've come out. It actually hasn't been technically true.
Right.
And so that's the other issue that we sort of have to be alive to as well. It's quite complex, as you could appreciate.
Senator Keneally, we will need to leave your time here. So if we could, we'll come back to you if you have further questions.
I do, and I flagged it, so I think to Senator Ciccone.
Thanks very much, Senator Keneally. I'll now give the call to Senator Scarr.
Thank you, Chair. Commissioner, good to have you with us today, and can I commend all the great work that members of the AFP are doing, and particularly congratulate everyone involved with Operation Ironside. I read your speech, National Press Club address, dated 28 July 2021 with great interest, and I commend everyone to have a read of it. I think it just provides a terrific overview of what the AFP is doing. And I'd just like to walk through some questions I had arising from that speech. You referred to in that speech that Operation Ironside, you knew it would be significant, but you were surprised by maybe surprised isn't the right word, by the breadth and scale of what you discovered. Could you please provide some comments around that? Why was it even surprising to you?
Yeah, I think, to have our Assistant Commissioner of Crime, who is Nigel Ryan, who's extremely experienced in this area and been fighting organised crime for a long time, for almost all his career, when he reported in to myself and the deputies that, as Ironside was going down to resolution, we had 10 tonnes of drugs on the water coming to Australia. That caught us a little bit as far as the length, I guess the breadth, of the issue, and how sadly much we're consuming in this country, and we're a profitable country for organised crime, given the markup that we have for drugs on the street here. So that was quite one observation. The second for us was probably the fact that our Australian priority targets and other targets have rebased themselves in hostile countries and are calling in murders from overseas very easily, just using their profits and hiring professional services and others that we hadn't seen before. That, the 29 lives that we saved, that was something that, again, we were able to see that in real time as well, and how these groups operate and the professional services you can buy by criminal groups. So that was a real concerning that, we don't want to have Australia move into some of those other countries where it's, you've got shootings on the streets and so on, which we've seen some of that over the past, but we're really concerned about that capability of the logistics their operations and their finance. And that's why for us, we're going after those three, including their communications. We're going after those using the SLED and other powers and working with other agencies to really destroy their business model, which is one to profit from the misery of peddling drugs into our communities.
Yeah. And when you talk about that, the great result in terms of saving those lives as a result of this operation, one of the examples you gave was one outlaw motorcycle gang planned to kill a family of 5 because they could not find a relative of theirs who failed to pay a drug debt. So this is a real threat. Is it correct to say this is a real threat of violence against Australians arising from this drug trafficking? Is that a fair comment?
Most definitely, and we are seeing that even now. And as I said, we were able to do some great work with our state police, and I must put hats off to them because they were able to operationalise that intelligence and help us prevent those deaths from occurring.
And also key is the relationships, not just with the state police, but the relationships you have with law enforcement agencies and other agencies overseas. And is it fair to say that the Australian Federal Police is quite unique in this regard in terms of the depth of relationships you have with international agencies which facilitated this operation?
Yeah, I think it's one of the... I don't know if the Australian community know how much work and effort has gone in the last 40 years to build those relationships. We know a lot of those senior officers now who are in the other police forces, and Australians have that unique way of being able to do business, and we're very upfront and honest, and I think those countries appreciate that. So we're working hand in glove with those agencies, and often we can't actually claim the stat, even though it's come from us, depending on the country to country, but there's a lot that's going on offshore. We've prevented tonnes and tonnes of getting to Australia in various countries just from those police-to-police relationships we've developed over those many years.
Yep.
And if I could just make one other quick comment, I think the other thing too, in relation to drug deaths, I mean, I think it's overtaken road toll deaths now in this country, so it is a serious issue.
Well, and sometimes, as we tragically know, and you referred to this in your speech, there's a connection between drug use and road deaths in terms of the impact it has on individuals and their families. Isn't that correct?
There is, and it destroys lives, and people don't realise the dangers of these illegal drugs.
And I think you made an interesting comment in this regard in the speech, and that's this, and I'll quote it. Quote, "There is no concept of personalised use of drugs. One user's actions can have far-reaching consequences for those around them, loved ones or strangers," end quote. Could you explain what you meant by that?
Yeah, I think there is different commentary around personal use and it's safe to use at home and so on. It's not. These when you find out what's in these chemicals and what they do to you, our view is it just should not be something that people are not taking seriously, and it's against the law. I was lucky enough to reside in a country for a while as an AFP senior officer who did have some relaxed laws. They're now in a problem because that created what they called narco-tourism, meaning all the organised crime decided to set up in those areas where drugs were legalised. So that's an issue too. I think there's sometimes a cause and effect to some of those decisions, and ideally for us, I mean, we enforce the law at the end of the day, and it is a policy matter for the government, so I'll probably steer away from that. But of course, being a law enforcement officer, we see the carnage that cocaine, heroin, methamphetamine does. It just doesn't make sense that you'd want to legalise that.
That's right. And just in that context, I note that there's a private members bill sponsored by ACT Labor MLA Michael Peterson, currently before the ACT Legislative Assembly, which proposes to decriminalise hard drugs, including ice, heroin, MDMA and cocaine. Are you aware of that?
I am, and I think we've provided some advice there. Obviously, it's a matter for ACT policing, but we've certainly given some advice around what's happened in Europe, Portugal, the Netherlands in relation to the legalisation of various drugs and what the unforeseen consequences can be.
So what are those unforeseen consequences? You referred to narco-tourism. Are there any other consequences that can flow from?
Well, I think
from that
also you've got,
policy?
the driving aspect, the community safety aspect, the misery that it causes. It means it's going to mean that organised crime will want to target this community in particular because they can move their product quite easily. It just makes it more difficult for us to combat the rise of cocaine, methamphetamine and heroin use, which is they're not recreational drugs.
So the experience from overseas suggests that it would make your job harder to do in the event that bill was adopted by the ACT Parliament. Is that a fair comment?
Yeah, that's my view from a law enforcement lens, obviously, because we think we'll be busier.
Okay, and I guess that ties in then, just to conclude, by a final reference to your terrific speech in front of the National Press Club, that, and I quote, "Each dollar spent on illicit drugs facilitates a supply chain of violence and horror stretching from our community all the way overseas," end quote. Is that
Yeah,
correct?
so you just quoted too that drug debts are often the reason why people get killed. So given the fact that, who you're purchasing your hard or those methamphetamine, heroin and cocaine off, and where does that lead to? There's a whole range of things that open up. So
Okay. Thank you very much, Commissioner.
Thank you very much, Senator Scarr. Before we go to Senator Faruqi remotely, I've just got to... Firstly, I just want to acknowledge the incredible hard work of the AFP and the dedication of your officers, Commissioner. I do just want to briefly ask you whether the AFP is providing any support to WA Police in relation to the tragic case of the young 4-year-old who's missing, Cleo Smith.
yeah, I respectfully, Chair, we are. I cannot go into the specifics, but they did, given the fact it's their lead, their investigation. I note their acting commissioner did mention that the AFP had provided support, and we have on a number of fronts. As you know, it's all in when it comes to, this particular matter, and when it comes to children as well. So we have.
Thank you very much, Commissioner. I will now give the call to Senator Faruqi, who is attending remotely. Senator Faruqi.
Thank you, Chair, and good morning, everyone. And thank you, Commissioner, and your team for being here to respond to our questions. I just want to go back to that SBS story that was published earlier this month, that the AFP's Joint Counter-Terrorism Team's caseload covering far-right extremism and racism has risen by 750% in the last 18 months, and it's now about 15% of your workload. In that particular story, the AFP Assistant Commissioner, Mr. Lee, was interviewed. And it was acknowledged that the bar for prosecuting investigations under the Joint Counter-Terrorism Team investigations involves an imminent threat of violence. So I just want to clarify that in all those circumstances, you're investigating, you have enough evidence to suggest that there is a threat of violence?
Sorry, Senator Deputy Commissioner Ian McCartney. Just to provide some context on the 750%, our caseloads increased from prior to COVID was at 2 to 3% to 15%. We'd argue our caseloads increased by 13%, not 750%. And I think there was, in terms of how that was interpreted by the journalists in terms of the headline. But I think, as we've noted, we've noted today, it is an increasing caseload in relation to the work that we do. Senator, can I just ask that, just to clarify what you're actually asking in relation to the level required in terms of proving these offences?
Yes, so I'm asking that in all those cases that you're investigating, you have enough evidence to suggest that there is a threat of violence.
We've got enough suspicion, to be able to charge. We need more than suspicion to be able to charge, but it's fair to say there's enough concern, there's enough suspicion, and again, it's very much a joint approach working with our state and territory partners and also our really good colleagues from ASIO. So in terms of the threat metrics, they've reached at a certain level that we believe is a cause for concern and requires a criminal investigation.
And in terms of these investigations of, far-right extremism and racism, what sort of violence are we talking about? Is it, I'm just trying to figure out, is it threats of violence towards specific individuals or to people in certain locations, or are specific people being targeted or specific groups of people being targeted?
That and everything else. I think it's very much a mixed ideology when it comes to right-wing extremism in terms of their views, and different groups within this context. Often their views are interchangeable and conflated across the different groups. But again, in terms of what they express, it's incredibly important in terms of the matters that we investigate. But from a policing perspective, we apply the legislation, and once we think that they're in preparing for an act that will relate to politically motivated extremism, that's when we take action, Senator. So in answer to your question, it is a mixed ideology in terms of different threats to government, to individuals, to religious groups. It's a very mixed ideology.
So have you investigated threats of violence towards people who might be gathered at mosques, for instance?
We have.
And what about synagogues?
We have.
Okay. It was also noted in that particular SBS story that Assistant Commissioner Scott Lee expected the threat to continue to climb. So I'm just wondering if you think there is enough government investment in countering violent extremism work as it relates to far-right extremism. And the Minister could answer that, if that's more relevant to the Minister.
Yeah, I think, as we said, we have received some additional funding to be able to combat this threat. It's just not us alone, though. The great thing about the Joint Counter-Terrorism Team is it's a joint effort between, us, ASIO, ACIC, State Police and others. So they're pretty well resourced, but of course we are finding that on the intelligence side, we have great support from those agencies that provide us with actionable intelligence. And, obviously for us, we'll have to watch and report back to our Minister depending on the growth or not growth. We're hoping that we can disrupt it. And as the Deputy said, we're pretty creative in how we disrupt. Unfortunately, it may not ever get media because there are different techniques that we use to disrupt those individuals. And it's not always charging people with a terrorism offence. So, we'll do all we can to make sure if they're getting into that attack planning mode that we're in there and disrupting them at the earliest possible opportunity.
I think the other issue, just following on from what the Commissioner stated, Senator, is just not a resourcing issue, but it's the support we've been provided through the PJCIS, through the government in terms of additional legislation. So once the environment changes, and it has, the legislation we've been provided by the Australian government has provided significant assistance to the work that we do. And again, we flag the dark web, the SLADE legislation that's been recently enacted. This will be crucial in terms of the work that we do in this space, Senator.
Thank you very much. Thanks, Chair.
Thank you very much, Senator Faruqi. I now give the call to Senator Patrick.
Yeah, thank you very much, Chair. Good morning, Commissioner. Just wondering, in the annual report, you've made mention of cooperation with Chinese law enforcement. Gave an example of some operations relating to narcotics. Has the AFP's collaboration with Chinese law enforcement been affected by a broader deterioration in our relationship with China over the last couple of years, or is it business as usual?
I would say it's business as usual. Just obviously not being able to move around has probably affected us more than anything else, but we have had referrals from the Chinese authorities on various matters and successfully made arrests in Australia as a result of that information.
Okay. Can you, perhaps on notice, provide a list of all of the full range of Chinese law enforcement agencies that the AFP deals with, and a sort of general indication of what sort of operations they might be involved with each of those organisations?
Yeah, I'll take that on notice.
Yep.
Yes, thanks, Commissioner.
Thank you. In your opening statement, you talked about IMVE. In relation to anti-lockdown protests, has there been any connection between those anti-lockdown protests and IMVE or ideological groups?
I think the Director General may have answered this question. I don't think we've picked up any intelligence on that, but we're obviously working hand in glove with the various agencies, including the State Police, on that front.
Okay, and they've had no part in orchestrating any of that. That's been independent, general concern amongst the community.
I think it's fair to say certain individuals involved have generated some interest, Senator, but we're not saying that a IMV group is directed and driven that activity.
Okay, in your opening statement you talked about both IMVE and what's the other one?
RVME.
RV&E. I think you said 15%, and then in response to Senator Keneally, I think you might have mentioned that's as a proportion of failed operations, or is that?
No, I think the best way to describe that's 15% of investigations or caseload that we're investigating in this space, Senator.
Okay, so it's caseload. You also mentioned that you thought some of this activity was in fact inhibited by lockdown. Predominantly the lockdowns, I guess, in many areas have just been border lockdowns. So does that indicate that these people are working across states, or are you actually referring to, say, the lockdowns in Sydney and lockdowns in Melbourne?
I think one of the factors from lockdowns is people staying at home and people accessing the internet, usually for genuine and lawful reasons, unfortunately. And the Commission has noted in terms of susceptible younger children online watching material that they shouldn't be watching, it is causing us grave concern.
Okay. During the have you seen a growth in those areas? So you say 15%. That's sort of in some sense a proportion, but has the overall absolute number increased?
Overall numbers of
in the IMVE space, have you seen an increase?
We have.
Okay, and what's the extent of that increase?
In terms of individuals or groups?
Well, I guess it applies to both the amount of activity that's occurring and indeed the amount of resources that you're applying to that particular area of policing.
Well, when we say 15% of caseload, that's 15% of, in effect, our criminal investigations that we'd undertake through the JCTT. So there's been an increase in caseload, an increase in resources that we've directed to this threat, but we've also seen an increase in terms of factors such as what we're seeing via the internet in terms of this sort of ideology being pushed through the internet, Senator.
And is its origin overseas, or does it have origin here?
Historically, it was overseas, but it exists here in terms of some of the hatred that we're seeing on the internet. But again, I think in answer to the previous Senator, it's a mixed ideology of just pure hatred to government, to individuals, to religious groups.
All right, just a couple more questions, thanks, Chair.
Thank you.
The degree to which these groups have been motivated by perhaps extremism in the United States and the sort of thing we saw developing over the Trump presidency, is there any indication that overseas increase is affecting things here?
Well, I think the Commissioner's noted in terms of a really good working relationship with the Federal Bureau of Investigations, this is their priority threat in the United States in terms of homegrown or domestic terrorism. I think we go back to the Columbine shooting many years ago, that high school shooting. That was a trigger, that was an instigator for other attacks, and I think we go back to the attack by Tarrant in New Zealand. Unfortunately, his manifesto has been an inspiration point for other attacks. So this type of ideology is fueling concern.
Okay, and just to close off that area, my last question, thank you, Chair. Have you seen any evidence of this sort of terrorism being inspired or invoked as a result of the activities that took place, the attack on the US Capitol? Has there any of that sort of flown through to Australia? Have you seen any links?
I think probably it's probably a bit tenuous, but that recent matter where that group across Australia, based out of Western Australia, actually were trying to overthrow the AFP or take over the AFP and the government. Probably more of that kind of activity, but I will defer to the deputy, and that caught us out, but most of them have been charged now with different offences.
My close colleague from New South Wales Police calls it the petri dish of hate in terms of what's on the internet, Senator, and I think that that's one other aspect that's thrown into the mix in terms of driving these sorts of groups. I think that there has been some groups in Australia that have looked at that in terms of as an inspiration point, but it's not binary. There's a lot of factors at play and a lot of different views at play.
All right, thank you very much. Thank you, Chair.
Thank you very much, Senator Patrick. I'll now give the call to Senator Keneally, and I believe...
Yeah, for a moment, Chair, and then if it assists to go to Senator Ciccone.
Senator Ciccone at the end. Thanks
Thank
very
you.
much, Senator
Just
Keneally.
to pick up on the end there of Senator Patrick's questions, I note that the AFP made a submission to the Parliamentary Joint Committee on Intelligence and Security regarding extremism and made a recommendation that in terms of a legislative gap that could yet still be filled, and that was, could you just speak to that very briefly? And I would also, that was in terms of supporting the criminalisation of paraphernalia associated with extremism.
Yes,
And then if you could also just reflect, I think Victoria's now moved to introduce legislation that would ban, or for instance, Nazi flags. Is that something that that the AFP welcomes?
So I think there's two aspects in terms of what we propose through that inquiry, Senator. Firstly is the insignia and paraphernalia, and I think we even said during that hearing there's no reason for that material to be in anybody's hands in Australia. And again, I think the other aspect was the sharing of abhorrent material and beheading videos online. The current legislation as it exists, we have to show a connection to an offence that's been planned for. So unfortunately, the current legislation, in our view, there's a loophole where this material can be shared.
Yeah.
And again, as we said at the inquiry, there's no reason for a 13 or 14-year-old to be sitting in their bedroom to be viewing this material. So in terms of the proposals that were put in place or that we proposed to the inquiry, there's ongoing discussions with the Department of Home Affairs and Government, Senator.
Can I just quickly ask, before I throw to Senator Ciccone, abhorrent violent content, you mentioned just a moment ago the Christchurch Shooters Manifesto. That's not a video, it's a text. Is
Yep.
that the kind of thing that could also be captured?
Correct.
Thank you. Thank you, Senator
Oh,
Ciccone.
thanks, Senator Keneally. Senator Ciccone.
Thank you very much, Chair, and good morning, Commissioner. And also just to echo earlier comments, just the great work that you and your officers do should be applauded. So,
Thank you.
in the last round of estimates, I think I'd asked some questions with respect to Mr Maguire and the Cash for Citizenship scheme. Has the AFP been in further contact with the Department of Home Affairs with respect to this matter?
We haven't received any information from Home Affairs in relation to this, Senator.
So you haven't been in further contact since the last round of estimates?
We're in contact with Home Affairs regularly, but in relation to
This particular matter?
I think the investigation that was being undertaken by the department and ABF, we haven't been contacted, no.
Okay, so there's been no contact. All right. Has the AFP been in contact then with ICAC regarding this matter?
In particular, that aspect?
Yes,
The
aspect
contact
regarding Mr Maguire.
No, the contact with ICAC was in relation to, and our contact with ICAC was parallel to the Leppington Triangle investigation, Senator, and was related to the information that was generated in terms of his involvement in potential purchase of land near the second airport in Sydney. So in relation to this aspect, no.
Okay. So not since estimates, or you just know that you haven't been in contact with ICAC about the matter generally?
We've been in contact through the conduct of the investigation, but it was in relation to that aspect, not the aspect you're referring to.
And what was the nature of that contact?
It was a deconfliction, Senator. It was engaging with investigators from ICAC to make sure that we were deconflicting in terms of those separate investigations.
With has the Department of Home Affairs referred any individuals for investigation or prosecution regarding this matter?
No.
Has the AFP prepared or submitted a brief evidence to the DPP regarding this matter?
In relation to which matter, Senator?
Darryl Maguire matter.
No. We have no active investigation in relation to Darryl Maguire.
All right. Have you been, or has the AFP been in contact with the former New South Wales Premier, Berejiklian, regarding this matter?
No.
All right. Thank you, Chair.
Thanks very much, Senator Ciccone. I'll now give the call to Senator Rennick.
Hi guys, how are you going? I've got some questions in regards to the Leppington Triangle.
We're really getting informal now, Commissioner.
How many staff were engaged in the Leppington Triangle investigation, and what was the estimated cost of that investigation?
Senator, non-investigators, but the investigations team were provided support from a forensic accountant and forensic analysts, so 11 in total during the course of the investigation.
11?
I haven't got the cost of the investigation. I'll have to take that on notice, Senator.
Yeah, sure, that's cool. That's okay. And what evidence was provided by the Auditor General's office that wrongdoing took place?
The original referral letter indicated that fraud may have occurred, and subsequent to that, the Auditor General provided a significant amount of digital material to the AFP as part of the investigation, Senator.
And this digital material, did it have documents of bank accounts and stuff where money was transferred or anything like that? What exactly did it involve?
Well, it involved, in effect, the audit that was undertaken by the Auditor General in terms of the transaction re Leppington Triangle. So it was a range of documents in terms of financial transactions, valuation agreements, a range of documents related to the actual transaction, Senator.
And no evidence was found of any wrongdoing?
We've put out a statement saying we identified no criminal wrongdoing in relation to the matter, Senator.
So do you know why, if there was no evidence of any wrongdoing and you've gone through it and you've got a forensic accountant to confirm that, why the Auditor General would think there was evidence of wrongdoing?
Well, I think you'd have to ask the Auditor General, but in the letter he provided to the Australian Federal Police, he indicated the suspicion of fraud in relation to the transaction. We received that matter, we decided to undertake an investigation, and as a result of that investigation, we haven't found criminal offending in relation to the matter, Senator.
Okay, and did you have to conduct raids on the staff's houses to get all possible records?
I think we've said before at Senate estimates, we don't conduct raids, we conduct search warrants.
Search warrants?
We conducted 2 search warrants, but I think I'm not prepared to say, I think, in terms of the open here, what they related to, Senator.
Right, okay. Well, it's just, my point, I guess the point of view is that these guys who turned out to be innocent have effectively been stood down for 12 months, had their reputations trashed and had their houses, whatever you want to call it. And I guess where's the accountability with the Auditor General to just write a letter making accusations, and it turns out there was absolutely no evidence.
So, Senator Rennick, I will need you just to direct your question to officers in relation to the operations of the AFP.
Sure. Okay. No worries. And okay, so that's pretty much it. Did you, however, identify, look at phone records as well when you conducted the investigation?
I'd have to take that on notice, Senator.
Okay, and can you also take this on notice? If you did look at phone records, did you look at phone records between the Auditor General and any staff or members of the Labor Party?
We wouldn't have done that, Senator, but I'll take it on notice as a matter of completeness.
Yes, okay, no worries. That's all. Thank you.
Thank you very much, Senator Rennick. Commissioner, I've just got a couple of questions in relation to the outstanding work of the AFP over the past 12 months, and I particularly draw on the 38.4 tonnes of illicit drugs and precursors which have been seized, which equated to $15 billion in avoided harm, as highlighted in your annual report. Commissioner, are you able to give the committee a summary of your work over the past 12 months?
Thanks very much, Chair. And look, hats off to all of our people in the AFP, but we've also been able to achieve a lot with all of our partnerships that we have, not just here in Australia with multiple law enforcement and other agencies, but also offshore. And I do want to recognise our offshore officers. This committee probably would not be aware that a lot have had COVID. A lot of their families have had COVID, their children. They've all voluntarily stayed at their post to serve their country. And we've got one officer in particular at the moment who's quite ill, but we're pretty positive that he'll come through. And that's the kind of commitment that the AFP officers are doing to make sure Australians are safe and Australia's safer. Within the last 12 months, 38.4 tonnes, 15 billion avoided in harm, 922 alleged offenders charged with criminal offences. We charged the first person in Australia with a foreign interference offence, 25 alleged offenders resulting from terrorism investigations by the AFP and domestic partners. 411 disruptions across 22 countries, and they're the ones that often people you don't see that necessarily in the media, including some major counter-terrorism disruptions across those countries where we have played a role. We charged 235 people in Australia with child exploitation offences. Sadly, that's a number that keeps increasing every year, as do our referrals. Providing close personal protection to 8 high office holders and the safety of 9 significant visits by foreign dignitaries. And obviously, I've given the stats around Operation Ironside, and even most recently, we seized a quantity of our largest quantity of heroin. Again, that was something that surprised us as to the heroin market in Australia. That was some 450 kilos. And in the last 12 months, we also had an increase in 22,680 reports of child sexual exploitation. And we charged those offenders, those 235, with 2,772 child abuse offences, compared to the previous year, 161 people with 1,214 charges. So we have been extremely busy, both in Australia and offshore, and all of our commands are pretty much maxed out at the moment. And hats off to the people and also the community for the work that the Australian community's done in assisting us, providing us support, whether that be cooperation or notifying of us of suspicious activity and so on. So really want to acknowledge that our mantra of building a bridge to community is going really well from that point of view. The other thing I'd just quickly say, Chair, is that what we're seeing is federal crime has actually increased. Conversely to a lot of the state crime seems to have held at the same time. This is during COVID, and of course that has been the fuel of COVID online, and whether it's reaching all of our crime types now. So we're pretty busy in this area.
So that the instances of online crime generally has really put great pressure on the AFP.
It has, and that's why we've been working with, whether it's the Australian Cybersecurity Centre and our other partners, as to how do we be quite innovative, use that preventative approach. But we've seen people's superannuation accounts, drained. We've seen their bank accounts. We've seen people, young people, exploited online. We've seen people's identities taken, radicalisation, all with the online environment. And I think in my opening statement I talked about the new frontier. It's pretty much hit us full on, and for us, that's why, as the Deputy said, we're very pleased with the new powers that we're getting to help us out, because it's multiple targets, unfortunately, that we have, and often they do tend to be offshore as well, some of our more serious organised crime. And even recently we had a particular individual who was radicalised from an offender that was based in Syria. This is our new norm now.
Commissioner, I've noticed even that, even myself in the last few weeks, I'm getting daily text messages clearly from scammers, and this must be going on everywhere.
Yeah, it's my pet hate, Chair.
Oh, it's so frightening, because you're told that your parcel is waiting, and just press on this link for the details of your parcel, and yet these are often very sophisticated organised crime networks trying to scam Australians, and I've just seen this dramatic increase in the frequency of these scamming, both text messages and also emails.
So that's something we're looking forward to using those new powers to, it is my personal pet hate. I get multiple ones a day. I've tried even different numbers and everything. They seem to be able to find it. But so...
That's a worry if you're getting them, Commissioner.
Yeah, I know. And I'm only one click away too. And a couple of times I've gone, oh, DHL, great. But realised, no, that's not great. Because they somehow often time it when your package is due as well. So there's something in that. But I have said to the team, I'm probably driving my deputy here crazy with my pursuit of how do we stop that, because this is just going to get worse and we're all going to be compromised just from one click. So I have made that a priority with our cyber team, and at the moment we're actually going through an internal review of how can we be more aggressive in cyber, and it may mean a mini restructure internally, Chair, for us to really have what we would call a cyber offensive operation arm of the AFP. Which would actually conduct hostile operations, disruption operations on these individuals. And as you know, a lot of them are based offshore. So we've also talked to the Five Eyes group, which I'm now the chair of the Five Eyes Law Enforcement Group, and talked to them about the threat of cyber. They're seeing the same. So we're going to be able to link up with our partners, but it is something that is really concerning for us.
So the strong warning is if anyone receives a text message or an email saying that there's a parcel or you've got to click on this link, do not click on a link unless you are absolutely certain as to the source.
Yes. Yes, and also, sadly, you've also got to check the numbers that come up on your phone. Some of them appear to be legitimate, but they're not. And even, I won't say, but in my family, we've had some issues too where, company purported to be Telstra wasn't Telstra, and managed to get away with some funds. So it's touching all of us at the moment.
So this happened in your own family?
Yes.
So one of your family members actually was scammed?
Yes. So I think all of us have probably got stories like that, family and friends. Some are probably too embarrassed to talk about it as well. But some of them are very sophisticated.
Thanks, Commissioner. I will now give the call to, just checking, Senator Cox, yes. Yes, Senator Cox.
Thank you, and thank you, Commissioner Kershaw, for your opening statement. I've got some questions in relation to the ANSPA anti-racism and cultural diversity principles. Can you tell us how AFP are integrating them across the policies, procedures and practice of the organisation?
So when I became Commissioner, having both experience in West Australia, and I'm West Australian too, Senator, with Indigenous communities, and obviously from my experience in the Northern Territory, understanding that you first, and elders taught me this, first you have to listen and understand before you make any moves in these areas. So what I did first when I came into the AFP was listen to our First Nations people and local elders as well about some of the issues that the AFP was facing, and that includes ACT Police and our police across Australia and overseas. And we created a new group, the First Nations Unit, which they actually control and are in charge of that particular unit. And that unit is also looking at a whole range of things. How do we increase our representation? Our support probably needed improvement. So they're working on that actively. On top of that, what's probably not known is I did sign an agreement with Kate Jenkins, a 5-year agreement around improving the culture of the AFP. And that includes the ANSPA protocols and what we've signed up to, alongside our Diversity Council and also our First Nations unit. But as you know, and I'm just being probably a bit opinionated here, but some of these, I guess, other organisations I've looked at just want to tick boxes. I don't want to do that. I actually want to do the work, which means I have to be patient, because I'm probably a little bit impatient at times, but you just got to be patient and understanding and go long range. So for us, one is being honest about the experience of our Indigenous officers, First Nations staff in our organisation and how they feel. And that was me listening to the feedback, which was not pleasant to hear that there's discrimination still, there's bullying and harassment. So we are actively working together to provide that solution. And as you know, Senator, a lot of it's about education and awareness and prevention. And then how do you not just tick the box, but really do achieve that initiative? So there's a lot going on in that area. And we've also expanded that out to SHIELD, which is our new health model, which is available for everyone in the organisation. And it's whether or not it's psychiatric sort of help, psych help, or it's physical health, well-being, a whole range of things, because the whole spectrum now, I have to look at our officers and our staff from the lens of, you know, your mental and physical health and well-being overall, and how do we actually show that we genuinely care as an employer and be an employer of choice. We've also changed our videos as far as our outward-facing one, which we're happy to send you a copy of, and I think you'll like it. It's different and it's out there, and we're trying to attract more women in particular. The AFP has one of the lowest percentages in sworn officers, so that's been something we're actively working on. And then also our training and where that's based, because we found from going to market that a lot of people didn't want to come and train in Canberra because it is beautiful weather here, but that was one of the issues they complained about. But so we are looking at moving our training around and training people from that region. Those regions who have the family support can actually spend a bit of time away from their family whilst they do their training. So it's a holistic, I guess, policy framework we have internally, and also my personal commitment to it, which everyone knows about.
Yep. Is there a particular budget attached to that, Commissioner?
There's, well, I probably shouldn't say this, but I haven't said there's a limit on the budget.
I'm sure Senator Stokes
yes,
will
the
be happy to hear that.
Actually, he'll probably help us out on that front. Thanks, Secretary.
Yeah. My second question, thank you for that answer, is in relation to the National Strategy to Prevent Child Sexual Abuse and the $60 million that AFP have allocated for that. Can you tell me a little bit about the intelligence gathering and the relationship with the Coalition of Peaks in relation to Closing the Gap?
So recently, again, don't know if this is public, but we did commission a project with Northern Territory Police around looking at certain communities in the Northern Territory around the online grooming environment. And sadly, that report came back to how we thought it would be, which is very, very disturbing and concerning. So we're now moving into how do we operationalise that intelligence, and I might hand over to the Deputy who's in charge of that particular project.
Yeah, thanks very much, Commissioner. Thanks, Senator. Yes, as a result of the recommendations that come out of that, we've been giving funding for a range of initiatives. One was the addition of 8 additional high technology dogs, and we can't underestimate the value of that. In terms of child sex offending, sadly, one of the assets they hold dear to their heart is their library of images. And we're fortunate that we've had some very dedicated people in Australia who've managed to train canines to be able to find USB hard drives, and the work they're doing is incredible. In addition to that, we've given funding to increase our strike teams and our intelligence. So as a result of that, we deployed staff to the Northern Territory into 3 very remote communities as a bit of a pilot study, very much done in partnership with the Northern Territory Police and very much led in unison with the elders who are very concerned about child safety in their community. So very much a pilot study. As the Commissioner mentioned, the findings, sadly, were predictable, that there was over-representation in those communities in terms of child sex offending. So we're now, we've taken the findings, we're continuing to work with those communities and Northern Territory Police and shape a strategy that's certainly in partnership with those communities to try and improve outcomes and close the gap in that regard.
Are there any other jurisdictions you're working with in relation to that, or is it just the Northern Territory?
Just the Northern Territory is a pilot. We've just finished that piece of work, but it's a good question because you may have seen the documentary on SBS last night about child exploitation, which I thought was outstanding, and it showcased the work law enforcement globally is doing in this area. The reality is it really requires a global task force, and I think that was borne out well in the show. The reason I raise that is, whilst we have 68 full-time staff at the Australian Centre to Combat Child Exploitation in Brisbane, we also have AFP members joined up with all state and territory departments and what we call jackets, which are our joint child exploitation teams. So we've got a wonderful network around Australia that is increasing. COVID has held us back in terms of importing some international expertise. That's our vision for the ACE, is to be a truly global task force, because as we all are aware, the same with the questions on cyber. Crime has moved from beyond our backyards, beyond our state boundaries. A lot of the criminals that are causing harm in Australia are located overseas, so we're very much joined up, and I think probably child exploitation and counter-terrorism, of course, are two areas where we really act as a global task force.
Great, thank you. Thanks for your answers.
Thank you.
Thank you very much, Senator Cox. Look, we have Senator Rice, who's indicated she wants to ask a couple of questions. Senator Rice, have you got just a couple of minutes before we go to Labor, because we'll run through with Labor senators until morning tea?
Yep. Okay.
So if I could just give you a couple of minutes, please.
Okay, thank
Thanks.
you. Look, thank you. So I want to ask about sort of issues with the AFP's involvement both in West Papua and in the Philippines, following on some questions that I asked at last estimates. I note the reports in The Guardian since last estimates of the human rights violations committed by Merauke Police Chief Untung Sangaji, who we discussed at last estimates as being one of the officers that were trained at JCLEC. So is there any evidence that you'd like to correct regarding him since the last estimates?
Thanks, Senator, for your question. I'll just have our Chief Operating Officer answer that.
Thank you, Senator. The information that was Charlotte Tressler, Chief Operating Officer, the information that I provided at the May estimates was correct. The AFP did undertake a search. We did not find any record of the individuals that were asked about at the estimates attending the JCLEC. That said, noting the reporting, I have done some further work on what our processes are. In fact, it was unsurprising that we did not have such a record, as we don't keep a consolidated database or list of JCLEC participants.
So what action has the Australian Federal Police taken since that report?
Senator, we have not undertaken further work. The JCLEC maintains a database of participants. It is a requirement that that information is not accessed by other agencies. Agencies are only allowed to inquire about their own participants at the JCLEC in order to protect the privacy of other policing organisations.
So how do you manage to, I mean, I notice that, you're updating your guidelines as to make sure that they're, the people that you are training aren't human rights abusers. How, if you do not keep any contact details of who you have trained at JCLEC, how do you manage to do that?
So, Senator, as advised before at this committee, it is a requirement at JCLEC that all training is human rights compliant.
But that's not the issue. It's whether you are training human rights abusers.
In relation to the participants themselves, what I can say in relation to the INP is that they do undertake a vetting of their own participants that attend the JCLEC. And if an individual was subject to a formal investigation which related to a criminal offence that could or could not involve human rights offences, they would be ineligible to attend the JCLEC.
After they've done that. So you don't do any vetting. And you don't have any contacts.
Senator Rice, last question.
I've actually got at least another 5 minutes. So
Senator Rice, I've only been able to give you a couple of minutes. I will need to go to Labor senators, so if you could just ask your last question, please.
Okay, well, look, I'll finish off with this with Untung Sangaji then. I mean, you say that you don't have contact. that Joklik, you don't keep lists of contacts, yet in the Guardian article, Untung Sanghaji publicly stated that all the foreigners exchanged phone numbers with us so that we could stay in touch.
Ms Tressler, look, we might just need Senator Rice to provide a copy of the article to which you refer.
I'm happy to table that.
Ms.
I think
Tressler,
I'm pretty
do
sure
you
that
need-
Ms
do you
Tressler
need-
is aware of the article.
Sorry, Senator Rice, just one moment. Do you need to have a look at a copy of this article to answer that question, Ms Tressler?
Thank you, Chair. I don't need to
Thank
see
you.
that article.
We will. I will want it. I would like it to be tabled. Nonetheless, Senator Rice, at the conclusion of this question, please.
Thank you, Senator. Noting the reporting, we did again do a search. We have not become aware of which individuals might have phone numbers. We do note that this is not an unusual practice for policing organisations to have contact details in order to do joint work together.
So would you
Thanks,
be training
Senator
him again?
Rice. That's the last question. We will need to move to Senator Grogan. So thank you very much for that. Senator Grogan, you have the call.
Thank you, Chair. On the 5th of October 2021, the BBC reported that Prime Minister Morrison had invited Brian Houston to a state dinner at the White House in 2019 with the then US President Donald Trump. And that article stated this was vetoed by the White House because the pastor was under criminal investigation. Mr Morrison has since confirmed that he did ask the White House to invite Mr Houston. And the New South Wales Police confirmed in 2019 that their investigation was ongoing into Mr Houston for failing to report his father's abuse of children. In 2015, the Royal...
Sorry, Senator Grogan, I'm just going to stop you here. I'm not across the details of this matter other than I believe that this is a live criminal investigation. So in relation to any matter under criminal investigation, there are limitations as to what can be asked and also addressed by the AFP. So in relation to this, I would just ask you to bear that in mind, please.
Of course.
Chair, just to be fair to Senator Grogan, I mean, these are first estimates, so she's just...
No, I understand. I totally understand
for
that.
the Commissioner.
Yep. So, no, thanks very much, Senator Ciccone, and it's wonderful to have Senator Grogan joining us in estimates for the first time. So just bearing in mind that particular issue.
Sure. So did the AFP ever receive or respond to any request from the American government or any agency of the American government to confirm that Mr Houston was under investigation?
I think I'll have to take that on, not to my knowledge, but I'll have to take that on notice, Senator.
And has the AFP ever opened any investigation into Mr Houston?
Again, not to my knowledge, but I'll take it on notice to make sure we get that right.
And has the Prime Minister's office ever sought any advice from the AFP on Mr Houston and the attendance at that dinner?
I'll take that on notice as well, Senator.
Okay. In regards to Mr Houston's exemptions to travel, are you aware that Mr Houston was granted an approval to leave Australia earlier this year?
I'm personally not aware.
Okay. And there's nobody else with you today that may have any understanding of this case?
I think if it's to do with entering Australia and so on, that's probably not a question for the AFP.
Okay. All right. In relation to travel exemptions in general, obviously Border Force deal with those. What sort of engagement does the AFP have in looking at any of those in terms of criminals being able to leave and re-enter the country? Is there any interface between you?
The only time there would be an interface is when we have the alert system, obviously. If it triggers one of our alerts, there's a protocol there for ABF, or if ABF or Home Affairs wanted us to perform some kind of intelligence for whatever reason. There's multiple reasons. However, I'm not aware of this particular matter. But again, I'll take that component on notice.
Okay, to other people who may or may not travel, when we're looking at other people seeking exemptions, would you have any knowledge of Tariq Zahed, the National Sergeant at Arms of the Comancheros, travelling to the Middle East despite the COVID-19 travel restrictions, Do you have any knowledge of him going through that process? Do the New South Wales Police keep you informed?
I'll take that one on notice, given the fact that that's going to be an operational matter for us.
I guess the issue is, are you kept informed when we have criminals or people under investigation travelling to and from other countries under COVID restrictions while they're also under investigation, and whether that is actually quite a challenging circumstance, and what you're doing about that?
Yeah, we have overt and covert notifications, so to speak. So again, operationally, I just don't think it'd be wise for me to answer that question in relation to that particular outlaw motorcycle gang member. And I would like to take that on notice, Senator.
Okay. And would you say that the state police forces have expressed any concerns about this situation, or Home Affairs more broadly, of the interface between who's granting exemptions to whom and why?
Hasn't been raised with me personally, no.
Okay.
Senator Grogan, have you concluded your questioning?
Yeah, if I could just hand over to Senator Keneally.
Thank you very much. Senator Keneally of the call.
Thank you. If I can just come back to the matter of Mr Brian Houston and just get some clarification. So has the AFP ever been briefed by the New South Wales Police in relation to its investigation into Mr Brian Houston?
I'm not aware, Senator, but I'll take that on notice.
Did the AFP play any role in reviewing the list of Mr Morrison's proposed invitees to the White House State Dinner in September 2019?
I'll take that on notice.
Did the Prime Minister's office seek any advice from the AFP on the status of the police investigations into Mr Brian Houston before including Mr Houston on a list of potential invitees to the White House State Dinner in September 2019?
I'll take that on notice.
When the Wall Street Journal first reported in August 2019 that Mr Morrison sought to invite Mr Houston to the White House State Dinner, Mr Morrison dismissed the reports as gossip, and for months he maintained they were gossip. And finally, in March 2020, Mr Morrison confirmed to 2GB Radio that he did ask the Trump administration to invite Mr Houston. So my question for you is, between August 2019 and March 2020, did the Prime Minister's office or Mr Morrison ever seek advice from the AFP on the status of police investigations into Mr Brian Houston?
I'll take that on notice, Senator.
And to come back to the questions that Senator Grogan was asking, I'm just trying to get a little more clarification in relation to travel exemptions. Is it your evidence to this committee that before the ABF grants a travel exemption, that is the Australian Border Force grants a travel exemption, are there any procedures in place between the ABF and the AFP to identify individuals who might be under police investigation?
There are, but the onus is actually on the police forces or those agencies to provide that information so that, of course, ABF know then to notify the relevant law enforcement agency.
Right. So how are the police forces supposed to know if someone wants to get an exemption to leave the country? Are they providing a constant list of their most high-profile
I think, Senator, it might be
targets?
best to engage with Commissioner Outram later on. But in short...
Well, I apologise, Secretary Pizzullo. The Commissioner just said the onus was on the police
correct.
force.
And to explain that point, there is a consolidated movement alert list, sometimes summarily called a watch list. Relevant jurisdictions are obligated to keep that list up to date.
Yep.
So the Border Force isn't going constantly out saying, person X is seeking to travel, do you have any concerns? It works the other way.
Right.
We would have a concern about person X travelling. That's meant to be then registered through a movement alert list. If that hits during the exemption process, the ABF will go to the jurisdiction saying, we'd like to let you know that person X is seeking to travel, do you have any concerns? But I'd ask that Commissioner Outram be engaged on the detail of that.
Thank you. My question then for the Commissioner, as far as you're aware, the AFP has that obligation to maintain, to use the colloquial watch list, be updated from your perspective. Do state and territory police forces have that same obligation?
Yes, and it's of their own persons of interest.
Right, okay. So if there are individuals such as the Comanchero, who was a sergeant at arms, that Senator Grogan asked about, who was under New South Wales Police investigation, that would be a question for the New South Wales Police.
It would be, because it's actually at their imprimatur to either put that person on that list or not.
Yep, okay. Thank you. And that would be the same for Mr. Houston, who was also under investigation by the New South Wales Police.
Correct.
And you have, just remind me again, your answer to has the AFP ever opened an investigation into Mr. Houston? Your answer was?
Took that on notice.
Great, thank you. Chair, if I may have the indulgence of the committee, just have a couple more minutes. Nothing. I don't portend to hold the witness here much longer than necessary. But
Yes, that's fine, Senator Keneally.
thank you very much. I take the advice the chair provided earlier in her opening remarks in relation to ongoing ongoing court cases. I don't portend to ask any questions about a court case in particular. I do want to ask in relation to the Foster Review. The Foster Review, under responding to serious incidents in parliamentary workplaces, including a recommendation 6 that went directly to the AFP as a matter of urgency, should review their operational procedures to ensure they're fit for purpose with respect to appropriately responding to serious incidents at Parliament House. Can you briefly point me to what steps the AFP has taken to act on this recommendation?
Senator Keneally, I'm listening very carefully to your question. There's going to be a strict enforcement of the position of the AFP in relation to the matter of the alleged sexual assault in Parliament House. I understand you're not asking about that, but if there's any direct or indirect connection with any such matter, then I just want to caution you very carefully.
May I make a point of order, Chair?
You don't need to make a point of order. You can respond to my direction.
Thank you. After last estimates, I sought the clerk's advice about the role of the chair and whether it was the chair's role to interrupt senators as they were asking a question. He referred me to Privilege Resolution 110, where it says it is for witnesses, including the minister, to raise an objection following any question on answering any questions. And then if the objection is raised, it's for the senator to ask the question in the first instance to determine if he or she will press the question. And the decision whether to answer such a question ultimately must be made by the witness. It's not for the chair to make that decision or to determine whether a question should be answered or pressed. The chair should not perform the role of the witness. And therefore, I would like to ask my question as I've asked it. And
Senator Keneally, before you do, I
response of
will respond to your point of order. It is the role of the chair to conduct estimates in accordance with the standing orders. That is what I am doing, and I will do that. And if you've got any issue with that, I ask you not to reflect on the chair. And if there's any issue in relation to that, you can always refer this matter to the Senate. So thank you. Commissioner,
Can I
over
ask a
to you.
clarification question?
No,
Chair?
we've got a couple
Of
more
you.
minutes. We will now go to the Commissioner to respond to your question.
Thanks.
Thank you, Chair. I'm happy to answer that question, Senator.
Thank you.
3 recommendations were referred to the AFP. We've engaged very closely with the Foster Review generally. That recommendation was a new framework for reporting and responding to serious incidents should be established. I'm pleased to say that we've worked collaboratively with DPS. We've finalised a draft protocol which was forwarded to APH on the 20th of October 21.
I think also, Senator, if I could assist the Deputy, just noting that we did answer a question around the recommendations on the 25th of May, budget estimates, page 19 of Hansard, and question on notice. It's for your reference, BE 21-007.
Thank you.
It's a pretty cool number.
Thank you. May I also ask in relation to the Gaetjens review, Mr. Gaetjens paused his inquiry again on 30 August 2021 in relation to who knew what and when in the Prime Minister's office about a matter. about the matter in relation to an alleged sexual assault. Despite commencing the inquiry months earlier in February this year, did Mr. Gaetjens pause his inquiry for a second time as the result of any advice from the AFP? And did he notify the AFP that he had paused the inquiry for a second time?
Given that, Senator, and I want to be as helpful as I can, we've answered 332 questions on this matter. I'd just like to take that one on notice again to just clarify and make sure that it's 100% correct.
Thank you very much. I appreciate that. Thank you, Chair.
Thank you very much, Senator Keneally. Commissioner, that concludes the AFP's evidence this morning. Well, Senator Rice, our time has concluded in the program. So what I might suggest is that we might take that offline just to ascertain how many more questions. How much more time do you need, Senator Rice?
Probably another 5 minutes.
All right. Well, look, if we could perhaps extend our, put on hold our morning tea break. Senator Rice, I could give you another 5 minutes now, and then we will go to morning tea after that. Over to you, Senator Rice.
Okay, thank you. Look, thank you for providing me with the guidelines both for JCLEC and on offshore situations. And I note that the guidelines on offshore situations are currently being reviewed. Can I just clarify that these guidelines, as they stand at the moment, do not cover the situation with, for example, of trainees at JCLEC. My reading of the guidelines is, as they stand at the moment, they basically only cover AFP appointees.
That's correct.
Right, okay. And are the revised guidelines, so can you tell me when the revised guidelines are expected?
They're still under review. We expect to finalise them in the next couple of months, Senator.
And will they cover situations such as trainees at JCLEC?
Senator, the guidelines are still under review, so obviously once that's completed, we're happy to appear before the committee again and provide an update.
But so you cannot tell me whether the revised guidelines will cover situations like the JCLEC trainees?
No, it's still under review, Senator.
Okay, because I note in terms of the information that you provided me about JCLEC, basically that doesn't seem to cover anything about, human rights vetting of people who have been trained either. That's accurate?
The current guidelines don't, and I think it's fair to
No, this is the document about, this is the, I've got it here in front of me, you provided it to me, the amendment to the protocol between the Indonesian National Police and the AFP to establish JCLEC. And my reading of those is there's nothing that would cover the situation of making sure that the people you're training aren't human rights abusers.
Senator Rice, perhaps you could give the Deputy Commissioner an opportunity to answer the question before you start speaking over him once more.
Senator Stoke, thanks very much, Minister. I do note that Senator Rice was clarifying her question, but that is correct. Witnesses do need to be given
limited time.
I understand. Witnesses do need to be given the appropriate opportunity to answer questions.
Senator, I think we've been on the record in terms of the training that we conduct at JCLEC, and all our training has a human rights component. We're on the record. There's over 80 countries that train people at JCLEC, and we rely upon the sovereign countries in terms of the checks that they undertake in relation to people they send to JCLEC.
So so in the case of someone like Untung Sangkaji, you rely upon the Indonesian police force to do those checks.
Correct.
You don't have any transparency. You just accept the people that Indonesia gives you.
Well, we rely upon the sovereign countries that we're dealing with to do those required checks, Senator.
Okay, I will leave it there. I find that appalling. I want to quickly go to the Philippines. On my question on notice from last estimates, you state that the AFP has assisted the development of a social media exploitation capability within Philippine law enforcement. In March this year, the UN stated it was appalled at the deaths of 9 activists at the hands of Philippines law enforcement. Can you give the Senate any guarantee that the work you're doing isn't equipping Philippines police to target activists who have been red tagged?
Senator, given the work we've done with the Philippines, 342 children. Let me.
Senator Rice, I would ask you to please
have
allow
been
the witness
rescued.
to answer the question.
There's been numerous terrorist attacks that have been prevented in the Philippines with the assistance that the AFP is providing. The guidance that we provide on this aspect is directly focused on child protection, both in terms of targeting people back in Australia and protecting children in the Philippines, but also targeting terrorists that would seek to do harm to the Philippine community and to the wider world community in terms of their activity centre. It's focused on that particular
I
issue.
understand your intent, and certainly with regards to child exploitation, it's a very honourable intent. But we do know that people are being arbitrarily executed by the Filipino police, which there is documentation of, with the UN report to the General Assembly outlined the concerns about that operation. So can you guarantee that the work you are doing with the Filipino police isn't equipping them to track activists and human rights campaigners and protesters for arbitrary extrajudicial execution?
As I said at started, Senator, our training in relation to this issue is tailored in relation to child protection.
Yes, but that's not my question.
Senator Rice, I'm sorry. I would ask you to please
I've
provide
asked...
No, Senator Rice, just pause for one moment. Please allow the witness to answer your question.
If he would answer my question.
Excuse me, Senator Rice. Please do not reflect on any witness here during this process. Deputy Commissioner, thank you.
Senator, I've answered your question.
So you cannot give me that guarantee then? That's how I take that question.
What I've said, our
that
training
answer.
is very boutique and it's tailored on protection of children in the Philippines and assisting the Filipinos in terms of the counter-terrorism work that they do.
Last question, Senator Rice.
That's good to know, but my question is, in doing that, can you guarantee us that that training is not equipping the Filipino police to be tracking through social media protesters, human rights advocates, lawyers, even judges, who are then being subject to extrajudicial killing? Can you guarantee that your training is not supporting that?
I've given you my answer, Senator.
Thanks very much, Senator Rice. And I would like to thank Commissioner to you and to your officers from the AFP for appearing today, for your time and for your evidence. We'll now go to morning tea and we will resume in 15 minutes.
You've got nothing.
Yeah, 15 minutes. Well, good morning, and the committee is now in session, and I'd like to call officers from the Australian Criminal Intelligence Commission and the Australian Institute of Criminology. Good morning, Mr. Phelan, welcome. Do you have an opening statement?
No, I do not, thank you.
We will go to questions from senators, and I give the call to Senator Ciccone.
Very much, and good morning, Mr. Phelan.
Morning, Senator.
Senator Keneally wrote to you on Friday, as I understand, to explain that Labor wanted to ask a number of questions with respect to the recent annual report to the 2020-21. And I'm not sure if you've got a copy there with you, but I just wanted to begin by asking questions about the security and integrity part of that annual report, which begins on page 67. Covers topics such as security incidents, breaches of the APS Code of Conduct and misconduct, fraud and corruption. Now, I've noticed the ACIC has stopped reporting individual statistics in that report. For example, in 2017-18, you reported 85 security incidents, but back in 2016-17, you reported just 31. However, since then, the annual report seems to have stopped reporting these numbers. And I guess my first question to you is, why have you stopped reporting these numbers on an annual basis?
Thank you, Senator. Michael Phelan, Chief Executive Officer of the Australian Criminal Intelligence Commission. Thanks very much for the question. I think the same question, in a broad sense, was put to me at the annual report hearing by the PJCLE as well. Last year into our annual report. We did stop reporting the level of granularity after the 2018 report, because we decided that what we do right across the board with our annual report was to report on our legislative requirements that we needed to under the PGPA Act. So we stripped it back to just what was required to be reported on. We still gather those statistics, so we still have them. It's just that we haven't reported them in our annual report, along with a number of other categories as well. We've tried to keep the reporting not to a minimum, not for non-transparency, because we're happy to publish the report, happy to publish the figures. It's no skin off our nose, and we do collect them. And most of those incidents are either have to be reported to the Attorney General's Department or indeed to ACLI in any sense. So I do have them before me in relation to the letter that Senator Keneally wrote me on Friday.
Are you able to provide those statistics to the committee this morning?
I can. I actually got, if you want me to read them out, I can. In relation, I think you asked a number of questions in relation to the number of reported security incidents. So in 2019, we had 60. This is in total.
Yep.
In 2020, we had 69. And so far, year to date, we have 45. And I've got a breakdown of those 45 as to what categories they go into too for this year, which I'm happy to either table or read out, whichever you prefer. And then also some of those, there's a subcategory within those that we classify as internal security breaches. So in 2019 it was 20, in 2020 it was 30, and so far year to date it was 20, and they are calendar years, not financial years as well.
Okay. And if you could also just table with whatever information you've got for the benefit of the committee, that'd be much appreciated.
Certainly.
I guess what was the rationale behind it? You talk about stripping down to just the legislative requirements, but wouldn't it be also important to be not just seen, but to be open and transparent with the Australian public about these statistics?
Our general concern, and this is, I think I alluded to at the hearing as well, is that providing the statistics without context can be a little bit problematic at times. So without having to write a detailed response in relation to each of the categories, like for the subcategories that we put out. And so, for example, just the first one that I've got on the list that I'm happy to table, it talks about a data spill. So in context, if you don't talk about what a data spill is, it looks as if the sky is falling in, when a data spill have all been very minor, and what they are is the unintentional and unauthorised release of information, usually staff accidentally sending an email to the wrong person or a person who wasn't authorised. So not out to the general public, but or to an email address that was a personal email address other than a secure address. So sometimes people inadvertently, our internal staff would send something to their to an external email that is not one that carries a security classification that's appropriate to carry material at protected level. So we class all of those as data spills, and they are generally picked up by individuals self-reporting. So most of the material, and also our systems, of course, pick up one that's gone or attempted to go to an address that's not a proper address. And then the other categories: loss of equipment, loss, theft of access pass, password account sharing, prohibited items in secure area. So someone accidentally taking a USB or a phone into a SCIF, and then I've got to go and get the SCIF cleared. All sorts of things like that. Costs us a lot of money unnecessarily, and also is a security breach. Suspicious activity is classed as a potential security breach, and that's where members of the public are either loitering outside ACIC material, or some of the conduct by our staff is a little bit out of character. Like our computer systems, the auditor might pick up a little bit of excess printing over and above what would normally be done, etc. Suspicious contact, so unsolicited contact with members of staff by a member of the public who is a person of interest, just by knowing who we are, making those contacts, and people self-reporting. So without context, I could write about, 1,000 words on all of those, and I don't know whether it gets us a long way.
No, and I appreciate that. And look, with whatever material you can table today, I'm assuming we'll be answering the questions that Senator Keneally,
it will,
including the last 3 financial years, I understand.
Yeah, I think we've got, yes, not with a level of granularity for that, but I'm happy to take that on notice and go further back for the last 3 financial years.
And if you could, what was the nature of those incidents as well too?
Yes, that's right. That's
I think indicate how, whether they were low, medium or high breaches, and the implications of those breaches?
Certainly. Nearly all of them were classified as low. Anything that's, just so we're clear, anything that's serious, anything that is a allegation of corruption goes straight to ACLI to be reported. And as a matter of course, if I have leaked documents, so if there are ACIC intelligence material that I read in the paper or someone else has got, then I will generally report that to the AFP.
Okay. And out of interest, was anyone's employment terminated?
As a result of
those breaches?
The security breaches?
Yeah.
We had one person terminated for this financial year for breach of the code of conduct that related to historical misuse of equipment many, many years ago. And I don't want to say any more than that other than because our cases are so frequent, I want to be careful about potentially identifying individuals.
And out of those incidents, how many met the definition of the Protective Security Policy Framework breach?
If I could take that on notice, Senator, I'll get those level of detail for you. That shouldn't be hard to get.
All right. Well, if you could push for if you could provide those numbers for the last 3 financial years as well, too, that would be appreciated as well.
Certainly will.
Look, could I just move on to the breaches of the Australian Public Service Code of Conduct? How many cases in 2020-21 were there where staff were investigated following referrals of breaching the APS Code of Conduct?
Okay. So far in 2021, there were 6 referrals.
Sorry.
6?
6, yep.
3 of the referrals were assessed and required no further action. 3 of the referrals were investigated for alleged breaches of the Code of Conduct. There were 2 findings of the breaches of the Code of Conduct, so one is still ongoing. Of the 2 who were found to have breached the Code of Conduct, 1 employee received a sanction and the other is still being determined.
And how does that compare to the past 3 years?
I'll have to take that on notice, Senator, but my understanding is, because most of those things come up to me, I don't see that as extraordinary in terms of my previous 4 years here.
Turning to the misconduct, fraud and corruption now, how many alleged cases were referred to the ACIC internally and externally in relation to misconduct, fraud and corruption in the year 2021?
You mean the other way, us referring it back out?
Sure.
Yeah. We recorded 41 incidents ranging from minor misconduct matters, potential serious conflicts of interest and declarable associations through to corruption allegations. So the wide variation of on the spectrum of potential matters. We referred 3 corruption matters to ACLI and 1 alleged matter of criminal conduct to the AFP. It was unrelated to employment.
Okay. So, sorry, in terms of how many, so any were substantiated or unsubstantiated?
I think we've still got a number of them that are under investigation by ACLI, and we consider 11 of the matters still to be open. So I can take on notice exactly how many have been substantiated.
Yeah, well, how many are open, unsubstantiated, withdrawn or substantiated? That would be great.
Certainly.
Yep. And also, what were the consequences for those staff members as well too?
Yes. Well, for the consequences would have been what I referred to earlier on for the breach of conduct. They would have been, I've had no one charged in relation to criminal matters, but certainly for breaches of the APS Code of Conduct, there were 2 that received a sanction.
All right. And again, for those last 3 financial years too, if you could provide that information to the committee.
Yes, certainly.
Now, I just want to move on to another topic. I think on page 33, 34 of the annual report, you identify that satisfaction has dropped amongst your stakeholders, that the ACIC intelligence is meaningful and useful.
Yep.
Your objective is that more than 80% of your stakeholders believe your intelligence products identify changes within the criminal environment and provide comprehensive and relevant understanding of crime impact in Australia. But before we talk about what's happened, can you tell me what kind of stakeholders are we talking about here?
So law enforcement agencies, so at all levels, so through their executive all the way through to practitioners, and some bespoke areas such as people using our National Policing Information System. So we would survey some of the practitioners, for example, had to use the National Fingerprint Database, DNA database. So we try and target it as best we can to some of those users. In areas of mostly to law enforcement agencies, though, to be their state crime commands or their intelligence areas. And also some of our other stakeholders are government departments, Commonwealth government departments, including the security agencies.
Okay. So, and what form do your intelligence reports take?
Three, really. I suppose we do tactical intelligence reports, some of them, specifically involving intelligence that we may have received from human source or other methods. And that will go directly to a law enforcement agency, depending on the circumstances of the information, because it may relate directly to a particular operation they may be conducting or one that is well and truly within their jurisdiction. Some of the intelligence reports we provide to Australian government agencies, particularly agencies in relation to the payment of social security benefits and so on. So direct information to them. We also provide strategic products, which will give us some insights into what's happening in the criminal environment. So, for example, over the last financial year, so predominantly since COVID struck, the agency has been working very closely on, well, what are the impacts of COVID? What does it mean for law enforcement generally? So what does it mean for the importation of drugs? What does it mean for supply chain management as far as criminals are concerned? What does it mean for the resilience of criminals? And we've been able to determine a number of things that were, quite stark, and to be able to give that information directly to state and territory authorities so that they can conduct their operations. Also, a number of strategic products, I think about 7, on the impacts of Operation Ironside in relation to what it means to the criminal environment. So what our human sources are telling us, what others are telling us, what it means in terms of dedicated encrypted devices, criminal encrypted devices, what's the likelihood of the uptake of those devices, the switching to other devices, etc. So that's where those are the sort of products we have put out over the period of time.
Just for the benefit of all here, those watching, Senator Ciccone has indicated he has about another 10 minutes of questions, so I will extend that time to Senator Ciccone, and then I've got a couple of brief questions after that. So thank you very much, Senator Ciccone.
Thanks, Chair. Look, in the annual report, I note that you received, I think, 661 requests for additional disclosure, which is quite a rise, I think, from the previous financial year, 456. What's driven this increase?
Well, it's interesting because, I think we've been a lot more forward-leaning in letting our law enforcement partners know what's available in terms of our capabilities. I'm not prepared to say that publicly, but some of our law enforcement partners have been working closely over a number of years, have seen the results of the specific intelligence that's been passed on to them, and they've achieved a number of highly public and also effective disruptive activity against organised crime, and therefore they've seen the value of working with the ACIC. It actually runs a little bit counterintuitive to the amount of satisfaction that we've received right across the board in terms of some of the reporting that's come back. And I think, to us, I think we've had a good look at it as an executive. We have to be a little bit more nuanced about who we ask the questions of in relation to our products. And that's not to try and skew a result. It's actually to try and get some meaningful feedback, because the feedback we're getting at the executive level and at the practitioner level is that all of our partners are extremely thankful and grateful for the sort of work that we've been doing with them. And most of it, of course, is not public.
And do you expect the year 21-22 to also be high?
I think Yes, we are constantly working with our state and territory and federal colleagues, and I do not anticipate those figures to go down at all.
Do you have any indication so far?
In the first 2 months, I don't
Yeah.
have the figures in front of me, but I'm happy to look at that and see what we've got so far.
Whatever
And
you can
I'll take
provide.
that on notice and
Yep.
produce
All
that
right.
to the committee.
Now, I understand only 2/3 of stakeholders thought your intelligence products provide a comprehensive and relevant understanding of crime impact in Australia. Now, that's a big drop from 74% in the previous year, but can you explain this drop?
No, I think I've got some theories, but I'm not say they're based in any significant foundation. I mean, some of the feedback that we got in the text was that the reports were a little bit too specific and to particular crime types, and and focused on particular areas. But what we've tried to do, certainly over the last 12 to 18 months, is to actually focus our work so that we're not trying to do everything. So we're trying to limit ourselves directly to what the determinations that are set by the board are, and try not to go off in tangents and do some work that doesn't fit within that serious and organised crime area. So a lot of our work has been focused on those particular areas, and sometimes that is of no interest or use to someone who is filling out one of the surveys.
I mean, could this be an issue to do with personnel or technology?
Certainly, I think the results in relation to our satisfaction with the National Policing information systems is in relation to technology. I mean, we're in the middle at the moment of two big uplifts in terms of our technology in relation to both our National Criminal Intelligence System and also the National Fingerprint System, which are our two biggest systems. And therefore, what we have embarked upon over the last 2 years in particular is we've got both the National Police Reference System and the NAFIS system, that's the fingerprint system, in sustainment mode. So just keeping it going at level, knowing that we've got two major upgrades to go. So it could well be that some individuals look at that and go, well, you know, I'm not getting the service I want yet, it's not quick enough, where's my upgrades to these systems, which we haven't had a large investment on, but we will.
So do you need more resources?
No, the resources are fine. The systems are, for example, the NSIS system is well and truly on budget and on scope. I mean, we're looking to roll out the first 3 jurisdictions to be fully enabled into the National Criminal Intelligence System by end of December. That's Queensland, Victoria and Western Australia. New South Wales are coming online in March. That's just a technical issue. And then the late adopters, which we've been funded for by government, to come on just shortly after that. And in relation to the fingerprint system, we're fully funded for that to be rolled out over the next few years.
All right, so you don't need a larger budget, is what you're saying?
I don't think there'll be a public servant that sits at this table who doesn't want a larger budget, Senator.
Hopefully the minister's taking
I'm no
note.
different to them.
All right, look,
Senator
thank you, and
Ciccone.
I'll have some other follow-on questions around the fingerprint later on.
Yes.
Thank you very much.
Thank you very much, Senator Ciccone. We will now go to Senator McKim, who is attending via telephone conference. Senator McKim.
Thank you, Chair. Appreciate that. Can I just check that folks there can hear me okay?
Yes, you're coming through loud and clear. Thank you.
Thanks very much. So questions for ACIC. In your 2017 report on serious financial crime in Australia, you said that the release of the Mossack Fonseca client data and similar data sets has shown that the extent of tax evasion facilitated by large corporate offshore service providers is likely to be considerably larger than previously thought. How about since the release of the Pandora Papers? Have you updated your thinking at all around that? And do you now think it might be even larger again than what you previously thought?
Senator, I think with the release of the Pandora Papers and what we know about them, and we've been working with we don't have access to the full data, but certainly we have enough of the data sets that are there that all it does is confirm the original assessments that were made in 2017 is that offshore enablers do cause us a problem, both from a revenue protection position in terms of our tax revenue, but also potential money laundering and obfuscating of funds that may well have been derived illicitly from activities in Australia.
Okay, thank you. You concluded that report by saying that targeting enablers of financial crime provides a unique opportunity to affect illicit markets. I assume that you would still believe that that is the case?
Yes, our position has not changed, Senator.
All right, thank you. And would it be fair to say that the release of the Pandora Papers has only confirmed the importance of enablers in facilitating financial crime?
Yes, Senator, I think that's what I just said a couple of seconds ago. Yeah, absolutely. Our position has been confirmed.
Thank you. You, in the 2017 report, went on to refer to opportunities for, and I'll just quote from the report there, policy, legislative or regulatory changes implemented in markets or against enablers. Would one of those opportunities be to include lawyers, accountants and real estate agents as designated service providers under the Anti-Money Laundering and Counter-Terrorism Financing Act?
I think the report actually does name those three particular groups in 2017, and from memory, Senator, you asked me the same question 2 years ago in 2019. I said things hadn't changed, and now here in 2021 my position has not changed either.
Good, and your memory is in accordance with mine. What's changed is that we've had the release of the Pandora Papers, and we still, unfortunately, haven't seen change in terms of an update to the AML-CTF Act. But I'll just leave that as a comment. Could I ask then, please, does ACIC believe that Australia's failure to include the professional facilitators in anti-money laundering laws has made us a more attractive destination for financial crime?
I wouldn't go so far as saying our failure, certainly, and I wouldn't necessarily say that we are a favourite destination for money laundering. As a matter of fact, Australia is a net consumer of serious and organised crime, which means generally the money goes the other way. So not a lot. I mean, whilst there are some criminal assets obviously kept onshore here, the monitoring and regulation that the ACIC does in conduct with AUSTRAC, information from State and Territory Police, the Foreign Investment Review Board, details that come from the Department of Home Affairs and other government agencies. We've got a pretty good handle on what's happening here, and I would not say that Australia is a popular destination for laundered funds. Popular in a sense of relativity, Senator.
Sorry, I just missed the last bit there, Mr. Phelan.
I said popular in a sense of relativity. So if I was going to hide my money, it would have been it'd been an offshore tax haven. It certainly wouldn't be here.
All right, but I'll put a question like this then. Isn't it true that Australia is now one of only 5 countries in the world not to have included the professional facilitators within the scope of anti-money laundering laws? And isn't one of those 5, the United States, now moving to fix that? And I guess I'm asking, if there's fewer and fewer countries where professional facilitators can legally turn a blind eye, then logically aren't more criminals going to be looking to Australia as a place to clean their dirty money?
I don't know the exact numbers, Senator, nor where our designation of various groups differs from some of those other jurisdictions. AUSTRAC would be well and truly aware of that and would be better placed to answer that question than me. I mean, I could go get some advice to answer the question on notice, but I'd only be going to AUSTRAC in any sense. But as I said before, Australia is not generally a good place to hide your money. It is easy, relatively easy, for law enforcement to trace assets here in Australia. So including some of the legislation that's been passed here in relation to unexplained wealth. So you'd have to be pretty game if you're not earning any money and then to own tens of millions of dollars, even in real estate in this country, and think that law enforcement will not catch up with you eventually.
Would it be more likely that law enforcement would catch up with you eventually if the professional enablers were designated under the AML-CTF Act?
Oh, I think that's what our 2017 report said. I think it is a vulnerability, and I'm not going to step back from that. I think that's obvious, but it is a matter of government policy as to what they choose to regulate and what they do not.
No, that's right, and I'm aware that we have AUSTRAC in shortly, so I won't pursue that. But if I could just ask Mr. Phelan whether ACIC would agree with the proposition that Australia's failure to regulate the professional facilitators under the AML-CTF Act creates a weakness in the international financial system.
Well, I'm not going to characterise it as a failure. That's your words, not mine. But I will say that from a law enforcement perspective, we are always looking at trying to advise governments and to try and close any capability gaps that we might see, from everything from money laundering through to drug legislation and everything else. So there are always gaps. There are always smart criminals and facilitators that play legislative arbitrage with all of us throughout the world, and we are continually playing catch-up. But I must say, I've been doing this for 35 years now. I'd much rather be a law enforcement officer in this country than most of the others, in terms of what we've got access to, in terms of information and crime-fighting abilities.
All right, I'll just rephrase the question then. Do you think that the fact that Australia has not legislated to include the enablers under the AML-CTF Act creates a weakness in the international financial system? So I've removed the word failure there, Mr. Phelan.
No, that's all right. I'm not trying to obfuscate. I'm just saying that if that goes back then to our assessment from 2017, which still says that those things are a vulnerability, and as I said twice before, in 2019 and again today, our assessment has not changed.
And so you would agree with the proposition that it does create a weakness in the international financial system?
I'm not sure about the international finance system, but certainly it is a vulnerability within the money laundering environment.
Okay, well, the Financial Action Task Force, whose job it actually is to identify vulnerabilities in the international financial system, have recommended that professional facilitators be covered by AML-CTF law. So would you agree that, in fact, that should happen?
Well, we've made the same recommendation in 2017, Senator.
All right, thanks. Are you looking at, this is my last question, Chair, are you looking at another report on serious financial crime, or updating your previous report, Mr. Phelan?
I don't know off the top of my head, Senator, but I'm happy to take that on notice. There could well be one under construction. Certainly I know we've got a number of other strategic products, of which serious financial crime is an element. So we are looking at updating our national criminal assessment, so basically a state of the nation environmental report that would come out sometime before the end of the year. I'm sure that financial crimes will take up a rather large portion of that assessment.
Senator McKim.
All right, thank you. If I could just ask that you take that on notice, and perhaps just in a slightly more broad way than I asked it. So whether there is an update of that report or another report or any other strategic work that you are doing in that area.
Minister.
Thank you, Madam Chair. Senator McKim, I might add, just for those listening at home who might not be across the concept of enablers, the International Financial Action Task Force gave us some recommendations about ways in which we can do everything possible to make sure that we're doing what we can to stop money laundering. Tranche 2, so we've obviously already implemented our first tranche of responses to that, but Tranche 2 would mean the government implementing regulation on all lawyers, accountants, real estate agents and the like within the current framework for anti-money laundering and counter-terrorism financing laws. These are going to be complex to implement, and they will have a significant impact on thousands of businesses across the country. So there's an in-depth consultation and sort of co-design process underway, because as many as 100,000 additional businesses, the majority of which are small businesses, sole traders and practitioners, would be captured. And so we want to make sure that while we do what's necessary to make sure that money laundering and like criminal activity is stopped, and it must be stopped, it's done in a way that is achievable and accessible for businesses that may not have the resources of, for example, our big banks.
Thank you very much,
Tranche 2
Assistant
was
Minister.
promised 15 years
We'll just
ago.
make this the last question,
15
Senator McKim,
years
please.
ago.
Do you have a final...
I'm just making the point that Tranche 2 was promised 15 years ago. Thanks, Chair.
Okay, thank you very much, Senator McKim. I will now give the call to Senator Thorpe, who is attending remotely via video conference. Welcome, Senator Thorpe.
Thank you, Chair, and thank you for appearing this morning. This is the last set of estimates, the last for the year, and it's also the 30th anniversary of the Royal Commission into Aboriginal Deaths in Custody. Are you in a position to advise the nation on how many Aboriginal deaths we have had in custody since we met last?
Since we met last, Senator, I think we might have given the figures for up to 2019. So, as you're no doubt aware, last month we released the report for deaths in custody, so all deaths in custody, for the 2019-20 report. We only released last month. And in that particular report, there was an increase of, let me see, sorry, I'm just going through the details here. In prison custody, 13 Indigenous people who identified as Indigenous, and 3 people in police custody, so a total of 17 for up till 2020. However, I'm also, as you know from last estimates, we decided to revise the reports. So instead of the reports coming out some 15 months after the statistics closed, we've decided now to bring them out a lot sooner. So, which does mean that the fidelity around the reporting is not 100%, because there are a number of things that need to be determined during that period, for example, the coronials and so on. So, but I do have more up-to-date figures for the end of the current, or the financial year just finished, so 2020, where the number of Indigenous deaths in custody was recorded as 15, so down from 17 to 15. Like I said...
Mr Phelan, just to clarify, are you talking about the 2020-21 financial year?
2021 financial year. The report has not been released yet, so I'm giving the figures raw because I knew that it would certainly be of public interest to this committee. So the latest figure is 15. So I suppose since we last spoke then, Senator, that'd be 17 plus 15, so 32, unfortunately, since 2019, the end of 2019.
Well, thank you. It's quite devastating for those families, I must say, and I must say after 30 years of the Royal Commission that we're still trying to work out how to count these sophisticated genocidal acts. But I'll ask my next question, and it's referring to my questioning additional estimates from the 22nd of March 21, question AE 21 of 143, regarding Aboriginal in custody and community involvement. In your answer, you advised that the Australian Institute of Criminology met with the NIAA to discuss how to engage First Nations people regarding identifying Aboriginal deaths in custody. So my questions are, what was the outcome of that meeting?
Certainly now what we have now is a committee that will look at the figures on a quarterly basis, and we will publish those figures on a quarterly basis. It was because we want to be able to be as transparent as we possibly can, and obviously the information needs to come to us to be able to make those. So part of the determination of what figures will be released will have Indigenous involvement in that particular steering group that looks at that. We did consider having monthly figures, but whilst we could obtain the figures, I would have thought that could be a little bit misleading, because what I didn't want is to have a month potentially where you had negative deaths in custody because someone's status was, as an Indigenous person, was not captured correctly and needed to change. So that's why we've moved to quarterly. So we've actually, given the time we've had these discussions at estimates, Senator, we've moved from 15 months behind to now 3 months after the closing figure for an annual report, which has a fair bit more fidelity around it. And now we're moving to quarterly reports that will be reported on our website. So the next report that will be on our website, or part of the dashboard, will be in April of 2022, which will have the figures from January to March, so first quarter next year. So from that moment on, we'll be moving to a quarterly reporting. And this is for policymakers' benefit. As you know, we just try and gather the statistics as best we can to provide as much granular information we can for policymakers right across the board. And what we are interested in at the AIC is making sure we have the correct figures. And that's why it was a big step for us to move them back from some 15 months after the closing date to only 3 or 4 months after the closing date. Because when it comes to the Institute of Criminology, the robustness and the correct figures are extremely important to us, so people can make informed decisions based upon that data.
Well, that's a positive step. I think if we're going to have more reporting, not so much real-time reporting, but I suppose it's something. Could you tell me a little bit more about the steering group and the First Peoples participation and what that looks like?
If I may, I might, Chair, if it's all right, I might ask Dr. Rick Brown to come up, the Deputy Director of the Institute of Criminology.
Thanks, Mr. Finlay.
He was actually at the meeting, so it'd be... Thank you, Senator.
Senator Rick Brown, Deputy Director, Australian Institute of Criminology. As the Director said, we had our first meeting of the steering group in July of this year, and it was had representation from every state and territory. We had representation from each of the data custodians. So that consists of each of the police jurisdictions that provide us with data and each of the correctional services that provide data. In addition, I chaired the meeting, and it was co-chaired by a representative from NIAA, and we also have a representative from the National Aboriginal and Torres Strait Island Legal Service as well. So NATSLs. At present, the Indigenous representation is an area that we continue to look at. We've got this group running, up and running since last estimates in recognition of the issues that were raised, but we will continue to look at the membership of the group to make sure that it takes on board as many parties' views as possible.
Thank you very much. It's great to hear that NATSLs are involved in that process, and I look forward to hearing how we can have more grassroots voices, particularly those families that the Prime Minister has refused to meet with. Those families also have something to say around this, and we really need to get those grassroots voices involved. NIAA are just a department of the government, but I'd like to also provide my assistance in getting more people around the table. So thank you very much.
Thank you very much, Senator Thorpe. We will now return to...
Before we
yes,
shift to a different subject area,
yes,
noting that this
Minister.
issue of deaths in custody is serious and it's sensitive, I thought I might put some key figures on the record that might be useful for people listening at home to understand the state of play in this area. And the first thing to say is that in 2019 to 20, 16 of the 113 deaths in custody were of Indigenous Australians. If we talk about prison custody, death rates of Indigenous prisoners per 100 prisoners have been lower than the death rates of non-Indigenous prisoners since the year 2003 to 4. And again, in prison custody, of the 81 deaths for which the cause of death was recorded, 59, or that amounts to 73% of those, were due to natural causes. For Indigenous Australians, 89% of deaths in prison custody are due to natural causes, and for non-Indigenous people, 71% are due to natural causes. Now, of course, any death, particularly those that aren't of natural causes, are very serious. But that little bit of detail can help to understand the complexity of the problem with which we're dealing.
Thank you very much, Minister.
Chair, could I just respond to that, please, with all due respect?
Senator Thorpe, if you have a final question.
I have a question for the Minister.
Yeah,
Chair.
just very briefly, yes, you have the call.
Thank you. Sorry, not Minister. Senator, Minister. Natural causes, I question, because from a First Peoples perspective of a natural cause, there's usually some other systemic racism that is contributing to the high rate of health issues in this country for First People. So I just think that the comparison that you draw, Minister, between natural causes of the general population in comparison to the First People of this nation is it's incorrect, and I just want that noted in Hansard, please.
Look, I'm happy to accept the proposition that there are a number of challenges that affect Australia's Indigenous people, particularly around life expectancy and health generally. I don't cavil with that proposition, but in the public mind, when they think about deaths in, for instance, prison custody, I think that conjures a particular image, and it's helpful to have an understanding of the different ways in which these, albeit very sad circumstances, are manifesting. So I do hear what you say, Senator Thorpe.
I do have one more question and then I'll finish.
We will need to finish up, Senator Thorpe.
Pardon, Chair. Minister, so how can your government communicate that so it doesn't create a racist slur, and the fact that far right and the extremist white racist people we have in this country say that exactly what you just said, Minister, exactly what you just said, that the comparison is, oh, well, in terms of the numbers, it's not that great. Aboriginal deaths in custody is a national crisis and it needs to stop. We need to stop police from killing Aboriginal people in this country.
Senator Thorpe, I'll take that for the most part as a contribution rather than a question, but I reject entirely what lies implicit in it, and that is the suggestion that all non-Indigenous Australians are racist. Well, that is an utter falsehood.
I didn't say that.
Well,
I didn't say that.
I think if you reflect upon...
Minister, Senator Thorpe did not actually state that. So just for the record, we need to clarify that.
The language as I recall it was these white racist Australians. And I do not accept the proposition that that is the case. And if that's not what you're saying, then we don't have a problem, Senator Thorpe. But I just want to make that very clear.
All right, so look, I'm going to, the Minister has addressed your question, Senator Thorpe. I realise that this is an extremely difficult and tragic issue to canvass, but I am going to need to move to other senators. So thank you very much.
Can I just finish my last answer?
Yes, Minister, if you just want to...
and the second thing is to say that the first thing we do is communicate honestly about the statistics in their full tragedy, in their light and shade, and in the way that they have changed over time. You asked us how we're communicating that. We are doing that by being forthright. The other thing we're doing is working diligently with the states to close the gap so that some of those underlying factors that feed into this are being addressed too. And that's part of the constructive and constructive approach that's focused on bringing Australians together that we're trying to use
stop killing
to address
blacks
this.
in this country.
Senator Thorpe.
Sorry,
Senator
I'm going
Thorpe,
to...
That's not necessary.
Senator Thorpe, that sort of... I would just remind all senators that we need to just direct questions to witnesses, including to the Minister. I'm now going to move... Thank you, Minister. I'm now going to move to Senator Keneally.
Thank you, Chair. I would like to, Mr. Phelan, canvass some ground on this very point that you and I have canvassed previously. And that is that sometimes I do hear an observation made, and it is a fair observation, that First Nations people who are in custody are statistically less likely to die in custody than non-Indigenous persons. And I don't quibble with that fact, but I do note that the AIC, as it was then, report in 2018-19 put that particular fact in another context. So please correct me if I'm wrong, that report found that Indigenous people as a whole are statistically far more likely to die in custody than non-Indigenous Australians because of the vastly disproportionate rates of incarceration.
Yes, Senator. I mean, the figures that we have, based on a proportion of the population of Indigenous people in Australia and the deaths of non-Indigenous people as a proportion of non-Indigenous people in Australia, that an Indigenous person is 6 times more likely to die in custody, and that is, and the line to be drawn there is clearly over-representation in the prison system.
And I think, and maybe Dr. Brown can assist here, your report also found that Indigenous people are nearly 10 times more likely to die in prison custody than non-Indigenous people.
I think it's slightly lower.
I think it was
this time.
6 times in police custody and 10 times in prison custody.
It's slightly different this year. I think you were quoting...
I'm referring to the 18-19
yes,
report.
Yeah.
I've got the figures here for 20. So,
great, that would be helpful. Thank you.
So it's where are we? It's represented death rate. Sorry, 5 and 6. Yeah. Okay. So 0.11 and. This one and this one. Yeah. So so for non-Indigenous people, it was 0.39 per 100,000 and 2.46 per 100,000 for Indigenous people. So 6 times higher, roughly. So
right.
0.39 to 2.46.
And was there a distinction in your figures this year between police and prison custody?
I have the figures for... No, it's not. Oh, hang on.
Yeah,
Yes, I do.
0.10.
Yep, it's... I'm just trying to here. 0.08 for non-Indigenous and 0.45 for Indigenous. So what's that? 5-6 times. So
yeah.
roughly the same.
Goodness. So that,
It's a pretty small number, though.
sure.
The granularity,
But I think that
for
context does help to understand. There are the raw figures, and then there are the rates of more likely than a non-Indigenous person. And I think that helps put all of these statistics in context. So thank you. And I do note that you and I canvassed last estimates that this information would be released more regularly. So I want to thank you for that. Chair, that's all the only question I had, but I think Senator Ciccone
Yes,
may
that's
have
right.
some additional questions.
Thanks very much, Senator Keneally. Over to you, Senator Ciccone.
Thank you very much, Chair. Look, I just wanted to turn to page 38 of the annual report, where it's noted that the National Automated Fingerprint Identification System had fewer data matches due to a number of factors, including the impact of COVID-19 and changes to fingerprint processing by police partners. Firstly, how does COVID-19, or how has COVID-19 impacted the fingerprint identification?
a number of factors. Anecdotally, the number of checks that are done. So the number of checks that are going against the system has gone down from 1.5 million to approximately 1 million. Now, a lot of that is dealt with just simply because less people going through the watch houses, less people actually being checked for fingerprints against the system, and just generally COVID-related law enforcement activity, and a lot of the states and territories will attribute this during the periods of high lockdown early in 2020 all the way through. There was a marked reduction in volume crime during those periods as well. And also, as I've just been advised then, less people crossing the border, which is a major contributor to checks into NAFIS. So people going for visas and so on like that.
So is this what you mean by changes to fingerprint processing by police partners?
A little, yes.
Yeah, okay.
Yes.
So do you also mean that state police have changed the way that they fingerprint?
Not really. They do it, but remote access is difficult with fingerprint analysis and so on. The systems are bespoke systems that sit within the policing environment, within their forensic capability areas, to the most part. So generally, that's what's occurring in that space.
All right. So no other changes to the national automated system?
No, the automated system is fine. As a matter of fact, we had a major upgrade only last year where we stabilised the hardware system, because the actual system we're using now is almost at the end of life, end of its serviceable life, and so we're negotiating now to have a long-term solution, which we are well advanced in negotiations to embed a new system.
Have you provided the committee with any information or updates on that upgrade since we last caught up?
It is only an upgrade, so no different than moving from Microsoft 10 to 11 or iOS 10 to 11. Same company, different attributes that are available in the system. Also, its ability to be cloud-based, so that we do not have to, in a secure government cloud, so that we don't have to worry about major software upgrades and hardware upgrades into the future. So really future-proofing the system, that is also being used through the exact same system through the same company, which is the company we currently work with, rolled out in the United States. The FBI have it, also the BKA in Germany.
Okay. So there's no, when do you think it'll be complete then, I guess?
Complete?
Yeah.
Probably another 18 months before it gets rolled out completely. For context though, we've got, the Australian federated environment is challenging. It may not surprise senators here that every state does things differently, including their IT systems and including the way in which fingerprint analysis is done in each of the jurisdictions. So some of them have their own bespoke systems that connect into the national system. So we've got to make sure that all those systems connect correctly into the national database for timely. The last thing we want to do is for no one to have access to the system. I think you'll see the amount of access time that it was available was up well above 99%.
Is funding already allocated for that upgrade? Or?
Certainly a lot of the funding internally, well, it comes out of the special account, so which is the ACIC runs, which is where the funds derive from the National Criminal Checking System. So when someone does a criminal history check, the wholesale price of those stays inside the ACIC. It's the old CrimTrack construct, where that money is then used to run all of the national policing information systems. And there is enough money in that, plus for the forward out years in terms of revenue projections, to more than cover the costs of upgrading the national fingerprint system, as indeed all the other systems that we run.
And how much did you say it cost?
I can tell you exactly. The budget is approximately $10.5 million per annum. It's the largest single national policing information system that we fund in terms of a percentage of the allocation of funding for the NPI systems, of which there are about 14.
Okay.
And 7% of our staff are dedicated to that particular service.
Yeah. So the X-ray I just quoted earlier on for page 38, it talks about that the fingerprint system is less effective due to a number of factors. What were the other factors that not relate to COVID or fingerprinting processing?
I don't know off the top of my head. I'll take that on notice and I can get straight back to you, Senator.
All right, if you could. So what's the impact of any reductions with respect to the effectiveness of the fingerprinting technology?
Well, at the moment, it's not a matter of what's anything less available, it's what will come more when the system is upgraded. So I don't consider the system to be less effective in terms of what policing organisations want from that system. As a matter of fact, it's one of the most robust out of the systems we do have.
So what are the state police telling you? Like, what's their feedback?
Their feedback is that in terms of the new system, there is obviously a lot more functionality that they would like. Having said that, if I ask any practitioner about systems, they would like the equivalent of a hamburger with the lot. What we are trying to do here with the new system is give everything we currently do, plus some additional enhancements into the system, but then try and not make it too bespoke per jurisdiction that the system becomes too unwieldy and difficult to manage in the out years in terms of financial viability. To be quite honest, that's what happened with the BIS project that we abandoned, is we were trying to be too prescriptive in terms of meeting all of the requirements of each of the jurisdictions, and now the system is designed to do the capability we already have, which is some of the best in the world, with the enhancements we'll have, and we will have, when it comes in, the best system that is available anywhere in the world today.
All right, so we're not going for the Big Mac, we're going for the quarter pounder is what you're saying.
Well, I'm going for something that's yummy and they'll be able to digest.
All right. Look,
Mr. Phelan.
Can I quickly just turn on to another matter?
That's a risky proposition you just put forward, you know.
With the limited time we've got. Now, I know police have been working very stressful times, obviously, with the pandemic of late. I just wanted to touch on page 40. So there's an extract there where it talks about the system reliability and some of the feedback from stakeholders. I understand half of the stakeholders don't believe that the National Police Information System meets their needs. And 1/3 don't believe that their systems are reliable. Sorry, your systems are reliable. What explanation can you give the committee for the 1/3 of your stakeholders believing that those systems aren't reliable, and what specific feedback are they giving you?
I think if I asked any person, and this is across the board, I'm not trying to defend the position alone, but if you ask anybody whether or not their IT systems are good enough, or could they be faster, could they do better search algorithms, then people are going to give you an answer that's in the affirmative. So the systems that we've got, we get good feedback back from the individual jurisdictions. Of course, there's more that we could do, right? But at the moment, the systems are doing more than what is required from each of the jurisdictions. And some of the systems, for example, as I think I alluded to earlier on, we've stopped in the short term investing in some of those systems because we have a new system coming online. So, for example, the National Police Reference System, which has the minimum data sets that the jurisdictions agreed to some 15 years ago that would be shared between each of the jurisdictions. We haven't been putting a lot of investment in that system over the last 3 to 4 years because we know that the National Criminal Intelligence System, which will have far more information in it than those minimum data sets, will be online and available. So we didn't propose to throw good money after bad. Some of the other systems that we maintain, for example, the National Vehicles of Interest System, which talks about, which deals with vehicles that may be of interest to jurisdictions, and then for lost and stolen across all the jurisdictions, plus relates back to the various registration organisations throughout the states and territories to make sure that they don't inadvertently register a stolen vehicle or a rebirth vehicle and so on. Those systems we intend to integrate into the National Criminal Intelligence System. So with future investment in all of those systems, we want to make a one-stop shop for nearly all of our national policing information systems, bar those that require a bespoke situation. So DNA database is different. Fingerprint database will be separate whilst it points back to the National Criminal Intelligence System because it will have a name and an entity and so on. So the National Firearms Database, trying to link as many of them into one national system so that when law enforcement accesses the system, a person or an entity, multiple avenues of inquiry can come out before them.
Okay, so it'd be your belief that rather than having half your stakeholders not believing that you're hitting the mark, that once this new system comes on board, that feedback will be a lot more positive?
One would hope so. I genuinely
Is there a
believe...
cost sharing as well? Are the state police or the state authorities chipping in?
Well, they chip in on a number of fronts. One, the former CrimTrack agency, so the ACIC, is now responsible. We collect the revenue from the wholesale sale of criminal history checks. So that was an agreement between all the states and territories at COAG. So I suppose indirectly they contribute through that, through selling of their services through the agency, plus also the connectivity in their own systems. They make it so that they can connect into the national system. So, for example, the New South Wales Police will not build a new computer system that doesn't have the ability to interact with the ACIC systems because there's so much interoperability required.
And this system isn't used with any overseas...
Okay, that'll be the last
bodies?
question, Senator
Sorry?
Ciccone.
The system isn't used by any international...
Has no one
Okay.
overseas has
All right.
access to the system.
Thank you very much. Thank you, Chair.
Thank you very much, Senator Ciccone. And that brings to a conclusion the time allocated to the Australian Criminal Intelligence Commission and the Australian Institute of Criminology. Mr Phelan, thank you very much for your time and for your evidence this morning.
Thank you. Thanks.
This afternoon now.
Thank you.
I now call officers from the Australian Transaction Reports and Analysis Centre.
Hello, Ms. Rose.
Ms Rose, welcome.
Thank you.
Would you like to make an opening statement before we go to questions? No? All right, thank you very much, Ms Rose. I now call for questions from senators, and I give the call to Senator Keneally.
Thank you very much, Chair. Thank you, Ms Rose and AUSTRAC for being here today. I want to ask some questions about new financial platforms and particularly their compliance with money laundering and terrorist financing controls. In a report for ASPE, Buying and Selling Extremism, Ariel Bogle identifies niche online platforms are being used to distribute and monetize extremist content, and that extremists, particularly from ideologically motivated extremist right wing, are fundraising on Telegram using these platforms, things like advertising, donations, and merchandise sales. What is AUSTRAC's responsibility in relation to these new financial platforms, and especially those that have geographical links to Australia? And should these platforms be complying with the AML-CTF Act?
Okay, thanks, Senator. There's a lot in that, so I might...
There is, I apologise, but I thought it was useful to lay it out for you.
That's fine.
Just for your first answer, if you could just give your full name and title,
Nicole
please. and-
Rose,
Thank you.
Chief Executive Officer of AUSTRAC. There's a lot in that, so I might go back to talk about where we started the majority of our work with counter-terrorism financing and go from there. So we established our National Security Team in 2014 in response to the rising threat from ISIL, using financial intelligence to identify Australian foreign terrorist fighters. Since then, we've worked with partners to identify domestic and international attack planning and incidents and those who provide funds or materials to terrorist groups or other national security threats. That National Security Team has extensive lines of effort with both domestic law enforcement and national security partners to identify, develop and exploit intelligence to combat threats from the IMVE, of which extreme right is obviously a subset, and religiously motivated violent extremism. This includes active support through outposted analysts to CT investigations and disruption actions, particularly to the two agencies you've just heard from this morning. It also includes working with our public-private partnership, the Fintel Alliance, to connect national security partners with key industry to harness their expertise and to co-design improved indicators of extremist funding. This has enabled us to produce a set of indications of IMVE-related financial behaviour to share with government and industry partners to improve detection and reporting of this suspicious activity, particularly on the new platforms. It's also allowed us to undertake dedicated financial intelligence profiling work centred on the purchase of ideological and capability equipment to detect threats and identify potential persons of interest to forward onto law enforcement for further investigation. Internationally, and this is where it comes to, of course, we don't have regulatory oversight of any internationally based organisations. We work with our Financial Intelligence Unit colleagues in the Egmont Group and the Financial Action Task Force to understand the links between Australia and offshore organisations and their various fundraising techniques, which they often change. And AUSTRAC also has members in each of the joint threat finance groups led by AFP located in Melbourne, Sydney, Brisbane and Canberra. And I might, if you would like some more detail on the specific areas, I might ask Dr Moss, who's in charge of our intelligence area, to come up and talk to you about the work we're doing in those JTFCs.
That'd be great, thank you.
John Moss, Deputy CEO, AUSTRAC. I oversee the National Security and Cyber team that's responsible for most of this work. We do have outposted officers with most of the national security partners and the law enforcement partners that have CT responsibilities. The CEO spoke about profiling work. For example, we've worked with some of those partners to find patterns in purchase of things like ideological items, insignia, clothing, books, and capability, so tactical equipment, gas masks, knives and so forth. Those alone don't indicate XRW, but they do provide persons of interest to share with law enforcement and national security agencies to investigate. That gives the opportunity to use and look at different technologies to understand whether those indicators are are actually posing a threat to our community.
Okay, thank you. First of all, you used an acronym there, XRW, I presume.
Extreme right wing, sorry,
Yes.
a subset of IMVE.
I think the world community is going to have to come to an agreement on what we're going to acronym that extremist movement to, because
Sure.
I've got RWE, RWX, XRW, so, but I thought for CANSARD it was useful. The ASPE report looked at from 1 Jan 2021 to 15 July 2021, that 9 Telegram channels that regularly share XRW content were promoting 22 different funding platforms with online monetization tools and cryptocurrencies. Some of these were things, like YouTube, BitChute, DLive, Entropy, Odyssey, Trovo, Patreon, Go Buy Me a Coffee, GoFundMe, and PayPal. Of those, how does your regulation cover some of those? Like, Buy Me a Coffee, do you cover that? Is that no? So you're not. It's not within your remit, is it?
Not when they're housed overseas. When
Yeah.
they actually start to exchange money domestically is when, that's why we rely so heavily on the banks if it's going through the banking system. But of course, much of this doesn't go through the banking
That's
system.
right.
So that's why we're enhancing our capability. And do you want to talk about the online work?
Yep, so it's about working with partners, about how we can use each other's legislation and capabilities so that the whole is greater than some of the parts for an investigation. A lot of our online work has been developed from traditional expertise around illicit goods and darknet, and that's evolved into CTF, and we saw lots of that in ISIL fundraising. It's now become specialised, and we can apply it to cyber crimes such as business email compromise or ransomware. It's quite a niche capability, it's very technical. We try to protect the capabilities we use. A lot of the information and data comes from specialised vendors and industry partners, and it's global. So we do a lot of work with like-minded and the more sophisticated FIUs bilaterally and within regional groups.
So the ASPE report recommended that AUSTRAC consider new processes to ensure emerging online financial platforms are recording and reporting suspicious transactions, among other obligations, even if the service is not located in Australia. Is that, I don't know if you've had a chance to see the ASPE report, but I just wonder if you've got a response to that recommendation.
I think in addition to AML CTF data, which is very rich, there are many other data sets available to government agencies and industry that we can use. REs have a diverse range of capabilities and information that we can acquire under our notices, under the AML CTF legislation. We can also work with offshore partners, including FIUs and other law enforcement national security partners that have access to services within their jurisdiction. So it's not solely about what AML CTF in Australia regulates, it's about the data available. And this is where the richness of the specialist online providers comes, where they can help us look for patterns and data sets that can be exploited and matched with our own AML CTF information.
So perhaps this isn't a question for you, I acknowledge that up front, but for instance, right now there is an individual who is currently facing charges whose Telegram account, and I won't name him, but his Telegram account continues to update the QR code to pay into a crypto wallet to fund his and other members of his group's legal fees. And it seems that there's nothing that's being done about this at the moment. I don't know if that falls under your remit, or if that's a question I should put to the police, or if that's just considered a perfectly legal activity, given that this group has not yet been prescribed.
Sure. Not knowing the details of the actual case.
Sure.
You're right, it is a matter for the police.
either we provide intelligence on targets that we may create ourselves, or that the police may actually ask us, national security agencies ask us to provide intelligence. So we couldn't comment on the individual item, but we would provide intelligence if it had been raised as a concern with any of our partners.
Right, okay. In terms of people making donations to extremist groups, whether they're ideologically motivated or religiously motivated, for example, the Christchurch terrorists reportedly made at least 14 donations to right-wing extremist anti-immigration groups and individuals before the shooting. And I'm recognising a fair bit has happened since then. Are there any levers available to AUSTRAC to restrict the fundraising capability of prominent extremists in Australia?
We can work with partners to help identify payments. We did that very well with the National Security Team of ISIL. The sums of money are quite small. They're normally for sustainment of the group or for particular operations. So they're difficult to detect. The stopping and having effect is a multi-agency approach, and it's not an AUSTRAC core mission, but we contribute to partners' efforts in those spaces.
Not just law enforcement and national security partners either. This is where our public-private partnership Fintel Alliance has really been of benefit, because we've done some great work with agencies such as Western Union in looking at typology and methodologies to see about the transfer of funds, and then they actually go looking for it as well and provide that information back.
So in the Fintel Alliance, as the CEO mentioned, we have a virtual asset working group. It involves the major REs and some DCEs, digital currency exchange providers. That will help us build indicators and financial crime guides that they can use to detect suspicious matter reports and give those to government. And we can share that information across the broader RE reporting entity cohort, and we can draw on overseas experience. We have close relationships with particularly the United States around online and crypto work, because they are the leaders in the space.
One last question. I know the Chair has got to move the call on, but just in terms of, Department of Foreign Affairs and Trade has a list of, groups or individuals where there are sanctions that apply that you're not able to provide financial support, and I believe the Christchurch shooter is one of those, is on that list. This group that I'm talking about that's currently fundraising for legal fees, they're a group that has been prominently featured in the media recently and are not prescribed as a terrorist organisation as of yet. What is the effect of either listing on the DFAT list or the prescription as a terrorist organisation? How does that change your capacity or your ability to take action against fundraising activities?
So people who are listed on the sanctions list, be they UN or autonomous sanctions, will be captured in World Check data lists, which are what the reporting entities use to raise SMR reporting. So people subject to sanctions are quite easily detected.
And that's when the intelligence unit provides the reports on any of those transactions and provides them to law enforcement.
So that's the case for the DFAT list. What is the effective prescription as a terrorist organisation? We currently have 28 groups prescribed as terrorist organisations. Do they similarly attract that kind of immediate attention?
They do, and they'll also be subject to a reporting entity's own internal AML CTF regime and risk tolerances.
So list only on the DFAT list, or, and I'm using that shorthand term, DFAT list, or prescription as a terrorist organisation does have a direct effect on their
Absolutely.
Yes, it does.
the
Absolutely.
response that you have. Okay, thank you.
Thank you very much, Senator Keneally. I'll now hand over to Senator Molan.
Thank you, Chair. My question arises from the recent exchange between Senator Keneally and yourself. and I may have missed some of it, but I heard Senator Keneally referring by initials to XRW, and I assume that is taken as extreme right wing. Was my understanding, CEO, that there was an agreement to use another term exclusively to refer, and I think it was ideologically motivated violent extremism.
Yes, absolutely. And we just see extreme right wing internally as a subset of that larger group when we're looking at a specific intelligence set.
I believe that the ASIO Director General has said both
Sorry,
terms are
Senator
appropriate.
Keneally, Senator Molan has the call. Senator Molan.
CEO, is that your understanding that both terms can be used?
Correct, but one is a subset of the other.
Thank you.
Senator Molan, no more questions?
No, no more questions.
Thank you very much. I'll now hand over to Senator Scarr.
Thank you. Ms Rice, I wanted first to ask you about debanking. So I participated in a Senate Select Committee looking at FinTech, RegTech, and the issue arose in relation to great Australian entrepreneurs who'd set up, say, for example, Bitcoin businesses. The commercial banking sector had decided that from a risk mitigation point of view, they didn't want to continue to provide financial services to those businesses, to those entrepreneurs. And then the individuals involved, who were directors of companies, etc., found they couldn't open a bank account anywhere. Because of the process they'd gone through in relation to their Bitcoin businesses. And this prevented them from, for example, setting up utility accounts for electricity, etc. I wonder if you can provide your views with respect to how that debanking process works in practice and whether or not there can be some adjustment to how the banks in particular are responding to the legitimate issues that arise in relation to money laundering, but not overstep the mark so that great Australian entrepreneurs aren't prevented from being able to open up an electricity account.
Yes. Excellent question, Senator. Very complex issue. And we had a long and fruitful discussion with Senator Bragg before he finalised his report on exactly this issue. So this is an international problem. It's not just domestic to Australia. And there's a range of reasons that banks debank or de-risk, they sometimes call it internationally, businesses. Certainly the RegTech and FinTech sectors have been subject to debanking of late. We've also got other sectors, so we've got, legal sex workers that are being debanked because they're being seen as high risk, or other areas that banks are making other decisions that it's just not financially viable for them to bank. Banking in the Pacific is a real concern for us. So debanking in itself is a real concern for AUSTRAC because, yes, we're the regulator and we expect that there's due diligence done by regulated entities taking on people and giving them bank accounts. But our other side, our financial intelligence unit, is very keen to ensure that those industries don't go underground, if you like, because they can't get a bank account in Australia. So we're working with Treasury and DFAT on this in a couple of working groups to look at what's being done internationally. As I say, the Financial Action Task Force, FATF, is finding that this is an issue across the world. Anti-money laundering legislation is often quoted by the banks as the reason why they're doing this. Now, certainly some of the risk mitigation they have to put into their processes is because of AML-CTF, but often it's just because commercially it's not a viable proposition for them. So I might just get my Deputy Peter Soros, who's on actually both of the working groups, to talk through where we're at, and I think he's on screen.
It's on the big screen.
Yes.
Yep, Peter Soros, Deputy CEO for Regulation, Education and Policy. So there is quite a bit of consideration given to an issue such as this, multifaceted and affects lots of different industries. So there is a Council of Financial Regulators working group looking at the issue of debanking. as well as other forums, and quite a bit of consideration has been given to the matter. It is challenging because ultimately it's the commercial entities and they're required to make decisions on their own basis. The Act, the NLC Act, doesn't require wholesale debanking as if there is. What the Act prescribes and outlines is that businesses, banks, need to consider risk of each individual company that they're engaging with and so we can say that it's incumbent on all the reporting entities to make sure that they're looking at their profiles, considering each case-by-case basis.
Yep. So, Mr. Soros, you're just breaking up a little bit. I could follow what you were saying, but just so you're aware of that. One of the issues a witness raised during the course of our Senate Select Committee was that her business was debanked, and then she as an individual, as a director of that business, effectively was then debanked, and she couldn't get any information as to why it was that the bank debanked her as an individual. So it wasn't clear as to whether or not their blanket policy approach had been extended just as a matter of policy beyond her business to the individual corporate officers, to the directors, etc., or whether or not there was some other concern. If there was another concern, because no one could tell her she didn't have the opportunity to correct the record or provide some sort of clarification. Ms. Rose, is there any way we can address that issue as well?
Senator, that is absolutely an issue because it's an offence for those entities to disclose information that might be in a suspicious matter report, and not knowing the incident, the business owner you're talking about, this is in a general sense, of course. So we are working through our education and guidance with entities to look at ways that they can better communicate with customers. We've actually drafted a statement for registered entities that's currently with Treasury before we send it out to give them better guidance about how they need to follow the legislation, what the legislation does ask for them and what it doesn't, so where there are areas that they can work with individuals. Brad, I don't know whether Brad or Katie wanted to add anything to that about where we're up to with that work.
Thanks, Bradley Brown, National Manager for Education Capability Applications, and I hope you can hear me, that we are getting a little bit of feedback. Certainly, in relation to and you raised around what banks may or may not be able to say to particular businesses. As the CEO mentioned, there's certainly a risk in relation to the provisions around tipping off, and banks are very mindful of those obligations in relation to the fact that if there is a suspicious matter that is provided to AUSTRAC or a possible indication of that suspicion, that they cannot advise the reporting their customer such, or give indication that exists, and that is both to protect the business themselves and also to protect any potential future law enforcement operations. We have generated guidance and we'll continue to promulgate that guidance with reporting entities, in particular the banks, that if there are other decisions that are made in relation to a risk basis that they, in relation to their customers, that they're open to be able to provide that advice to a customer where it is not tipping off and where there's no indication that a suspicious matter report has been made to AUSTRAC. So that certainly in terms of their processes and their risk appetite, if they have made and determined decisions based on that risk-based approach that they've applied, AUSTRAC considers that there is a manner to which reporting entities.
Okay, thank you.
Customers can be involved. No, thank you, Senator.
That's fine. I haven't got much time left. Sorry to cut you off, Mr. Soros. Ms Rose, I really commend you on the work you're doing there. It's going to make a big difference to people's lives. I was mortified by the evidence we heard. My last question, Senator McKim is going to no doubt ask you some questions about rolling out or extending the AML-CTF legislation to accountants, lawyers and real estate agents. I want to ask you, have you done work at looking at the compliance cost, the regulatory burden, any such designation of real estate agents, lawyers, accountants, many of whom are small businesses? Have you done any work looking at the compliance costs that would impose on those small businesses as opposed to the benefit, the general good, in terms of extending the legislation to apply to those groups? And if you have looked at it, what are the results of your analysis in that regard?
I might defer to Home Affairs, Senator. We haven't, but we certainly participated in work done by the then Attorney General's Department, did a cost-benefit analysis back in 2017, I think it was. Yes.
I should, Senator, make clear, and no doubt it'll have a bearing on Senator McKim's questions, given what he asked about earlier. The administration of the Act is not a matter for the regulatory agency, it's a matter for the department. So it's the department that provides policy advice to the minister and also undertakes the kind of analysis that you've spoken about. So we'll be more than pleased when the relevant officers are in attendance to speak to those issues. It's not really a matter for the regulator, because otherwise they're administering their own legislation, which regulators typically don't. Point well made. Thank you.
Senator Carr, thank you very much. We are now going to suspend for lunch, but I would just ask that AUSTRAC return to the table at 1:30. We're running a little bit over time. I'm hoping that we can then go to ASIO by 2 p.m. So that's just a general guidance. Okay. Thank you very much, and we will resume at 1:30 p.m. Well, good afternoon, everyone. The committee is now in session, and I welcome back to the table the Australian Transaction Reports and Analysis Centre. And I give the call to Senator McKim.
Thanks very much, Chair. Can I just check that you can hear me okay, please?
Very well, loud and clear. Thanks, Senator McKim, who's attending by way of telephone conference.
Thanks very much, Chair, and good afternoon to the folks from AUSTRAC. I wanted to ask some questions about the major bank risk assessment that you released last month. In one of those reports, you identified the role that professional facilitators play in helping criminals hide their money and launder their money. Can I just firstly confirm that when we talk about professional facilitators, we're talking about groups that include lawyers, accountants and real estate agents? Is that correct?
Yes, that's correct. Sorry, I think my microphone was off.
Thanks. Is that Ms Rose?
Yes, it is.
Okay, thanks, Ms Rose. You say in those reports that you expect banks to report any suspicions of professional facilitators or enabling parties to illicit activity. But can I just be clear with you that at the moment, professional facilitators are currently not required themselves to report suspicious activity?
That is correct.
And that's because tranche 2 of the reforms to the Anti-Money Laundering and Counter-Terrorism Financing Act that were promised in 2006 are yet to be enacted. Is that correct?
That's correct.
Thanks, Ms Rose. So basically, AUSTRAC's relying on banks to tell you when lawyers, accountants and real estate agents might be facilitating money laundering because lawyers, accountants and real estate agents are not themselves required to tell you. Is that correct?
Yes, banks are one of our 16,000 regulated entities that are required to report to us, and if any of those suspicious transactions go through them, they are required to report. But as you state, those professional facilitators are not part of that regulated entity population at the moment.
Thanks, Ms Rose. So my understanding is that Australia is at the moment one of only 5 countries not to have included these professional facilitators within the scope of anti-money laundering laws. Can AUSTRAC confirm that?
That's correct, although we do have a number of reports that come into us, international transaction reports and threshold transaction reports that other countries don't have the benefit of, but your statement is correct.
Yeah, okay, thank you. I appreciate that. And are you able to confirm that besides Australia, it's now the US, China, Haiti and Madagascar, that those are the 5 countries that are yet
I believe
to
so,
include?
but I trust that you've done your research on this, so I...
Well, I believe that is accurate, but thank you for your response. Can I ask whether AUSTRAC's examined whether Australia's, or whether the fact that Australia has not included accountants, lawyers and real estate agents within the scope of the AML-CTF Act makes it more likely that criminals will use Australian banks to facilitate money laundering, for example, rather than banks somewhere else in the world?
Well, I'll take that in 2 parts. I would hope that due to the significant uplift that Australian banks, we've seen in Australian banks in the last couple of years in their AML-CTF procedures, that no one would try and use an Australian bank at the moment to launder money. So that's my first point. Secondly, no, we haven't done specific work. The department have certainly looked at various options, but we are looking, Senator, at guidance for those professional facilitated cohort to see if we can increase their knowledge of the risks of money laundering.
Okay, thanks. So when you say that you're looking at guidance, that would be, I guess, information that you would provide them, but that would not constitute a requirement for them to notify suspicious activity.
No, that's
correct.
correct.
Would that be right?
No, that's correct.
Yeah, thank you. One of the reports you released early in September entitled Australia's Major Banks Money Laundering and Terrorism Financing Risk Assessment, you said that one of the potential issues that we're facing is the widespread or concentrated real estate purchases driving property prices up and pricing legitimate buyers out of the market. So can I take from that basically Australians who are wishing to buy real estate are competing with international crime syndicates, and that competition and the fact that international crime syndicates are participating is driving prices up and pricing Australians out of the property market?
We wouldn't make that as a general statement because we believe that is occurring in specific areas with specific properties, obviously. I might ask National Manager Brad Brown, who oversaw parts of those risk assessments, to speak further. But yes, Australian real estate is certainly an attractive wealth gathering, an area where people are attracted to certainly not just live but also invest. And laundered money, we know, has contributed to the purchase of some of those properties, and that has been borne out through work by our law enforcement agencies, and of course the criminal assets confiscation team is looking at such acquisitions regularly. But I might just throw to Brad Brown, hopefully the connection is a little bit better after lunch, to talk about the discussion around that real estate piece, if you don't mind, Senator.
Thanks, Ms Rose, and thanks, Mr Brown.
Thank you very much. Can you hear me?
Much better.
Yeah, thanks. Senator, in relation to the assessment that AUSTRAC completed in relation to major banks, the consequences that we describe are in the context of potential implications for Australia ultimately and potential implications from within the major bank sector in relation to the criminal threats that were identified throughout the report and the vulnerabilities that they face. As a natural consequence of the assessment that was undertaken, that's where we determined the average person that is seeking to purchase real estate would actually be at a disadvantage where they're potentially competing against a person who is looking to utilise criminal proceeds and does not have the same limitations to which a normal customer, you and I, may face. So that's the determination and how we've borne out that particular consequence that's outlined in the report. So it's not necessarily a direct evidence per se, although I think the AFP and other state jurisdictions have certainly continued to property and real property as proceeds of crime, and I think the extent of forfeiture indicates just the size or quantum of that risk. But in terms of the assessment that Austrac did, it's a potential consequence that individual customers may be competing with people who have illegitimate funds. Thank you.
Thanks, Mr. Brown. Can I just ask a follow-up question which goes to the last point that you made? And I'm sorry, you just broke up a little bit, which may be at my end, not yours. But I think you were speaking about potential evidence that this was occurring. And can I just be clear, did you say that Austrac is aware of evidence that this is occurring that has been sourced by the AFP and state and territory police forces?
Yes, and I will just clarify. So certainly law enforcement in Australia, the Australian Federal Police and other state and territory law enforcement have certainly seized real property, as in dwellings, that has been purchased with the proceeds of crime.
Thank you. I appreciate that. And if professional facilitators were included as designated service providers under the AML CTF Act and therefore fell within the reporting requirements, what effect would that have on the risk of Australian banks being used to launder money through real estate?
Could I answer that first? Senator, I think there's two areas that have quite different impacts. So would there be an impact on the international facilitators being used, particularly by serious and organised crime, with their head office, if you like, overseas? Probably it wouldn't have a great deal of impact just singularly. What it would have an impact on are those professional facilitators who are perhaps unwittingly being used to facilitate either the purchase of property or the laundering of money somehow, because it's a gap in their education and they don't understand the risks that they're dealing with.
All right, thanks, Ms. Rose. Your report also said that professional facilitators were sometimes identified receiving suspicious cash or international payments, and in particular lawyers. Can I just ask, when you've identified that lawyers, for example, are receiving suspicious cash or international payments, what happens then?
And I'm happy for Mr. Brown or Dr. Moss to come up and add to this. But if it's identified through a bank as a suspicious transaction, they will fill in a suspicious matter report and provide that to us, and that's when we will create an intelligence report for law enforcement or another regulated entity that picks up on that transaction. Solicitors are also required to report large transactions, and as I said earlier, we get international transaction reports and threshold transaction reports. Saying that, we also get millions of reports a year, so sometimes just one threshold report certainly wouldn't raise our suspicion. But Dr Moss, did you want to add to how we deal with that in intelligence fashion?
Sure. We receive about 500,000 reports a day. In that 500,000 reports, there would be 820 SMRs, or suspect matter reports. It's impossible for each of those to be looked at by a human being, so we have automated systems that look for profiles and patterns, and there's about 20 to 25 of those profiles live at any one time. They look at entities, keywords, methodologies, networks. That would escalate the SMR to a triage team. The triage team would work up an intelligence report on issues that of known entities or networks. Our partners also receive the SMRs near real time, so for within 24 hours of receipt in AUSTRAC, the SMR is visible to over almost 5,500 users in law enforcement and security agencies and border. Once we work up that target, regardless of the types of people involved, not every SMR is the same. Some requires a lot of work. Some are very easy to use and turn into referrals. We will refer that to a law enforcement agency or a partner.
Senator McKim, we are going to need to move to Senator Ciccone. Do you have a final wrap-up question?
I do, just one question. Chair, as a
please.
final question, thank you. And could I therefore ask, given that response, if professional facilitators were included within the reporting requirements of the AML-CTF Act, would that provide, would that requirement and then presumably the reports that would flow from that to AUSTRAC, would that provide helpful additional data that would assist in your automated processes identifying potential transactions of concern?
Look, I'm an intelligence practitioner, so I like to receive information. But our partners who do tranche 2 work overseas report that they get a lot of defensive reporting that clogs up the systems, and that a lot of it's low quality and unactionable. So I can't actually answer the question until I actually understood the quality of the data. It's just enough a data source that would come to us, and not everything has to come through AML-CTF reporting.
Thank you very much.
All right, thanks,
Moss.
Ms Rose and your colleagues. Thank you.
Thanks very much, Senator McKim. I'll now give the call to Senator Ciccone.
Thank you very much, Chair. Ms Rose, Senator Keneally, I understand, wrote to you late last week with some questions, and I was just hoping to go through the annual report with you. I want to begin on page 67. There were some questions there with respect to security and integrity. I noticed that AUSTRAC appears to have stopped reporting individual statistics in your report. Are you able to explain why your organisation stopped reporting these statistics?
Similarly to ACIC, Senator, is that it no longer was a requirement, so we just haven't reported them. We do report them in other areas, in other government reporting, but since it stopped being a mandatory requirement, like a number of other things that dropped off being mandatory, we didn't do it. But I'm happy to go through that now.
Look, we'll see how we go with the time, but maybe, I don't know if you're able to even table some of the information that, or the information that Senator Keneally had requested. Are you able to table that information for the committee's benefit?
Absolutely.
Just in the interest of time?
And just very shortly, we had no reportable incidents, and there were no referrals of investigations, and there were 4 misconduct matters with only 1 substantiated, but we'll give you the details of that in writing now.
Okay, if you could do that now, that'd be great. And just to confirm, you still track the numbers, it's just not in the annual report? Okay, all right. Since these numbers aren't public, and I'm not sure with what information you do table for the committee's benefit, are you able to describe what the nature of those incidents were?
Yes, so as I said, we had no reportable incidents. We had 10 warnings to staff, which were below the threshold. They were minor in nature, obviously being below the threshold, such as leaving low-level classified documents on the desk in an office unattended, leaving a computer screen unlocked, as ACIC had, misaddressing unclassified or low-level official emails to the incorrect recipient, or plugging in an unauthorised device into an AUSTRAC device, but we've got those details for you.
Okay, so no one's employment was terminated?
No, absolutely not.
And you're able to provide it or indicate whether they're low, medium or high level breaches?
Yes, or low. And do you want me to talk about the misconduct matters, because they're a separate...
Well, why don't we do that now?
Yep.
That would be good, thank you.
So 2 were an external referral and 2 were an internal referrals. 3 were unsubstantiated. 1 was substantiated, and that was a failure to take reasonable steps to avoid an ongoing conflict of interest, and a security breach notice was issued.
All right. And in the same fashion as earlier this morning, are you able to also provide the last 3 financial years? I'm also interested in the security incidents and how they meet the definition of the protective security policy framework breach.
Sure. Can we take that one on notice? We don't have that today, but take that on notice. So
Okay.
we'll table this year's today and take the others on notice, absolutely.
Okay, thank you very much for that. Just moving on to the Australian Public Service Code of Conduct. Also, how many cases in the year 2021 were there where staff were investigated following referrals?
Nil.
Okay.
Nil.
And how does that compare to the last 3 financial years?
I don't have them, but I don't think it's radically different. We're the smallest agency in the Home Affairs portfolio, and we've actually got the lowest risk of serious breaches. But
Chris Collett, Deputy Chief Executive Officer, Capability and Strategy. Senator, we don't have the numbers on codes of conduct for previous years, but my expectation is they're of a similar scale, very low numbers.
Could you confirm that and take that on notice,
Happy to
please?
take that on notice.
Thank you.
For the last 3
financial years.
Sure.
Yep. Now, just quickly turn to misconduct, fraud and corruption. How many alleged cases were referred to ACIC?
None. So these were the four misconduct matters, 2 external referrals and 2 internal referrals, and that's just where they've come from.
Sorry, 4
misconduct matters.
Yep.
Over 2021.
2 you said were?
And the language is confusing, so I apologise. 2 were matters that came internally from staff, and 2 were matters that came externally. 3 of those were unsubstantiated, and 1 was substantiated. That was the one about a failure of a non-ongoing employee to take reasonable steps to avoid a conflict of interest, and a security breach notice was issued. But we've got those details in the tabling.
So was that individual terminated as a result?
They're non-ongoing, so I suspect... Yeah, they were an IT contractor.
Senator, the individual was not terminated, as the CEO says, they're a non-ongoing employee. They did receive a breach notice, which is a formal warning, and were cancelled, and there was an aftercare plan put in place to ensure that they had understood and changed their practices. I should note, without going to the specifics, Senator, that the matter was not of a nature that would warrant the termination of an individual, a junior staff member.
But their status was non-ongoing.
Sorry?
You said they're non-ongoing.
They were a non-ongoing APS officer,
Okay,
but
all
that's
right.
not particularly germane to your question,
And-
Senator.
Okay. And I don't know if you could also provide me with the last 3 financial years as well too.
Sure.
Now, can I just quickly turn to another matter? I know late last year you had provided some evidence to the committee, and this is with respect to, I think even Senator McKim had touched on the AML.
Yes.
Now we've heard in previous rounds of estimates there have been sustained breaches of AML laws within Crown Casino.
Yes.
And there's been a culture of non-compliance that was not detected or prevented by AUSTRAC until recent years. Now, I just wanted to ask you, can you confirm media reports that AUSTRAC commenced an investigation into Star Entertainment in late 2019?
Yes.
Do you agree that the recent media reports of problems at Star suggest there's a systemic issue with money laundering?
We haven't come to any conclusions yet, so we're part-way, I won't say halfway, part-way through our enforcement investigation. So we're still requiring information and producing notices to STAR to get that information. But I think I've said previously, we've got serious concerns.
And not just with STAR, but also do you have serious concerns within the casino sector?
Yes, we do.
So on October 20 of last year, you told this committee, if we had evidence that there was money laundering going on, we would provide that intelligence to law enforcement agencies, state, territory and federal. They would take action. Now, with that in mind, can I ask, when did AUSTRAC first become aware of the serious AML compliance issues and potential breaches of the Act at Star Entertainment?
I might ask my General Counsel, Katie Miller, if she's there. She's Head of Enforcement.
Yes, Katie Miller, National Manager, Legal and Enforcement. Can you hear me?
We can, Katie.
Yes, we can. Thanks, Ms. Miller.
So just to clarify the CEO's comments, so what happened in 2019 is that we commenced compliance activity in respect of a number of members of the casino sector. Some of those compliance activities have continued into the enforcement space, and it was this year that we commenced an investigation into the STAR. The focus of that investigation is into whether the STAR has complied with its obligations under the AML-CTF Act. Now, while the presence of money laundering activity by individuals can be relevant to the issue of the STAR's compliance with its AML-CTF obligations, that is not the focus of our investigation. We are also simultaneously working quite closely with state regulators of the casino sector, and we are engaging with them about our respective activities. And of course, we also, as an entity, as a financial intelligence unit, engage closely with state law enforcement agencies about matters that might be of shared relevance. That's something that's more relevant to the financial intelligence side of the agency and something to which I would defer to Dr. Moss.
Does that answer your question?
All right. Can you tell me, or tell the committee how you became aware or who informed AUSTRAC?
We've done, I think, 12 compliance assessments, and Katie, please correct me if I'm wrong, 12 compliance assessments over the last 5 years in the casino sector, and it's those compliance assessments that have raised issues of concern. So we've gone back and done further compliance assessments. As Katie said, we started those really in-depth compliance assessments in 2019, and once we found what we found, we moved into the next phase.
Okay. Now, I'm assuming you're aware that there are 2 independent inquiries by KPMG.
Yes.
That were presented to the CEO at Star. Are you also aware that these inquiries found that Star Sydney, Star Gold Coast and Brisbane's Treasury Casino did not have an anti-money laundering system that was implemented or operated consistently to manage and mitigate its risks, money laundering risks?
Yes, so we're working quite closely with each of the inquiries, because there's a number in each of the states, and each of the regulatory bodies in those states about the inquiries and their own regulatory oversight.
On the 12th of October of this year, Star informed ASX that it previously shared information about its AML breaches and internal review with AUSTRAC. When was AUSTRAC first informed about these matters by Star or provided with these KPMG reports?
Unless Katie has that, I think we'll have to take that on notice, because I do believe there was a bit of toing and froing about that issue.
Ms. Miller,
Nicole,
can you just clarify? Can you add to that answer, Ms. Miller? Just because obviously Ms. Miller's attending by way of video conference, it's a little bit clunky. Sorry, Ms. Miller, go ahead.
Yes, as the CEO says, there was some toing and froing about that. I believe that there was engagement with the Star this last year, but for specifics of the dates, I think we would need to take that on notice.
Was there something else? I'm not sure if one of the two gentlemen down below also had something to add as well. I saw their mouths move before.
Mr. Soros or Mr. Brown?
Yes, yeah. So
The gentleman down
as
below,
part of our
are-
in-depth-
sorry, just to clarify,
Sydney and Melbourne.
the gentleman down below are attending on a video screen below the table. So just to explain,
Below the table here,
they're
but
not. They're
on
not
the telly
somewhere.
screen. Yeah.
They're not somewhere underground. Just want to clarify that. Senator Ciccone.
I wasn't sure if the witness was about to say something, Chair, because
Mr. Soros, do you have any further information to add?
unless it's Friday.
Soros, Deputy CEO. Now, as part of the detailed compliance campaign that Rose referred to, we were provided with those KPMG reports, and that's what's informed the development of our thinking and part of our concern, obviously, is related to that work, and we've undertaken and started those enforcement activities since then.
But we'll have to table the dates because I don't think we've got those in writing, do we? Or here.
All right. So Austrac wasn't aware of the scale of AML problems at start before then, like before.
Certainly not to
KPMG.
the extent we are now.
All right. But you were aware of some issues beforehand?
So each of the compliance activities are not on their entire AML CTF regime because it's so complex. We'll go in and look at one particular part of the regime and then have an exchange about whether we believe that they're robust enough. Certainly some of the areas that we've got concerns about hadn't been raised as issues previously, and that's what we're working through.
Okay. Are you aware that the chairman of the New South Wales gaming regulator, Mr Crawford, recently said in relation to the failure of the anti-money laundering controls at Star, you say it's been happening for years, I have no knowledge of that, we don't know that, and if it's as bad as you, being the Sydney Morning Herald, say it is, they certainly have something at Star, should have been reported to us. Now, if Austrac was in possession of the KPMG reports into Star and the facts about Star's AML breaches, why wasn't this information shared with that regulator?
Mr Soros, and I think the KPMG report came rather late after we'd asked for it through enforcement action. Is that correct?
Look, we'll check the timing and detail. Katie, you might want to jump in as well. As part of our regulatory and enforcement work, we have specific obligations about the nature of certain documents who we can share them with. And so we have to carefully consider that as part of our ongoing compliance and work, but we do engage closely with state regulators on a regular basis on those matters.
So what are your protocols when it comes to sharing such information?
I think it depends on the nature of the document, how it's been provided to us under what legal provisions and how that operates. It's not a blanket rule that we can automatically share everything. We have provisions in place that determine that, and we do engage closely with state regulators. We meet regularly with ILGA and other state regulators on these matters.
I just seem to recall from, I think, the last round of estimates that, and I could be wrong, but that you gave me the impression that you'd always shared this type of information with state regulators.
So
is that not the case?
No, we engage regularly with state regulators, but we can't always share all the information that we have, but I'm happy to take that on notice.
When you engage, I mean, what do you actually do? Surely you'd share information.
Meet with them regularly and discuss the entities that they're supervising and that we also supervise.
But there'd be an exchange of information, would there not be? Or at least a heads up about, hey, look, we've got problems with this organisation?
Yes, but I think Ms Miller might be able to explain what we can and can't share a little bit more articulately.
I'm sure the CEO could describe it articulately, but I could have detail. In respect of each of the state-based gaming regulators and indeed other government agencies, we will have, for some entities, we will have a memorandum of understanding. Where such a memorandum exists, we will have a much clearer sense of what information we can share and whether that extends to specific documents, because essentially the ground rules will have been established beforehand. We don't have an MOU with every single government agency. We really do negotiate those based on the respective levels of interest and overlap work that we have with those agencies. Where we don't have an MOU, we can still exchange information, but it does mean navigating Part 11 of our Act, which is our secrecy and access provisions, and there are some limitations on what we can disclose directly. In particular, we do exercise a fair degree of caution and care where we have used our coercive powers to obtain documents. And while we might talk to agencies about the type of information that we might be gathering through either a compliance assessment or investigation, it's not our practice to share documents that we have obtained coercively. It's not our practice to share those directly, and that's because there's a range of protections that the Act applies to those documents.
I mean, is there any reason why AUSTRAC hasn't publicly taken any action against Star, given that the breaches go as far as back as 2014?
We've commenced an enforcement investigation, which for AUSTRAC is a very serious step,
Chair, I know we're very limited time. I've just got one small matter which will probably take, depending on the length of questions, and maybe you want to take some of these on notice, but might just take about 1 to 2 minutes max.
I will extend another 1 to 2 minutes
Thank you.
max.
I appreciate
Senator
it.
Ciccone, thank you.
Could I just turn to Pandora Papers?
Yes.
Okay. Now, AUSTRAC's been monitoring, or have you been monitoring the...
Yes, we're working closely with the ATO, who have the
All right.
lead on Pandora Papers.
And you'd also be aware it reveals large amounts of Australian property has been bought by individuals implicated in significant criminal activity in other jurisdictions.
I don't know that we can go as far as to say that as a statement, but there are suspicions around some of those transactions, yes. And maybe Dr. Moss might want to go into that in a bit more detail.
Including one, I think it was a very large farm in Tasmania associated with some Nigerian money. Are you aware of that?
I don't think we'll dive down into entities inside the Pandora Papers. We're working with ATO under the Serious Financial Crime Task Force construct. And that work takes us from lists of entities and people where it's not illegal to have these vehicles or hold money offshore to investigate if there are issues around tax.
I mean, the papers have shown around 400 wealthy Australians have taken advantage of the services provided by providers of aggressive offshore tax advice. Have the papers changed AUSTRAC's perspective on, I guess, the MLTF risk?
The papers relate to 14 offshore service providers that provide professional services. It's not an indicator of criminal activity. It's not illegal. It requires further investigation, which the Serious Financial Crime Task Force has in hand.
And I think to answer your question, Senator, this doesn't surprise AUSTRAC.
Will you be running a project on the data in the Pandora Papers?
Absolutely. As I say, we've got a number of analysts working on the task force led by ATO.
All right. And look, given the time, can you just take on notice the progress or provide us with an update on the Fintel Alliance priority projects?
Yeah. Happy to.
All right. Thank you very much. Thank you,
Thank
Chair.
you very much,
I appreciate
Senator Ciccone. My pleasure.
understanding.
I'll now give the call to Senator Van.
Thank you, Chair. Ms Rose, I was aware earlier this month, I believe it was, from the media about a sting on some money laundering. I think it was titled Operation Taipan. That was led by Victoria Police.
Yes.
And I believe it recovered or found $62 million that had been laundered. How did AUSTRAC come to be involved in Operation Taipan? And could you outline what support AUSTRAC provided to the operation?
Well, it was our great intelligence officers, so I'll let Dr. Moss tell you what fabulous work they did.
Thank you. Look, in February 2021, we created an intelligence referral for Victoria Police that centred around potential money laundering using ATMs in the eastern suburbs of Melbourne. The entities involved at that time were unknown to Victoria Police. We work with Victoria Police, including their criminal proceeds unit, the Piranha Task Force and their financial crime squad. We identified with them $62 million since June 2021 being moved in this methodology. We worked for the banks using the Fintel Alliance, our public-private partnership, to identify persons of interest and identify bank accounts that are being purchased for the purposes of money laundering. In October, Victoria Police executed 6 search warrants, arrested 5 individuals. 4 of them were not known to Victoria Police, had no previous criminal history. The banks were fundamental to the identification of those persons of interest and providing new leads. It also impacts on organised crime money laundering work in both Perth and Melbourne. We've got seizures by police of cash, illicit firearms, luxury vehicles and drugs. And the banks have now moved to put in place measures to limit the funds that can be deposited at ATMs, and we've shared that knowledge across the broader Fintel Alliance cohort.
Thank you. You mentioned Task Force Piranha. Does that mean that it was organised crime? Because that's the task force that normally investigates organised crime in Victoria. You would suggest that's what it was?
Yes.
Thank you. Normally, how does AUSTRAC work with Commonwealth and state agencies and private enterprises to identify criminal behaviour such as that you found in Operation Taipan?
We have well-established networks and relationships with Commonwealth and state law enforcement agencies, both bilaterally and through multi-agency initiatives such as joint management groups in each jurisdiction. We also work through task forces. We're a member of 14 task forces that are generally multi-agency, multi-jurisdictional. And our public-private relationships, in addition to the good relationships we had through the regulatory side of AUSTRAC, we have the Fintel Alliance, which is 29 partners working with us. Their analysts sit with government analysts in Melbourne and Sydney, and we work on projects of mutual interest.
Thank you. Probably a change of topic almost 180 degrees, but I understand AUSTRAC updated an AML CTF rule to assist victims of domestic and family violence. Could you please outline what AUSTRAC is doing to assist women in these situations?
Yes. We've done, actually, looked at a couple of different things to assist in women's safety. Firstly, we did payment reference project, which we established within this public-private partnership, the Fintel Alliance, and that focused on the free text within domestic digital payments as an enabler of crime, where the primary function is criminal communication rather than the transfer of funds. So when you put the description in your transfer, that was being used by partners to abuse their victims rather than just the transfer of money. So the introduction of the new payments platform increased the amount of information that can accompany a transaction. In late 2020, the risk of free text fields being utilised for criminal communication was identified, with domestic abuse seen as the greatest risk. So from November 2020 onwards, we began collecting the intelligence and feedback from Fintel Alliance partners, mainly the big banks, to identify the prevalence of this activity and extract any patterns or methodologies and communicate that to our REs. Outcomes from the project working with law enforcement to date has included 2 arrests, each involving the protection of a vulnerable member of the community, and a couple of hundred suspicious matter reports and intelligence reports to law enforcement for them to follow up on. The other piece of work we did in May 2020 was a change to the AML CTF customer ID and verification rule to help people experiencing family and domestic violence. So if a female victim, a woman is leaving a violent situation and has to leave her place of residence without gathering her ID, or the perpetrator is actually keeping that ID from her, this is providing an alternate way for her to set up a bank account to actually get access access to her money. So we worked with the Australian Israel Chamber of Commerce and the Australian Banking Association to look at that issue and work through it. And found that 63% of women experiencing financial stress have a background of financial abuse as well, and their bank accounts, benefits and living expenses were being withheld from them or their children. So what we did, we changed the rule to give bank staff the flexibility they need to use alternative methods for verifying a customer's identity for those experiencing family domestic violence while still maintaining due diligence for all of the risks that we consider issues. And it's been a great success.
Well done. Thank you. Sensible changes, and thank you, Chair.
Thank you very much, Senator Van. Ms Rose, that brings to an end your time, and we want to thank you so much for both your time and also your evidence today.
Thank you.
Look forward to seeing you at the next one.
Yes, thanks.
It's now my pleasure to call officers from the Australian Security Intelligence Organisation. Mr Burgess, welcome to the table. Would you like to make an opening statement before we go to questions?
Yes, thank you, Chair. Good afternoon and thank you. Australia's threat environment remains complex, challenging and changing. ASIO is responding as we always have, with agility and ingenuity, doing things our adversaries think or consider are impossible. We have continued to do this during the pandemic that's altered both our threat and operating environments. I'm sure you can appreciate the challenges of safely, securely and secretly meeting our human sources. And while I can't share details, I'm proud of the innovation my officers do and their workarounds and how they maintain and have maintained a hold on all our priority targets without compromising officer safety. This clever, creative work ensured ASIO could continue its mission. While the terrorism threat remains a key threat and countering threats to life will always be a priority for ASIO, based on current trends, we anticipate that espionage and foreign interference will supplant terrorism as Australia's principal security concern. On a daily basis, multiple countries are making multiple attempts to conduct espionage and foreign interference against Australia. These attempts are sophisticated and wide-ranging. They are enabled and accelerated by technology, and they take place in every state and territory, targeting all governments or levels of governments as well as industry and academia. In addition to attempts to steal sensitive and classified information, interfere in our political institutions and intimidate diaspora communities, I remain concerned about the potential for Australia's adversaries to conduct sabotage against us. It is entirely plausible that our adversaries would seek to pre-position malicious code on our critical infrastructure. Such cyber-enabled activities would be used or could be used to damage critical infrastructure in the future, especially at times of increased tension. These activities represent a threat to Australia's way of life. They can undermine our sovereignty, democratic institutions, economy and national security. ASIO is stepping up its resources in response to these threats. We work with a range of partners. We have dismantled spy networks, recommended visa cancellations and conducted other forms of disruption. At the same time, we've worked closely with government and industry to harden our environment and make it more difficult for adversaries to operate here in Australia. Australia's national terrorism threat level remains probable. This means we have credible intelligence to indicate that there are individuals in Australia with the intent and capability to conduct an act of terrorism. Religiously motivated violent extremism groups such as ISIL continue to urge attacks. At the same time, our investigations into ideologically motivated violent extremism has increased. There has been considerable and understandable attention given to nationalist and racist violent extremism, but we're also seeing a growth in single-issue motivated groups and individuals that have the potential to embrace violence. We saw this, for example, in the recent anti-lockdown protest, where some adopted violence as a tactic. ASIO has been concerned about this for some time, and it's one of the key reasons why I changed the terminology we use to describe categories of violent extremism. The most likely attack in Australia will be that of a lone actor, someone who mobilises to violence with little or no warning. While the threats facing Australia continue to evolve, we remain well placed to counter them. In May 2021, the Australian Government announced a significant new investment in ASIO's sensitive capabilities. The investment of $1.3 billion over 10 years will enhance our ability to connect the dots through human-led, data-driven, technology-enabled approach to security intelligence. We will work with the Australian technology sector to deliver this capability. It will allow us to continue to counter the threats from sophisticated foreign adversaries and violent extremists. And finally, I recognise the importance of using our capabilities and statutory powers responsibly, proportionately and with propriety. ASIO is subject to stringent oversight, including by the Inspector General of Intelligence and Security, who has powers of a Royal Commission. We welcome this because it allows ASIO to demonstrate that we operate lawfully and with integrity. On this note, I'd like to acknowledge the sad passing of the Honourable Margaret Stone, the former Inspector General of Intelligence Security, a former independent reviewer of adverse security assessments and a respected colleague. Margaret held us to account and was generous to ASIO staff, both with her time and advice. Margaret will be missed. Thank you. I look forward to your questions.
Thank you very much, Mr Burgess, and we too express our sincere condolences on the passing of Ms Stone. I want to, first of all, give the call to Senator Keneally, please.
Thank you, Chair. Thank you to Mr Burgess and Ms Bennett for being here today. I want to ask some questions first about foreign interference, and as you've just pointed out, and as your annual report forecasts, foreign interference is likely to supplant terrorism as Australia's principal national security concern by 2026. Specifically, what intent, capability and tactics are you seeing that's led to this assessment?
Thank you, Senator. So it's Mike Burgess, Director on Security. It's a whole range of standard espionage, both through the human form and through technical form, cyber in particular, so much so. And it's simply the scale of what we're seeing. Mm-hmm. So it's just a judgment based on the amount of activity, multiple attempts from multiple countries across the range. And as I said in my opening statements, my concerns about nation states preparing for sabotage, not so much the act of sabotage itself, on top of the amount of espionage and foreign interference attempts we see, leads us to conclude that it is actually the most significant issue that we face, or it will be shortly.
Mm. If I might go to you warned of the technology-enabled espionage in your annual report. In July, The Guardian reported that Israeli cyber surveillance software called Pegasus was being used by authoritarian governments to target journalists, human rights activists and dissidents. Is that an example of that type of technology you're referring to?
Yeah, it is. Obviously, that's a slightly different thing because that's not coming at Australia, but yes, the use of software and computers to exploit computers to gain information has been used by nation states for many a century. Of course, it's also being used by criminals, so yes, that's one example.
So you just said that Pegasus has not been used against Australians? Is that what I understood that comment to be?
As far as I'm aware, but of course we're not all seeing and all knowing, so it may well have been used against someone's mobile device and we would not have visibility of that.
But you don't have visibility of Pegasus being used in Australia?
Well, we understand through the information available to us what that public reporting was referring to and who was targeted. Beyond that, I can't speculate who might have been targeted by that software or that company.
Okay, thank you. So if we look out to 2026 and beyond, say to 2030, how might the foreign interference threat affect Australia, its citizens and its interests? And I ask this because, having now been engaged on this issue with the PJCIS for several years, I'm still not entirely clear that we've made clear to the Australian people the direct impact of foreign interference on their lives?
Sure. So the very nature of foreign interference, I think it's best to start with, again, the difference between influence and foreign interference. So I'm talking about, and this is defined in law, it's acts that are clandestine or deceptive and being done at the direction of a foreign government which are detrimental to our national interest. So I recognise that's still broad. It comes across a number of areas. In communities, you see foreign intelligence services or foreign governments actually understanding what's happening in diaspora communities and actually looking to coerce or bully or threaten individuals not to protest things that actually that country would think are detrimental to their national interest. But of course, in our country, any foreign government doing that, actually that's counter to our national interest. These are people in Australia and they're being interfered with. That's one case of foreign interference. Another example of foreign interference would be where, again, covertly, individuals have been used to generate and develop close relationships with politicians at either local, state or even federal level, and then those relationships over time build to a point where they've stepped over a line and individuals might find themselves actually doing things again at the direction of or suggestion of a foreign power, and they don't realise they're doing it. That's foreign interference, and that's, I would suggest, corrosive to our democratic society just as much as the lack of transparency isn't, because you get out there in the sunlight and everyone can make their informed judgments.
I've heard you give this answer before. I think it's really important because it goes to the issue of transparency and visibility. So you've just given us a good definition of foreign interference. Can you speak a little bit, just for those listening to home, on the issue of how that differs from influence?
Sure. Well, I guess in the case of a politician, example I gave, there's nothing wrong with a foreign government or someone who believes in some views just being very open that actually this is me speaking or I'm speaking on behalf of my foreign government friends here and I'd like you to consider this view and consider my country's perspective on that. That's done open and freely, then the individual themselves, it doesn't have to be done in public, but can make an informed decision about what they're saying and what they're doing.
Thank you. Sorry, I apologise. If I can go to the Critical Infrastructure Bill, the Parliamentary Joint Committee on Intelligence and Security has made a number of recommendations. The Minister, and I acknowledge the Minister, has accepted those, and if I might just take this moment to publicly thank her for her willingness to work in a bipartisan way in the national interest with me on that bill. I do note that the PJCIS recommended that building cybersecurity and resilience and the resilience of democratic institutions was something that the government should review the risks to democratic institutions, particularly from foreign-originated cyber threats, with a view to developing the most appropriate mechanism to protect them at a federal, state, and local level. Is this a challenge that ASIO is turning its mind to?
Sorry, Senator, which challenge? Helping?
The challenge of protecting democratic institutions, state and federal electoral authorities, political parties, for example, from the threats of cyber security. I think that it'd be fair to say the PJCIS report took a view that the Security of Critical Infrastructure Bill and the mechanisms in that which apply largely to the private sector and to providers of services, was not necessarily the most appropriate mechanism to protecting democratic institutions. Sure. So my question is ASIO turning its mind to the best ways to provide protection, resilience, and secure the critical infrastructure that is our democratic institutions?
Thank you for that clarification, Senator. There's no doubt our focus on espionage and foreign interference says, yes, we're turning our mind to that, but we're not the policy response to that particular problem. Our job is to identify, help understand, and then through our action of ourselves or other partners or through a policy action, actually get that disrupted or have our environment hardened. So we're active across the board in that regards, but I suggest there's a broader conversation required. There's no doubt the action's already taken, though, the introduction of the espionage and foreign interference legislation, the resourcing of the Counter Foreign Interference Task Force has enabled action to be taken, which has resulted in the hardening of this environment. Has it removed the problem? No, because the demand from foreign intelligence services and foreign governments to interfere in our political system, as I said, is unacceptably high.
Well, I'm thinking now in particular of the coming federal election, whether it is this year or next year. The committee heard about the role of disinformation as a tool of state-backed foreign interference that has been reported as affecting a number of democratic elections in other jurisdictions. We've spoken about this before, but is this a threat for Australia too?
So there'd be no doubt that the ability to put out information which is designed to, in fact, actually push people into the wrong direction or hold the wrong view is something that happens in this information-rich, internet-enabled world. So, yes, it could be used against us. Have we seen nation-states lining up issues in an attempt to provide disinformation on certain topics? Yes, we have seen that. Do we expect that for an election? Maybe. We'll continue to watch that with other agencies and put out the appropriate advice at the time. I think there's something wonderful, though, about our democracy. It allows information and disinformation to be debated and challenged openly. So I think there is a good defence there. I think our democracy is fairly robust in that regard. But of course, we wouldn't let it rest. The community would not let it rest if we saw a nation-state engaged in acts of misinformation or disinformation. That would be drawn to the government's attention, and during caretaker it would be drawn to both parties' attention.
I want to pick up on that because you did say you would put out advice at the time. You just said that right now, and you just mentioned caretaker conventions. Indeed, the Parliamentary Joint Committee on Intelligence and Security received evidence from Christopher Krebs, who I think will be known to you, in relation to that very question of how advice is provided in an election context if there is an act of disinformation or foreign interference that seeks to persuade people during an election context. Mr. Krebs said you never want the incumbent with the ability to put their thumb on the scale and change the outcome of an election. And he's speaking about in the US, in a particular incident. He said you would not have wanted the White House press conference for those sorts of announcements because that in and of itself can be politicised. His advice to the committee was that the way in which it was handled in the US, where the FBI made an announcement of that sort or put out advice at the time to the American people, was through the FBI. So could you just step us through how you would understand if there were to be a disinformation or foreign interference threat from a state-based actor or otherwise during an election campaign? What process would you follow?
Well, if you're talking about in caretaker mode,
convention,
and
yes.
Obviously as Director General Security, in our view, we came across and we had beliefs of concerns. There's no doubt I'd be having a chat with the Electoral Commissioner. Of course, it depends on the nature of the concern that we come across. And again, I can't speculate beyond. There'd be no doubt that I'd be talking to both the Prime Minister and the Leader of the Opposition at that time. But
Right.
it depends on what the nature of the problem was.
Great, thank you. I have one last question, mindful that many senators will have questions, and indeed I flagged to the chair I will have it set on another set of matters. But if I can just touch on something in your opening statement where you talked about the various motivations behind ideologically motivated extremism. You and I have spoken before about, a subset of ideologically motivated extremism is right-wing extremism, and you've talked there about, this morning the AFP mentioned that, extremists, ideologically motivated extremists, particularly in the far right, were motivated by neo-Nazi, nationalist and white supremacy points of view. I meant to ask the AFP this morning and I didn't get a chance. To what extent are you also seeing ideologically motivated extremism motivated by misogyny?
Right now, we're not seeing too much of that, certainly not at a level that comes up to priority focus for us, but it is something that we're very conscious of. We do see people, I guess, talking around in that space, but not to the point that we've, I'd put it up there as the major problem we face, but I've been very clear, and that's why issue-motivated violent extremism is a broad range of issues and not just nationalist, racist, white supremacist. There are a range of other societal or economic grievances that actually drive people, unfortunately, to then going to violence, as we've seen in the case of involuntary celibate, for example, in other countries.
You have previously warned of incels, as they call themselves, as an example of another type of ideological motivation. But it's your assessment that hasn't risen to the same level of...
That particular, if I can call it a cohort, is not at the same level of others that we've discussed, but it is one that we're concerned about because, as I said in my opening statement, the most likely attack will be an individual that motivates and goes to violence with little or no warning, and it could be from anyone in those cohorts, on any of those cohorts, not just the major ones we've focused on.
Thank you.
Thanks very much, Senator Keneally. I'll now give the call to Senator Molan.
Thank you. I am continually confused, Director General, about nomenclature, about what we are calling what, and we've spoken about it this morning. Can you tell me what subsets exist under ideologically motivated violent extremism again, please? I know that you've spoken about this many times, and Senator Keneally has spoken about it as well just a minute or two ago. What exists under IMVE?
IMVE, issue motivated violent extremism?
Correct.
Yeah, so that's a whole range of issues or ideologies that motivate people to violence. It can include white supremacist, nationalist, racist views. It can include involuntary celibate. It can include groups...
And what was that?
Involuntary celibate, people who... It's kind of incel is the name, but actually how... It's kind of defies logic, but actually it means something to some individuals. But there are a whole range of ideologies. People who don't like or don't believe in vaccination, for example. So there's a range. There's a range of crossover between nationalist or racist with child pedophilia. It's just a wide soup of weird things. Of course, we focus on ideologies that go to violent extremism, and we deliberately chose the term issue-motivated violent extremism because it's a broad church and we want to capture everything. And there's some labels some people choose to put on it that actually are unhelpful.
What's an example of that?
Extreme right wing. That is a category, but actually it's unhelpful in the broad because it is a broad church. As I said in my opening statement, we are seeing a whole range of single issue grievances that are motivating people and going to violence. And it's not just that cohort, so assign it to political spectrum. It may well be political, but it's not the only thing in play.
No. And but we don't propose to use the ideologically motivated violent extremism terminology to the exclusion of others, do we?
No. Oh no. It's the broad label. If I'll say it here, National Socialist Network. If it's a neo-Nazi organisation, I'll call it out as a neo-Nazi. If that's assigned to the right wing of the spectrum, I'll call it as right wing. But actually, I think it's more helpful to use the broad label and then the specific ideology we're seeing, such as racist or white supremacist or involuntary celibate.
Okay. And I guess for officials, it would help if officials used that standard terminology, wouldn't it?
We've put it out there, and most people have adopted our terminology, but it's not to be used. Providing more definition actually is also helpful, so we're not stopping people from doing that.
Yeah. Okay. I think that's fine. I think that's clarified it for me now. Thank you. And Chair, that's all I've got.
Thank you very much, Senator Molan. Yes, Senator Van?
So other groups that might be under there, would they be like animal activists, like the the groups that vandalised this place, Australian Parliament House, would they fall under
Yeah, they
that
could,
label?
groups could well, but it's helpful. I guess it's important to understand from ASIO's perspective, we're talking about people with issues that are motivated by those issues that go to violence, so violent extremism. If they're passionate about a whole range of things, they're not of focus or target of our investigations.
Well, thank you. Thank you, Chair.
Thanks, Senator Van. I'll now give the call to Senator Faruqi, who is attending via video conference. Senator Faruqi.
Thanks, Chair. Thanks, Chair. Good afternoon, and thank you, Mr. Burgess, for coming to respond to our questions. And I'll start with a couple of questions about some of the comments you made in Nine's Nazis Next Door investigation, which was published in August this year. In that investigation, you said that ASIO's domestic counterterrorism caseload now has ideologically motivated violent extremism occupying about 50% of the work. Is that still the case? Is it still 50% or has that changed?
Thank you for the question, Senator. And I'll clarify this so people understand. So in terms of our priority counter-terrorism caseload onshore, IMV, issue motivated violent extremism, and religiously motivated violent extremism are on par at this point in time. But that number does move around, so it is dynamic. So priority onshore counter-terrorism investigations by ASIO, it's about 50-50 at this point in time.
So it's still about 50%.
Correct.
Yeah, so I mean, 50% is still pretty alarming since it's risen quite a bit over the last couple of years. Why do you think that is the case?
Yes, so you're correct. It has risen since about 2016. We've seen a slow and then more rapid increase. It's increased for a number of reasons. One, and we're still working through the final view on all of this, but actually my agency has been watching this particular issue motivated violent extremism for many decades, in fact, and we have been applying more resources. So as we come across things which are of concern, we step up our lines of inquiry and investigation and then go to use of intrusive powers under warrant. We've been looking at more of these. It's important to note it is dynamic, so we do see some cases drop off. We've been putting more resources into it. There's something interesting going on in the world, not just here in Australia, and we're seeking to understand our part and reasons to understand why that's occurring.
Okay, earlier on in the hearings this morning, I questioned the AFP about the increase in their caseload as it had been revealed through an SBS story earlier this month that their caseload now covering far-right extremism and racism has risen to about 15% from, I think, 2% a couple of years ago. And in that questioning, it was also revealed that AFP have investigated threats of violence towards people who are gathered at mosques and also at synagogues. And given, the history or the terrible history of an Australian man killing many people in mosques in New Zealand, is there a fear that something like that could happen in Australia?
There's a fear that an individual, from any of these ideologies, that an individual will go to violence with little or no warning. The most likely targeted place will be crowded places and with a car, a knife, a gun or some form of basic weapon, but I know basic weapons can still be considerably deadly.
Mr. Burgess, you have frequently linked the growth of far-right activity to the disruption of the COVID pandemic and the conspiracy theories that people can attach themselves to during these times of global crisis and uncertainty. And I think you did mention that in your opening statement as well. For people who have been recruited to these groups through the COVID pandemic, do you think it's likely that they leave these groups now that lockdown restrictions are easing? Or is it possible that they've gone too far down the rabbit hole?
So firstly, I'd just be clear in terms of your interpretation of what I've said. There's no doubt during COVID, people being online have potentially been subject to information that helps them on a path of radicalisation, and obviously with lockdowns, they don't benefit from the social interaction that tends to normalise what people get through their online interaction. So there's no doubt COVID has been a factor. But if you look back through when myself and my agency have been talking about this rise happened before COVID, so the rise is not solely on COVID.
So, but was there an element, you think, of the rise that is linked to COVID and people being online and maybe radicalised through that?
I think it's safe to say that's a factor, yes.
Mm-hmm. And does ASIO consider certain public figures to be radicalising people down the, I guess, extreme far-right path or towards ideologically motivated extremism? And do you monitor people like, for instance, Craig Kelly and other COVID conspiracy theorists for what they're saying and how their words could be impacting people susceptible to the COVID conspiracy theories?
We wouldn't.
Senator Faruqi, I would just remind you of the standing orders, which do not allow reflections on other members or senators, please.
Mm-hmm. Thanks,
you.
Chair.
Thank you. I'm sorry, Mr Burgess.
No, it's fine, Chair. Senator, so we only monitor people who are involved in violent extremism. In this country, Australians are free to express any view as long as they're within the law.
Thank you, Chair. Thanks, Mr Burgess.
Thank you very much, Senator Faruqi. I will now give the call to Senator Patterson.
Thanks, Chair. Mr Burgess, you'd be aware that recently the Deputy Chair of the Parliamentary Joint Committee on Intelligence and Security, Mr Byrne, resigned from the committee. He did so as a result of internal Labor Party matters that I don't seek to comment on, and I know you won't seek to comment on either. But during that public discussion, it was suggested that a reason that he may need to resign from the committee is because intelligence and security agencies could no longer trust him, given his disclosures before IBAC. As Director General of Security and speaking in his capacity as a PJCIS member, did you hold any of those concerns?
Senator, thank you for your question. If I may, I will answer it this way because I don't generally comment about individuals. What I can say about Mr Byrne, though, in his role as Deputy Chair of the Parliamentary Joint Committee, I've engaged with him extensively, both during my time as Director General of the Australian Signals Directorate and for the last 2 years as Director General of Security. And in that capacity, I've found him to be someone who is deeply thoughtful and probing in his understanding of intelligence and security matters, the threats we face, and actually what's needed to protect our country from these threats whilst upholding the law of this land. So I've no doubt would assess that Mr Byrne is someone who cares deeply about national security and what's in Australia's national interests. So that's my comment on Mr Byrne. For clarity for everyone, though, if I had concerns about a Member of Parliament, I would talk to, and it depends on the nature of those concerns, but I would talk to the Leader of the party.
Thank you, Ms Burgess. Thank you, Chair.
Thank you very much, Senator Patterson. Mr Burgess, I'm wanting to ask you about the importance of protecting Australia's critical infrastructure. Could you describe the threat as you see it to Australia's critical infrastructure at the moment?
Yes, thank you, Chair. So, as I've said, espionage and foreign interference will supplant terrorism, just noting that terrorism is still a threat to life and will continue to be a priority as our country's principal security concern. Part of that is actually our concerns around critical infrastructure, and obviously critical infrastructure is by very definition critical, and there are elements of industry and government operations which are critical to this country's well-being. I'm concerned about nation states who are actively mapping out networks in critical infrastructure, and that's not just to steal intellectual property, that would be to understand how those networks work. So it will allow them to think about how they could disrupt that network and cause a problem for this country, which would not be in our national interest. So I have grave concerns about preparation for sabotage, which is one of ASIO's heads of security. So that is most definitely one of those areas. Of course, more broadly than that lane, which is for others to speak on, critical infrastructure, like elsewhere in society, is benefiting greatly from the use of digital. So the internet and technology and connectivity provides great benefit, but with those great benefits comes the potential downside risks as well. and it is easier to steal or break, and therefore, criminals who are looking to hold companies to ransom for money can actually inadvertently disrupt critical infrastructure, which would not be in our national interest. So there could be misadventure or deliberate, vandalism in the name of getting money that could cause this country problems. So my lane, though, is looking at nation states, AFP, Home Affairs and others, and ASD worry about more broadly than just those issues, and it's of grave concern.
And Mr Burgess, in terms of the damage that this can cause, sabotage to critical infrastructure, are you talking about threats such as shutting down power networks or the operations of roads, bridges? Could you perhaps describe this in a bit more detail?
Certainly, Chair. It's the full broad of the power's not running, but not across the country in a specific area at a specific time, which has a direct effect. It could be water supply is not clean or water supply is not available. It could be sewage treatment functions don't work correctly. It could be the financial sector is not operating properly. Transfers between banks isn't happening when it needs to happen. People can't access their money online. It's a full range of things. To be clear, this is a very real threat that actually does need to be managed effectively, and there are many elements of that, including the critical infrastructure legislation that Senator Keneally mentioned. Things like that are critically important in their full to be implemented to help us, private sector and government together, to better identify and manage these risks that we face as a country.
So in recent years, the government has passed a range of laws in order to better protect critical infrastructure and to broaden the definition of critical infrastructure. How important have these reforms been?
Yes, Chair, there are others, and Secretary Pizzullo may wish to comment on this later, but I can think of the telecommunications sector security reform legislation that was passed a few years ago. That is absolutely critical. Communications underpin critical infrastructure. Without that running, then they'll find it hard to function. Absolutely important. The new legislation, which is currently before Parliament, I think, around the security of critical infrastructure, that tranche and the follow-on tranche are critically important.
Can you explain why?
Well, it helps, in terms of the telecommunications sector security reform, it actually sends a signal to that element of critical infrastructure that security is important, outlines expectations on them, and actually explains how government and industry can work together to manage that risk effectively. And there's no doubt as a result of that, I've seen insecurity increase in the telecommunications sector. You've seen the government's 5G decision, which was critically important in making sure that the 5G, which it's not just about faster speeds on handsets, actually 5G will underpin all critical infrastructure that's reliant on digital, and there's not any element of critical infrastructure that does not rely on digital. And if 5G wasn't there, then they would have trouble running. That's a great decision that puts us in a good position. But all these decisions in isolation are important, but actually it's the constant work and vigilance of industry, the owners of critical infrastructure, and others, led out of the Home Affairs Department, critically important to ensure that we maintain a vigilance on this, and people are doing everything they can to understand the threats, make sure they've identified the right risks, and those risks are in fact being managed effectively.
Mr Burgess, I just want to ask you, I asked the same of the Commissioner of the AFP this morning. We're seeing a dramatic increase in the targeting of Australians by way of scam emails and text messages. I, for one, am getting almost daily text messages which are clearly scams, encouraging me to click on a link because there's a parcel which has just arrived. This is clearly also a concern for ASIO. Can you describe the nature of these risks and what ASIO is doing to combat them?
Sure. So the examples you call out there is, like probably most Australians, I too are getting frequent SMS messages that telling me that I've got a parcel being delivered, or I've in fact got a voicemail, and it's clearly not legitimate. Unfortunately, if you click on that link, it may well result in your device being compromised, or takes you down a path where they're compromising your personal information that allows some criminal to benefit from that. So most of those are actually, that you've been calling about, are criminal in nature. The ones I worry about are far more sophisticated than that. So nation states generally wouldn't send you the voicemail email unless they're amateurs. So I'm not focused on the cybercrime element of that, but I am focused on espionage on actions of nation states. That's something where we all have a collective responsibility, though. The individuals themselves should be alert to, if you didn't order something, maybe you shouldn't click on that link. If it doesn't look familiar to you, then delete the SMS. Of course, I know there's actions, which is not ASIO's involvement, where Home Affairs are working with carriers on projects to look at how you can clean up that and have telcos themselves or the service providers remove those malicious attachments so they don't become a problem for the consumers. But it's another great example of connectivity provides great benefit to our society. At the same time, the criminals know that and they're exploiting it.
But given the number of Australians who engage in online shopping, there's a fairly good bet that if you get a message saying that the parcel is about to arrive, someone may well be expecting a parcel to arrive. So it's a pretty scary proposition when so many Australians are receiving these text messages, which could, as you say, not just compromise your own security, but lead to bank accounts being drained or any other types of harm that people may not foresee.
I totally agree with you.
What can be done? How can you talked about working with the telecommunications providers to stop these sorts of attachments being sent or capability to send links? Because it seems that this is quite an urgent situation.
Yeah, again, Chair, I mean, this is not really ASIO's lane. The Australian Signals Directorate, Secretary Pizzullo, again, I'm sure will be able to share what the department is doing in that space of countering cybercrime and the policy initiatives that are underway. For me, though, it's, this is a serious problem. It comes back to technology is great and it provides much benefit, but at the same time, criminals are able to exploit that and they're able to do that in a far more agile way than most of us and able to make considerable money. It requires constant attention. My best advice to anyone is just be streetwise and be aware. If you've ordered that DHL parcel, unless you gave them the mobile phone, more likely than not, they'll send you the email with the parcel delivery. Just exercise caution.
All right, thank you very much, Mr Burgess. I'm now going to give the call to Senator Keneally.
Thank you very much, Chair. Thank you. I'd like to ask some questions back on ideologically motivated extremism. And Mr Burgess, over the past year, you have been publicly warning of the steady rise of ideologically motivated extremism, including that which has broadly come under the umbrella of far-right, particularly neo-Nazis and white supremacists. And you've said it's 50% of your domestic counter-terrorism caseload. Can you give us a sense of what characteristics or indicators do your analysts look for when assessing someone's vulnerability to radicalisation to this wide spectrum of ideologically motivated extremism?
Firstly, it's 50% of our priority counter-terrorism caseload onshore.
Thank you.
Because our counter-terrorism caseload is a far greater number.
Yes.
In terms of whether an individual is vulnerable to radicalisation or getting hooked by this, that's not our starting point because we're not looking at people to understand who might be vulnerable so we can be ready watching them. We normally come across them through other means, so we're not starting off at the point of are they vulnerable, therefore we better watch this person. In terms of when we're looking at people, however they've been drawn to our attention through our community contact reporting, our own sources, National Security Hotline or whatever, yes, our analysts will take into account what we know about that person and where they are and where they represent a threat. And of course, when we do that, especially when they're talking about violence, we have to assess whether they have the intent and capability to go to violence. And then what to do about that is actually something ASIO doesn't do in isolation. We're very much integrated into joint counter-terrorism teams. Or as part of those activities or through other activities, there may be some intervention from people who are experts in countering violent extremism and radicalisation.
So let me put it to you this way. How and where are people most often coming into contact with ideologically motivated extremist ideology on the online?
That's a good question, Senator. I will take that one on notice to make sure I get you the full answer, because it may not be online, so I don't want to offer you an opinion at this point. I'd rather discuss that with my team.
Well, your annual report did say that the COVID-19 pandemic has been used by issue-motivated groups and that they are seeking to exploit social and economic dislocation, and their ideology has been spreading more quickly and widely as Australians spend more time online. So I presume that online...
Well, your question was, is it more online or is it more in person? I'm being open with you. I can't answer that question because, yes, we did say that in annual report. That doesn't mean to say there's more of that than online.
Sure.
We know these groups do actually regularly meet up. We know these groups attend or actually run, some of these groups run like fitness fighting clubs. And that's how new members get introduced. So it's probably not all online, and to get you the right answer, I'll talk to my team to get you the full answer.
Okay, thank you. Again, from your annual report, in April 2021, ASIO published advice on the Australian elements of one of the groups involved in the Capitol violence in Washington, US. I apologise. I may have missed the publication of that advice. Can you speak to what that advice was that you published?
I'm not sure. I know there are Australian groups. Could you give me a...
It's page 37 of the ASIO annual report. This is in April 2021, ASIO published advice on the Australian elements.
Oh, well, I'm sure that advice would have been protected, not public, so that's just a statement of what we did there.
So you didn't publish it in the
when
ordinary
when we
English
say publish, Senator, you
meaning
know,
of the word?
most of our publishing is classified and
Yes.
therefore not for public consumption.
Is there anything more you can say in a public arena about the Australian elements of one of the groups involved?
Well, it isn't clear to point out that there was no Australian groups involved in the Capitol riots in the US. They might have had a connection to an association with a group called X, but beyond that, we're not saying that they were involved, and that's not what we're meaning to apply.
I don't try to put those words. It says the Australian elements of one of the groups involved.
So that would mean there's a US group that's got a label, and we see people in this country who identify with that ideology or that group, and we would have published something around that.
And you're not able to tell us what the group was that was where there were
I
Australian...
wouldn't comment on that publicly.
Okay, thank you. Now, I want to also ask about prescription. We've discussed this before. Australia only this year listed its first far-right terrorist organisation or ideologically motivated organisation, the Sonnenkrieg Division. It, in fact, has disturbingly some motivation in pushing, acts of sexual violence as a way to disrupt democratic societies. As we've heard from you, from the AFP, as well as Nine Media and SBS organisations, are you able to confirm that ASIO has recommended to government that other ideologically motivated extremist groups active in Australia also be prescribed?
I don't talk publicly about groups that I've asked for or suggested should be considered listing, but we do regularly review these matters, and so that's an ongoing process for us, and obviously Sonnenkrieg Division example of where that has happened.
I believe there was actually a confirmation in a Nine News article that you had recommended other ideologically motivated groups. I'm not asking which ones, I'm asking if that is correct.
If the question is, do we recommend groups or suggest groups should be considered for listing, yes, we do.
Okay, thank you. And just to confirm for those listening at home, ASIO is no longer the, you don't drive that process
No, we
anymore.
don't.
That is being done.
We could say this group should be considered for listing, but others can get to that view as well, and that process of managing all of that is the Department of Home Affairs.
Yes, thank you. I wanted to ask about certain social media platforms. It does seem that there are certain less regulated online spaces that are used by ideologically motivated groups, such as Telegram. Has ASIO provided any advice to the government on individual platforms or on members of parliament promoting certain platforms like Telegram that are popular with ideologically motivated groups, extremist groups?
So we wouldn't be in the business of just commenting on platforms.
That's, well, have you provided any advice though to government about the use of certain platforms and their use by ideologically motivated groups?
I don't believe we have. I have been on the public record, though, as saying that there is a significant issue that we have around lawful access, and also made the point that technology platforms should not be beyond the rule of law.
What do you mean by that?
Well, they shouldn't be safe havens through which people can promote, radicalise and engage in and discuss matters of violent extremism, for example, as in a way that is deniable to law enforcement under warrant having access to such communications.
Well, that would presumably be, you're talking there about encrypted platforms.
Yes, Senator.
Some of the platforms I'm thinking of are not encrypted. They are there in plain view.
So they wouldn't be a problem for me.
For you,
They wouldn't be, if we have free access to it and we were driven there because we had security concerns, then we would freely be able to make our judgments.
All right, thank you. Chair, I might leave that there in terms of ASIO. I don't know if we have any other.
No, we don't,
Okay,
Senator Keneally, so thank you very much. Mr Burgess, thank you very much for your time today, and Ms Bennett, and for your evidence. It's very much appreciated by the committee.
Thank you, Chair.
Thank you. It's now my pleasure to call officers from the Office of the Special Investigator. We might just suspend for a couple of minutes while officers come to the table. The committee is now in session. I welcome Mr Chris Moratis from the Office of the Special Investigator. Mr Moratis, would you like to make an opening statement?
Thank you, Chair. If I may, I'd like to just put a few things down on the record
as
a way of summarising what we've been up to the last few months. The OSI has been made substantial progress since our last appearance before the committee in May. The joint OSI-AFP investigations process is now well underway. More than 50 investigators and intelligence analysts are now on board, almost all of them drawn from state police and from the AFP. They have all undertaken a substantial induction program, and those from state jurisdictions have been sworn in as Federal Police Special Members, which provides them with the necessary training and powers to undertake these, what we all agree are complex and challenging investigations. The investigators are benefiting significantly from advice and guidance from the Special Investigator, that's Mr Mark Weinberg, the Director of Investigations, Mr Barnett, and our Special Counsel team led by Tim Begbie QC. Information has started to flow to the investigators from various sources, the Department of Defence, the Inspector General of the Australian Defence Force, and from other sources. In all cases, we're following appropriate protocols and agreed procedures to protect the integrity of the investigations and any potential future prosecutions. Investigators are undertaking their work with a clear focus on progressing as expeditiously as possible. Senator, we're also conscious of the welfare of those who are or may become involved in our investigations. We recognise there are other processes underway with the potential to intersect with our remit, such as, for example, the Royal Commission into Defence and Veteran Suicide. Like everyone, we monitored recent events in Afghanistan with concern for the safety of all those involved and, if I can say, a deep appreciation for the efforts of our colleagues in various Australian government agencies working on evacuation efforts there. To date, our work has not been markedly impeded by the situation in Afghanistan. Investigation teams are primarily focused on information from a variety of other sources. We will, of course, in consultation with key partners, keep an ongoing watch and assess any implications for our investigations as they progress. Can I also say that, like other workplaces, the OSI has navigated the additional challenges raised by the COVID-19 lockdowns in 3 cities we're located and the restrictions that have taken effect. However, their effect on our officers and workforce across these jurisdictions, with careful management, has not had a significant impact on our progress of our work. With 10 teams of skilled investigators up and running within the joint OSI-AFP investigation model, and as I said, appropriate systems and protocols in place to support impartial and rigorous investigations, and the agency as a whole, we have made what I think is pretty good headway in the less than 10 months we've been officially established. So we're well placed, I think, to continue the unique and important work which the Government of Australia has assigned to us. Thank you, Chair.
Mr Moretus, thank you very much. I'll now... Yes.
Sure, I can do that.
Yes, it's just been tabled. It's just been tabled and it's been... Mr Moretus' opening statement has been distributed to senators now.
It's not verbatim. I've ad-libbed it.
Yeah, no, it's all good.
We'll check on delivery. Thank you. I will now give the call to Senator Keneally.
Thank you, Mr Moretus, for being here today. The Burton inquiry did recommend that 19 current or former ADF personnel be referred for criminal investigation. And I apologise if you did say this in your opening statement. Can you confirm how many current or former ADF personnel you are currently investigating for alleged war crimes?
Senator, we have taken up the remit of Brereton, but I won't go into the details of how many we are currently investigating because it's operational, but clearly that's within our remit and we'd like to progress all of those referrals when we've got the appropriate clearances from our lawyers. But there are a variety of other sources as well and allegations we're exploring. So I don't want to give you a binary answer because one, it could be misleading because there are other things going on. Secondly, I don't want to go into operational details of our investigations.
Okay, thank you for that. Well, I'll ask this question and
Sure.
and then you can tell me whether you're able to answer it. Has the special investigator been able to exonerate any of the 19 current or former ADF personnel who were initially referred for investigation?
Way too early, Senator. We have not exonerated anybody. We are starting our investigations to examine the evidence.
Thank you. When do you expect the investigations to conclude? Are we looking at a year, 2 years, 5 years?
Yes.
Yes. So it could go...
It could go a year. It could be, hypothetically speaking, in a year's time, I can tell you that we don't have sufficient evidence to prosecute anybody, or we can say, yes, there's a good evidence to take forward to the DPP, and they will progress 2-3 years. So I can't really tell you. That's why it could be anywhere in that range you've suggested.
Okay, thank you. I'll ask another question. You can let me know if you can answer it. Are the individuals under investigation cooperating?
We have spoken to a variety of potential witnesses, but we won't go into the details of cooperation or otherwise. That's an investigation matter.
Thank you. Has the situation in Afghanistan, in particular the return of the Taliban, had impact on the investigation? And if so, are you able to tell us how?
As I said in my statement, the situation in Afghanistan has not meant that our investigations can't proceed. As I said, there are a variety of other sources we can investigate. As I said back in May, when the situation was still unclear, well, much less clear than it is now, I said that the situation is not ideal from an investigation perspective, and it's pretty self-evident that access to individuals in Afghanistan or even evidence or even places is extremely difficult, if not currently impossible.
So it may hinder some ability to collect evidence, but you're telling this committee that you have other
All I can say
avenues?
is I'm not an investigator, and my investigators are very experienced. We've chosen some pretty experienced people who've pursued a variety of challenging matters in the past, and I'm very confident they'll pursue all avenues.
Okay. Another question I'll ask, and you can determine whether or not you're able to answer it. Has the defamation proceeding involving Mr. Ben Roberts-Smith had any impact on the investigation?
In short, no, it's a separate matter. It's a private civil litigation. It doesn't impact on our work. Obviously, like everybody else, we're aware of the proceedings. We're aware it's been postponed because of COVID. And obviously, we'll keep an eye on how that may or may not impact on our work.
Thank you. My last question, in your judgment, do you have adequate funding and resources to complete the full and thorough investigation of these?
In my judgment, very much so, Senator. Thank you.
Thank you. All right, thank you, Chair.
Thank you very much, Senator Keneally. Senator Kitching,
Thank
a couple of questions. I'll give the call to Senator Kitching.
Thank you. Thanks, Mr. Moratis, and it's good to see you.
Good to see you too.
Could I ask, I don't think it's in your as delivered speech, but I think you said there were a variety of other sources or some words like that. Are you able to list those other sources?
I'm able to, I'd rather not, but I can speculate in generic terms.
Yes, that's fine.
There's been a lot of public media commentary. There's a lot of stuff on the record. There's a variety of evidence we can source or pursue outside of Afghanistan. That's what I'm basically saying. And gives we have 10 teams of investigators working away, and quite a few of them are pursuing leads, but not necessarily in Afghanistan.
So, are you exploring similar fact evidence? Are you exploring something
I won't
like...
go into those details.
Okay. Do you envisage being able to have the Afghans who would give evidence to give that evidence in person in Australia?
At this stage, it's hard to envisage that happening. It's contingent on a variety of factors, which I really can't, with any confidence,
but all things,
comment on.
Oh, so leaving aside, because hopefully we're all going to be able to travel very soon, leaving aside pandemic issues, would you consider it, best to have in-person evidence given?
I can speak in generalities, and
Yes.
what I'm learning on this new job. Obviously, having a person present in person provides certain advantages. However, as has been shown in many other situations, getting video evidence or video conferencing is quite feasible now with technology. It just depends on a variety of other factors.
And you would have done many Zoom meetings, as I'm sure we all have, but I still think you miss things.
Yes, and obviously...
And I think in examination in chief and in cross-examination, you would want someone in person.
I totally agree, and obviously it's complicated by language. If video conferencing with Zoom, imagine with language
Yes.
issues, reliability of electricity supply, let alone coverage, and a variety of other factors to do with people's state of mind, their well-being, their welfare. There are standards we'd like to, in an ideal world, try to uphold in this process.
Thank you, Chair. Thank you, Mr. Moratis.
Thank you very much, Senator Kitching. We will now suspend for 15 minutes for afternoon tea and return after that time. The committee is now in session. We are continuing with the Office of the Special Investigator, and I welcome attending remotely Senator Steele-John by way of video conference. Senator Steele-John, welcome. You have the call.
Thanks very much, Chair. So my questions, first of all, will go to the Director of the OSI, and it's been directed to the corporate plan that has been announced by the organisation, by the agency, particularly to the last few sections of that corporate plan, which talk about risk mitigation, the risk mitigation frameworks that you are utilising. It says specifically that the board has articulated an appetite for risk, and that is why you have put in place that framework. And in reading it through, I was able to identify a number of different sections that dealt with very important areas, such as systems, relationships, and the maintenance of a good investigation generally, independence and integrity, all critical. What I didn't see, which surprised me a bit, was anything in relation to the physical safety and protection of members of the office, the investigative team, witnesses that you are engaging with. So I wonder whether you could tell me whether that has been factored in to your risk frameworks. If so, where? And if not, why not?
Well, thank you, Senator. I think I got the gist of your question.
Yes, we are having a few communication issues, a bit of cutting out, but we will do our very best. Thanks, Mr. Gracious.
And thank you very much for reading the corporate plan. We try to articulate what we're doing, and you're right, the risk discussion in that plan is a very, at the higher level of risk. It's the level of risk which encompasses the enterprise, as it were, the way we've designed our structures and how we're going forward with the variety of risks. The examples you've mentioned about personal security risk, witness security, that's a separate process. We're engaged in a protective security space, and that's work we're doing at the moment, and that will be articulated. In fact, it's literally happening in the last few weeks once we've got the corporate plan in place, which is the big picture risk. All these things that you've mentioned, Senator, in your question are very much, actually at the beginning of our conversation about risk were there. It's just that in this context of a corporate plan, that's not where you put those or articulate those risks. They're done at the protective security space. And in fact, we have some experts working with us in that space. But as you can imagine, we're already well aware of that. It's just a question of how and where we articulate that risk and at what level of specificity. As I said, in the corporate plan, it's much broader, a risk analysis. When we say we have a high risk appetite, we have a high risk appetite because our reality is a very risky world in which we're operating. It's legal, it's operational, it's getting the right mix of workforce, it's about interoperability in creating new systems and designing new systems to work with the structures we have in the existing law enforcement space, whether it's at one hand the Federal Police, at the other end it's the Director of Public Prosecutions. So all those risks have been analysed because they're risks that we need to mitigate at the beginning. And these are risks operationalising our work, whether it's protection of witnesses or protection of our investigators. They've been already factored in operational terms. Our investigators have those protections. And when and as we get into the next stages, they'll be put in place. And as I said, all the other issues of protective security will be articulated in a protective security plan, which I'm not sure if it's actually made public, but we can certainly talk about it when we've got it finalised. And we have, in fact, we are reporting on our protective security this week to the Attorney General's Department. In my previous role, I used to be the recipient of this material, so I'm confident that we can satisfy the Secretary of AGs about what's required in that document. So that's the answer to your question.
Thank you. I'm just wondering when that plan is finalised. It sounds like it'll be finalised, if I understood correctly, that it will be sent to the AG next week. Said, because I'm having some auditory challenges as well, I do apologise. But when that's been finalised, will some element of that plan be proactively communicated so that witnesses feel comfortable to engage with the investigative office? I'm asked this question in the context of news reports that have spoken to potential activities which were intended to intimidate witnesses from coming forward. It'd be great to see some kind of proactive communication sections that exist if people have got information and wish to disclose.
Yes, thank you, Senator. I think I got, again, the gist of what you're asking, and I take on board your point about being proactive. I think we're trying to be as proactive as we can in our world, and we're explaining how we operate. And that's certainly stuff we would like to put out into the public domain to help people come forward and to feel comfortable and reassured. Just so you know, for example, our communications portal is a single portal to do with an email address, and that's all premised on protecting individuals in a variety of ways. And so certainly we will design our future engagement and communications in the security space with that in mind, because it is a challenging space.
Okay, thank you. Now we've seen a lot of reporting recently, which seems to mistakenly inflate the administrative actions taken by Defence and the work that the investigation doing OSI is doing. So I'm just wondering if you'd be able to confirm, just for the committee's benefit, that your work as an office is entirely separate from the independent and internal decisions made from Defence, the subjects that you may be investigating.
Yes, Senator, I can absolutely confirm that it's separate.
Excellent. So decisions made by Defence in relation to the Brereton report administratively to do with personnel have no real bearing on investigations.
That's correct. It's not relevant to our work.
Okay. And finally, just in relation to Measure 2 of your plan, which talks about evidence that the OSI, evidence that the OSI has an appropriate investigative team in place, a structured partnership with the ADF for jointly managing investigations, including appropriate oversight mechanisms. I just wanted to ask you some basic questions about your staffing profile and its footprint, and answer them as you are able to answer them, without revealing anything that you obviously can't. But how many, was it 50 individuals you say now work with the OSI?
No, we have at least 50 investigators who are led by 3 senior investigators, including Mr. Barnett, who's the Director of Investigations. He has 2 commanders, and then we have 50 plus investigators working. We have an additional 30 staff located in various places. We have a special investigator. We have staff assisting him in Melbourne. He's also assisted by 2 counsel. We have some corporate and legal staff assisting the investigating team in Sydney, and I have corporate and policy staff. So the total is about 80 ASL, 80 or so ASL.
Okay. Thank you. And you answered in relation to my colleague's question in relation to Afghanistan. You articulated that there were some challenges interacting or eliciting the evidence of witnesses or individuals of interest in Afghanistan at the moment. Now, I think many of us can imagine what some of those challenges may be. But could you just step out for us briefly what the barriers are to soliciting that evidence from your perspective at the moment?
Very quickly, just in general terms, in a criminal space, you need to have state-to-state cooperation for mutual legal assistance. So we just can't turn up in a country without the host state being aware of that. And there's a whole legal process. At one extreme, there's extradition. At a very early stage, there's legal assistance requests. We do it all the time, all over the world, whether it's to do with, a variety of criminal offences. In this space, you need to cooperate with the state. At this stage, I don't know we can do that. We're obviously working closely and following Foreign Affairs' work in this space and how they will engage with Afghanistan in the future. We can't do that, so that's the first necessary condition for engaging in that space. The second one then is finding counterparts we can deal with in the law and justice area. And then, of course, when it gets to the operational investigation space, having investigators travel to a place like Afghanistan at the moment is extremely difficult, if not impossible, I dare say. And then obviously locating individuals who may be of interest is obviously going to be an extra challenge. And then, of course, securing that evidence in a way that can be adduced in a court of law in Australia by prosecutors to be able to form the basis of charges. That's, again, massively challenging at the best of times. So that, in a nutshell, is what we're dealing with.
And have those challenges been exacerbated? There are many exacerbating factors, but in the absence of a permanent diplomatic presence on behalf of Australia in Afghanistan, does that create additional barriers that we don't have an embassy there at the moment?
It could if you, let's just say 10 months ago, if we were going to Afghanistan, we certainly would have sought the services and assistance of the embassy in Kabul. Having said that, in many situations, law enforcement activities go on in places where there are no Australian embassies, and law enforcement officials through state-to-state cooperation will turn up in a country and operate with the local authorities without necessarily having an in-residence embassy. But that depends on a whole spectrum of variables ranging from the security situation, the level of engagement with that country, how good the relationship is, how difficult it is to get around. There's all these factors. So yes, it'll be very good to have an embassy there, but not impossible in the absence of an embassy to undertake law enforcement cooperation in another country.
All right. Well, I'm aware of the committee's time, so I'll just make this my last question. We obviously have had a significant outflow of individuals from Afghanistan in the aftermath of the fall of the government. There have been a number of individuals brought to Australia, but there are many more that have moved beyond the border of Afghanistan currently. There may also be those within country that wish to give evidence to the inquiry without through the processes of seeking the support of their government to do so. So just, is there currently the process for witnesses to incidents or individuals of interest to the investigation who are either out of country or in country and wishing to simply make direct contact with the investigation? Can that be done? Is there a pathway for that to take place?
I won't go into the details, but yes, we're pursuing all avenues that are available to us outside Afghanistan.
Okay. And is there, I'm sorry to do this naively, but it is without possibility that a member of the public or somebody in country in Afghanistan may seek to speak with a MP or individual wishing to pass on information to your office? Is there a place that you would, is there a place they go to make contact with the investigation?
Yes, there is. We have, as I said, we have, for reasons I can describe, it's basically have an email which we invite people to put in their details and then we contact them. The only reason we do that is because that controls any information flows that comes to investigators, because if someone says something to us which has been sourced from, say, the Brereton inquiry, and that was compelled evidence, that can actually be a bad basis to pursue investigations. So it's really to control the inflow of information. We strongly encourage anyone who has any information of relevance to our work to come forward, either directly or through members of Parliament. And the means is through that email, so that we can control the conversation, so that we don't inadvertently receive evidence or potential evidence which may be affected by other matters that have other controls around them, like the Brereton, which means we can't start off an investigation with someone telling us they heard from someone who was told something from Brereton which was compelled. That creates a bad downstream effect. So yes, we'd encourage Senator anybody to come forward.
Okay, thank you very much. That's very heartening to hear. Thanks, Chair. Appreciate it.
Thank you very much, Senator Steele-John. Mr Moretus, that concludes the committee's examination of the OSI. Thank you so much for your time and evidence this afternoon.
Thank you very much.
I now call officers representing the Department of Home Affairs, including the Australian Border Force, in relation to cross-portfolio, corporate and general matters. We might just suspend for one moment while we get organised. The committee is now in session and I welcome to the table Mr Bozzolo. Mr Bozzolo, do you have an opening statement?
I do, Madam Chair, and I'll be pleased if it's your wish to have it tabled.
Yes, if you could table it, please. Would you also like to read it out?
Yes.
Thank you.
At the direction of the Australian Government, the Department and the Australian Border Force, or the ABF, have been preparing for the reopening of the international border at scale. Fully vaccinated Australian citizens, permanent residents and their families are the most immediate priority, with passenger arrival caps for these travellers to be lifted in New South Wales and Victoria from 1 November 2021. In September 2021, I should say, a contract was signed by the Department with Accenture to deliver the Permissions Capability Platform and its first use case, the Digital Passenger Declaration, or DPD. Initial operating capability for the DPD will be delivered in December of 2021. It will incorporate the Australian Travel Declaration and pilot digitising the existing incoming passenger card, otherwise known as the IPC. The DPD will digitally verify the recently launched International COVID Vaccination Certificate and will be a key tool in reopening the international border. From March 2022, the IPC, or incoming passenger card, will be completed digitally by all passengers, and data collected will continue to be securely shared with state and territory public health authorities. Last financial year, the Department delivered 160,052 migration program places, which is to say the permanent program, including the largest partner visa program in 25 years. The increased planning level for partner visas supported the reunification of Australians with immediate family members during the pandemic. The migration program also provided Australia with skilled workers to ensure continuity of critical goods and services, supporting Australia's pandemic response and our national economic recovery. The Department continued to focus on maintaining the integrity of our immigration program. To take an example, in 2015-16, the refusal rate of applications was 2.5%. With changes in how the Department applies intelligence discovery and analytical tools to the immigration program, the rate of refusal of visa applications has increased since that time. In 2020-21, the refusal rate of applications decided was 3.8%, which is to compare with the earlier figure of 2.5%. More details on the achievements in our immigration and citizenship services can be found in the latest edition of the publication, known as the Administration of the Immigration and Citizenship Programs, which is now available on the Department's website, and I've included a link in my opening statement to that publication. Turning to Afghanistan, the deteriorating situation in Afghanistan early this year demanded a rapid and coordinated response to ensure the safe return of Australian citizens, permanent residents, visa holders and former locally engaged employees, or LEEs, L-E-Es, LEEs and their families. I commend the departmental staff and ABF officers involved in this operation in Kabul, facilitating border clearance of evacuees, including their identity and security checks. Their efforts contributed to the evacuation of 4,100 people, with more than 3,500 evacuees now residing in Australia. Since 2013, more than 2,000 humanitarian visas have been granted to Afghan certified LEEs and their families, including 887 since January this year. Last month, the new Memorandum of Understanding for an enduring regional processing capability in Nauru was signed, underscoring Australia's commitment to regional processing as a key pillar of Operation Sovereign Borders. I wish to thank Nauru for its partnership in hosting a ready capability for any future illegal maritime arrivals who are not either turned back at sea or returned otherwise. By the 1st of January 2022, regional processing arrangements in Papua New Guinea will have transitioned to the PNG government's independent management. I should like to thank PNG for its long-standing partnership in the fight against maritime people smuggling and commend its leadership and determination in supporting individuals remaining in PNG along durable migration pathways. The Department is becoming increasingly concerned about the potential for adversaries to pre-position malicious code in critical infrastructure, particularly in areas such as telecommunications and energy. Such cyber-enabled activities could be used to damage critical networks in the future. The increasingly interconnected nature of Australia's critical infrastructure exposes vulnerabilities which, if targeted, could result in significant consequences for our economy, society and sovereignty. As I have said previously to this committee and to the Parliamentary Joint Committee on Intelligence and Security, or the PJCIS, it is pressingly urgent that the Parliament deals with this problem by way of consideration of the full suite of measures as set out in the Security Legislation Amendment Critical Infrastructure Bill 2020. The Department will, of course, work under the direction of the Government to address the concerns about this bill which were expressed last month by the PJCIS in its report on the bill. The Ransomware Action Plan, which was released earlier this month by the Minister for Home Affairs, sets out reforms to respond to ransomware and related malware. The plan includes legislative reforms to ensure that cyber criminals are held to account for their actions and that harsher penalties apply to those who engage in ransomware or who otherwise target Australia's critical infrastructure. This month, the Department participated in the International Counter-Ransomware Initiative, which was convened by the White House and which brought together over 30 nations to build a global response to the ransomware threat. Australia led a panel discussion on disruption. These like-minded nations have agreed to better coordinate their efforts, and Australia is prepared to lead streams of action in support of this goal. And for the benefit of the committee and its interest, should it be interested, that is, I've attached by way of a link to the joint country statement that arose from the International Counter-Ransomware Initiative meeting. Thank you very much.
Thank you very much, Mr Bozzolo. And we will firstly go to Senator Grogan.
Thank you, Chair. Thank you for your introductory statement. I have some questions about the borders reopening, and I'd like to ask them now because they do relate to both the visas and the border force and directly relate to some of your opening commentary. On the 22nd of October, Mr Morrison stood alongside the New South Wales Premier and the Qantas CEO to announce that Australia's borders are starting to reopen. But I did notice that the Home Affairs Minister, Andrews, did not use the same language in her media statement on that day. There's a little bit of confusion in there. Minister Andrews simply stated that from the 1st of November, the government would expand exemption scheme so that parents of Australian citizens and permanent residents can apply to come to Australia. Can you confirm what the exact extent of that 1st of November announcement is? And, you know, is an exemption form still needed to be completed? And do they need to prove their relationship? So what's the full extent of that?
Senator, I just would seek some guidance from the Chair. She's given me some guidance in the past, so it'd be remiss of me not to check again. Typically, while, as the Senator points out, these matters straddle a number of programs, typically you've guided me, Madam Chair, previously to confine myself to management and budget issues, typically, and things like legal expenses and the like under general and corporate. And then when we've got the benefit of other witnesses at the table, you've typically directed the questions. Now, in this case, the bulk of the Senator's question would relate to 3.2, which is border management. It is the case that it touches on visas as well at 2.2, so I'll just seek the Chair's guidance as to how I should proceed.
Well, look, I think it more properly sits in outcome 3. Obviously, this is a general matter.
Can I just make a point?
Senator Grogan, are you in a position to return and ask these questions in outcome 3?
Yes, however, I do think that we potentially miss some of the elements that will fall into outcome 1 and we'll end up at the end of the day saying, sorry, those people aren't able to answer those questions because they've already left. I wonder if we could just try and explore some of this, because there is a point of confusion between what Minister Andrews has released in her statement and what we see on the website.
I'd suggest the question of a distinction between the language used in both is a matter that is squarely within outcome 3. If there was something arising from Senator Grogan's questions that went to matters of budget, for instance, then that might be a logical course. But at the present time, it sounds like something squarely for Program 3.
Yep. Senator Grogan, I do believe that it does sit properly in Outcome 3, and particularly when all the relevant officers, because of our COVID safe requirements, are not necessarily in the building. If we could return to that matter in Outcome 3, that would be most appreciated. Do you have any? Yes, Senator Keneally.
Labor senators as well as other senators to understand, is it your determination that only matters relating to budget specifically?
Well, generally
can be asked
matters
in cross-portfolio,
well,
because then we can all plan a bit more.
Generally,
quickly.
cross-portfolio relates to corporate matters, budget matters, and other general matters that don't fit within any one of the other designated outcomes. So that's probably the best way that I can explain it.
I do understand from the clerk that it is possible to ask about things that the witness touched upon in their opening remarks, and the Secretary did touch upon and mention the announcement with the Prime Minister and the Premier of New South Wales. But if it is your determination, and if the committee agrees that we won't canvass other issues besides corporate matters in cross-portfolio, that would be useful to know if that's the will of the committee.
Well, it just is constructive in terms of obviously not having the right officers in the room or available at the right time. So that's the reason that we divide the estimates program up as we do. Obviously cognizant, if you're able to return Senator Grogan and ask those questions in Outcome 3, that would be very much appreciated. Do you have any other questions that relate to corporate matters or cross-portfolio matters?
Chair, I might indicate from a Labor perspective, we would be quite happy to move straight to Outcome 1.
Outcome 1?
That is the will of the committee.
I will just check, do any other senators have any matters to raise in cross-portfolio?
Well, I wanted to, I'm not sure where in Home Affairs my questions are, so I wanted to ask them here.
Yes.
And if I get told elsewhere, then I will take that advice.
In fact, Senator Rice, I would like to do the same after you go ahead though.
All right, we'll just check. So Senator Rice, if you could, I'll give the call to you, and if you could just be cognizant of the scope of this part of the program, which relates to cross-portfolio, corporate and general matters.
Okay, so my questions are about the over 60 Australians, including 40 children who are languishing in appalling conditions in northeast Syria in the Al Hol and Al Hoj camps. I have previously asked questions about these people in Foreign Affairs, and there have been a range of aspects of those questions that they have told me were better suited to Home Affairs. So I want to bring them to you
That's
here.
very kind of them too.
That's right. So, and given that you come before Foreign Affairs, it's important that I get the opportunity to ask you. So they're some of the questions that I want to ask. Can I ask them here?
Well, Senator, it's not for me to restrict what you ask, but in terms of where that typically would be located, those matters would typically arise under 1.4, which is counter-terrorism.
Well, I mean, not strictly counter-terrorism, but is that where you want to respond to them?
From our point of view, it's about counter-terrorism. It's about people who have gone overseas to fight, or their associated family members, and potentially pose a threat to Australia from the point of view of terrorism.
Okay, all right. Look, I'm happy to ask them in one.
Any other questions in relation to cross-portfolio before we go to Outcome 1?
I just would like to check, Chair and Secretary, I want some guidance on where matters should be raised. Earlier, Senator Ciccone asked about the AFP, about the cash for visas scandal, where the ex-boyfriend of former New South Wales Premier Berejiklian had quite a side hustle going on, where he sold visas for cash and got paid for it. Where should we ask questions about that?
Typically, Senator, that would be a visa enforcement matter, so 2.2 would be appropriate, and to the extent that our border enforcement colleagues who would appear under 3.4, we'll just manage that in terms of their attendance, because it's a COVID safe issue that the Chair referred to, but
Sure.
My recommendation to the Chair would be perhaps to start that line of questioning under 2.2.
2.2, yes, under visas.
Now, last estimates, I asked questions about the Queensland LNP and receiving tens of thousands of dollars in secret donations from senior executives and associated entities of Canstruct International, a Brisbane company awarded $1.4 billion contract by the federal government in late 2017 to provide welfare and garrison services on Nauru. If I wanted to return to that, where would that be?
Well, leaving aside the question of donations, but in terms of the Canstruct contract, we've typically dealt with that under IMA offshore management, which is to say 2.4.
2.4, great. Last estimates, I also asked questions about the community safety grants, which frankly appeared to be more about the electoral safety of the government. Where would I ask those questions about community safety grants?
That falls under national security and criminal justice. The law enforcement element comes under community safety, that is, falls under criminal justice, so 1.2.
1.2, great, thank you. And recently the Auditor General confirmed what I've been trying to establish for some time, that there are big problems with the Morrison government's maritime surveillance program, and including that there's not been a single month where maritime surveillance has been completed as planned. When will I ask about that, Mr. Pizzullo?
Border management and border enforcement 3.2 and 3.4.
Great, thank you, Chair.
Thank you very much, Senator Keneally. So if there are no other questions from senators in relation to cross-portfolio corporate and general matters, confirming, we will now move to outcome 1. And Senator Grogan, do you have any questions in relation to outcome 1?
Senator Ciccone.
Or just
Ciccone, I think.
Chair.
All right.
Yeah.
All right, I will give the call to Senator Ciccone.
All right. Thanks a lot, Chair, and good to see you again, Mr. Pizzullo.
Senator?
Now, could I just ask some questions with respect to the AML? Why did the department lead Australia's delegation to the February plenary of the Financial Action Task Force rather than the AML regulator, AUSTRAC?
Well, to the extent that the matters in question related to policy, legislation, regulation overall, and that's the department's responsibility. The regulator, as I think I intimated when AUSTRAC were appearing, administer the legislation on a day-to-day basis, but policy responsibilities for those matters fall to the department. I can't recall to mind the specific meeting in question, and it almost certainly would have been some sort of joint activity, but in terms of leadership of the delegation, it's really a matter that falls to the Department of State.
Has the department usually gone to those type of meetings, or has the regulator?
Well, I believe it's been a combination. It really depends on the nature of the, and I'll ask Mr Ablong or one of his colleagues to join me just to clarify anything that I might misstate, but it would depend typically on the nature of the meeting. It might be a subgroup that's very technical in nature, in which case the financial intelligence units would typically meet together. But generally speaking, policy questions are matters for the department, and prior to the establishment of Home Affairs in December of 2017, that would have fallen to the Attorney General's department, and then there might be some other plenary or sub-plenary activities that are much more technical in nature, which typically are for AUSTRAC and its counterparts. But Mr Ablong, can you shed any light on this question?
Thank you, Secretary. Mark Ablong, Deputy Secretary, Strategy and National Resilience. As the Secretary has said, it's the Department of State, the Department of Home Affairs that leads the delegation to all FATF meetings at a national level. The Secretary is right, there are a number of working groups where specific items like cryptocurrencies or other matters are dealt with by the experts, but the plenary sessions and policy discussions are always conducted by the Department of Home Affairs.
Were there any representatives from AUSTRAC?
There were, yes, Senator.
Okay, so the department went along as well as AUSTRAC, not just the department.
It was an Australian delegation, so it had membership from both the department as well as AUSTRAC.
Anyone else?
I'll take that on notice to tell you exactly who was in the delegation for that February meeting. I just don't have that information on hand with me.
So what's the status of the Tranche 2 legislation?
Senator, as was canvassed earlier today, the government is currently involved in looking at the nature of the regulatory burden that applies to entities that might be picked up in Tranche 2. That's not a simple activity. It would increase the number of entities that are covered by the AML-CTF legislation from around 13,000 to over 100,000, and would include entities that are sole traders as well as large multinationals. And so there is an activity underway at the moment to understand what the cost benefit is of that regulatory requirement, how we might deliver what is the intent of the tranche 2 in ways that might not require a legislative solution. So is there a way, as Ms Rose mentioned earlier today, that better guidance to entities would provide them with sufficient information for them to understand what they might do, rather than requiring a legislative solution.
So as part of that analysis, looking at not legislation, but some other form of regulation?
Indeed, Senator, and particularly now with the Australian economy looking to reopen and many Australian entities being suffering from the effects of COVID, we're very conscious that we don't want to put additional regulatory burden on companies while they are seeking to re-establish themselves. So we are currently investigating ways in which the intent of the AML-CTF regime could be applied without the need to regulate those entities. We have not come to any conclusions on that yet, and we have not provided any advice to government on that yet.
So without legislation, how do you then expect to, I guess, counter any of that anti-money laundering?
Well, as Ms Rose said, there is a number of ways in which the current entities that essentially are responsible for the movement of cash or money are provided with information that allows them to identify when there is a suspicious transaction and to make the appropriate connections through intelligence systems to law enforcement. So irrespective of whether the facilitator of a transaction is a real estate agent or a legal firm, essentially it involves the transfer of money, and the transfer of the money is dealt with principally by financial institutions.
Was it the case that Australia was criticised at the February meeting for failing to meet international standards on, for failing to meet our international obligations or standards?
Senator, I don't have the transcript of that meeting with me, and I can't recall off my head, so I'll take that on notice.
Was there anyone here that attended that meeting?
There is not anybody here due to the COVID restrictions. The staff are not here, but I'll see if I can get that information to you before the end of the evening.
Who was the most senior official that attended?
It's a band one. An assistant secretary is the head of the Australian delegation.
So does the department have any visibility on the task force's fourth round mutual evaluation follow-up assessment?
Yes, of course we do. The Financial Action Task Force and each of the nations that go through these evaluations, that's a process of negotiation. We were expecting Australia's evaluation to occur in early 2020, then COVID came along, and the Financial Action Task Force has ceased all country evaluations for the period of time that the COVID crisis is running, because they just can't get the relevant officials into jurisdictions to be able to do that evaluation.
So you actually need people to come here physically?
That's correct, Senator.
Is it not the case that other countries have also had follow-ups since?
There was a series of follow-ups that was started. Each country usually goes on a 5-year basis, and all of the countries of the Financial Action Task Force go through it on a regular basis. We were due ours, but a number were started before COVID took the impact that it did, and those assessments were continued, but it was a decision of the Financial Action Task Force not to commence any during the COVID crisis.
I understand the task force has, I think, recently grey-listed Turkey. Is the department concerned that Australia's ongoing non-compliance with a number of requirements, I think R22, 23 and 28, could also expose us to the risk of being grey-listed by that task force?
Senator, the process of grey listing is one that we are aware of. We work with both the task force as well as the authorities here in Australia to determine the best method of achieving the impacts of each of the requirements of the Financial Action Task Force. If there is continued non-compliance, yes, you might end up being grey listed, but there are a number of extenuating circumstances which are usually taken into account. The Financial Action Task Force looks at not just the nature of your regulatory and legislative regime, but the way in which there is cooperation between regulated entities and the authorities, the intelligence systems that operate, as well as a number of other things. So, while grey listing is the process that occurs when you have failed to meet the requirements and they do not see you being able to mitigate those requirements, that's a fairly long process to get grey listed.
And I guess one of the, costs would be high cost of capital for Australia as well too, would it not be?
Potentially, if a grey listing was to occur, then it does impact on financial institutions' risk rating and what they might then determine they would require in terms of the cost of capital. That is one of the potential outcomes of a grey listing.
Have you provided any advice to governments?
We have provided advice to government on the Financial Action Task Force process, where we are in respect to our requirements under the Financial Action Task Force, and advice on the tranche process for AML-CTF.
And the implications?
Yes, our advice usually canvasses both implications, sensitivities, etc., etc.
All right. And if legislation was to come to the Parliament, then is there an expectation of a certain date or time frame you have in mind when that might be finalised?
Senator, that's a matter for government.
Okay. Thank you very much, Chair.
Thank you very much, Senator Ciccone. I will now give the call to Senator Van.
I have some questions under 1.6, emergency management.
I'll ask the Director General to join us if he's here.
My understanding was that Senator Mackenzie was going to attend to deal with emergency management. I beg your pardon?
Was there a particular time that she was going to be arriving at the table?
Would you indulge
Assisting
me
Minister?
to check in with her and see how Minister Mackenzie's going? Sorry, Senator.
Look, I think...
Yeah. From the chair, is emergency management in outcome one?
Yes, it is.
Yes,
1.6.
yes.
Thank you.
Yes, I appreciate, obviously... Well, what we might do is...
if it's okay, I might just check.
If you check in, and Senator Van, if you wouldn't mind if we just put your questions on hold in relation to emergency management, we might go to Senator Rice, if that's okay, and then we could come to Senator Van up to Senator Rice. Does that work?
Sure.
Given your other, I know you've got other commitments too.
All good.
All right, terrific. Senator Rice.
Thank you. And look, as flagged, so my questions are about the over 60 Australians who are in the Al Hoj and Al Hol camps. And again, some of these questions you may say are foreign affairs questions, but I think there is overlap. So we've got, in May, DFAT officials indicated that the government would consider repatriation of Australian women and children from detention camps in north-east Syria on a case-by-case basis. And since then, I'm aware that Save the Children have provided details on 3 separate cases of children who are suffering from severe health conditions, including untreated wounds with pieces of shrapnel lodged in their head, severe malnutrition, 11-year-old who's got an untreated shrapnel wound. So what action has been taken to address these urgent medical cases?
I'll ask Mr Kefford, who's the CT coordinator, along perhaps with Mr Feeks, to join me at the table. I'm familiar with that evidence, and it is the case that as a matter of policy, the government's willing to entertain repatriation on a case-by-case basis. It does fall within a more general policy direction from government that unless agencies come to a view that it's operationally feasible and safe to do so, in other words, to undertake a repatriation, then no repatriations are to be acted upon. We haven't returned to government. In fact, and you're right, Senator, it's a jointly shared responsibility. DFAT have got the lead on the consular and looking after the interests of Australian citizens overseas. We've got the counter-terrorism brief, so together we are jointly responsible. We haven't yet returned to government with any contrary policy advice, which is to say that the conditions are not appropriate for repatriation. So when officials put that advice back to government, then we'll be in a position to consider cases in their specificity. But Mr Kefford, as the CT coordinator, you'll work this issue more closely than I do. Have you got anything to add to my answer?
Thank you, Secretary. Andrew Kefford, Deputy Secretary, Social Cohesion and Citizenship. Senator, we are aware of the cases to which you're referring. Obviously, we'll be careful about how much detail we share in a public forum. Without departing from the Secretary's evidence just now, we have had meetings with Save the Children recently as the last couple of weeks in relation to those matters, but they're all subject to the broader considerations of security, including for Australian consular officials in being able to access the camp to support any repatriation activity.
Okay, look, I'll get to that, the security and the ability to repatriate. But first of all, just on sort of the background on these cases, I mean, so you said you've met with Save the Children, and through that or otherwise, have the department sought any further information on the cases and welfare of those Australian children?
Senator, the issues canvassed, and it was with also, Mr Feeks will correct me, with at least one family member in Red Cross as well. So yes, there was gathering of information, I would describe it, but again, all subject to the broader security considerations about what we would, at what point we might be able to move.
Okay, so that gathering of information, have any Australian government officials visited the Al Hol Al Roj camp since I asked questions in estimates in May?
Not that I'm aware of, Senator, but I'll just check with Mr Feeks.
Senator Richard Feeks, First Assistant Secretary, Counter-Terrorism Coordination Centre. No, as Mr Kefford said, not that we're aware of.
Okay, so you're certain of that?
I'm not aware of any, certainly no consular officials.
Okay, so it's contrary to other advice that I've been given that...
Well, Senator, we'll take it on notice. The answer that I've given and Mr Feeks has given is that neither of us are aware of that happening.
Okay. In going to the conditions that you make it, you say that it's unsafe. We know that other countries are repatriating their citizens and that the Kurdish authorities want countries to repatriate their citizens. So, I mean, can you give me a bit more detail as to why at the moment the position is that it's not safe for Australia to do that?
Well, Senator, it's something which, as I indicated, the Secretary of the Department of Foreign Affairs and I have been charged jointly to re-examine. I wouldn't want to get ahead of that re-examination. Safe to say that we're working jointly with the Department of Foreign Affairs and Trade. Should officials, and the two departments will confer with other colleagues across the Australian government, should officials come to a view that's different, that would change the settings, we would advise government first.
So what will have to change? Because I'm aware of the evidence that you've previously given, and my sense is because other countries, and we've had the US offering to help, other countries are repatriating. What needs to change for Australia to repatriate?
Well, we're familiar with the experience of both the US inclination that you've just described and also the experience of European partners, and we're speaking to them. But as to what specifically would need to change, until I confer with my colleague, the Secretary of DFAT, I'd prefer for those discussions to be held amongst officials first so that we can confer without any kind of public positioning of our advice, and then we'll go to government.
So, and what's your expected timing on consideration as to whether...
It's actively being looked at the moment.
And what, so within a month?
I'd rather not put a time frame on it because I don't want to prejudice the course of those discussions.
So meanwhile, you're happy for these Australians to be living in what the UN have described as torturous conditions.
I'm not sure if you asked me a question or you simply made a statement, but I'll choose to.
Perhaps in the category of commentary, Mr. President.
I suspect it was commentary.
Okay. So there was a response. I mean, the UN experts sent the Australian government a letter about repatriation, and in response, the Australian government stated that the Kurdish authorities are only allowing the repatriation of foreign children, specifically unaccompanied minors, which contradict statements made by the authorities, who continue to urge states to repatriate their nationals, including adults. So, I mean, what can you, in terms of that contradiction, can you comment on that?
Well, Senator, I'd ask you to assist me. In whose name was the response couched? I can't speak for, unless an officer of my department gave that response. I'd prefer not to speak for positions adopted by other persons. So when you say the Australian government responded, which element, if I might ask, just by way of clarification, Senator, provided that response?
I will have to pull that up on my...
Thanks. Just to assist me with understanding
I haven't got
how best
the
to
information
respond.
to hand. My staff may be listening in and
Thank you, Senator.
tell me.
I appreciate that. Thank
Yes. So I will get some information as to who exactly has responded, but I've been told that it contradicts the statements who are urging states to repatriate their nationals. So can you tell me what specifically that the Autonomous Administration of North and East Syria has advised the Australian government on this matter?
Mr Kefford, are we, noting that we do this jointly with DFAT, but are we specifically as a department, but you've also got a role as the CT coordinator more generally, are you aware of any facts that could assist in answering that question?
I'm not Secretary, I'm sorry.
So we'll take it on notice.
Okay. And whether the government has raised the contradiction. Look, actually, could I have 5 minutes to, if
Yes,
you could
so
go to
why don't
somebody
we-
else and I will get the details
Yes,
of
thanks,
that
Senator
response.
Rice. That would be
probably
terrific.
easier. If you could come back to me.
I'll come back to you. I'll now go to Senator Van.
And are these questions for the EMA?
Yes.
Can we briefly suspend so that I can get Senator Mackenzie to the table?
Well, while you need to suspend or just to make those arrangements?
Just to swap.
Yeah,
people
all right.
to the
We will suspend and we'll resume in a minute or so. Thank you.
And I might have my details.
Senator Rice.
I'm comfortable.
And then is Senator Mackenzie coming to the chair or you're not sure? Table or you're not sure?
I beg your pardon?
Is Senator Mackenzie coming to the table?
Senator Mackenzie's on her way. Yes.
On her way, okay.
Okay, so it was a letter to...
Sorry.
Oh, sorry.
The committee is now in session and I will give the call back to Senator Rice to continue with her question. Senator Rice.
Thank you. So this was a letter to the Ms Beatrice Balbin, the Chief Special Procedures Branch, the UN Office of the High Commissioner for Human Rights, and it was from Sally Mansfield, the Ambassador and Permanent Representative of the Australian Permanent Mission to the Office of the United Nations and Conference on Disarmament. And in that letter, which was 23rd of August, the Australian government understands that local authorities administering the camps are not permitting repatriation of any other category of individuals at this time. So basically saying that the only individuals who are being repatriated were unaccompanied Australian minors.
If that's a communication from Her Excellency the Ambassador, I would suggest that you pose that question to our colleagues at Foreign Affairs, Senator.
Okay, so can you tell me anything else of the information that Home Affairs have in terms of repatriation of adults as well as children?
I'm both familiar with reports of repatriation of adults undertaken, I think, typically by European nations from memory. I'm familiar with our engagement with both UN organs as well as with, I'll use the shorthand Kurdish authorities, but all of those activities are led by the Department of Foreign Affairs and Trade, and I would ask that you ask that question of them.
Okay, and so in terms of the revised position that's being put to government as to whether to allow further repatriation, that's a joint position from Home Affairs and Foreign Affairs and Trade.
So the Department of Foreign Affairs obviously has regard to a person's citizenship status, their right of return to Australia, the potential for offences to be an issue. There's legislation around temporary exclusion. There's legislation around citizenship cessation. So that's, if you like, on the domestic side. And then in terms of engagement with whether it's the autonomous authorities, whether it's UN bodies, whether it's with other like-minded, that's a question for DFAT. All of that advice, I can assure you, Senator, will come together. We don't hold information back from one another, as well as that which we can gain through intelligence and other colleagues. All of that will be canvassed by the two departments, I can assure you.
Could I just ask, in my final questions, in terms of reasons as to which have been given previously about why we couldn't repatriate, and one was that we didn't have a consular presence in Syria. So do you consider that lack of a consular presence really is an insurmountable barrier to repatriation?
Our department doesn't manage consular activities around the world. That question is better posed to the Department of Foreign Affairs and Trade.
Okay, and do you have a role, or again, as at Foreign Affairs, in terms of the understanding of the legal basis for the ongoing detention of Australian citizens by the Syrian Democratic Forces?
That would be a matter for the Department of Foreign Affairs, to the extent that it related to consular assistance or consular issues around Australians abroad.
Okay, thank you.
Thank you.
Thank you very much, Senator Rice. I'll now give the call to Senator Van, and
I will give the table to Minister Mackenzie.
thank you very much. Don't take the table with you, though, will you, Minister?
Chair, can I just also clarify with respect to the next flow of questions?
So welcome to Minister Mackenzie. So we'll go to Senator Van, and then while Minister Mackenzie's here, we might go to Senator Watt.
That would be great.
And then Senator Molan has indicated he also has emergency management questions as well. So if I suggest Senator Van, Senator Watt, Senator
We'll try
Molan.
to deal with emergency management.
We'll try and deal with that in one block if we could.
Right, okay. And then I deflag, I have other sets of questions.
And then you've got other sets of questions in outcome one.
Yes, thank you.
Senator Van.
Minister, welcome to the table.
Great to be with the committee.
Great to have you here. A key finding of the Royal Commission into National Natural Disaster Arrangements was that the Australian and state and territory government should develop a national aerial firefighting capability. What has the government done to deliver on this recommendation?
Oh, sorry, Senator. I've been in another area.
Is that a question?
Is it for
specifically to the minister?
To the minister or to the emergency management? Can I call Joe Buffoni?
It could be probably Secretary if you'd like to take it.
I think it'd be great if Joe could come.
I'll ask the Director General to join us, and if we need to refer any matters to the minister, then of course, as the standing orders allow, we'll do that.
Yeah, thank you.
So the recommendation, Mr. Buffoni, that relates specifically to aerial firefighting.
Yes.
And particularly the recommendation of the Royal Commission.
Good afternoon, Senators. Joe Buffoni, Director General of Emergency Management Australia. In relation to the recommendation of the Royal Commission, at the time the government noted the recommendation and then noted that the current arrangements that were in place were suffice to actually deliver against that recommendation. However, since that recommendation, there has been significant effort that has gone into aerial firefighting. And it's probably worth putting a bit of context into the arrangements within the nation on national aerial firefighting. The first is that it actually does rest with the states and territories through the arrangement through NAFC, which is the National Aerial Firefighting Centre. And it is the states and territories that determine the type of aircraft, the quantity, their location. The second point is that following that there has been significant investment from the Australian government into the National Aerial Firefighting Centre. So that has been increased initially by $11 million. So that takes it up to $26 million, still not being specific around the type of aircraft, the operational deployment, etc. A follow-on from that, in fact, on the 5th of September this year, there has been, the only variation to that is that there has been a commitment of $4 million specific for a large aerial tanker that will be a national large air tanker that will then cover for the overlap of seasons with the Northern Hemisphere and the Southern Hemisphere, and also for the early starts and late finishes. So that's currently being sought and should be in the country by December. The way the arrangements work, though, is that there is actually significant aircraft that are actually provided by Australian companies, so that's the sovereign context. And the other thing that we are shaping within the guidelines is that the investment from the Australian government actually provides opportunity for Australian companies to build that capability, however, not impacting on the capability itself. So just managing that. So looking forward for this season, there is 142 aircraft that will be sought through the National Aerial Firefighting Centre for this high-risk weather season. And again, noting that it is the Commissioners and Chief Officers and the states and territories that determine the type of aircraft, their location, the deployment, based on risk and based on the outlook from the Bureau of Meteorology. I'll just stop there, Senator.
Thank you very much, Director General. On Saturday, the 23rd of October, my good friend Labor Senator Christina Keneally posted on Twitter and Facebook suggesting that the Liberal and Nationals government have not funded aerial firefighting capacity. Given the answer that you've just given us about the record investment from this government, would you say that this statement from Senator Keneally was factually untrue?
I just feel a need to intervene. The Director General's laid out some facts. I'd very much be reluctant for my officers to get into a shooting match between members of Parliament. Whether it's adequate, whether her statement, is appropriate, it might be a matter for the Minister, but Mr Bafoni's laid out the facts.
Sure.
I would really be reluctant for him to engage in commentary
I accept that. So,
on what a shadow minister or indeed a member of Parliament has said.
I accept that.
Thank you.
Well, I think on
Minister,
that point,
if the Minister might wish to...
Well, thank you very much,
Thank you.
Secretary. I think Mr Bafoni absolutely laid out the facts that our government has not been shy in actually stumping up to ensure that we have the capability here at home, particularly for those shoulder seasons, now that we see the extension of the fire season at either end, meaning that we usually lease that capability from overseas. So there is now a sort of an overlap, both at the start and the end of our traditional bushfire season, that having that capability here on the ground, ready to be deployed when and where required, and in response to Fire Chief Commissioner's requests, I think is incredibly important. And our government does not shy away at all from our commitment to protecting Australians through these difficult times.
Thank you. So, Minister, in your view, was that statement untrue, factually untrue?
Well, the facts are we've put $4 million on the table to get the National Aerial Firefighting Centre and the large air tanker procured. We've also put up an additional, that $4 million is in addition to the $26 million that we give to the National Aerial Firefighting Centre itself. And so for anybody to be claiming that we aren't doing our bit and that we don't take this seriously and that we're not funding appropriate infrastructure and capability is simply wrong.
Thank you. Because of our government's record investment, does this mean that we're better prepared for bushfires this season?
Absolutely. Yes. I'm now better prepared too. Absolutely, we're going to be better prepared. And I think what we've seen over time is through the work of Emergency Management Australia, we've really built an integration between state and territory emergency management ministers and fire services, emergency services more broadly, and the federal government. We've been able to have a much more collaborative approach, I think, which means we can respond where we're responsible swiftly. Yep. And indeed, my own relationship as the emergency management minister with my other state and territory colleagues has gone from strength to strength. We've been meeting regularly, briefing each other on challenges in the upcoming high-risk weather season, and I'm confident that we've got each other's backs as we head into that.
So, Minister, what else is the Commonwealth doing to prepare for the bushfires over the coming season?
Well, we've got a range of programs. We've got the hardware coming, as Joe says. We're also regularly meeting with officials. One of the issues, I think, from the last bushfire season, particularly with the issues around COVID border closures, was actually making sure that state and territories allow not just emergency services personnel, but telcos, health workers, etc., other support workers that you need to recover and respond to an emergency, whether it is a tornado like we've seen rip through, for instance, Barnaby's electorate recently, bushfires or floods. So we've been working with state and territory governments to facilitate the movement of appropriate personnel as required. But Joe, do you have other things you want to brief the committee on?
Yes, Minister. We've been running a series of preparedness briefings and exercises across the country. To date, we've ran 23 specific briefings. That's with states and territories, private sector, charities, government departments. And what we do is we give the outlook from the Bureau. We then talk about the changes within the Australian government, which includes enhancements to EMA. It also includes the establishment of the National Recovery and Resilience Agency that is very focused on relief and recovery. And then we actually even do a live poll to get a sense of how prepared the country thinks that they are. And this is from the chiefs and generally across the board. There is a sense of that they are well prepared. Now, obviously, it depends on what nature brings at the time, but in terms of preparedness, in terms of exercising, we're relatively confident. We've also ran a specific exercise on the National Emergency Declaration legislation with the Australia-New Zealand Emergency Management Committee, so that we can step through that in a pure in a process sense of what the thresholds may or may not be, and that has been scenario-based. So we've done a fair bit of work in establishing that. As the Minister said, in relation to the protocol, that was established last season. Now, there is no unilateral exemption in relation to crossing borders because, as we're all aware, we're operating in the Federation and the health orders rest with each state and territory. But we've done a lot of work on streamlining that, which was used last season. And as the Minister has stated, we have included relief personnel, recovery personnel, insurance assessors in that protocol, and it's just going through the processes to be signed off as we speak.
Thank you, Mr Bafani, and thank you for all your effort on that. Thank you, Chair.
Thank you very much, Senator Van. I'll now give the call to Senator Watt.
Thanks, Chair. I don't have too many questions here. I'll have some other disaster management ones this evening for the NRRA in another committee. Just on the aerial firefighting point, so you were saying that the new money that has been allocated by the federal government, effectively that will be used for a new air tanker that will become available in December?
Correct.
Yeah. So that obviously won't be available for those states and territories whose bushfire seasons start earlier than December.
For this year, Senator, there was a large air tanker, through those arrangements in Queensland, which was established.
That's the one the Queensland government fully funds.
Oh, it's still through the National Aerial Firefighting Centre. I mean, as we said, the government doesn't specify where that money goes, but for the $4 million specific to the large air tanker, starting from December, it will then be available for Queensland, Northern Territory, WA in the northern fire season, because that generally starts earlier. So that will be available nationally.
So will it be in Australia's possession for 12 months of the year, every year?
I can't give you the specifics on that, but it will be available for the majority of that period, yes.
So it will become available for particularly areas in Northern Australia, which have earlier bushfire seasons, earlier than December in future years?
Absolutely.
Right. What about helicopter? It seems to me that helicopters is possibly still an area where we don't, as a nation, have access to the number that we need. They can obviously be used in a different way, and it's been put to me, while they may not have the carrying capacity in terms of water or retardant of a large aircraft, they can get in and out more quickly than a big tanker, which can only be filled up at certain locations. What's our national fleet in terms of helicopters?
The advice that I have at the moment in relation to helicopters is that the chiefs and commissioners are comfortable with the arrangements. As I said, the National Aerial Firefighting Centre determines the mix, and that is a mix of heavy airlift helicopters, so rotary wing, as well as LATs, as well as a range of others. And it's a blend of what the states fund, and then the contribution from the Commonwealth is then dispersed by the National Aerial Firefighting Centre. The only prescriptive funding that we have provided is the $4 million for the large air tanker. So it still rests with the states and territories and the chiefs to determine that mix.
There's about 156 aircraft, isn't there?
Yeah, there's 143 in total that are delivering 157 services, including rotary wing
helicopters.
Helicopters, yes.
Right. I just want to turn to preparation for the coming disaster season. Can you just give us a really brief synopsis of what it looks like we're facing in terms of disasters this season?
Yeah, absolutely, Senator. So with La Nina being on alert, that means that there's probably about a 70% chance of that occurring through summer. So in a
7 or 70?
70. Yep.
70% chance of La Nina or
La Nina, La Nina. So basically what that means is above average rainfall, higher risk of flooding. The interesting thing around fire is that in particular Western Australia, South Australia, parts of Victoria, because of the rain means that you get more grass, more crops. So there's a higher risk of grass fires, which are very, very different from traditional bushfires. Fast running, very, very quick, and if you think about that mixed with lightning strikes. The other thing is there's also an increase as we move through the season into January, February, March in particular, an increase of tropical cyclones, a chance of tropical cyclones as well. So if you think about it, it's an eclectic sort of season with higher risk of flooding, higher risk of severe weather, higher risk of grass fires in certain areas, but not widespread, and then a higher risk of cyclones.
And in terms of the flood risk, particularly coming from cyclones and other heavy storms, is that flood risk particularly in the north of the country, or is it in other areas as well?
Senator, it's pretty much across the country. So through the north initially, and then through the east coast as well. And a lot of our scenarios have been based on that outlook.
You mentioned in your answer to Senator Van some of the work that's being done to accommodate issues which also arise because of COVID restrictions. Yep. Can you just give us a quick overview of what you're doing differently to prepare for this disaster season because of the additional issues related to COVID?
Yeah, absolutely, Senator. So as I said, the main focus for us is the national protocol, which is for emergency services and essential services as well. And what we've done is we've recategorised the essential services so that it's explicit around people that will go into support relief, early recovery arrangements, insurance assessors, tradespeople that are making safe, in that period. So, and then obviously that's lining up with the national plan so that as there are changes and as as vaccination rates increase, then we will align to that arrangement. The key thing here is that what we're doing is streamlining the discussions, and everybody is aware of the requirements between the requesting jurisdiction and the responding either jurisdiction, agency or organisation. So we've ran a national coordination mechanism with states and territories and many other stakeholders to step through that protocol, and we're just refining the administrative elements of it as we speak.
Mm-hmm. Because of course, as you well know, natural disasters don't respect state borders. There are many, many times when interstate personnel are called on to assist with a disaster in another state. To what degree do you expect either border closures or lockdowns, localised lockdowns, as a result of COVID outbreaks to interfere with disaster preparation or response?
I can't comment on the specific lockdown question, but what I can do is look at what we did, for example, for Tropical Cyclone Seroja. There were lockdowns at that particular time. There was different arrangements in each state and territory. So what we do is we bring together the commissioners and chief officers. I actually chair that committee, and then we discuss where the support is required from, and then the jurisdiction makes the decision around where they will accept or not. The chiefs, though, have given a commitment, and obviously depending on the risk. So if you've got, if we have a catastrophic event, then there's a balance between the risk of COVID versus the risk of not allowing people in to actually respond. So it's through a risk lens rather than a procedural lens. So it is designed to be adaptable, flexible, and basically to align as we adjust. I mean, what we're hearing, and we're obviously taking this into account, is we're expecting to have more localised, impacts of COVID rather than the broad COVID. And as you're aware, Western Australia had very, very strict border controls, but we still got a lot of support with a COVID overlay into Western Australia very quickly.
Mm-hmm. So, because of course, even under the national plan, there is still the potential for both border closures and more localised lockdowns. But you're satisfied that arrangements are in place to ensure that that wouldn't become a problem in terms of disaster prevention or response?
Senator, we've done everything that we possibly can within the confines of the Federation and the Constitution and where the health orders sit, but we have done everything we can to streamline and support a requesting jurisdiction to get support in, whether that be from states and territories or from the Australian government.
Mm-hmm. Minister, I know you just today responded to a letter that I'd written to you about these issues. It must have been as if you expected me to ask for that response.
I just collected my in-tray and was working
Funnily
my way
enough,
through
there
it
it was.
in another committee this morning.
You're probably aware, Minister, then, of a report that was released by the Insurance Council of Australia last month calling for a national approach to natural disaster recovery in light of COVID restrictions and border closures. You're aware of that
Yes,
report?
I am aware.
And I think specifically the issue that the Insurance Council was raising was the risk that due to border closures or lockdowns, it might be difficult to get insurance personnel or tradespeople in and out after a disaster for repairs and recoveries, What's being done to act on those issues?
Well, I think you've just heard the Director-General talk about how we have been working with state and territories, and I think it's a really great example of everyone putting down their tools and working towards a great outcome. As you said in your opening comments, natural disasters don't respect state borders, and they don't respect which political party is in control either. And so this is the one thing I think where we have absolute bipartisan agreement, and the state and territories have all agreed not just to let emergency service personnel to cross borders when and when they need to respond, but also, to your point around the Insurance Council, tradesmen and women, telco service providers, etc., to get electricity, those that work on actually getting the electricity network up and running again after a natural disaster as well. That's critical to get a community back on their feet and for the recovery to begin in earnest.
Okay. Just finally, a couple of quick questions about funding that was provided to EMA in this year's budget. So it included a commitment of $90 million over 4 years, including $15.2 million in capital funding for, quote, key enhancements to EMA's operating model. Can you just outline what this year's allocation of funding for EMA's enhancement has gone towards so far? Mr Buffone?
Yes, thanks, Senator. To date, the funding has gone to aligning the staffing model to the changes. It's also gone to establishing a national joint common operating picture, which is effectively a single portal that will provide a national picture of what is occurring, what the incidents are, and we will have a minimal viable product in place and operating by the 1st of November. That's where the majority of the effort is going. The second part is establishing an exercise capability that will then run a series of exercises at the national level for severe to catastrophic events. And to date, there's been a number of exercises already ran by that capability, including the one I mentioned for the Australia-New Zealand Emergency Management Committee.
Okay. So how many extra staff have been hired to undertake this work, and what capital works projects are underway?
Okay, so at this stage, the additional staff, I don't have the exact figure, but it's about, I think, about 20 additional staff at the moment, 20 to 25 additional staff, and that will progress over the 4 years. There are no capital works underway at this stage. It's all in the scoping and requirement stage. It's in the most of the investment is in this national joint common operating picture, which is about the technology, the platform, and the personnel to actually increase that. Some of it is also around some specialist capability. So we're shifting our capability so that we can actually do more analytics through that national, at the national level, so that we understand the consequences at the national level. So we've engaged some GIS specialists, some open source intelligence specialists, so that they can add to the technology.
Thanks, Chair. That's probably
Sorry,
enough.
Senator Watt, can I just give you a bit more information about the protocol that's being
Sure.
reviewed?
If the Chair is willing to indulge us.
Of course. Thank you very much, Minister.
Yes, thank you. Thank you, Chair. So states and territories were in agreement that the protocol provided nationally consistent guidance, and that it was in line with the opening up in response to the national plan according to vaccination rates. So we've gone out to state and territories. They've provided feedback, including that from the Insurance Council of Australia, to update the protocol. Then it'll be reviewed by the commissioners and chief officers before being tabled at AHPPC.
Thanks.
Thank you, Minister. And Senator Watt, thank you so much. I'll now give the call to Senator Molan.
Thank you, Chair. Almost all of my questions have been purloined by other people, Chair, which will give great joy to everyone. But, Director-General, thank you for your forecast. A bit more rain, floods, cyclones, grass fires. I guess what caught us unstuck 2 years ago was the simultaneity of the problems, and we've we've come up with one aircraft, the large air tanker, but we've got 142 or 43 other aircraft as well. Are there any other large air tankers in Australia at the moment? I think Senator Watt mentioned one, but my memory was New South Wales had one as well.
Correct. So there's one that's been in Queensland, and New South Wales have actually purchased a large air tanker.
Yeah.
So that was the Marie Bashir that's just returned recently from overseas in America.
Okay, and there are no others apart from those?
Not at the moment, because they are being brought on. So again, they are brought on based on risk. They're not just brought on at one particular time, so they'll be phased in on the needs and at the request of the operational chiefs.
How do you express then the overall risk, particularly of simultaneous fires, as we've seen them in the past in Black Summer as well?
Well, Senator, I mean, it's difficult to sort of foresee that, but what we are prepared for is concurrency. So that's
a better way of putting it.
Yeah. So that's something that we've been focused on. So the concurrent activity and the compounding activities that occur. So there are lessons from starting with the monsoon, floods, Black Summer, even last season we had concurrency. So a lot of our preparedness, a lot of our thinking is based on that concurrency. So in relation to fires, there's still a risk of concurrent grass fires, and the aircraft that are being sought are to suit that risk.
Yep.
So it's not just large air tankers, it's fixed wing, it's also the single engine air tanker, which are the seats, the crop duster type of aircraft, that are all part of the mix of capability.
Yep. And from I was a director of NAFC for about 4 years, as well as being a firebombing pilot. My memory was that when we had $15 million, we could do roughly 100 aircraft a year for the years that I was a director there. It's gone up significantly. If you're getting 142 for 26, that's not bad.
Correct.
And but then, is it not the case that there is much more money going into this than we're just seeing? Now we're seeing $30 million going into it. That's not the state's contribution, is it?
No, that's the Commonwealth contribution.
Yeah.
The states also contribute, and they also fund the operating costs.
Correct, and so the 15 plus 11 gets you 142 aircraft for an initial period of time, and then the states take over the funding of them as they're distributed.
Well, it's a contribution to that. It's not a fixed, it goes into the NAFC pool. So that 30 million, NAFC then determines how that is distributed across the states and territories based on the service chief's requests.
Could I ask then that we express the national effort in relation to aerial firefighting from a national point of view, Minister, because we continually say that we're putting $30 million in to get us 142 aircraft, whereas we seem to be putting a lot more in the nation into that effort.
Well, I think we need to be louder and prouder about our contribution, but simultaneously states and territories are very proud of their own firefighting services in particular, and we need to make sure that we don't tread on their autonomy at the same time.
Certainly. Yep. Thank you. Thanks, Chair.
Thank you very much, Senator Molan. Just for everyone's benefit, I think Senator Patrick is seeking the call, also in relation to emergency management, and then after then we might let Minister Mackenzie go. So I will give the call now to Senator Patrick.
Thank you, Chair. Just a couple of quick questions. You mentioned the New South Wales aircraft was in the US. I presume that was for their fire season. Is that what it went across there for?
Correct.
Okay. It's been put to me, and I've raised this in the Senate before, that a lot of Australian companies would invest in aircraft such that they could service Australia, but also then perhaps bring in export dollars, if you like, for conducting operations overseas in our off-season. But they can't do so because the contract periods for them to provide services are short enough that banks won't lend money to them. Obviously, we'd love to see Australian-owned aircraft operating here as a first priority, operating overseas. Is there any move towards addressing that problem so that we can see that sort of situation, where Australian owned aircraft are used?
So again, because of the arrangements and because of effectively, we put funding into the National Aerial Firefighting Centre. Through the grant agreement, we encourage that to occur, but it's actually the National Aerial Firefighting Centre that has to determine the length of the contract. So, because, the Commonwealth doesn't actually run the contracts. It's actually the National Aerial Firefighting Centre that does. So picking up on that point, our focus is to encourage the National Aerial Firefighting Centre to engage with the industry and understand what those requirements are, and so that they can modify them accordingly.
So noting that appear before estimates, and it is Commonwealth money that goes to them, is there any, you could be extremist and bind the money to particular conditions. In your assessment of that encouragement towards finding the mechanism to allow Australian industry to invest, can you report, even on notice, what you've achieved in that space through encouragement?
So it's pretty much through the grant agreement, and NAFC are currently going through their tender process, procurement process, etc., and we will wait for them to come back to us to see.
Have there been any changes to look at that particular issue?
Yeah,
I'm sure the Minister would love to see Australian aircraft, and unless someone actually says, I'm going to take charge of this and I'm going to try and press for this to occur, everyone can sit back and just say, well, watch and see what happens. And I say it's not acceptable. I'm looking at the Minister now.
You are, but are you asking the Minister?
Well,
Senator Patrick, we've had this conversation before. Obviously, it'd be fantastic, but again, NAFC is an organisation that is made up of independent, autonomous fire chief commissioners, each with their own capability in their own space and place, and we've mentioned here today. New South Wales has a capability, for instance, that other states don't have. And so it's through that mechanism that they collaborate and share that resource. So I, obviously, as Mr Buffoni states, we would love for there to be that national capability here and for it to be made at home. But ultimately that is a decision for that organisation to make.
Yes and no, and that they are firefighters and they concentrate on that, and you can have an input on this, and they would be required for you to listen.
We've been very forward-leaning on this.
Okay. On notice, can perhaps someone provide some evidence that of what you're doing in that space?
Absolutely.
I'd be grateful for that. Thank you. Thank you, Chair.
Thank you very much, Senator Patrick. We'll now go to Senator McKim. That concludes, I understand, the examination of emergency management matters, Minister.
Thank you.
So that might be a good opportunity to do a quick swap.
Thank you, Senator Stoker.
With Assistant Minister Stoker coming to the table. Senator McKim is attending remotely by way of teleconference. Senator McKim, you have the call.
Thank you, Chair, and good afternoon to the Minister and to Mr Pizzullo and folks from Home Affairs. Can I just check you can hear me okay, please?
Yes, loud and clear, thank you.
Great, thank you. I've got some questions about the statutory review of the Anti-Money Laundering and Counter-Terrorism Financing Act. One of the key findings of that 2016 review was that the scope of designated services be expanded to include accountants, lawyers and real estate agents, known as Tranche 2. That was first promised a long time ago, almost lost in the mists of time now, back in 2006. What is, in fact, the status of the government's response to this finding?
Well, Senator, the answer to that question really is subsumed within the evidence that Mr Abalong gave earlier, which is to say whether it's as a function of the FATF stipulations or guidance, or whether it's in response to statutory reviews, which, as you say, are required under the legislation, the policy position is the same. And indeed, I refer you not just to Deputy Secretary Ablong's comments, but to the Minister at the table when either ACIC or Austrac, I can't quite recall which minister, but Minister Stoker also made some comments to the effect that you need to balance, in this case, the burden of reporting on sole traders, small real estate agents, small solicitors and the like, versus the intelligence benefit to be gained from large volume reporting regimes, as distinct from what Ms Rose described when Austrac appeared, which would be more targeted reports that might be able to be elicited by way of better training, education and guidance as to what Australia's criminal laws consisted of. So pulling all that together in response to a direction from the Minister for Home Affairs, as reflected by the Minister earlier today, we're looking afresh at the cost-benefit trade-off. There was a cost-benefit analysis done that you have asked us about before. Back in 2017, it was done by a professional services firm. We are looking at the economics, if you will, of the reporting burden afresh. And when I've got more to say to this committee under government, after the government's made a decision in relation to these matters, I'll have more to say. Thank you.
Well, thanks, Mr Pezzullo. So just to be clear, 15 years after Tranche 2 was first promised, 5 years after the statutory review of the Act recommended that Tranche 2 be implemented, you've now, or the government has now recommissioned a cost-benefit assessment that has already been done once. Is that what you're telling the committee?
It's been done at a point in time with certain parameters and working assumptions, and yes, we're redoing that work, or I should say we're having that work redone.
All right, when did that start?
I'll ask Mr Ablong to rejoin me, but certainly in the last 12 months, and it really goes to the balance to be struck between regulatory burden and impact and effectiveness, and that work is certainly underway. But as to when we commissioned it, Mr Ablong, can you refresh my memory?
Mark Ablong, Deputy Secretary, Strategy and National Resilience. The commencement of the work on the next phase of this cost-benefit cost-benefit analysis was started earlier this year. I don't have the exact date on me, but I can certainly put that on notice. It's fair to say, Senator, that the 2017 cost-benefit analysis concluded that it was really difficult to do a cost-benefit analysis on this particular sector just because of the size of the sector. They weren't able to come up with a formal cost-benefit analysis that would have met the regulatory impact statement requirements of legislation introduced into the Parliament because the nature of the challenge, both in terms of the money laundering challenge, but also the nature of the various sectors. And as I said a little earlier, the difference between a sole trader who might be a real estate agent or a lawyer all the way through to large multinationals who participate in those activities made it a case of how long is a piece of string. So the 2017 work didn't provide a comprehensive cost-benefit analysis, which is why we've started that process again.
All right, so you got a cost-benefit analysis in 2017 that didn't provide you with a cost-benefit analysis, and then 4 years later you commissioned a further cost-benefit analysis. When is that due to be completed?
Senator, there is no definitive date yet for it to be completed. Part of the challenge, as I mentioned earlier, is we are relooking at the requirements for legislation, and until such time as we have clarified exactly what the legislative burden might be, it's difficult to do a cost-benefit analysis of the regulatory impost of that regulatory burden. So working with the relevant sectors, we are trying to determine whether there are methodologies for achieving the intents of the AML CTF legislation without requiring a legislative solution. particularly in the current context where companies are looking to try and regenerate themselves out of the COVID crisis, and putting additional regulation on them at this time may well be quite a dampening impact in terms of their ability to meet their profit and loss requirements and rebuild their businesses.
So Austrax recently released their risk assessment of Australian major banks, and in that they identified that there were, and I'll quote from their report, widespread or concentrated real estate purchases with the proceeds of crime, driving property prices up and pricing legitimate buyers out of the market. So you've got a situation, I guess this is a question to the Minister. You've got a situation, Minister, where ordinary Australians are being priced out of the housing market because they're bidding at auction against international crime syndicates, and 15 years after these gatekeepers and these enablers were first promised to go into the reporting requirements of the AML-CTF Act, we are now stuck in some kind of endless loop, and it looks like hell will freeze over before we ever get some movement on this. Why is it that the government is deliberately stalling and delaying this important anti-counter-terrorism financing and anti-money laundering reform?
Senator McKim, there's a few things to unpack in the question/comment you've just presented. The first is to say that I very much doubt it's as widespread a problem as you say. The second thing to say is that there are substantial other tools in the toolkit of Australia's agencies that deal with and police and hold to account those who engage in money laundering of illegally sourced funds. The third thing to say is there is none of the delay of which you complain, in the sense that we have simply adopted a staged approach, and step by step we are working through the ways to make sure that we can implement this, along with the many other tools we have given to agencies that deal with this issue. And we are doing it in a way that is taking great care to make sure that what are often small businesses who I might add have had a very rough trot, particularly in the context of COVID, are given the assistance they need to be able to implement whatever regulatory requirements are necessary in a way that balances the burden that we would place on them by doing so. It's very important that we don't regulate these businesses out of existence, but rather that we work with them to find a constructive way to make sure that the public benefit in ensuring these types of illegal behaviours are absolutely stamped out isn't achieved at the expense of the businesses and the jobs they provide and the assistance they provide to our communities. It's a balancing act, but we are using a staged tranche approach to getting it done.
Well, you reflected on what I'd said, Minister. I was just simply quoting an Austrac report at you that said that real estate purchases with the proceeds of crime are pricing legitimate buyers out of the market. I mean, that's a direct quote from an Austrac report. That is not my opinion. That is Austrac's opinion. I wonder if I could ask in regards to the cost-benefit assessment that is currently underway and that there is no timetable for. What stage of that assessment are we at? Has it been scoped? Has the methodology been agreed? Like, where are we in the process of that assessment?
We might need to make this the last question too, Senator McKim.
Senator...
Oh, I'll need another tranche of questions.
All right, no problem at all.
Senator Mark Ablong, Deputy Secretary, Strategy and National Resilience. We have been working with the sector to both as I said, look at what the potential options for different solutions that don't or might not require legislation, as well as what some of the legislative requirements might be that will allow us to appropriately define a cost-benefit associated with the regulatory burden of any legislative solution. So that process has been underway with the sector, or the sectors, I should say, but we haven't commissioned a formal independent cost-benefit analysis until such time as we have done both that policy work and work with the sector to better define what a future legislative package might require. So the cost-benefit process has started, and we are scoping out both the economics of AML-CTF, the potential requirements there might, or the potential size of the expected money laundering counter-terrorism challenge here in Australia, and then what the potential impacts of any regulatory solution might be. So it's in initial days in terms of better understanding the nature of AML-CTF in this country, the types of transactions that we would need to cover, and then we will work through an independent cost-benefit analysis once that work has been completed.
Thank you very much, Senator McKim. Senator McKim, we will need to leave it there, but we will return to you. I do now need to give the call to Senator Keneally.
Thank you, Chair. Thank you to the department for their attendance today. I flagged that I will have questions in relation to the community safety grants, ideologically motivated violent extremism, and specifically the Fearlessly Australian podcast, and also about cybersecurity and ransomware and disinformation. So just flagging ahead of time where I intend to go in outcome one.
Can I assist, Senator, just in one respect, and so just the way in which we divide up our work against programs, social cohesion, so to the extent to which Australian values are a social cohesion matter, probably 2.5, but the extent to which your questions might relate to violent extremism, and this is a spectrum, so these are not easy distinctions to draw, Senator. Australian values social cohesion to the extent that they thwart violent extremism, 1.4, counter-terrorism, the extent to which the Australian Values program, the Fearlessly Australian podcast, for instance, is a social cohesion program in its own right, probably better dealt with under outcome 2. That's just a function of which officers are here at any particular time.
See how smoothly this goes when we communicate.
It's a spectrum. So.
Thank you. Excellent, thank you. If I can start with the community safety grants, we are currently in, in August, did the round 6 applications close for the community safety grants?
I believe so, but we are up to round 6. So as to where we're at, Mr. Ablong and perhaps it might be Ms. Spencer will join us. The question relates to where are we with round 6?
And specifically, Mr. Ablong, if I can ask, what are the aspects of round 6? It seems to me there's a security infrastructure grant, and there is also an early intervention activities for youth at risk grant. Is that correct? Are there other aspects to round 6?
I'm just getting to the relevant page.
That's fine, Mr. Ablong.
And to assist the Deputy Secretary, seeing if the First Assistant Secretary is available. Not? Okay, it's all yours.
Excuse me. Senator Mark Ablong, Deputy Secretary, Strategy and National Resilience. So round 6, which is a total of $35 million, consisting of $29.3 million over 3 years for grants from 21-22 through to 23-24, and $5.7 million over 4 years from 2020-21 to 2023-24. For eligible community organisations with demonstrated experience in providing early intervention activities to youth at high risk, to prevent them from engaging in criminal activity or antisocial behaviour. The infrastructure stream, which you mentioned, opened on the 15th of June and closed on the 19th of August. Up to $10 million is available to protect schools and preschools places of religious worship, community organisations and local councils that wish to address security risks associated with racial and/or religious intolerance via infrastructure
The
works.
infrastructure component is part of round 6?
That's correct.
Thank you.
So, and I apologise, I'm just trying to unpack this. So we've got round 6 has the infrastructure component. How much is that worth?
$10 million.
Yep, okay, got that. And then the
Early
early
intervention
intervention
stream.
is worth how much?
The balance, which is 25.
Is that right?
Sorry, 20. I apologise, 20.
Yeah, 20, okay. So,
Sorry, just by way of clarification, over what period of time are we referring?
Over 4 years, from
Yep.
2020 through to 2024.
a moment ago you said it was worth 35 million?
35 million is the
So-
total.
What is the other, and so the 5, where does the other 5 million come in?
So there's 29.3 over 3 years for the grants and 5.7 million over 4 years for the Grants Hub administration that's undertaken.
The Grants Hub administration.
That's correct.
So we're spending 5.7
Million over 4 years.
to administer $30 million worth of grants.
That's correct, Senator.
Is that a usual
It is.
administration to money awarded ratio?
There's a formula that relates to
That's-
grants processing. So from memory, our grants hub is it the Department of Industry still? I can't quite remember.
Because
So-
that's
so,
20%.
Minister, So there is perhaps it's a good business to get into. So there are
Yeah.
a number of consolidated
I'm
grants
in the wrong
hubs which process applications.
Yep.
Our parent, if that's the right term, or our sponsoring, or whatever the right term is, hub is the Department of Industry, sorry. And the Chief Operating Officer will correct me, I'm sure, but there is a set formula by which they determine their costs, which is either relevant to volume of applications or volume of funds. I can't quite recall which, but that element is not particularly Mr Ablong's remit. That's probably a matter for our
So the Department of
Finance
Industry
Officer.
essentially comes up with an amount they're going to charge you, and it's either based on the volume of funds or the volume of applications.
There is a hub formula.
And
Is
if
the
I want to get
CFO
that
of the
formula,
industry?
do I need to ask the Department of Industry?
No, I can check. The Chief Finance Officer always tries to sit as far away as she possibly can. She's literally in the farthest corner. I'll ask Ms Cargill to join us and she can explain to you... Sorry, I should be facing the table. Ms Cargill will explain the Grants Hub administration formula to the best of her ability. So Mr Ablong owns the policy and, if you like, the policy objectives
Yeah,
of the
yeah.
grants,
Yeah.
and then the administration is a matter for the Grants Hub department.
Yeah.
Ms Cargill,
Thank you,
I
Secretary.
almost couldn't recognise you behind your mask. Thank you.
Thank you, it's rather large. Stephanie Cargill, First Assistant Secretary, Finance. So in terms of the Grants Hub costing, what we actually do is we actually get a quote from the Department of Industry, and it's based on, as the Secretary said, I actually can't answer the question as to whether it is volume of dollars or process, but it does relate to what they actually, the activities they have to undertake to actually administer the grants program, and the amount that's actually put up by the industry hub is costed by the Department of Finance through the budget process.
Okay.
And I assume there'll be some kind of formula attached to that.
That's right. I'm just not aware exactly what the formula is,
Well, we
but that's
might-
a fairly standard.
That element we'll take on notice then.
That's right. It's a fairly standard amount.
Okay. Thank you, and we can chase that also through the Department of Industry. If I can go back to the round 6 early intervention activities grant, when was the closing date for the
The
application?
5th of August 2021.
That was, yes. And then the security infrastructure grants, they closed on the 19th of August?
That's correct.
Was that an extended date?
The closing dates for each stream were extended by 2 weeks at the request of the Assistant Minister to allow flexibility to applicants subject to COVID-19 restrictions.
The Assistant Minister being Minister Wood?
That's correct,
Right.
Senator.
Okay, so he requested due to COVID, okay. Now, I'm just looking at the eligibility and the assessment. The assessment on business.gov.au says a minister in the Home Affairs portfolio will make the final decision, taking into account the application assessment and the availability of grant funds. So I take that to mean, while there are assessment criteria, the final decision rests with the minister, a minister in the portfolio.
That's correct, Senator.
So that could be, for sake of clarity, that could either be Minister Wood, Minister Tudge, or Minister Andrews.
Not Mr Tudge, no.
No, sorry, I apologise. You are right. There's been so many immigration ministers. I apologize. Minister Hawke.
Well, I'm not sure that the immigration minister,
I'm
whoever
seeking
that,
clarity as to.
it would be the
yes.
Home Affairs Minister or the Assistant Minister, and it's a function of any relevant delegations that Minister Andrews has made.
Correct.
So Minister Andrews
Has delegated this to Minister Wood,
And
Assistant Minister Wood.
She's delegated it to Assistant Minister Wood. Did Assistant Minister Wood have that delegation for previous rounds?
He has had that delegation in previous rounds. I believe he had it for round 5.
Had it round 5, but prior to that, did Minister Dutton have that?
Minister Dutton had the...
I believe he had it for round 3.
That's correct.
We've
Yes.
given evidence on this. Certainly 3. I can't recall 4. We'd have to,
Sure.
we'd have to clarify that.
I know he had it on 3.
We have given evidence on 3, and that was Mr Dutton.
Yes, I do recall that.
In fact, round 4 was Assistant Minister Wood as well.
Okay. And so they've closed on the 19th of August and the 5th of August, respectively, for the 2 different programs. Just confirming, do you have any date for announcement?
Not at this stage, Senator. The Grants Hub is doing the evaluation of the proposals against the criteria. They will then provide that information to ourselves, and we will then provide a submission to the Assistant Minister specifying what the Hub has found and how he might want to consider those applications.
Yep, great. And the Chair's I will try to wrap this part up, Chair. Thank you. So just so I'm clear, the Grants Hub is assessing the applications now. So that's where the stage of the process we're at. It hasn't yet gone back to the department.
That's correct, Senator.
And at that point, the department will take a submission to the minister, but providing advice on what the Grants Hub has recommended. Does the department add any value in that process? Like, do you add any commentary or recommendation?
Senator,
and I don't mean that you don't add value. I mean, are you a post box for the Grants Hub, or do you actually provide some
we're
commentary?
not a post box. We do provide.
Pardon me?
We're not a post box. We do provide our value add.
So you will provide some value add as well, and then it will go to the minister. Just, do you, and I know that we're now in round 6, so Chair, this will be my last question on this. With previous rounds, has there been a usual time frame for that decision-making process from the closing point to announcement?
It depends, Senator, on the expanse of the criteria, the number of applications that are put in. So there isn't a usual time.
Sure. Do you have any sense of the number of applications for round 6?
I don't have that detail on me, Senator.
Okay. Can you take that on notice,
I
please?
can.
Thank you, Mr. Ablon. Thank you, Chair.
Thank you very much, Senator Keneally. We will now return to Senator McKim, who is attending by way of telephone conference.
Thanks very much, Chair. So these questions are on the same topic as my last tranche. So I'd just like to be clear, if possible, has the new cost-benefit assessment that you referenced earlier, has that actually been commissioned yet, or are you still doing preparatory scoping work?
Well, insofar as the work around a cost-benefit analysis has been commissioned, the answer is yes. As to the engagement of an external specialist expert, that would be expert in government regulation, the costing of government regulation, whether it's from one of the major accountancy firms or a specialist economics and financial advisor. I'll just clarify, Mr. Ablong, that commissioning has not occurred.
That's correct.
But as Mr. Ablong said before, the sequence of questions was broken, and we went to other topics. The question of what is to be costed would be relevant to any contracted expert. So, in other words, and this was, I think it's fair to say, considered to be a flaw, perhaps not a flaw, a point of critique that was applicable to the earlier one. It was just a one-dimensional replication, as I recall it, of if you were to extend the current SMR regime, which is to say suspicious matters reports, as if you had the same kind of regime that's applicable to banks, for instance, replicated without any distinguishing or differentiating features, say to real estate agents, to accountants, to solicitors, and so on and so forth. What would be the cost of that? And I think it's fair to say that the answer is fairly one-dimensional when you receive the answer. If, however, you scope alternative ways of gaining the same information, including do certain types of transactions meet certain thresholds, that could be on alert, that could be, if you like, more tightly defined, whereby reports might be made by more definitive exception, how much would that cost? I think it's fair to say, Mr Ablong, it's defining those questions, so setting the right question for the modeller, that we believe would lead to a more accurate and a better sense of both the cost and the benefit. Have I described the scoping work that you're currently doing, Mr Ablong, fairly accurately, or indeed accurately?
Secretary, you have described it accurately. The other dimension that I would add is to which of the entities would you apply those rules? So would you have the same application for a sole trader, real estate agent as you would for a large real estate company? And so,
or indeed a national law firm, as distinct from what is sometimes described as a suburban practice.
Correct.
Or indeed as a barrister in chambers.
Exactly, Secretary.
All right, so Mr Pizzullo or Mr Ablong, I mean, am I to take from that answer that the 2017 cost-benefit assessment simply looked at the costs and benefits of implementing Tranche 2 into the AML-CTF Act? Is that right?
I wouldn't quite describe it like that. It looked at a particular mode of doing that, which, as I recall, and I'll have to refresh my memory of it, it's been some time since I've read it, in a way that assumed a greater likeness with current arrangements than perhaps common sense would suggest. Now, if I've mischaracterised the 2017 report, I'll come back to you on notice and correct myself accordingly. But effectively, as I recall it, Mr Ablong, it assumed that in the same way that banks have got dedicated teams that look at SMRs, you would in a sense replicate that, allowing for scale, all through these other professional services organisations.
That's correct.
Now, if that needs to be amended, if I've mischaracterised the 2017 report, which from memory was undertaken by KPMG, I will come back and correct that evidence.
All right, thanks. I appreciate that. Can I ask when did the department receive that in 2017, or when did
it was received? It was received by the former Department of State responsible, which is to say the Attorney General's Department, and that was part of a suite of documents in this area that were handed over to the Department of Home Affairs once we were established in December of 2017.
All right, thank you. Can I ask if you could provide on notice, please, the date that the Attorney General's Department received? Oh, well, perhaps I'll ask them tomorrow. That's fine. Could I ask, please, whether you could provide the committee with a copy of that report?
Senator, I'll need to take that on notice. I think that has been asked for before, and I think there have considerations about public interest have been attached to that question. I'll look at the record. I'll take it on notice. I will take it on notice. But I think determinations have been made previously about the releasability of that report. I'll revisit those issues and I'll take the matter on notice.
All right, thank you. Is the department aware that Australia, and this is based on evidence from Austrac earlier today, is now one of only 5 countries in the world not to have included these gatekeepers, that is, accountants, lawyers and real estate agents within the scope of AML-CTF laws?
I'm aware of Ms Rose's evidence. Indeed, I was in attendance when she was giving that evidence.
Oh, I appreciate that. I apologise, Mr Pizzullo. I obviously can't see you at the moment, so happy to accept that, obviously. Can I ask, back on to the work that you're currently doing to prepare for the external commissioning of this report, just so I understand the evidence that you've just given, you're scoping alternative ways that that may be able to be implemented that are not simply including tranche 2, the accountants, lawyers and real estate agents within the reporting requirements of the AML-CTF Act. So you're actually scoping... You're not scoping that?
No, Senator. It presumes that all of those entities, individually and also collectively, come within the reporting regime. The question then is, what is the best design of a reporting scheme that allows for the fact that they're not banks, they're not major institutions? What are the types of reports with their thresholds, the frequency, the cadence of reporting? What would a scheme optimally, at least in a hypothetical sense, because obviously the modeller then has to apply their modelling techniques to that, what would that look like without presuming, which I think is the premise of your question, the exclusion of different types of facilitators? In other words, Mr Ablong, please feel free to correct this, starting with, because government will want comprehensive advice, what would it cost to have different types of reports that embrace all of those sectors, solicitors, barristers, national law firms, accountancy firms, real estate agents, and then presumably, depending on how granular the modelling could get to, what might be the cost by sector? I'm assuming, Mr Ablong, that we'll be asking both questions.
We will, Secretary.
Thank you.
All right. Thank you. I appreciate that answer. And just so that I'm clear, that is the work that is currently being undertaken by the department. There is no, as yet, no end date set for that work, and there has been no external provider of a cost-benefit assessment commissioned as yet. Is that accurate?
I'll just get Mr Ablong to confirm both or to qualify both.
Senator, you are correct.
All right, thanks. I appreciate that. Thank you, Chair.
Thank you very much, Senator McKim. We'll now go to Senator Patrick.
Thank you very much, Chair. I have some questions just in relation to illicit tobacco. Is that covered off here?
We might best, given the availability of officers, direct those questions to the ABF under Program 3.3, Revenue Collection, and the associated program is 3.4, Enforcement.
Okay, so when we get to them, I'm accepting you're saying that'll be more...
Certainly the Commissioner will be here for Outcome 3. He would have given his opening statement, which he typically does at the start of either 2 or 3, depending on the Chair's guidance, and then I'm sure he'll have his officers available.
Okay,
as well.
and he'll be able to talk to me about what measures are in place and so forth.
Yes,
Thank you.
He leads on that question, and typically it's a combination of revenue under 3.3 and enforcement under 3.4.
All right, thank you. I'll move then to just another question, just about critical infrastructure and perhaps policy. Is that appropriate for here?
That's me.
Okay. Just looking at some of the investment plans of the government up in Queensland in relation to there's a Gemina pipeline that goes from Mount Isa to I think it's Gladstone. There's a proposal to have a new pipeline between Tennant Creek and Mount Isa. Does that sort of infrastructure generally fall within the remit of or the definition of critical infrastructure?
Well, indeed, the definition of critical infrastructure, which was first passed by the Parliament in 2017, is subject to the passage through the Senate of the revised bill, going to be expanded to a number of sectors and in asset classes within those sectors. That legislation passed the House last week, and I understand it to be scheduled for Senate consideration with the resumption of the Senate after estimates. The short answer would be yes, because it would fall within one of those categories of power, gas, water, depending on fuel, depending on what's actually carried in that pipeline. So there's a current definition in the original Security of Infrastructure, Critical Infrastructure Act that was passed by this Parliament in 2017. That's been expanded under some amendments that the government proposed, and which the House of Representatives passed only last week, and that's due to go to the Senate when the Senate resumes.
Okay, so this goes to a question in this instance. The new pipeline one would presume Gemini are in the box seat because they own one of the ends. I'm just wondering about process in terms of. I'll just state openly. My concern is that's a 60% owned Chinese state company. Just in terms of process, is it like FIRB invokes a consideration in relation to acquisition?
Yes.
What happens in the circumstances where it's not an acquisition but perhaps a development? Can you help out there?
So the two regimes, the regime under the Foreign Acquisition and Takeover Act 1975, which has obviously been in place for many decades, is designed to be complementary with the SOCI. I'll use SOCI if you don't mind, Senator, as a shorthand. So SOCI relates to controls outside of conditions that might be set by the Treasurer, or indeed approvals that might be either agreed or rejected by the Treasurer. So that relates to the source of, if you will, the capital. That's dealt with under the regime. Sometimes it's called FIRB. That's the advisory board that advises the Treasurer, but the legislation itself is the Foreign Acquisition and Takeover Act 1975. What SOCI, and indeed the improved, augmented, strengthened SOCI, whichever of those adjectives you might wish to apply, that will relate to controls that are outside of foreign capital. So the two, we work very closely, I should stress, with Treasury, so that you can have two ministers, the Treasurer and the Home Affairs Minister, with a complementary set of tools that might mitigate a risk. The Treasurer might make a decision which could have conditions attached to either accept or not accept that investment in the first instance. Once that investment is through, to your point about development or further management, then it really falls under SOCI. That's been a gap in Australia's legislative armoury for many years, and that's why the government's so intent on proceeding with the full suite of the SOCI measures, subject to addressing some matters that the Parliamentary Joint Committee recently drew attention to. That would allow the Minister for Home Affairs, in consultation typically, because the law will require this, both with any other relevant minister, and we would have to consult with any co-regulator, so it might be the Australian Energy Regulator, it might be, if it's a federal regulator that is, it might be other authorities at the Commonwealth level, to create obligations that might mitigate or manage certain risks that are outside of foreign investment. So the Treasury and the Treasurer look after foreign investment.
Sure.
What SOCI is designed to do is to provide a complementary set of tools outside of foreign investment.
Okay, and I'm just thinking of a Port of Darwin moment where, on reflection, we may not have gone down that path had different notifications been made and things considered differently. Under the new regime, are there formal notifications to SOCI that something may fall within its area of interest? How does that bit work?
I'm in a slightly complicated position because I need to speak to the legislation that was introduced by the government in December of 20 that would have certain reporting and other obligations were that bill to be passed in its full suite of measures. The Parliamentary Joint Committee has since, in September, reported and said, do some things initially, which those are the matters that I spoke of earlier. The House has passed a revised bill, the Senate will soon consider it. Obligations outside of an immediate cyber incident have been put at the committee's request into a subsequent piece of legislation, effectively modifying the bill which Mr Dutton originally introduced into the House in December of 2020. I won't speak about the Port of Darwin or indeed any potential decision that hypothetically might come before a minister, whether it's to do with a port, an airport, a pipeline or whatever, but in general terms this is how the scheme would work if the Parliament sees fit to pass it in its full extent. If, first of all, you've got to be within an ambit of critical infrastructure, 11 sectors, that passed the House last week. Oil, gas, fuel, ports, etc., telcos, food and grocery, quite interesting, sensitive research and higher education. 11 sectors. Within those 11 sectors, the way the definitions work as follows. The Minister designates certain asset classes that are within those sectors, and this is only if the full bill passes, so elements of it I've dealt with the bill presently before the Parliament.
I understand there's a caveat to this.
And there's a caveat. So were the full bill to be passed, yes, the Minister of the day, he or she, could designate, on advice from the department, so we've got a cyber and infrastructure security centre. They work very closely with ASIO. You heard the Director-General earlier today speak about his concerns, for instance, about pre-implanted malware, for instance, that could potentially create sabotage risks on our critical infrastructure. For whatever reason, on whatever threat or risk basis, as long as it's within the parameters of the law, should it be passed in its full measure, the Minister could then designate certain classes of infrastructure to be systems of national significance. I'm sorry to use another acronym, but a SON. If you're designated to be a SON, and the plural of which is SONs, then the Minister of the day could impose certain obligations, which could include a number of things. Things like the citizenship or security clearance of key operatives, people who typically could operate machinery or who could operate actual hardware that could result in sabotage risks, people who could implant cyber malware, or the Minister of the day could impose other obligations such as vulnerability assessments or obligations to prepare particular risk management strategies pursuant to those obligations. They are called positive security obligations, or PSOs, that would attach to SONs. Sorry about the welter of acronyms, but I'm a public servant, so it's genetically encoded.
It's okay. I'm defence trained, so it's all right. So just finally then, you mentioned a range of things, but ownership was not one of them. Obviously, ownership might in some way leak into some of those domains.
Yes.
But
we're conscious, Senator, as a matter of practice, the way we're going to co-regulate with our colleagues in Treasury who support the FIRB is, if the question is principally one for the Treasurer around either a yes or no decision on the investment or yes with conditions, we will triage it, and we've already set up the arrangements with the National Security staff in Treasury to ensure that matter is led by the Treasurer, because constitutionally and in relation to legal authority, that's a question better dealt with under the Commonwealth powers in relation to foreign investment. That was well established in 1975 when that legislation passed, and has been 40 years of decisions and case law. That goes to ownership. If, however, you might decide that you want to take a combination approach, that is to say you might have a restriction or a condition around ownership, but you might combine it with things like the citizenship requirement of key operators of machinery, security vetting, security identification cards, like the ones we have at ports and seaports, ASICs and MSICs, for instance. Regular reports about vulnerability assessment, mandatory reports about certain incidents, vulnerability assessments, then that would fall to the Home Affairs Minister, who in a sense would have a more diverse set of tools available to her, which would work then in combination with an ownership decision. So SOCI is designed to be it's designed to be complementary to the FATA legislation.
Okay, that's very helpful. Thank you very much, Chair.
Thank you so much, Senator Patrick. And now we'll go back to Senator Keneally.
Thank you very much. If I can pick up on the Security of Critical Infrastructure Bill and start with the work that the department is doing to, quote, as you say in your annual report, deliver enhanced framework to protect critical infrastructure, including system of national significance. In that annual report, it was assessed that the department had partially met this performance metric of delivering an enhanced framework to protect critical infrastructure, including systems of national significance. What led to the determination it had only partially met that metric?
Well, clearly we weren't able to persuade a number of key stakeholders, including the committee upon which you serve, that the bill in the state that was presented to the Parliament in December 20 was ready for passage as expeditiously as I and Director General Noble tried to convince you otherwise. So we've got a bit more work to do, clearly, to convince you.
Well, for the record, it's not just me.
No, indeed.
It's a bipartisan committee with a unanimous report.
Sorry, I didn't mean to personalise it,
Thank
Senator.
you.
I do apologise.
The annual report describes as, quote, fully met the aim of effective policy development and coordination to safeguard critical infrastructure, including consultation regarding the Critical Infrastructure Bill's reforms. In fact, it even features a case study on the co-design of critical infrastructure legislation and regulatory requirements. on page 43, the department, say that the bill reflects a co-design process with industry and it will be vital to ensuring the reforms achieve a real and meaningful uplift. But Home Affairs self-assessment does jive with what the does contradict or not seem to be in cohesion with what the Intelligence and Security Committee's bipartisan and unanimous report found, that stakeholders did not feel like their input or feedback had been actioned or acknowledged. Does the department still believe, having now read the PJCIS report, that it fully met the metric of effective policy development and coordination?
Yes. And
Why?
I say that, well, I've read your report, the committee's report very carefully. I was also a witness, obviously, in proceedings, and I think it's fair to say it is sector specific. Some sectors, I think it was a question of, we've got to think about the regulatory burden, how will their reporting requirements work, and I think it's fair to say that in the balance of the majority of sectors, I think we have reflected not just the views, but in fact we've improved how the regulatory and operational arrangements would work as a result of both the evidence they gave to the committee as well as the submissions that we received directly. I think in some cases, and you've seen it since the PJCIS report was brought down, there are a number of sectors who have got, I'll tread very carefully here and I'll be as courteous as I can be, such a deeply vested set of interests that they'll never agree, so they'll always mark you down and say, we haven't been heard. The foreign cloud providers, for instance, the most vested, self-interested and indeed loudest complainants about process tend to be the ones who actually are concerned about the material impact on their business. So I note, for instance, with interest the statement that companies such as Amazon have put out in relation to the legislation. If Amazon had their way, they would see no legislation passed ever. So
But it wasn't just Amazon, was it? To be honest.
Foreign multinational
The BCA?
cloud. I'm talking about the companies, the ones who actually have got
But Mr. Pizzurro,
material
with
skin in the game.
respect, I can't think of a submission that actually said, yes, this bill should be passed. We had a range of stakeholders, including the Business Council of Australia, the Australian Council of Trade Unions, and almost every sector come to us with serious concerns about the department's consultation. I quote, "The committee received extensive evidence and submissions and at public hearings that many companies, industry bodies or stakeholders did not feel like their input or feedback had been actioned or acknowledged. While the department provided reasons of varying complexity for not supporting or accepting proposed amendments or concerns of submitters, the committee was not substantially aided by the department's response." So I just ask you again, you stand by the claim that you fully met the aim of effective policy development and coordination?
Yes, in terms of the policy that underpinned the bill as initially presented. Obviously now we've got the benefit of the wisdom contained in the committee's report, so obviously under government direction we're acting on that wisdom and we're having regard to both sector by sector but also generally what's been said about regulatory burden, about complexity around rules, frequency of reporting obligations, and hopefully on the next go-around we'll be able to satisfy the Parliament that we've had full regard or even fuller regard to those concerns.
When do you anticipate Bill 2, as the committee referred to it, to be back to the committee for consideration?
I can't speak with any specificity because the government hasn't taken a final definitive policy position because they need to authorise the relevant amendments, other than safe to say that, as the Minister's indicated in her public comments, including I think when the legislation was put to the House, the government wishes to deal with this matter as soon as possible.
This year or next year?
Well, I'd be speculating, but given that we're in estimates, so the Senate meets for two weeks from the 22nd of November, I'd be speculating, and I wouldn't care to do that lightly. I don't think it's likely that a revised bill will be put back to the House and the Senate to deal with Bill 2 matters, given that Bill 1 is still before the Senate. But again, I'd be speculating. But it's my understanding, and I'll take this on notice and correct it otherwise, that the government wishes to deal with it urgently, given they're well seized of the intelligence basis for it, they're well seized of the threat, they're well seized of the sabotage and other risks that Director General Burgess spoke about. They are, the government's concerned to ensure that the committee's conclusions and recommendations around reporting obligations, the burden of reporting, duplication in reporting, particularly where there are multiple regulators, the government's absolutely determined to ensure that those issues are dealt with, and the Minister's made it very clear to me that she wishes, for me, in leading the department, to make sure that we deal with those matters as urgently as possible. But as to the government's legislative timetable, I couldn't really add to what I've already said.
Thank you. You told the committee that you would like to have the emergency government assistance measures, quote, on the statute books tonight, and that was in your evidence in July.
Yes.
Now, in asking this question, I want to acknowledge right up front the bipartisan way in which Minister Andrews and her office have worked with me to get the first of the SOCI bills, Bill 1, considered by the Parliament, and I want to publicly thank her for that. But it's now the last week of October, and for some reason, I believe the government Senate leadership didn't bring the bill to the Senate last week. So with only one sitting period left and without those powers on the books, is it frustrating that that bill has not yet passed the Parliament? And what has it done in terms of leaving us vulnerable to cyber attack?
Well, it's always a dangerous thing to respond to a question about your state of satisfaction or indeed your state of emotion about a particular matter. So I'm going to try to avoid
Well,
that.
you did give evidence to the committee about the urgency that you wanted to see in relation to this bill.
So I'll answer it indeed, Senator, thank you. The committee honoured me by quoting me at quite a number of occasions in its report, including with respect to if I had my way, and that's the caveat, I don't have my way. We've got a democracy, so. But yes, but if I had my way, the emergency powers should, when I was speaking in July.
Which are in Bill 1, correct? Yes.
The emergency powers whereby ASD would be able to, with lawful access, come onto an Australian domestic network, which when you think about it is quite transformative. It's a very big step. It's one of the most transformative steps that any democracy has taken in respect. Should Bill 1 pass, I did say in perhaps a moment of flourish in my evidence in July, because it wasn't a prepared statement, that if I had my way, that those powers would be on the statute books that night, which was in July. I did also say that the rest of it I'd want, if I didn't say the following morning, I certainly gave the committee every reason to think that that was my view. And the reason why I say that, Senator, is because it's fine to have the step-in powers, but it's like saying to the fire brigade, you are now lawfully authorised to attend a premises, put a hose onto a fire and put the fire out, but we're not going to tell you, I'm not going to give you a street directory, not going to tell you where the hydrants are, I'm not going to tell you what water pressure is in those hydrants, not even going to tell you what coupling for your hoses there are. And oh, by the way, it's not even required that people have smoke alarms in their house. You wouldn't do fire safety like that. And so that's why I'm urging the Parliament through this evidence in due course, and obviously we do have to address those issues around regulatory duplication and regulatory burden. I spoke to Senator McKim earlier about another instance of regulatory burden. We're very sensitive to those questions. But the larger picture is this. The full suite of powers are required because you do need to be able, at a certain level of sensible regulation, be able to mandate the smoke alarm, be able to say to the fire brigade, here are where the hydrants are, because otherwise you are literally driving fire trucks around the city just looking for the smoke. That is potentially where we've ended up.
Well, we could have had those bills passed last week, and for the record, I stood ready to debate the bills and get them through the Senate.
Sorry, Senator, just so I'm not being misquoted or mischaracterised. What I've just described to you is even if you get Bill 1 through, it's less than half the job.
But it does provide the emergency assistance measures.
It allows the fire brigade to drive around the city looking for the smoke coming from the fire, yes.
And to get their hose out. They have those measures available to them.
And whether or not they've got a hydrant with a coupling, I don't want to extend the metaphor too much.
Yeah, it's getting a little tired, that metaphor. I have some questions about ransomware. Chair, what's the plan here on timing? And
Senator
the call?
Keneally, I don't believe any other senators have questions in outcome 1, so you could continue.
Thank you, Chair.
Can I clarify before Senator Keneally just one matter?
Yes, Mr Bozzolo.
Several times today, Senator, Madam Chair, you've raised the question of spam and so on and so forth.
Yes.
If that's to be dealt with, just to give guidance to our officers here, that would be dealt with. So as critical infrastructure came up before, we're dealing with that now.
In outcome one.
If you wish to have any information provided on cybercrime and those spam text messages that you and Commissioner Kershaw spoke about, just for the convenience of the committee, that would also be dealt with under Program 1.
Thank you very much,
before
Mr.
we get to
Bozzolo.
2, I just wanted to make that clear.
Thank you.
Thank you so much, Chair.
Senator Keneally, would you like to continue?
Yes,
and
please.
then I will raise these matters with Mr Bozzolo.
Thank you, Madam Chair.
Thank you. So the ransomware action plan, which was recently announced, states the government's making a $164.9 million investment in its capability to combat cybercrime. What proportion of that announcement is new spending as opposed to the funding that was announced as part of the cybersecurity strategy in 2020, excuse me?
2020. And to what extent it's the AFP as opposed to ASD component, I'll just need to check. Mr Ablong can assist me. And the reason why I'm expressing a degree of uncertainty, there was some funding associated with the cybersecurity strategy directly, and there were further tranches of funding, including in the budget, as I recall it, for the AFP, but we'll just check with Mr Ablong.
Senator Mark Ablong, Deputy Secretary, Strategy and National Resilience. The money you mentioned in the Ransomware Action Plan is all cybersecurity strategy money.
So that $164.9 million that was part of the Ransomware Action Plan comes out of the Cybersecurity Strategy 2020?
Yes.
Correct, thank you. The Ransomware Action Plan also states that the government's making a $6.1 million investment in ID Care to support victims of cybercrime. Is that the same investment that was announced in April of this year?
That's correct, Senator.
Okay. The Ransomware Action Plan also, it seems, re-announces the establishment of a multi-agency law enforcement operation dubbed Operation AUKUS, which was established in July of this year.
That's correct, Senator.
What disruption activities have been undertaken in the first 3 months of this operation?
So, Senator, as you would have heard from the Commissioner of the AFP, there's a couple of administrative matters which need to be dealt with as part of the Slade Act.
Right. So you're waiting for those
the
warrants to come
designation
into
of
effect?
magistrate.
That's correct, yes.
So you're waiting for those 3 warrants that came in under the Slade bill to
That's
come
correct,
into effect?
Senator.
Right. Minister, do you have any insight as to when the Attorney General is going to finalise those administrative matters?
Look, I can tell you that we are committed to passing it.
It's passed, Minister. I'm trying to understand when the warrants
Sorry,
are
I
going
thought
to
you were
come.
talking about the second. I beg your pardon.
No, the Slade bill passed Parliament on the 25th of
Sorry,
August.
We're talking about different things. I beg your pardon.
This is the so-called dark web disruption.
Oh, I'm sorry.
The 3
talking about something
warrants
completely different. I beg your
Yes.
pardon.
So there's the 3 warrants under the Slade bill. They passed on the 25th of August. I've now had 2 agencies tell me they're waiting on administrative arrangements through the Attorney General's office to finalise those warrants.
Why don't I take that on notice for you?
Thank you. So I suppose my next 2 questions will probably be irrelevant. How many criminal investigations have been launched under Operation AUKUS, and how many criminal charges have been laid?
Senator, those questions best left to the AFP. I do
Sure.
know that there has been operational activity, but it's principally for the AFP.
Right.
I think we can say it's an AFP operation, but just so that the Senator is not under misapprehension, AUKUS, not AUKUS, but AUKUS, spelled with an O, the AFP operation is not
That just
dependent-
might be my accent, Mr. Pizzillo.
No, I wasn't going there. The AFP operation, as I understand, is not solely reliant on the Slade warrants. There are a whole lot of other legal authorities that pre-exist Slade that the AFP is able to rely upon, as I recall it. It's a matter for the AFP, but just from a policy and legislative point of view, I just don't want to leave the committee in any doubt.
Okay. I might take that up with the AFP then. The ACSC's annual threat report has stated that there have been nearly 500 reported ransomware attacks in 2020-21, an increase of nearly 15% over the previous year. And ACSC's advises that ransomware remains one of the most disruptive threats to Australian organisations. Now, the AFP did advise in Questions on Notice in May that it only had 5 investigations which had criminal elements relating to ransomware. Did the Department of Home Affairs provide any advice to government on the number of expected investigations that will arise from the new standalone offence for cyber extortion as signalled in the Ransomware Action Plan?
Number of investigations?
No, Senator, not to that specific question that you raised.
Right. Thank you. Given that a ransomware attack, as I understand it, already constitutes a criminal offence under Australian law, why does the government believe a new standalone offence is necessary?
Senator, the Ransomware Action Plan talks about an aggravated offence, so...
An activated offence?
Aggravated.
Aggravated, sorry.
Which creates a higher criminal penalty, so more time in jail.
So the new offence is to actually create a higher penalty?
We haven't fully designed it out with our colleagues in Attorney Generals simply for this reason. Yes, we want to have a higher level of aggravation so that particularly attacks on critical infrastructure for the sorts of reasons we discussed earlier, extortion of businesses are hit with more stronger penalties. The question is just capturing in legislation the type of, if you like, malware. So ransomware's got a particular function, which is to extort.
Yes.
But there might be other equally serious or indeed more serious consequences that arise from malware that's deployed without necessarily a connection to extortion. So I think it's fair to say we just want to get the definitions right and ensure that we sweep up, if you will, ransomware plus.
So when will the new offence, in terms of its penalties and when will that be defined?
As with the evidence I gave earlier under SOCI, the Minister's made it clear that she wants to move expeditiously on this question. So the next step is to gain policy approval from the government in relation to the specific offences. Again, I wouldn't want to preempt or presume anything about the government's legislative program in terms of the work, the pace at which we're working, and subject, of course, to our colleagues working with our colleagues in Attorney Generals, because they help us manage the criminal code. I certainly would be seeking government policy approval before the end of the year.
Before the end of the year, you're
Yes.
seeking policy
Yes,
approval.
and the Minister's made it very clear this is a very high priority for her.
Yeah.
Now, as to when the government then schedules with whatever category of legislative priority, that's a matter for government, obviously.
Okay, thank you. So so you don't have any clarity on the legislative authority. Okay, thank you. The ransomware.
No, I've got clarity on its priority as to
No,
its,
I'm just to its time frame.
As to its sequencing, I'd have to take that on notice and ask the government.
So if you are taking it on notice and asking the government, can you ask if the legislation to enable the new standalone offence of cyber extortion will be introduced in this term of Parliament?
Given the very clear directions I've received from Minister Andrews, my instinctive answer is yes, but I also like to check my instincts, so I will check that.
Mm-hmm.
And not only introduced, but I suspect it's a very high priority for her. I suspect also passage.
Mm-hmm.
But again, I will check.
Okay, thank you. I appreciate that. The Ransomware Action Plan signals the introduction of a ransomware incident reporting framework.
Yes.
It was reported in The Age by Anthony Galloway that the exact details of how soon a company would have to report an attack will be worked out after consultation with industry over the coming months. One, is that correct? And two, how does the government define a ransomware attack that needs to be reported under this proposed legislation?
So referring back to the evidence I gave earlier, once Bill 1 passes, so there's a nexus here at least to critical infrastructure, which is the most important, I'll rephrase that. The most consequential ransomware attacks that then have got broader societal impacts, be it hospitals, energy, banking, etc., would be captured within the definition of SOCI or CI. Yes. So once the Senate gives consideration to its passage in the next sitting fortnight, we will have the enhanced or enlarged definition of CI, as well as reporting obligations. So that's actually carried within Bill 1, that bill that's passed the House. So once that bill passes the Senate, Australia will have a regime of mandatory cyber incident reporting as it relates not just to ransomware, noting what I said earlier. Extortion's is a really important factor to look at, but there's other motivations for deploying malicious malware, which could include sabotage. So all of that will be encompassed by the reporting obligations under SOCI once Bill 1 passes the Senate. Sorry, I shouldn't presume that.
So it'll be
were it to pass.
So you'll basically be using the definition that's in the SOCI bill, or the SOCI bill becomes the definition.
In relation to critical infrastructure, as to the general economy,
Yes.
as to the general economy beyond SOCI,
Yep.
noting that the SOCI definition is likely to encompass 1,700 entities or
Yeah,
thereabouts.
it's the 11 systems of national
11 critical
significance.
infrastructure sectors. The systems then sit within those definitions. As to the general economy, Mr Ablong's been leading a process under the cybersecurity strategy to engage in best practice regulatory design, which deals with the general economy outside of CI. That's due to report to government before Christmas as well.
So wait, I'm just I'm just trying to be clear.
Yep.
The definition that's in SOCI that of a serious critical incident that requires reporting
Yes.
is there for the 11 critical infrastructure sectors.
Yes.
But the ransomware action plan that signals the introduction of a ransomware incident reporting framework, which will be broader
Yes.
than the 11 systems
For
or the
companies
11
with revenue
sectors.
turnover of over $10 million, I think,
Yes.
from memory.
So that definition, or the definition of what will need to be reported under that framework has not yet been resolved.
Correct. But
But it's
insofar
not
as-
necessarily the same definition as the SOCI definition.
Correct, and for this
Yes.
reason. So the legislation that relates to CI talks about significant impacts on the nation at large. So if your power system goes down, your telcos go down. There's a particular reporting sensitivity, 12 hours in the case of the most aggravated impact, 72 hours otherwise. Ransomware otherwise, which isn't going to have, if you like, an interdependent consequential impact that courses throughout your economy. It's not going to affect banking, it's not going to affect power, but it's critical for that company. In other words, that company's impacted. It might be, it's arguable, we haven't landed this with other agencies and other co-regulators, that such a stringent definition is perhaps not required or applicable for the general economy. And that's, Senator, just a function not to dismiss the impact of a company that's had all of its files locked up and it can't conduct business, but candidly, impacting a bakery is different from impacting the power grid.
And Senator, if I could just add a little...
we all like our bakeries, but...
The Security of Critical Infrastructure Bill 1 talks about a cyber incident, not necessarily a ransomware incident.
Right.
Yep.
So it could be any other type of cyber attack, whether it be
That's
for
right.
sabotage, damage,
Which is
whatever.
what I was trying to understand.
That's right. So a general economy measure that just specifically focuses on ransomware as opposed to cyber attacks that are affecting the general economy it creates a different kind of framework that you'd need to deal with. You can't use the same definition as you do for a general cyber attack.
Well, that's what I was trying to understand.
And so the first thing that we have been working with those in the sectors as well as our colleagues in the Australian Cybersecurity Centre is how would you know that it's a ransomware attack as opposed to just a denial of service attack in the first instance? So at what point do you get enough of a sense of the indicators, or you have actually been told by somebody that you have been ransomed?
Yes.
And so those sorts of parameters we're just working through in terms of, for an ordinary company, at what point would they be sufficiently aware that it's a ransomware attack for them to report? And we just need to go through that
And common
process.
sense would suggest that it's a function of whether there's a demand for payment, of which, and regrettably, though, the incidence of those types of attack is increasing. So whether we can modify the definition of a critical cyber incident to look at ransomware in the particulars as the government's asked us to is something that we're actively working on, and I certainly would like to get advice before the government sooner rather than later. We do need to work with a number of our colleagues in
So
other
it seems
agencies.
like you are thinking about demand for payment being a crucial aspect.
What is and aware that you've issued discussion papers. The government's got a
thank you,
policy
Mr.
paper
Pizzula.
on that. It's a very active.
Mr. Watts and I are very comforted by the fact you read our position papers.
We read everything very carefully. I mentioned in my opening statement the international communities focused on this. 33 nations met under the auspices of the White House.
Yes.
We're all grappling with a number of issues here. One, ransomware is certainly very topical, and it's hideously impactful, and it really affects particularly smaller businesses who literally look at that screen saying everything's been locked up, and unless you give us payment, we're not going to unlock it. And then you get into a whole lot of moral questions around payment, and no different from the physical world with hostage taking. But is that this season's concern? Is there another wave of malware that could be coming down? So we need to be careful to future-proof definitions, but I think in the first instance, common sense would suggest that a nexus to a payment, i.e. extortion, is probably the one feature which turns the whole definition.
Because you can imagine, just receiving a phishing email from a known initial access broker may not be sufficient enough to merit it as a...
Correct.
As
or your website might be being spammed for denial of service, just simply to render your business inoperative, but no payments demanded, and you see DDoS attacks occurring without a nexus to payment.
So, will this reporting framework, do you anticipate it will require legislation?
Well, certainly the elements that relate to critical infrastructure will, and I've dealt with that in my previous answer. One of the questions that the government's asked us to examine as part of the best practice regulatory framework is whether starting something voluntary, less than mandatory, shall we say, outside of critical infrastructure is certainly something that we're looking at. Yes.
And
we are conscious of regulatory burden.
I'm conscious of the Chair's concern about time, and I'm trying to respect her efforts to drive us to an agenda on time. Do you have any time frame on when that work will be completed?
I anticipate that the policy work will be completed this side of Christmas. Now, when government decides how to move forward, whether it's by legislation, regulation, voluntary codes, and I want to stress this is outside of critical infrastructure, so I'm putting that to one side. But in relation to the general economy, as I said, Minister Andrews has made it clear this is a very high priority for her.
I think she said time's up.
Sorry?
I think she said time's up.
Time's up. No, we're going hunting. We're using offensive capabilities. Once certain administrative arrangements are put in place, you'll see the AFP very active going against covert IT infrastructure. So her comments were well understood within government agencies in terms of their urgency. That's true. We are going on the offensive, and both. Well, Commissioner Kershaw wasn't asked specifically, but I know if he was here, he would say that. But certainly, Director General Noble, under the technical assistance powers that are available to her under the ISA legislation, they're hunting. They're hunting every night, I can assure you.
Okay, thank you, Chair.
So yes,
I imagine you want a break for.
Yes, I would like to finish outcome 1 at 6:30.
Oh, you want to finish outcome 1?
I would like to finish outcome 1.
I do have questions about disinformation, and I just seek the advice from you or the Secretary as to, and particularly, I refer to some questions I did ask previously of Dr. Richard Johnson, the FAS for social cohesion, and managing disinformation and responding to it. Which outcome is that most appropriately
disinformation typically has got a nexus to national security, so I would suggest 1.2.
So, Chair, I did want to ask some questions, but on that subject.
Well, what we might do, so you're seeking about another 10 minutes or so, are you, in relation?
Yeah, I would imagine that it would be about...
All right, look, I might just ask a couple of quick questions in relation to the issue of email and text scams. We will break for dinner, and then we can return to you, Senator Keneally,
Thank you, Chair.
After dinner. Mr Pizzula, as we just referenced briefly, many Australians are receiving scam emails and text messages. I've been receiving them daily, sometimes more than once a day. Senator Keneally, yes, just received one while she was sitting here in estimates. We heard from the Commissioner of the AFP that a member of his own family has lost money and been scammed, and many Australians have suffered as a result of these scams. What work is the department doing to combat the alarming increase in scams, and how quickly can you shut down these criminals?
In two parts, and very briefly, you might wish to revisit it later. It's not solely a function of working with the telecommunications industry to block some of the messages. I'll come to that further upstream, whether it's in relation to the new powers we have under Slate or under other cyber crime and cyber-enabled crime powers. The AFP is very actively engaged with international colleagues to go after the gangs that don't only engage in ransomware, time's up for them, but also other forms of identity theft, phishing, and so on and so forth. We just had a discussion with Senator Keneally about not being too restricted in the methodology of the malicious methodologies that we go after. But in terms of protecting you at your phone, obviously the Australian Cybersecurity Centre puts out a lot of advisory information that would be well worth reviewing in terms of what you can do to protect you yourself at the device level. There are certain things you can do, as does the ACCC in its consumer protection function. But for all of that, you put up all your defences, you've done the right thing, you've updated your software, you've downloaded the latest operating system, and you're still getting these blasted messages.
That's right.
We are in discussion with the telcos that provide your services. There are provisions. I don't want to be too prescriptive here because there's matters of law here, and we're still working through the legal issues with our colleagues across government. But under the Telecommunications Act, Section 313, there might be a possibility for the telcos to act as a authorised blocking agent. That is to say, it's unwanted. I don't want this to come to my computer. I don't want this to come to my phone. It's malicious. And Mr. Ablong's leading the discussion with the industry. We're actually the regulator, as it were, under the telecommunications security provisions of the Telco Act. So 313 might be applicable. There are some complexities there because there has to be a nexus to an offence. So scamming, click this link, may itself not be an offence, in which case our advice to government in due course might well be that legislative change is required. But the act of clicking might create a nexus to an offence. That offence might be identity theft, fraud, etc. So, Mr. Ablong, we're looking at this actively and with some urgency. Can you describe very briefly for the Chair?
Well, I am concerned to hear that you may not have the necessary powers to combat what is clearly on prima facie criminal conduct.
We think we do, Chair, insofar as use of a carriage service for all sorts of reasons can of itself create a criminal offence. The question that Council's looking at, our Council for the telco providers and others, and no doubt we're engaged with our colleagues in AGS and AGD as well, is whether use of a carriage service to get you to click on a link itself constitutes the offence, or whether it's a subsequent action taken by the criminal actor or the malicious actor to then take advantage of your clicking, that's the criminal offence, and in which case is the nexus too distended? And I think we're getting closer to a view with our legal colleagues.
That's correct, Chair. It would be equivalent to if somebody was to send you a letter in the mail, actual physical letter, rare though that is these days. The actual mail carrier isn't responsible for the contents of the letter. And so if there was something criminal in there, you wouldn't go after Australia Post for sending you a letter. You would...
but sorry, and nor would you ask Australia Post to block the letter?
To block the letter. And so the nature of the conversations that we're having with the telco sector at the moment is, do they have sufficient information at scale to be able to block the whole class of these spam messages? Or would they need to report each and every one that came in? So as you know, if you receive a piece of an email that's a scam email, you can send it to ScamWatch, and they then can block the specific internet service provider address associated with that email. Now, do you have to do that with every one of the spam SMSs that you get, in which case it'd be very resource-intensive activity, or can you do it at a matter of scale by saying this class of SMS that looks like this should be blocked. Now, there's a challenge in that, and as you mentioned earlier today, they say you're expecting a package. So how do you block that message from a legitimate message from Australia Post, Star Trek or DHL that says we're about to deliver you a package? And on the face of it, they look very, very similar. And so part of the challenge for the telecommunications companies as well as ourselves is to be able to define the attributes of the SMS message in a way that allows us to say, block the bad ones, but not the ones that are coming from Australia Post or DHL or FedEx. It's not a simple, this class we can block. It's about how you would classify the attributes of that class.
But I would suggest that this is quite an urgent issue that requires immediate action.
Yes.
We're working on it urgently, and I'm sure that if in the end, with colleagues in Attorney Generals and elsewhere, we come to the conclusion that there's a deficiency of legal authority, I'm sure that the Minister would be very keen to hear from us in terms of options around legislative change. But we are looking at the law as it currently is stated. Use of a carriage service for criminal purposes is a crime. But as Mr Ablong said, how would you, in a sense, distinguish those text messages that quite properly are saying the delivery is about to come and you're actually expecting it versus these criminals that use their own artificial intelligence and IT systems at scale just to spam out very authentic looking messages, often with just very minor errors, a decimal, a punctuation mark or a misspelling. How you would block that at scale is both a technical challenge as well as then potentially a legal conundrum as well. But we're not looking at it, in a theoretical sense. We are getting on with it urgently, I can assure you.
All right, thank you very much, Mr Bozzolo. As I indicated, we will now suspend for dinner and we will return at 7:35. Thank you. The committee is now in session. I hope everyone had a very lovely dinner. Mr Bozzolo, welcome back to the table. Assistant Minister Stoker. We are continuing with outcome 1 and I give the call to Senator Keneally.
Thank you very much, Chair. I do have some questions about disinformation and these are prompted by the fact that when the Senate Select Committee on Foreign Interference through Social Media asked what area of government was responsible for tackling disinformation, my colleague Senator McAllister got a different answer from Home Affairs, Finance, Attorney Generals and the Australian Electoral Commission. So what is Home Affairs' role in identifying, managing and countering disinformation, whether traced back to foreign interference or not?
So the starting point relates to our responsibilities to administer relevant legislation, including the ASIO Act that deals with security intelligence. Our starting point is state action. So disinformation is deliberate action to misinform for state purposes. So for us it's a vector or it's a tool or it's an instrument used along the spectrum of espionage and foreign interference. So we've got the very clear policy lead for that, and obviously ASIO's got the statutory security intelligence role. Now, disinformation, of course, can bleed along a spectrum very quickly into misinformation, where you might have information that is false, information that is deliberately or otherwise designed to distort public debate. It might relate to, for instance, vaccine efficacy. Let's just take that as an example.
Yep.
That would be misinformation. Our role there is a supporting role. Because of our tracking of social media, our deployment of analytics, our deployment of social media analysis, we can assist other departments, in this case the Department of Health, in terms of discharging their responsibilities in relation to accurate public health information. So Dr Johnson and his team amplify messages, for instance, around vaccines that relate to misinformation. We don't have a role in health, we don't have a role in therapeutic treatment, but we have tools that can assist the Department of Health with respect to misinformation. So if I confine my remarks, having set out that context, to disinformation, typically in my world, disinformation is a tool generally employed by state actors, state actors who have got a very deliberate intention, so there's an element of intent to, for instance, disrupt an election, to cause political division, to cause social cleavages within a society for a reason that typically falls under the umbrella of foreign interference. So we lead on policy and we lead on any advice to government around legislation. Now, Senator McAllister, you referred to, I think was given, I think you described it as different advice. Well, maybe it might be the proverbial elephant being assessed. Someone's got the trunk, someone's got the tail, someone's got the ears. If you're the Australian Electoral Commissioner, you're going to be concerned both about misinformation and disinformation within your statutory remit, the conduct of free and fair elections in Australia, and we work therefore very closely with Commissioner Rogers and his team through the particular lens that he brings to bear, which is electoral, and you asked about those matters earlier. I think, did you mention the Department of Finance? I think you might
No,
have.
I didn't.
No, sorry, can you go back?
Oh, I did, I apologise.
You did.
You're right.
So the Department of Finance, they are the Department of State that administers the Australian Electoral Act. So they will have a particular lens that is specific to that sector. That is to say, attempts to subvert our democratic practices and the conduct of our elections, whether it's through cyber, whether it's through disinformation or misinformation. And again, we play a partnering role. We don't administer the Electoral Act. We support the Department of Finance and the AEC. Could you assist me, Senator, by indicating which other departments, Senator
Attorney
McAllister?
General's, which I know manages FITS.
So the Attorney General's Department has got, and these are about associated areas of policy. So foreign influence is not of itself criminal. Foreign influence relates to transparency. So my colleague Catherine Jones, the Secretary of that department, has got responsibilities under her Minister, the Attorney General, to administer the Foreign Influence and Transparency Scheme, otherwise known as FIT. So disinformation is a technique, but we all have different statutory responsibilities and responsibilities as departments of state. So logically, disinformation shouldn't be counted with by a Department of Countering Disinformation. It's a technique. It's like saying cyber. I know this is a contested topic, but lots of people have got a stake in cyber, so inevitably you arrive at functional arrangements that look like a matrix. And that's just life, because it's ubiquitous, it spills over boundaries, as it were.
Yeah. Well, let me ask you this then. You made the point about misinformation and disinformation, and you talked a bit about the role of Home Affairs in assisting, say, the Department of Health. Now, there does seem to be a page on the Home Affairs website in relation to misinformation and truths about coronavirus. You know, that whether or not COVID-19 is a hoax, whether or not vaccines are safe, whether or not it's a cover to collect your DNA, whether it causes infertility. I mean, it's quite an extensive page. So clearly the Department of Home Affairs has some role in terms of countering misinformation. You don't just leave that to health. You don't provide them analytics and say, there you go.
No, indeed. So we've got a very active role in supporting the lead Department of Agency. So in that case, and Mr Kefford, who is also the Foreign Interference Coordinator, but he's also very helpfully the Social Cohesion Deputy, can assist me with any further evidence here. But the content there would be generated by health professionals. So we would take the content from the Department of Health. We would not generate our own content. We wouldn't do any research. We wouldn't have any role at all in providing the Australian public with advice on therapeutics. But because our networks are different from the Department of Health's networks, we amplify their messages through our channels, through our website, through our social media, and I would describe it, Mr Kefford, as an amplifying role, especially in relation to misinformation, noting that misinformation, the I won't say a very different kettle of fish. It's similar because some of the techniques are similar, but typically the attacker is different, and therefore the responses need to be dealt with differently. But to the Senator's point about our website, the material that we have on countering COVID misinformation, we would, I think it's fair to say, have no role in generating that content. We might work with health to present it in a way that's accessible, particularly for culturally and linguistically diverse communities, but we don't have a separate public health mandate from the Department of Health.
No, that's correct, Secretary. So, Senator, what we've done in that context is work with health to, health develop the messages, which we then, as the Secretary has described, amplify both on our website, as we have done with COVID information since the start of the outbreak, as well as using our regional directors and community liaison officers in the states to pass that information directly to community groups.
So, Mr. Kefford, a couple questions arise out of this. One, do you measure the reach of this page to see if the efforts are working?
Senator, I'd have to take on notice the specifics about access to that particular component.
Right, okay.
But we do have metrics around access to our website
Indeed.
pages, and so we could take that on notice and answer it accordingly.
Right.
And Senator, as part of that, as I say, there's been over close to 17,000 engagements by our community liaison officers and regional directors through the course of the pandemic, staying in that topic, and so we're getting very clear and quite swift feedback from the communities about where this information that needs to be counted is existing and how we can provide that in a way that is accessible and useful.
Do you see this primarily, do you see this role of the Department of Home Affairs in providing this information, primarily through a security lens?
No.
Is it a CVE? Is it a health matter?
In relation to...
I'm trying to understand, why is the Department of Home Affairs running
In
these
relation to coronavirus, it would
questions
be
and answers?
largely in relation to using our amplifying reach, so the engagement that we have with multicultural communities, ethnic community leaders, our ability to translate material quickly into diverse languages. So we see that as a supplement, or as think of it as an extension to the role played by the Department of Health. And like all good public health messaging, it's about public confidence, it's about informing public behaviour. And in that sense, I suppose, in a larger philosophical sense, you could say it's about social cohesion. In other words, a better informed public can make decisions on the basis of the same information, whether it pertains to vaccination or to other matters, and you'll have a community that's more cohesive. Disinformation, you make reference to violent extremism and a security lens. Disinformation, as I said earlier, is more sinister. It is related to conscious state action and typically delivered by state actors, but through a foil or, if you like, through the veil of other actors. It has a different resonance, and therefore the analytical tools we apply to it are different, how we respond are different, and we potentially engage in aggressive, offensive actions, how shall I say this, to counter, which we can't easily discuss in an open forum. Violent extremism sits somewhere in the middle. Some violent extremism is an extremely distorted, extended version of misinformation, which might be to do with the twisting of beliefs, the twisting of theology. So that can be misinformation that starts to become ideated in the minds of people who might not be violent in the first instance, but they become violent over time. But there can be, in some cases, a very sinister form of disinformation, which is designed to create racial and other discord, which can then lead to acts of terrorism, which on their surface might be ideologically or religiously motivated, but they might have, sitting underneath them, a very sinister, deep, motivating drive.
I have a range of other questions on this matter, but I might put them on notice in interest of time in the effort to try and land this hearing today. Because we do have several areas of questioning outcome 2 and 3, but that's very helpful. Thank you, Mr. Pizzullo.
Thank you, Senator.
Thank you very much, Senator Keneally. We are now going to move to outcome 2. And
yes,
I would like to
I think Senator Grogan
ask
has
who
some
is seeking the
questions.
call in relation to outcome 2 questions.
Senator Grogan would like to.
Senator Grogan.
kick off, please.
Were you going to start?
No, I think, I thought you
That's
were.
right, we'll just,
I thought you were Senator Grogan.
just standing by.
Stand by. What page are we on? 22, okay. Was I going to start?
I'm happy to, but I thought that was...
Okay, I'll kick off then.
All right,
Senator
you'll kick
Grogan.
off. Senator Keneally, thank you so much. You have the call.
I note that the Senate Foreign Affairs, Defence and Trade References Committee inquiry into Australia's engagement in Afghanistan, there weren't any officials from Home Affairs there. Why was that?
Senator, sorry, on which
The
occasion?
11th of October 2021. Were you not invited?
No, I thought departmental officials did attend.
You didn't attend?
Well, no.
Secretary Priscilla?
You asked me about officials. My officials attended.
Sorry, I apologise. You did not attend.
That is
That's what I'm
correct,
trying. Were you invited?
I think the department was invited. I don't think the level of officer was specified.
Right. Is there a reason why you couldn't attend on that day? It's a pretty significant, was a pretty significant operation by the department and a pretty significant moment for Australia. I'm just trying to, was there another, did you have another engagement?
No, I don't dispute that characterisation, but Deputy Secretaries are very senior officers, and particularly in terms of being able to speak to questions of fact, I had every confidence in the officers that I sent to that inquiry.
Can I ask you, if you can't recall now, to take on notice if you had a conflicting engagement?
No, I'm pretty sure I didn't.
Right, so you just chose not to come?
Well, it's not a question of choosing not to come. I was confident in the officers that I signed the duty to.
Okay. In answers to questions on notice, sorry, I apologise. Actually, what I might do, Senator Grogan, do you want to proceed with your questions, and I'll come back to the ones I was going to.
Sure.
Thanks very much, Senator Keneally. Senator Grogan.
Thank you. The Safe Haven Enterprise Visa is for people who arrive in Australia without a visa and are seeking asylum. All states and territories are part of the CHEV arrangements, although not all parts of all jurisdictions are included, because it's divided by postcodes. In 2016, the whole of South Australia opted in to the scheme by the Weatherall government. But the main difference between the CHEV and the temporary protection visa is that the person must intend to work or study in a regional area.
Correct.
So after 5 years on a CHEV, the person can then apply for a permanent migration visa.
That is correct, Senator. Yep.
Can you tell me how many
Having, from memory, worked or studied in the designated area for a period of 42 out of 60 months. So you've got 5 years, which is 60 months, and then over that period. So these are amendments that were made to the Migration Act in December of 2014. You have to be able to demonstrate, not continuously, but within a 60-month period. I think from memory, Mr. Wilden will assist me if I get this wrong. 42 months of which 42 months of which have to consist of either work or study in a designated CHEV area. I can't quite remember what the designation is. It is done by...
No, that's fine.
It is done by postcode references, I recall.
It is done by postcode reference, is my understanding. So how many of the CHEV visas have been issued for South Australia since the state government opted into the scheme in 2016? Do you
Mr.
know?
Wilden, do you have that information?
I'd have to take on notice how many in South Australia opted, but I'll come back. Sorry, David Wilden, First Assistant Secretary, Refugee, Humanitarian and Settlement Division. I don't have a state-by-state breakdown on the CHEV participants at the moment.
Do you have the national numbers there?
I would have somewhere.
And so you're referring to grant, so where a visa's been granted?
Yep.
Right. So CHEV grants.
So CHEV grants. In terms of total, there have been 12,880 CHEVs granted and 5,000...
Sorry, over what time period, just to be clear?
That's as at 31 August 2021, since the program began. 12,880 CHEVs granted and 5,187 temporary protection visas granted.
Okay. And how many of those are from Afghanistan?
Well, I'll have to come back. It may be buried deep in... We have many, many stats that we brought around Afghanistan, so I don't know if Ms Pfeiffer, who's also with us today, may have those figures, but I might ask her to check her papers as well.
I think we can officially say it's tonight.
Yes.
I think Ms Pfeiffer is with us tonight.
Tonight,
Sorry?
correct.
Sorry, Mr Bouzlot, I didn't hear your response.
Ms Pfeiffer, I believe she's here tonight. I was just distinguishing between her being here today and even though it's all artificially lit in here, I think it's night time.
I'm not sure that the sun has actually quite set, but...
How many Chev have actually transitioned into a skilled migrant visa, if there's any transition into that
I can give you
category?
some data on that, yes. So in terms of, and again, these are the national figures, not specific to South Australia. The first step is you apply to see if you meet that criteria for consideration. And we've had 36 requests have come in. Of those, 26 have met the pathway requirements, 7 have not met, and 3 are under assessment. And that can be obviously for a range of visas that they can qualify for. But to date, none have had any granted. So that just means that there are, of those 26, we're either awaiting application or the application has come in but is not yet a decision.
Okay.
And it probably should be pointed out to the Senator that Chev's also got a particular application to illegal maritime arrivals.
Correct, yes, yes.
Okay. So with the Chevs, can you explain how a person on one of those could have an adult sibling denied one despite them arriving on the same boat? So coming to your maritime point, if you had 2 siblings coming on a boat, one gets accepted and one does not.
Accepted into the Chev program?
Yeah.
Well, that would come down, if it's the Chev program versus temporary protection, that would come down to the visa that they applied for. If someone was rejected, that comes down to the fact that their individual claims, and remember, every claim for protection is individual and based on individual circumstances. So the fact that they are siblings does not mean they have identical claims. So a refusal and an acceptance for 2 family members probably means that their claims were different.
And would they need to be vastly different? I mean, I get that there are very stringent
Well, they'd have to be
requirements.
sufficiently different that one met the threshold for protection as defined through the Convention and many, many supporting documents. One had met that threshold and one had not. Or similarly, just to be clear, one may have met the Chev based on where they were going to be living, and the other one, if they weren't living in the same area, may not.
I was just going to say, Mr. Wilden, and so it's because this is an anonymous case, it's not known to us, and so we just need to be careful about how we're answering it. But the denial of a type of visa when you're speaking about refugee and humanitarian turns on a number of issues. The primary issue relates to a well-founded fear of persecution, so the first part of Mr. Wilden's answer is applicable. So it might be that there are different circumstances. One might have, and again, I'm just speaking hypothetically, I don't know this case at all, and I'm not suggesting that you better inform us in a public place, Senator Grogan.
Indeed.
But it might be that one sibling, because of their employment, because of their political activities, because of their some other characteristics of their former life, attracted a degree of persecution that met the test of well-founded fear of persecution. It might be that the sibling, and again, I'm not seeking a comment on the case, I don't know it at all, had a lesser fear of persecution, as it were, because they couldn't satisfy us that they had a well-founded fear of persecution because of employment, political beliefs, religious beliefs, and the like. The other factor, though, that relates to Chev is one might have been willing to live in a regional area and presumably the other one perhaps didn't. So it really turns on what was the reason for the referral. Was it around protection or was it around the conditions of the Chev visa? They're 2 quite different things.
Okay, can you maybe take us through what the Chev scheme, it appears to have limited impact on addressing labour shortages, which was part of the idea of putting them into regional areas, was to actually assist in that in the agricultural sector, particularly in South Australia?
I just take a very slight exception to the characterisation. I was Secretary of the Department of Immigration at the time that Mr Morrison put the legislation through the Parliament. It was an amendment to the Migration Act that was designed to provide a pathway for those who otherwise couldn't get permanency because of the mode of their arrival.
Yeah.
And the agreement that the government struck, as I recall it, with crossbenchers, I believe, was that if persons were willing to live in regions or study in regions, not to the extent that it would have had additional benefit of assisting with regional labour issues, true, but if people were willing to basically do that 42 out of 60 months that I spoke of earlier, to demonstrate a commitment and a commitment to Australia, then that was the only circumstance in which the government, the then Abbott government, was willing to contemplate them being able to then make an application for a permanent visa, because otherwise temporary protection doesn't allow for a pathway to permanency. So I don't know I'd agree with the characterisation that it was designed to, I think you said something like alleviate or address regional labour issues. That was, I suppose, an ancillary benefit. The purpose of the amendment was to give people who'd arrived by boat, to use that phrase, who had no other pathway to permanency, some pathway to permanency, albeit after 5 years of demonstrated behaviours.
So I guess, do you have a set of statistics you can maybe take on notice around where those people have worked and what that looks like in terms of contribution towards the agricultural sector?
Well, given what we said earlier about South Australia, we must have it by region.
Yeah.
Well, we do. So we know where people are.
Yeah.
We can give you some data, I think, on employability, but of course COVID has had a fairly good impact on that. What we were finding was that people on TPVs and Chevs in regional areas had very good employability, so their employment rates were very high.
Well, I mean, that's certainly what we've seen in South Australia. We have serious challenges in those areas. So one would assume or make an assumption that there would be a good level of employment. So I'd be really keen to see those statistics, both for South Australia but also for Australia as well.
The only qualification I'll provide on our, in relation to how we'll come back to, is that the requirement is to work or study.
Yeah.
So some people have exclusively studied, some people would have exclusively worked, and other people would have undertaken a mixture. Yeah. But we'll, as best as we can, get that data.
Can I just go to the one last question? I've only been given another minute. Very concerned about the safety and stability of people from Afghanistan coming over here. Obviously, we're all aware of the situation. And how that safety and stability of those people arriving here is going to be measured by the department, and what the situation then is for any sort of further repatriation. Any repatriation?
Well, I'll deal with the first part of the question, which relates to those who have arrived, but particularly since the fall of the former government and its displacement by the Taliban regime. We have a Coordinator General of Migrant Services who reports directly to me. She provides an integrated end-to-end service, working in consultation with state and territory, and in some cases other organisations such as community groups, sporting groups and the like. We have a range of providers who are contracted providers. They typically operate state by state, although some of them have got overarching national head organisations. These are well-established settlement and integration providers who are very skilled and adept in relation to trauma issues, in relation to employability that was mentioned earlier, language training, supporting youth, so helping newly arrived parents to helping them navigate the school system, childcare, access to government benefits, access to Medicare and health care. So we use a range of service providers that our Coordinator General, Ms Larkins, could speak about at some length. Mr Wilden's got a general awareness, but we've got a dedicated unit that sits alongside Mr Wilden's division. And we very much are focused with the Afghan community here in Australia. Mr Hawke, the Immigration and Migrant Services Minister, set up a consultative group to ensure that, if you will, an end-to-end arrangement is put in place that deals with everything from mental and emotional and wellbeing issues through to employment, through to income, through to becoming acquainted with Australia. The very basics about, even if you get English language training, apparently there are some idioms and some cultural practices here that take a while to get familiar with. And so those service providers, under the auspices of our Migrant Services Program, provides that end-to-end support. Now, we've got great partners, I should add, in state government, territory governments, faith groups, community groups, sporting groups. A lot of business associations, indeed individual companies, are coming forward saying we'd like to participate, we'd like to open up employment pathways. We've got some great Australian companies working with these providers, and Ms Larkins and her team coordinates those efforts. Mr Wilden, would you care to add anything?
Look, the only thing I'd say is in terms of the engagement, it's regular with state and territories. We meet weekly to talk about how it's going. In terms of the initial settlement, because of quarantine requirements, we did make sure that people were contacted. They went into their quarantine and then were put in contact while in quarantine. We had some wonderful generosity where, tablets and phones and all that were provided for people already in quarantine. They were introduced to their providers, and then obviously upon exiting they were taken to their accommodation and they get on their settlement journey as the Secretary outlined.
Thank you very much. And Senator Grogan, thank you for your questions.
I didn't address the question about repatriation, but
yes, Mr Pezzullo, if you want to finish your answer.
It might come up in subsequent questions, or...
please finish your answer.
In terms of repatriation, I'll take that term, Senator, in its larger sense, i.e. people coming from Afghanistan here to Australia. As Minister Hawke has made clear, whilst the crisis phase of the evacuation has come to an end, there is an ongoing effort, and as he said publicly, in some cases been done very discreetly, and in some cases in relation to people who are at significant harm and vulnerability, to assist through lawful means people to both leave Afghanistan, but more particularly people who present, for instance, at border crossings, or who might have presented elsewhere because they got on a flight, they ended up somewhere, and then they hold up a bit of paper saying, actually, I've got a visa for Australia. So there is an ongoing effort post the, if you will, the crisis phase to undertake some ongoing repatriation efforts. And then on top of that, although obviously it's going to have to be synchronised with that, is the government's allocation of at least 3,000 places in the refugee and humanitarian program. The Prime Minister has described that allocation as being a floor and not a ceiling. The policy settings for that program, in other words, how applications will be considered prioritised, is still a matter that the government is actively considering. So if I can divide into three phases, there was the crisis with the fall of Kabul, the airlift and the other matters that became globally known. There's the period that we're currently in now, which is targeted, limited, highly discreet, in some cases very sensitive repatriation efforts. And then there's the program, which will consist of at least 3,000 places, if not more, because it's a floor and not a ceiling, where the government will be making some decisions in the near future and no doubt then making some announcements as well.
Thank you very much, Mr Pezzullo, and thank you, Senator Grogan. I am going to go to Senator McKim, but Senator Van has just indicated one quick matter he wishes to raise.
I just wanted to pass on the thanks of the committee for the work you and your department did, both helping me in my office and I'm sure many of my colleagues in helping get people out of Afghanistan, helping them now. It's been a wonderful effort, and I'm sure the nation thanks you completely.
Thank you, Senator. I'll ensure that each of the officers who did the actual work are advised of your...
especially those who are on the ground in Kabul.
Yes, no, thank you. I'll make sure that's passed on. Thank you.
Thank you.
Thank you very much, Senator Van. I'll now give the call to Senator McKim, who is attending by way of telephone conference. Senator McKim.
Thank you, Chair. Just on the situation around visas for people who are or were in Afghanistan, can I just start by asking, please, since the fall of the former Afghan government and its replacement by the Taliban, how many visas have been issued to date to people who were or are in Afghanistan?
We've answered a number of these on notice, and so some of those answers, Mr. Wilden, might have a bearing. Do you want to lead off?
Yeah, certainly. So just to clarify, Senator McKim, when you say were or are, what because obviously there's many moving parts to Afghanistan. We've been granting visas to Afghan nationals for a very long time. Just help me give an accurate answer. I just appreciate some guidance on if you're talking about a particular time frame or a particular visa type, or are you just looking for sort of broad numbers?
I was just after a total. We can talk about the different classes of visa in a moment, but basically since the fall of the former Afghan government.
Okay, since the fall.
If you have that time frame, I mean, what I'm trying to get to is, as Mr. Pizzullo has just outlined, the Prime Minister first committed to 3,000, then later on said that was a floor, not a ceiling. So, how many have been issued, and in particular, how many 449 visas have been issued since the fall of the former Afghan government?
Certainly. Thank you, Senator Kim. That's very helpful. So there's 3,507 people who have been evacuated who were visa holders. And the subset of that, there's a range of permanent visas which included partner and refugee visas. There are a very, very small number of child and orphan visas, less than 5. And then in the temporary, there's obviously the largest cohort was the 449s, and there were 2,844 who have been granted and who've arrived in Australia. And then smaller numbers, including temporary work, uplifted and arrived in Australia since the fall of Kabul.
Thank you. And what about people who remain in Afghanistan? Do you know how many visas have been issued to people who are still stuck there, including 449 visas?
We don't know how many people are in Afghanistan. That's one of the challenges, obviously. There's been a number of visas granted across a number of categories. Some of the people had their visas granted 2 or 3 years ago and have never presented at an Australian border. So we can't say with any certainty how many people are in Afghanistan. People are crossing borders. We hear of hundreds into Pakistan every week, hundreds into Iran. We have people with 449s popping up in all manner of countries who have either been evacuated by other nations as part of that process or have made their own way there. So there's no accurate figure I can give in relation to how many visa holders are currently in Afghanistan.
Okay, so you've said, I think, 2,844 449 visa holders in Australia. How many 449 visas were issued in total?
I'll just see if I can find that, or if Ms Pfeiffer already has that to hand, she can jump in as well, but I'll just need to go through my papers.
Thank you.
Yep. So do you have the visas granted who have not arrived, Ms Pfeiffer?
Certainly. Sally Pfeiffer. I am the Assistant Secretary for the Humanitarian Program Operations Branch. The total number of subclass 449 visas granted is, up to the 12th of October, is 5,337.
And just to be clear, we are talking there in that 5,337, they were issued to people who were in Afghanistan at the time of issue. Is that right?
No, we can't be certain of that.
No.
Senator McKim, this is the difficulty that Mr Weldon was referring to. Visas are issued in relation to a person's nationality, not in relation to a person's locality. And it's entirely plausible, as we work through the data with like-minded countries, with our partners, that people who might have gotten out, if I can use that term, by way of a land border, people might have gotten on one of the commercial flights that have been recently started to be resumed. Some people, in fact, have come to notice who were lifted out by coalition partners who subsequently said from, I won't name the countries, but let's say like countries or comparable countries, actually I've got a visa here from Australia, and we're being contacted by that jurisdiction to say, I think we've got one of your visa holders. So it should not be assumed that a simple mathematical netting off of the visas in our system, which, as Ms Fife has indicated, we know the number of visas that we've granted because they're in our system, and we know the number of visas that attach to arrivals because they've come through the border. It should not be assumed that the subtraction of one number from the other gives you the number of people who are in Afghanistan. We just simply, don't know.
Perhaps I wasn't being clear. What I'm trying to get at here is I assume that when we are given that total of 5,337 449 visas, that none of them, for example, were from South Sudan or Vietnam or...
No, indeed. As I heard Ms Pfeiffer's evidence, it related to the number of that temporary stay visa that relates to Afghan nationals. Is that right, Ms Pfeiffer?
That is correct, Secretary.
So you're right, it doesn't relate to persons who are from South Sudan and other places. What I'm saying to you is that when you asked her the question, or when you asked the question about their locality, I'm just saying we cannot be sure. We don't know.
No, I appreciate that. Thank you. That's clear. Thank you. Now, 449 visas are time limited, 3-month visas, and we are, I'm not exactly sure, but somewhere around about 2/3 of the way through the 3 months if someone was issued relatively soon after the fall of the former Afghan government. What is the intention for people who are still in Afghanistan on 449 visas and are watching their visas tick down?
Mr Hawke has sought and is receiving advice on his options, and he's giving that matter very active consideration. He has not made a definitive decision that I'm able to share in this forum, but it is certainly a question that is constantly under review. He's very alert to the temporal stipulations of that visa. It is a 90-day temporary stay visa, and it's only with the exercise of his discretionary authority that persons can apply for other visas. He's also conscious of the fact that there are other tools potentially available to him in relation to the group that you've just described. So not speaking for Mr Hawke, but understanding the direction that he's given us, he's giving those matters very active consideration.
All right, then 2 follow-up questions, please, Mr Pezzullo. Is one of the tools that is available to Mr Hawke, I'm not suggesting that this is, I'm not asking you what he is going to do, I'm simply asking is one of the tools that is available to Mr Hawke to roll the 449 visas over in some form, either to extend them or to grant new 449s? Is that available to him?
Yes, and in terms of the legal form, and Mr Wilden, if you have to be assisted by Mr Vo, I'm not sure if it's about the issuance of in legal terms, whether it's the issuance of a new temporary stay 90-day visa or whether, quote, it gets rolled over. I can't quite remember how the phrasing of the statute, but extending is certainly available to the Minister, correct?
Yes, the Minister can make several decisions. The only question would come down to the tools that he needs to do that, be that through changed regulation or policy. But the option to either conceptually roll over, so continuation of the existing, or reissuance are both available to the Minister.
In other words, the law doesn't preclude, it doesn't say 90 days the visa expires without any replacement.
The current visa is for 90 days,
yes.
So that is its current limit in its current form,
that's right.
But the options are several were the Minister of a mind.
Yep.
All right, thank you. Has the department provided Minister Hawke with advice on that particular issue? That is the case of the 449 visa holders who remain in Afghanistan. And when did that advice?
Well, whether again, I go back to locality. It's independent of locality, but in terms of
all right, so to Afghan nationals.
Afghan nationals, in terms of his options, he's been the beneficiary of several rounds of advice as to when specifically advice around. Are you asking about advice in relation to extension or rollover?
Yes, or any of the other tools.
Or other tools,
toolkit,
sorry.
you put it.
Mr Walden?
So yes, several pieces of advice have gone up to the Minister in relation to the 449 cohort. I couldn't have the dates off the top of my head, but certainly since, if you like, we ended the evacuation phase, we have provided several pieces of written advice and we have briefed the office regularly.
All right, and can I ask just finally on the issue of 449 visa holders who remain in Afghanistan, and I can assure you there are some because they're in touch with my office. Obviously, I don't know how many there are. It wouldn't surprise me if there was a couple of thousand at least. Have they been contacted at all, to your knowledge, in terms of by either your department or the Minister or the Department of Foreign Affairs? Because the contacts into my office are that people who are holding valid 449 visas have not been contacted by the Australian government in terms of the fact that their visa is going to expire within a few weeks.
Mr Wilton?
Yes, we have, and Ms Pfeiffer may have the date, or we may have to take that on notice. We sent out, so the same contact details that we had for the issuance of the invitation and the issuance of the visa, we did send out, probably a month or so ago now, advice to people that they have the visa, that the visa is valid for 90 days, and that we would come back to them with further information as it became available. We also, I think at that time, encouraged them to look at permanent visa pathways. But Ms Pfeiffer may have something to add to that.
Nothing to add, that's correct.
Okay, no, so we'll come back on notice with the date that was sent out. And that was sent out to all the primary holders, so not every individual, because obviously there was large family groups, etc. But where we had a primary contact address, that was where the email was sent to in the first instance.
All right, thanks very much. Is it still...
Just make this the last question, please, Senator McKim.
Yeah,
Thank
sure,
you.
Chair. Just to indicate to you that
Sure.
I do have many other questions in this outcome.
Okay, thank you.
So happy to come back to me later. Can I just ask last question on 449s? Are any 449s still being issued to people who are in Afghanistan, or are people simply being advised to apply for refugee and humanitarian visas?
So at the moment, for people in Afghanistan, we aren't issuing the visas purely and simply because we don't know if people can get out, and processing of visas obviously is a challenge in country. Where people present outside of country and have claims links to Australia, may have already received a letter but not a grant, then yes, they are being processed at the direction of the Minister.
Thank you.
If I could just ask... All right.
Senator McKim, we will need to share the call around. We will come back to you, bearing in mind that I am going to need to stick to the program this evening. So if everyone could just be mindful that we do need to wrap up outcome 2 as close to 9:15 as we can. I'll now give the call to Senator Ciccone.
Thank you very much, Chair. Now, I just wanted to touch on the government's announcement with respect to the agriculture visa. When was the department made aware of the government's intention to establish this visa?
Well, we provided advice on the design of a visa, or at least its broad outlines, when we were advised of its intention.
Sorry, Mr. Pasilla, could you speak up, please?
I'm just advised of the government's decision. I mean, its intention to introduce a visa has been a matter of public record. We've had discussions about it at numerous estimates. So the intention to introduce a visa, I'm not sure is something that I can readily call to mind, but advice on the government's decision to so establish a visa, an agricultural visa, Mr. Willard?
My question was, when was the department made aware, first?
Yes.
Second bit, of its intention then to establish the visa. So are you able to provide me with two subsets there? When were you first told?
Well, it's been a matter of long-standing coalition policy to have an agricultural visa, so I suppose we've been aware of the government's intention to have such a visa for some years. But in terms of the form that the government finally settled, which was recently announced, we obviously contributed to the policy development and to the features of said visa. So it's not so much awareness of its intention, because...
Okay, well then the next question then, the establishment. When were you advised by government?
In terms of the decision to establish it, we would have seen the Cabinet decision when everyone else saw it, I suppose.
Michael Willard, First Assistant Secretary, Immigration Programs Division. Yes, so the agricultural visa was announced on 23rd of August 2021.
I'm aware of when it was announced, but just mindful of time, when were you made aware of the decision?
Well, it was a subject of a cabinet process. So, I mean, we write the cabinet submission with other departments. So, I suppose at that stage we have.
Can you tell me a month? Like, it was this year, so.
Well, they didn't hang on the announcement. So the decision, when was the decision made? In August sometime, wasn't it?
Yeah, I would have to come back with the precise details of when the decision was made. It was either July or August.
So July or August, okay. And in terms of the design feature, were you not asked to provide advice to Cabinet?
Yes, of course.
So you would have been, I guess, aware prior to Cabinet making a final decision?
Yes.
Okay,
Yes.
so when were you then asked to provide advice?
In terms of the final shape, because
yes,
because this thing's evolved. The idea of an agricultural visa has evolved over quite a period of time.
We've had many discussions here at Estimates, but...
we've had those discussions here. In fact, I've been asked about the government's intention to introduce such a visa on quite a number of occasions. But Mr Willard, taking the question to be the visa that was finally settled upon, in other words, its design, when did we provide advice by way of input to submissions and the like?
I would have to come back with the precise dates in terms of advice on that.
Do you have a month?
Mr Willard has taken that on notice, Senator Ciccone.
He's taken on notice the precise date, but I'm asking if provided a month.
Well, it would have been in the lead up to the cabinet decision, I'm assuming. Senator, if I can reassure you, it didn't fall out of the sky as a complete surprise to us.
No.
We are the technical experts on the Migration Act. We would have provided advice on the Migration Act, whether it was July or June.
Was advice also provided to government with respect to this design to go beyond just horticulture sector, to also provide advice with respect to fisheries, forestry and meat work?
We're starting to get into the specifics of advice. I'll take some guidance from the chair. It seems so long ago, but I remember the chair reading out the standing orders that pertain to...
I just pulled out my little book about
when
the,
advice
the
is
nature of the
tendered
advice.
and the general nature of advice. But once you start to go, did you advise this option versus that option? I mean, you might as well just be reading out the cab sub, I suppose, at some point.
You've got that. Please provide that.
That shoe always drops on the other side. I've been here for so long. You know, when you. I don't have another side. So. Well, except for you, Senator Patrick. Yes, you're consistent.
And I ask because the many discussions we've had in estimates, there was always this discussion around an ag visa at the agriculture industry. When the announcement was made some months ago by government, it's obviously not just agriculture, it's meat and forestry and fisheries. What advice had you or your department relied on to government to expand, I guess, the design just from agriculture to include those other sectors?
You've couched the question, what advice did we rely upon? We rely on the knowledge that we have of the Migration Act, and we rely on our own professional expertise and judgment in relation to how the Act or visas under the Act are best administered. As to the government's policy intention, meatworks, fisheries and so on and so forth, that's a matter ultimately for government. You asked me earlier, when did we advise about the expansion, and I provided a bit of guidance to myself, which the chair seemed to validate. Once you start to answer that question, you're really starting to particularise the type of advice, and I'm reluctant to do that, certainly without checking the record.
Question? Is your answer then that the policy design, that is what sectors it covers, how...
Or the policy objective, perhaps.
The policy objective is by the Department of Agriculture?
Well, no.
And you don't have a role in it?
The policy objective
Are you a mechanism or are you a policy department when it comes to the agriculture visa?
Understood. The policy objective is always a matter for the government of the day, whether it's the permanent program, the temporary program, the chefs that we spoke about earlier, or agricultural visas. So the Minister for Immigration administers the legislation. He looks to us to provide advice on efficiency, effectiveness, the functionality, if you like, of the administration, what the government's trying to achieve with particular types of visas, get more skilled workers, address labour shortages and the rest of it, is a function of intergovernmental or interdepartmental consultation. So the agricultural department's obviously got a concern for its sector. The Treasury's got a concern about population. The Industry Department's got a concern about skilled workers in high-tech industries. We're a policy department insofar as we advise on the policy of administering the immigration program, ensuring that compliance enforcement can be effected. But as to the vitality of our fisheries industry, I'm not the expert.
So is that something better suited for agriculture?
I think my colleague, the Secretary of Agriculture, knows a lot more about fisheries than I do.
Or DFAT? Because I understand DFAT's now the lead agency.
Not quite.
With respect
They administer a Pacific and... there are two schemes here. There's a Pacific Labour Scheme and a Seasonal Worker Scheme. DFAT administers one of them, the Pacific Labour Scheme. But Senator Keneally was asking me about the policy objectives about how to address workforce shortages, for instance, in fisheries. That question is best directed to my colleagues at Agriculture.
Are you saying DFAT's not the lead agency for the ag visa?
On the Pacific Labour Scheme, they certainly
Well, I know
are.
they are for that.
Not the PLS or the SWP. We're talking about the ag visa.
Mr.
Which
Willard.
agent? So
Which
which department is the
agency
lead agency?
Mr. Willard.
There's a number of agencies involved in the Australian Agriculture Visa. The Department of Home Affairs provided the framework for the visa within the migration regulations, and the regulations came into effect on the 30th of September. Department of Agriculture is closely involved in terms of settings around the visa and input in terms of engagement with the sector, and the Department of Foreign Affairs and Trade is involved in terms of managing the program that the visa supports, and that's the similar to the work that I've been doing in respect to the Pacific Labour Scheme.
Is there not a lead department on this?
Well, it depends on the question. Who issues visas? My department. Are there any decision makers in other departments? No.
So ultimately, your department has the final say who gets to come into the country.
Yes,
on,
we
on
issue
this
the visa, and we
Okay.
also do border clearance. But do I concern myself with how many welders we need in
I'm not asking that. I'm
but
not
it's
asking
the same
that.
point. So every department that's got a stake in a sector, be it mining, resources, fisheries, forestry, etc., have got policy objectives that they wish to pursue. They come along to us as, if you like, the recruitment agency of Australia, and they say, do we need a new visa for this, or can you modify an existing visa? We say, well, you're better off either introducing a new one or panel beating one that we currently have. Once that decision's taken, there's only one authority that, if you like, issues the visa and ensures compliance and enforcement. That's my department,
Okay.
as a matter of law.
Does your department then look at the impact that such a visa will have on other labour agreements?
Other labour agreements.
So you might have a HILO, for instance,
Oh, I see.
or a DARMA.
Yeah.
So in terms of visa design, all the other options around visa arrangements are taken into account.
Senator
Has your
Tony, do you
department done
have-
any-
we might just need to wrap your time up. Can you finish with one last question in this block?
No, not really.
If I might flag, we have a number of
I
questions.
know, I realise you do, but I do have Senator Patrick here, so
Oh, no,
I do.
I'm not disputing Senator Patrick. should be
So
able to
I would-
answer. I
what
just
I-
want to flag that,
Alright.
and with the greatest of respect, maybe if we could have shorter answers, we could also move through more quickly.
Has your department done any modelling?
Of course, Mr. Bozzolo, it is up to the witness as
Of course,
to...
but I flag that we are all united, I think, in the aim of not having a spillover day.
We
and I
would all
would
like to
presume the
finish by,
department
that's
would
true.
share
We are
that aim.
united in that aim. I will now give the call to Senator Patrick, as he indicated he needs about 5 minutes. Senator Patrick.
Thank you very much, and I hope I'll be quick. My questions relate to prospective marriage temporary visas, class 300. My understanding the way these work is that you apply for the visa, sometime later you are successful or unsuccessful. If successful, you then have a time period to then come to Australia and get married. And of course that's been fettered by COVID. My understanding is the department has in some cases issued extensions, but in other cases, and in particular I've got a constituent where they were coming from England, didn't get an extension, been offered a refund, but don't really want to go through the couple of years processing time. Now in a response to my constituent, in a letter back in September, the department said it's aware of the adverse impact of COVID-19, and then went on to say we're considering various options for assisting prospective marriage visa holders adversely impacted by travel restrictions and whose visas will expire in the coming months. So I'm in a situation where my particular constituent has already expired. They don't want the refund because they're hanging on to the idea that there might be some remedy. So can you just give me some help here as to what the department's doing? It's clearly not the fault of the visa holder.
Senator, there were a couple of measures introduced. One was an extension of time for visa holders whose visas were current at a particular point in time, and the other one was the capacity to grant the visa for longer, which wasn't available to decision makers prior to the change that came into effect. I think it was in about late February. The other option is the one you've already highlighted, that anyone who was affected by COVID would be eligible for a refund, from what you say, it sounds like the constituent you refer to is in that category.
Yeah, well, the application was made in December, so it was before February, so not application, the visa was granted in, I think, December.
Right.
So they didn't get the February option. So isn't there not something in terms of ministerial discretion in these cases?
There's no ministerial discretion in the sense of that individual case. Consideration is being given more broadly to the situation with subclass 300 visa holders. A few months ago, they were included amongst the group.
Is the term of the visa not spelt out in primary legislation? Is that the issue?
It's spelt out in regulations.
In regs,
there's no flexibility to grant it for longer at the time. In this circumstance, they are eligible for a refund, but the constituent is not looking for that. There's been a number of COVID concessions introduced over the period of the pandemic, Senator, and we continue to review those concessions and look at advice and options in terms of different cohorts. But for the individual you refer to, at this time, the option available to them is a refund.
Is there any option in those circumstances that they can get an expedited application? We're very close to opening up again,
yep,
and they don't want to go through the 2 to 3 year application pathway.
The intent was to expedite applications that took advantage of the refund and then reapplied. Yes.
So that is an intention. So that's a pathway for my constituent and others in the similar circumstances.
Yes, noting we're reviewing those circumstances frequently and looking at options for people like those in your constituents' situation. We have been trying to contact individuals in that circumstance, so they're clear of what their options are.
All right, so I've got a letter to the Minister on my constituent. So it's at least formally registered, and I'll take you on your word for expediting as I give them some advice. Thank you.
Thanks, Senator.
Thank you very much, Senator Patrick. Senator McKim, appearing by telephone.
Thanks, Chair. There are currently at least 4,200 Afghan nationals in Australia on temporary visas. The Immigration Minister has said no Afghan visa holder currently in Australia will be asked to return to Afghanistan while the security situation there remains dire. Given that commitment, what is the intention for Afghan nationals who are currently in Australia on temporary visas?
Senator, I don't know that I can really add to what the Minister has said. As a matter of law, temporary protection visas, which were introduced in December 2014 at the same time as the Chevs of which we spoke earlier, as a matter of law, they cannot lead to any other kind of visa outcome, permanent or otherwise. The group of which you spoke relate to illegal maritime arrivals. As a matter of policy and direction, because we have to take into account not just reform obligations but also the practicalities of the logistics of returning someone, as a matter of practice and operations, the government intention, which has been communicated as a direction to me, to not return people to Afghanistan holds for so long as that security situation holds and as long as that government direction holds. So when you say what is the intention, it's no different at one level from the situation prior to the fall of Kabul, although obviously the objective circumstance on the ground there have changed. The legal situation is no different because it's legally impermissible for those persons, save the abolition of temporary protection visas, to apply for any other kind of visa, just as a matter of law.
So there's no intention to provide any of those over 4,000 Afghan nationals with any kind of a pathway to permanent residency?
The only way that I can see consistent with the law as it currently stands, Senator, would be for a transference across to the SHEV program that we spoke of earlier in relation to Senator Grogan's questions, because that does have, after 5 years, the ability for a permanent pathway to be opened. But no, short of that, there is no possibility under the law as it stands for those persons to transfer into any other kind of visa pathway.
Well, governments can always attempt to legislate to change the law, Mr Pizzullo, and I guess what I'm asking you is, has the department given the Minister or the government any advice around this issue? Firstly, potentially to legislative amendments, or secondly, in terms of providing a pathway onto a pathway to permanency via, for example, SHEV visas, as you've just articulated?
Well, the advice in relation to the management of SHEVs is something that we keep under review, and Mr Walton can speak to the last time we turned our minds to Afghan nationals. But in response to the first part of your question, have we given advice to government about changing the law? No, we haven't.
All right. I wanted to ask you about people who've applied for partner visas. These are partners of Australian citizens or Australian permanent residents who are Afghan nationals, many of whom are currently still in Afghanistan, and many of these applications were lodged in 2018, 19 and 20. As your visa team would be aware, we escalated about 240 partner visa applications for Afghan nationals to the department in the weeks leading up to the fall of the former Afghan government, and requested urgent assessment of those applications, and some of those people have been evacuated, and a small number, that is 27, did receive visas. I've currently got 223 on the books in my office who are waiting for a response to their visa application. Some of them are at risk of persecution, imminent persecution by the Taliban, and as I said, have been waiting years for their visas. What's the plan for these people, and is there an intention to conduct a priority assessment of their applications?
Well, I'm not sure if Mr Walton can speak to the partner visas. That's a matter that Mr Willard
No, I was going to suggest Mr Willard might come and talk to about the plans for the partner visa, but I was just going to reflect on the fact that we were, and thank you to your office and many other officers at Parliament House who advised where people had current applications. I think the principle was where we could finalise visas, we did. But if we weren't at the point where we could get them finalised, they were offered 449s, and I'll come back with the exact number, but there were several hundred 449s were granted to people with active partner applications to make sure that they could get out of country. But Mr Willard's just come back to the table and he can talk about the plans for that caseload going forward.
Thanks, Senator Michael Willard, Immigration Programs Division, First Assistant Secretary. Senator McKim, we have established a team within our partner visa processing branch that looks specifically at applications from applicants who are what we would term affected by Direction 80, and the issue with partner visa processing relates to a ministerial direction around processing priority, which determines the order in which we process partner visas. And a number of applicants from Afghanistan, but also some other locations are the lowest priority because they're sponsored by a former IMA who is a permanent resident and not yet a citizen, and that determines the priority we can give to applications.
Thank you.
So
Sorry, I didn't mean to interrupt. Please go ahead.
I was just going to add that we've formed this team to handle this cohort in particular for a few reasons. One is because of the 72,000 plus partner visas delivered last year. We're in a position now to be able to start dealing with this caseload, although it remains the lowest priority in terms of processing priority directions. And the other reason is that it is a very challenging caseload to deal with, where we're dealing with issues of identity and genuine relationship that require a degree of specialisation in order to be able to handle the caseload efficiently. So the team has been formed up in order to drive that effort.
All right, thank you. I appreciate that news. Can I ask then whether the department has given any consideration to providing advice to the minister to change or remove Ministerial Direction 80?
Senator, the direction, the effect of the direction at this point is more limited than it has been in previous years, and that's because of the size of the partner visa program versus the number of applications that are on hand in the partner visa program. So we have around 60,000 applications on hand, and we have a program size of around 72,000. So the effort to process applications is being directed across the on-hand caseload and across all levels of processing priority.
So there's been no consideration given to changing or removing Ministerial Direction 80?
I mean, it's a ministerial direction, Senator, so a matter for government.
Okay, fair enough. What about people who've applied for partner visas who are in Afghanistan and they are basically decision ready and they just need their final health, character and identity checks? What are you advising those people to do given the current situation in Afghanistan?
At this time, Senator, we're not, because of the situation, because of the risks involved, we're not directing people to undertake health checks or further checks.
So you're providing no advice to them?
We're providing advice at this time I mean, the availability of health checks is limited. We don't know for certain where people are located, but we're not advising people to undertake health checks if they're telling us they're in Afghanistan.
All right, so they simply can't have their visas granted because of the lack of capacity in Afghanistan to provide those checks, is that right?
That they wouldn't be able to meet a partner visa criteria in that circumstance. They may be eligible for other visas in the humanitarian space.
So I guess that's what I'm asking, whether they're being provided with advice that they ought to apply for a humanitarian visa, for example.
They're provided advice on all of their options, including the humanitarian visa.
All right, thanks. I've got some questions around the announcement recently that the Australian government would be abandoning about over 100 people who sought asylum in Australia in Papua New Guinea.
Senator McKim, we are at the end of your allocated time. We will need to return to you and to share the call around. So this might be an appropriate time to move to Senator Ciccone.
Thank you, Chair. And I'll just continue on from my earlier questioning. How many workers will arrive in Australia through the agriculture visa program to assist farmers with this year's summer harvest?
Mr. Willard, it's not a capped program. It's
not
a function of demand.
CAP program is demand driven, and as yet that hasn't been determined. The intention from DFAT is to phase the program in over 2 phases, with an expectation that initial arrivals would occur towards the end of the year.
Do you expect to have any people on this visa by the end of November?
By the end of the year is the
My question was the end of November.
I think that what DFAT is working towards, and the reason DFAT are involved as well, that I didn't mention more earlier, is that the visa does rely on bilateral agreements with other countries, which DFAT are negotiating. Arrivals are a function of that process of negotiation, and then the process of selection of both employers and visa holders. So the expectation is end of the year, whether that's in November.
What do you expect by the end of the year? How many people will be on this visa by the end of the year?
Initial numbers are expected to be in the hundreds.
In the hundreds, okay.
This, Senator, it is a demand-driven visa,
year.
so it's always a function of employer demand for particular visa holders at particular times.
Okay. You mentioned about bilaterals, and I might just quickly get to that now. Out of the 10 ASEAN countries and the United Kingdom, how many have signed up to the agriculture visa framework?
You'd have to address that to DFAT, Senator.
Okay, so the Department of Home Affairs is not involved with any of those discussions?
Not in bilateral negotiations with other countries.
Do you know who's leading those discussions?
DFAT.
DFAT, okay. All right. So Home Affairs is just about the framework, whereas DFAT's talking to those nations. With pathways to permanency, what does that look like under an agriculture visa? There's been a lot of discussion about one of the features that this visa offers is a pathway to permanency.
The government has committed to exploring the options for pathway to permanency for the ag visa, and that will be developed in due course. The pathway will be a product of consultation with a range of stakeholders around what a pathway to permanency might look like for this particular cohort.
So it's fair to say at this stage we don't know?
It involves further design work at this stage, yes.
And given that it's uncapped, people who would apply under this visa wouldn't fall under the 160,000 cap? Or would they be a subset of that cap?
So the initial visa is a temporary visa, so it wouldn't be factored into the permanent program and the 160,000 figure. Subsequently, converting onto a permanent visa, that would then be a migration program outcome.
Are you aware of any arrangements that will be put in place with the states and territories to facilitate quarantine when people on this visa arrive into the country?
There's, through the Pacific Labour Scheme, the seasonal worker program, there's been a facilitation of arrival of, I think it's over 10,000 workers, and that involves engagement with state and territories.
But what about the ag visa?
Well, this would be a similar process for the ag visa, particularly with chief health officers in terms of capacity to accommodate people above the caps, and that's the basis on which the Pacific Labour and Seasonal Worker Program visa holders have been entering.
But there are no current arrangements in place with respect to people on the ag visa?
Not at this stage. The process is that DFAT is still working on bilateral negotiations that sets up the partner countries for the ag visa.
Right. With I think DFAT has a fact sheet but I don't know, might be something I'd raise with them later in the week. Is there, in actual fact, I think your department has a fact sheet as well on the Australian Agriculture Worker Visa Arrangements fact sheet. And it talks about full conditions for the Australian Agriculture Worker Program will be developed and implemented over the next 3 years. Now, you mentioned about phases. So when will phase 1 be complete?
Phase 1's towards the end of this year. Phase 2 is in, and again, these are DFAT phasings, but I think it's March or April next year. The reference to that longer term relates to the development of a permanent pathway for the ag visa, which would be contingent on spending time, first of all, on the temporary visa before determining eligibility for a permanent visa.
So what happens to someone that's on the visa and these other elements of that visa haven't yet been developed, so they don't have the full benefits of being able to apply for permanency in the meantime? What happens to them?
The visa could be granted for a period of up to 4 years as a 4-year temporary visa, and similar to other arrangements for visas that have been introduced, and thinking about the regional visa, about visas for Hong Kong nationals, the development of the pathway occurs during that period.
So potentially someone could be on a 4-year visa and 3 years goes by without them actually having the ability to apply for permanency or having the other protections built into the visa because the departments haven't yet consulted with various stakeholders.
Generally on most temporary visas, there's a qualifying period. It ranges between 2 and 5 years in terms of transitioning to a permanent visa.
All right, look, my last question on this, Chair. What protections are being built in to protect these individuals who do apply for this visa against exploitation?
The visa is a sponsored visa, so the employers must be sponsored and meet the requirements to be a sponsor under the Migration Act. They're also then required to fulfil sponsor obligations and are subject to sanctions if they don't fulfil sponsor obligations. That's a narrow migration regulations definition of the measures that are in place to protect workers. There are also the Fair Work Ombudsman provisions that support workers, and there's also the program design element, which, similar to, again, the Pacific Labour Scheme, involves another layer of protections about how employers are able to access the agreement, and also the selection process for visa holders in the first place.
And those protections you just mentioned at the very start, who polices them? Is that your department?
Yes, it's Australian Border Force.
Okay, all right. Thank you, Chair.
Thank you. I'm sorry.
Might have.
You caught me mid-evening snack. Thank you very much, Senator Ciccone. Senator Keneally.
Thank you. I wanted to ask some questions about the Fearlessly Australian podcast. So if there's any specific officials that need to come to the table. The department's launched an online platform and podcast called Fearlessly Australian. Can you tell us how much did this initiative cost?
So, Mr. Kefford and Dr. Johnson.
Thank you, Senator. The Fearlessly Australian podcast is part of our programs designed to counter violent extremism, and so there's 8 million in this year's budget, 3 of which goes to the Living Safe Together program. There's 3 for these online initiatives, of which this is a part, and then 2 for the research to which the AFP Commissioner referred this morning.
Right, so 3 million for online initiatives. what other initiatives are under the online initiatives besides the podcast? Is that the Australian Values Campaign, or is that something else?
Senator Keneally, Richard Johnson, First
Dr.
Assistant
Johnson.
Secretary. Good evening, Senator. The $3 million is divided between the Fearlessly Australian information capability, the wrapped capability, online analytical capability and staff. So we have three.
Could you repeat that? I couldn't quite hear all of that.
So we have an ongoing allocation of $3 million per annum for strategic communications. We divide the $3 million into an online platform called Wrapped.
Wrapped.
R-A-P-T exclamation mark.
Wow. Okay.
Which is largely...
I think if you've led with that, you should probably describe it.
I paused for effect, Secretary.
Thank you. Roll straight. Just roll straight.
It's an ongoing...
Is the exclamation mark a necessary part of the title?
If you were to search for it, you'd need that.
This is Wrapped, Together Not the Same, a platform for young Muslim Australians?
That's exactly it, Senator
Okay.
Keneally. That's been going for a number of years.
Yep.
It's part of our CVE strategic communications capability. We've introduced a new pilot called Fearlessly Australian this year.
Yep.
And we also have done a number of digital literacy events, young people, teaching them about the online environment, critical thinking, et cetera, et cetera. So we use the $3 million across those different capabilities.
Right. So back to my question: how much you've allocated to Fearlessly Australian specifically?
Within the $3 million, this year we've allocated 1.3, and we've spent of that $938,000 to date.
Right. The podcast has 3 episodes. Should we expect more?
Yes, you can expect more. The pilot was anticipated to have initial podcast series of 4. COVID has impacted on the production of the last of those. So yes, you can expect more podcasts.
So at least one more.
At least one more, and we have an option to continue the capability.
Right. Do you know how many listeners you're gathering?
Yes, that data obviously changes week by week. Bear with me while I look for it. As at 21st of October, there had been over 40,000 video views.
Mm-hmm.
There had been over 5,000 website users and 77.9 hours of videos consumed on YouTube.
Mm-hmm.
The podcast had 549 listens, and there had been a total of 18,329 engagements with the various content that we've put out.
Right. Who's the target audience for this podcast?
Young Australian men.
Mm-hmm. And the content is informed by this research?
It's part of the broader CVE program, Senator. The other thing I'd add, so in part, we heard evidence this morning from the Commissioner and the Director General about the extent to which the online environment is one that in which there's exposure of individuals to radicalising material. So this is part of the response to put alternative narratives into that space to contest some of those positions. And so what we're doing with this one is particularly targeting, as Dr. Johnson said, at young men. The WRAPT program is more specifically targeted at young
use it across staffing, online analytical capability, plus the contractor who produces the contract, plus the individuals who are involved in it.
Right. Okay. still seems quite high, but all right, well, I might come back to that. I'm mindful of the time. I do want to ask a couple more questions about the ag visa, if I could, and then I might ask some questions about Australian values, just in terms of the ag visa, so we're clear. On an interview with Michael Bailey on 4RO, Minister Littleproud was asked whether the offer of permanent residency was an important carrot to attract workers to Australia under the agriculture visa program, and he said, it is. So what we're trying to say is we're trying to bring the next generation of migrants to Australia, ones that want to stay in regional Australia and be part of agriculture. So can you confirm that pathways to permanency will be put in place for agriculture visa workers?
Yes,
They will be?
Consistently with the evidence that Mr Willard gave earlier.
Yes, I'm just trying to, because then the DFAT fact sheet that was published the same day as Minister Littleproud's interview with 4RO, it said that the government was, quote, exploring permanent residency pathways. So which is it? Will there be a pathway, or is that question still open? Are you still, is the government still exploring pathways?
The government's policy decision is that there will be a pathway.
There is a pathway.
Well, that's the evidence.
Okay, so we've established there is a pathway to permanency. All right, thank you. Will there be a cap on the number of peoples entering on the ag visa?
I think that evidence was given earlier. It's
Sorry, I just wanted to be clear again.
It's a function of demand.
It's no cap, okay. Reports in Malaysian media last week suggested the country didn't want to sign on to the visa. Are you familiar with that? Or is that a matter for DFAT?
Bilateral negotiations are being handled by DFAT.
Okay. All right. If I can go on to the Australian values. Sure, of course. Yes.
Through you, Chair.
Senator Ciccone, yes.
Mr Willard, earlier you said that was that sponsorship. I thought the whole idea with the ag visa that the individual wasn't tied to the employer. Is that not the case?
There's a sponsorship, so that there must be an approved sponsor responsible for the
being an employer.
Being an employer. There's also a capacity for the visa holder to move from one employer to another.
But they have to be sponsored initially, is that right?
All employers have to be approved sponsors in order to be able to access workers on the ag visa.
Okay, so for someone to come here, it's not like a backpacker.
It's not.
They need to be sponsored.
Yeah, it's only employers who are participants in the scheme and who are an approved sponsor are able to.
All right, so once they're with one employer, then they can move around, but to the other approved employers.
Yes.
And how long do they have to be with that one employer for?
There's no specified minimum
period. Is that level of detail being worked out?
In terms of visa regulations, there's no specified minimum period.
So is that a question I should put to DFAT or AG? I mean, someone comes from one employer for one day, can they then go to another employer?
If that was the agreement, they could in terms of visa regulations.
But the one employer has to agree to bring someone or people into the country first.
Yeah, and it would be more likely they'd be looking to do that for a longer period.
Right, okay. At which point then that individual, once the term expires, can then move around to other employers. Is that your understanding?
Provided the employers are participants in the scheme and are approved employers in the migration regulations.
All right, thanks for clarifying that.
Thank you very much, Senator Ciccone.
Christina?
Yep, that's fine. I'm actually
We're now going to move to Senator Grogan.
Yep. I'd just like a bit of an update on the Australian Values campaign. Can you confirm the previous and the current contracts that relate to this campaign? Specifically, what is their total worth and what do they cover, and who are the key suppliers?
Dr Johnson gets another here. Mr Clifford. Happy to go straight to Dr Johnson.
Thank you, Senator. Richard Johnson, First Assistant Secretary, Social Cohesion. The funding for this comes from a budget measure in last year's budget. An allocation was made of $23.6 million over the forward estimates. So 2020 to 21, 5.1 million, 2021, 22, 6.1 million, 22, 23, 6.2 million, and 23, 24, 6.2 million. That funding goes to contracting, staffing, and operational things like translations. You'll notice that the capability has information which is translated into four languages. So the contract specifically with World Services Australia for the period until 30 June 22 is for the value of $5,974,000.
Until when, sorry? Till the end of...
Up until 30 June 2022.
Okay. And is that the only contractor or just the main contractor?
We do have some particularised services with translators. World Services is the main contractor, but we also have a number of contracts with providers who can do the translations for us.
Okay. Would you be able to give us a list of those?
I'd have to take that on notice. But yes, we can.
Okay. And what exactly does the World Service do for the contract?
They work in partnership with us and with other agencies who we work with to co-produce content, and they produce and curate the content and run the platforms for us.
Okay. Now, did you receive a report from a private contractor to inform these campaign views on the Australian Values campaign? And did you block its release via an FOI request?
We didn't block its release. The department made a decision under a number of FOI headings not to release 5 of 6 requested documents. Some of them went to cabinet deliberations, others related to the commercial in confidence aspect of the contracts.
And so you blocked it on that basis of the cabinet and commercial
They weren't released under FOI.
Okay. And if you blocked 5 out of 6, did you say? What was the one you
5
released?
out of 6 documents.
And the one you released?
I have to take that on notice.
So could you just walk us through what the metrics that you're using to judge the success of this campaign?
Yeah, absolutely. So far there's been 2.4 million views of the content. There's been 190,000 engagements, online engagements. So we have an ongoing tracking of the engagement with the material online, so to speak. We also have used the capability to engage in a number of partnerships, both within government and with non-government organisations. So, for example, we curated some content with a Sikh community organisation in Perth. So we see the extension of the values capability in terms of partnerships with particularly community organisations as part of its impact and part of the success that we're seeking to measure.
So we had a little look, and would it be right to say that you have 591 Twitter followers, 1,200 Facebook followers, 494 Instagram followers and 20 YouTube followers?
I'd have to check today's numbers, but I think you're in the ballpark in terms of followers. But of course, impact and reach is not just about followers. It's about, as I said, 2.4 million people have viewed the content.
Mm-hmm.
So it's not just the regular followers, but it's who's seeing content as it's going out live and getting on their devices, but also the sharing and the organic sharing that we're seeing amongst community groups is also an important feature.
But also connecting in a deeper fashion is a longer term measure of success of such a campaign.
Indeed, indeed it is, and the reality is when you're building a new capability, it takes time and patience and consistent effort to build it up.
And how long has this been? Has the sort of
The
social
day
media
before,
side been live?
the day before Australia Day this year.
So January.
Yes.
So 10.
End of January. Yep.
10 months.
Yes, that's correct.
So, Senator, if I might add to that, the values that we're drawing on here are founded in the Migration Act itself, and so in the migration regulations are the values. They're consistently there through in that context through the visa application process. It's there in the Citizenship Act and the Citizenship Pledge and the Our Common Bond booklet, and then it's also very much aligns with the work that the National Australia Day Council has done, including in terms of their shaping of themes around Australia Day. So it's not the deeper engagement to which you refer, which of course is the intent of fostering this ongoing discussion about what it means to be Australian and what the Australian values are that we ask new citizens to sign up to.
Well, leveraging off what you've just said then, maybe you could give us an estimate of what the current cost per follower is then.
Well, Senator, of something of that magnitude, I'm not sure that would be a meaningful measure. This is a relatively new program and new approach, and to boil it down to that would miss the substance of the engagement that we're seeking to deliver.
But it would give us a good sense of how effective and how efficient the program is in being in actually achieving its outcomes.
Well, Senator, then you'd use not the followers accounts, because as Dr. Johnson said, it's the reach and the distance and the engagement that happens, and indeed the conversation that happens around it, that is a much more powerful indicator of success than how many people choose to actually follow the platform on a particular
Mr. Kevin, do you have that? The details of the...
Well, Senator, we could...
Sorry, do you have the details of the question that was asked of you?
Well, we do, and we could do the mathematics. I suppose what I'm saying is I'm not sure that would be a meaningful measure of the success of this
Senator
program.
Grogan has asked that question of you. Whether it's meaningful or not is obviously for others to judge. But are you able perhaps to take that on notice?
We can take the mathematical answer on notice, yes, Chair, of course.
Thank you.
Yeah, because you just think, certainly as when you look at the sort of connectivity here and how you would actually go about building a social media campaign, Craig Kelly's got 62,500 Telegram followers. George Christensen's got 24,000. You know, there is a point here about getting that reach, and so we'd be really keen to understand just what that number turns out to be, but also what the sort of further plan is then to get that reach into the community, because then I wouldn't say there were spectacular numbers for a 10-month campaign.
Senator, I'll just read out again the data I gave you. 8.1 million impressions to date, 4.2 million in terms of reach, 2.4 million views.
Maybe you could just put all that down for us, and
We'll take the question of
Yeah.
reach and
to do
impact
that.
on notice, Senator. Yeah.
The other point that's completely valid here in terms of developing deep organic connections is the willingness and the increasing appetite of community organisations to want to partner with us to showcase Australian values in their own voice.
So there's also a social media cohesion strategy announced by the Minister for Immigration in March this year. What progress has been made on that?
The timing in terms of the government's release of the social cohesion statement is obviously a matter for government. It would be fair to say, though, we're in an advanced form of developing the draft material for that.
And any plan for when that's going to get off the ground?
That's a matter for government.
So as part of this strategy, the Minister announced that the Department of Home Affairs and the Attorney-General's Department would work with the Race Discrimination Commissioner on a national anti-racism framework. What meetings has the Minister and all staff from the Department of Home Affairs, or the AGs, had with Mr Chin regarding this framework?
Indeed, the Minister, in fact, invited the Race Discrimination Commissioner to a meeting to brief State and Territory Multicultural Affairs Minister mid-year. We've had 2 workshops with Chin Tan and his team in terms of the development of the framework, and I think from recollection, Mr Tan went out to the community last week seeking public submissions.
Be very keen to understand also what funding has been provided for the development of the framework and how it is actually being linked in to the Australian Values Campaign.
So the questions, the Attorney-General's Department or portfolio is the actual lead for the race discrimination work, so we don't provide any funding through our department or portfolio to Mr Tan and his efforts. The link in terms of the connection to the Australian Values platform and the promotion of Australian values. Obviously, that's an area where we've briefed Chin Tan and his team on and keep them up to date on, because part of the work and the logic underneath what we're doing there is to promote an inclusive national identity and to showcase it. So I think they're very interested in the work we're doing and see a synergy between the social cohesion objectives that we have and the objectives that they're working on.
Senator Grogan, we are going to need to wrap up your allocation of time here. We are now going to suspend for supper, and we will resume in 15 minutes at 9:40. Thank you. The committee is now in session. We are continuing with the Department of Home Affairs, including Australia Border Force, Outcome 2, and I give the call to Senator Ciccone.
Now, can I just turn to the matter regarding Mr. Daryl Maguire, Mr. Pasulo? Could you or your department please provide an update on following numbers for the committee's benefit? The number of visa holders that were linked to the Cash for Citizenship scheme. Do you have those numbers handy?
Well, I'm not sure that I have them handy. I know that
any of your officers do.
I know that my colleagues in the Border Force have been working on the possibility of criminal charges being raised and laid. So I'm just going to tread carefully. But you're asking me about the number of holders who were caught up in the so-called scheme.
Scheme, scam. I mean, the department previously provided.
So I think to assist the department, we're looking for an update on those numbers.
All right. Well, if one of the, if either Miss Moy, who is now in that role, or one of her Band 2 officers has that data readily to hand. There you are, Miss Moy. So Miss Moy was our Chief Operating Officer, has moved across to Immigration and Settlement Services. And you're joining us at this late hour.
I am, thank you, Secretary. Yes.
Might need to update her little sign.
Thank you. Thank you. You're kind. I'm sorry, Senator, won't be a moment.
That's all right. Take your time. It's not too long. We've got not enough time.
There's a lot of paper to turn. So, Senator, as at 31st of August 2021, of the 14 current and former visa holders named in the ICAC operation hearing between 21 September and 16 October 2020, 9 are currently onshore, 5 are offshore, and 3 of the 9 who are currently onshore have acquired citizenship.
Okay, so let me run through the, so just to help me out as well too. So the visa holders linked to the scheme were how many?
14.
Okay.
Didn't Mr. Cafford tell us at a subsequent estimates hearing it was 37?
I'm not quite sure. Of the 37, there was, so of the 14 that were named in the ICAC in September 20 and October 20, there were 14. In total, 20 persons of interest, primary visa holders, have been referred for visa cancellation consideration, 6 persons in ICAC and a further 14 identified as being of potential interest. So in terms of the original number of 14, there are often people attached to those 14 who have also acquired visas.
So the 37 figure, would that include family and secondary visa holders?
Well, we shouldn't speculate. We should
No,
review that
I'll
evidence
check.
and just make
I'll
sure
check
that we're
the
giving
37.
apples and apples.
I'll check the 37 and come back on
if
notice.
you could check, because that was the evidence given previously.
Okay, so then the onshore you said was how many?
9 are currently onshore.
Okay. Visa holders granted citizenship?
3 of those 9 who are currently on shore have acquired citizenship.
Dependents linked to the visa holders?
So secondary visa holders who are dependents of the family members, 3 named in ICAC, additional persons 14.
Visa holders referred for visa cancellation?
Primary visa holders referred for cancellation consideration 6 named in ICAC with 14, which gives us 37. Senator Keneally.
Thank you.
Okay, visa holders with cancelled visas?
So of the 20 primary visa holders referred for cancellation, 13 have been cancelled. The visas cancelled included 1 temporary work, skilled class 457, subclass 457, 5 resident return, 3 employer nomination and 4 regional sponsored migration scheme, and the additional 14 members have been subject to consequential cancellation. 3 of those were temporary work, 2 were resident return, 4 were employer nomination. Visa holders have been assessed as not having cancellation grounds enlivened.
Okay, so visa holders issued with a notice of intention to consider cancellation.
I'll have to take that one on notice, Senator.
Visa holders undergoing consideration as to whether issue a notice.
3 visa holders are continuing to undergo cancellation consideration. 1 was cancelled on 8 September. 2 are undergoing further analysis.
And visa holders assessed as not requiring cancellation.
In terms of the 3 who have attained citizenship, those 3 have not enlivened any reason for cancellation.
Thank you, I appreciate that. Can you confirm whether your department has had any further contact with ICAC regarding the matter?
Not at this point. We have a watching brief on ICAC in terms of any information that may come to our attention which impacts on anything to do with visas.
And further, have you had contact with the Australian Federal Police regarding the matter?
Not the Australian Federal Police. The ABF have undertaken an investigation in regard to the management and the conduct of visa sponsors, etc., and have prepared a brief to the CDPP.
Do you believe that the criminal misconduct has occurred as part of a scam?
Senator
I can't
Ciccone,
give that
that
opinion.
question's not in order, so I'll need to
Does
ask you to
Does the
move on,
department
please.
intend to refer matter to the AFP for prosecution?
It's been referred to the CDPP.
Okay.
I can just explain. We've been over this ground before. The Australian Border Force is the enforcement authority under the Migration Act. It's got its own ability to refer matters to the DPP, to send a matter for the DPP. We don't need to go through the AFP to secure a prosecution.
Can the department confirm that the number of representatives were made by state and federal members of parliament on behalf of visa holders associated with this scam?
I wouldn't be able to confirm any details of information in the ABF brief of evidence, given the fact it's an ongoing investigation, Senator.
And are you aware if the former New South Wales Premier, Berejiklian, made any representations to the federal government to support these visa holders that are associated?
Not aware, Senator.
All right.
Could I just ask 2 clarifying
I'll hand over to
questions very
Senator
quickly?
Keneally.
Senator Ciccone, have you completed your questions?
Senator Keneally has some follow-ups.
All right.
Yeah, just
Senator
2 very
Keneally.
quickly ones. In relation to the dependents linked to visa holders, were any of them born in Australia?
2 children were born in Australia.
And what's going to happen to their visas?
So the 2 children who were born in Australia when their parents held permanent residency acquired Australian citizenship by operation of law at the time of the birth.
So are they amongst the 3 Australian citizens?
I'll come back to you on that, Senator, just be sure.
Okay. And what...
Well, one parent had to be a citizen.
So how did they get
I'll come back to you on whether or not they were
make
part of
sense.
the three who had citizenship.
Right, and of the three that have citizenship, we'll determine if two of them are children or minors, but this seems rather complex. What avenues are available to the department in relation to their citizenship if it was granted based on them fraudulently receiving a visa?
The Act has got certain stipulations that relate to their own criminality. So once you acquire citizenship, the visa that you're on lapses. Obviously, you're an Australian citizen.
Yep.
And this is not Ms Moy's area, it's in fact Mr Kefford's area, but the grounds then to revoke citizenship, leaving aside dual citizenship connected with
Yes.
terrorism, let's put that to one side, there's quite a high threshold that we have to establish in terms of criminal conduct at the time of your, on your own behalf, at the time of your acquisition of citizenship. And Mr Kefford's joined us. So he used to do immigration, now he does citizenship, so you can close the loop.
Thank you, Secretary. Senator, the decisions to revoke citizenship in this circumstance would turn on either a conviction for fraud for the individual in the visa application, or indeed the conviction of a third party for fraud involved in the applications. The third ground is for serious criminal offences of other natures, which is not relevant here. But in either case, those matters remain in abeyance until we see the course of what other prosecutions may occur. And indeed, based on the outcomes of those, were those thresholds for convictions met, then we could consider the citizenship action.
Okay, thank you.
Which wouldn't be ruled out.
No, indeed.
Yep.
Yeah, that's fine.
Thanks, Senator Keneally. Senator Ciccone.
That's it for
no,
me.
that's it?
No, thanks, Ms Moy. That was
All right,
really
thank you very
efficient.
much. We are trying to plough through our program and catch up a little. I will now give the call to Senator McKim, attending by teleconference.
Thanks very much, Chair. Could I ask, please, what is the total cost of the offshore detention regime in Papua New Guinea from its commencement to date, including any projections you have to cover the remainder of that arrangement?
Mr Ablong, perhaps assisted by the CFO, might come to the table. And Senator McKim, just while they're joining us, I don't think you can see us, but we can hear you. You said from its commencement, so the relationship that we've had with PNG in relation to IMA is going back to 2013. Is that right?
That's right. In fact, I think there were even some people transferred there in 2012 prior to the 2013 announcement.
Yeah, well, I think that's right. Mr Ablong, the cost over time?
So the cost over time, apologies, Mark Ablong, Deputy Secretary, Strategy and National Resilience. Since 2012, the total cost for regional processing in PNG is $3.743 billion.
All right, thank you. And can I just confirm that includes any payments made to the PNG government plus payments made to contractors both based in PNG and based in Australia?
Senator, that is for departmental administered operations and capital costs. So yes, it covers off on the cost to the government of Papua New Guinea as well as contract costs.
Okay, and not just for capital works, right? Am I to understand correctly that that would also include contracts to service providers?
That's correct, Senator.
All right, thank you. And how many of the offshore cohort are left currently in Papua New Guinea?
Let me just go to the...
122?
I'll give you the...
I understood 124.
As of the 31st of August, there are 121 transferees remaining in PNG.
Okay, thank you. And do you have the breakdown of how many of them have been found to be refugees? How many people are simply people who sought asylum, and how many of those, if you have the breakdown, never applied to have their refugee status determined?
So of the 121, there are 86 refugees and 35 failed asylum seekers.
All right, thank you. What's being done at the moment to keep them safe from COVID, given what is a pretty massive and tragic outbreak of COVID-19 in PNG?
Senator, the Australian government has been supporting the government of PNG in terms of the cohorts management for COVID. If I can give you the statistics, since the 4th of March 2021 and as at the 22nd of October, 23 transferees have contracted COVID, of which 7 transferees and 3 family members are currently active COVID cases, and the rest have recovered. All of the transferees contracting COVID-19 have been provided with the health services and welfare support to assist with isolation requirements so they don't pass it on to others in the cohort. Some transferees have isolated in PNG government-approved sites to support their compliance with isolation requirements, and others have isolated in their residences. The PNG government has a central task force to manage COVID-19 response and has introduced a national isolation strategy, implemented movement restrictions and measures on mask wearing, gatherings and social distancing. We provide all of the transferees with personal protective equipment, information on appropriate personal hygiene practices, social distancing and reducing physical contact to limit the risk of exposure and transmission. All of the transferees are able to be vaccinated for COVID-19 as part of the PNG government's vaccination program. Only some of them have taken up that offer.
Thank you. Of the 23 who did contract COVID, were any hospitalised?
Senator, I don't have that figure on me. I believe that no is the answer.
All right, thank you. Can I ask, will there be an agreement between the Papua New Guinea government and the Australian government to confirm any ongoing commitments that may exist once the end of this calendar year happens and PNG assumes full responsibility?
No, Senator. And to be quite precise about it, the PNG government has always had responsibility for the regional processing cohort and their management. The Australian government has provided support to the PNG government through the contracts for welfare and other supports to the cohort, but their management, their asylum seeker claims are all undertaken by the PNG government. So with the end of the regional reprocessing agreement with Papua New Guinea, the PNG government is taking on those contractual responsibilities for welfare, garrison and other health support. And that's principally the only change that the end of this agreement means.
So there'll be no commitments given by the Papua New Guinea government in terms of, for example, providing a pathway to permanent residency or citizenship? Is that what you're saying?
Senator, the PNG government has already been in contact with all of the transferees to talk to them about the opportunities that exist for them, either as a pathway to permanent residency or ongoing support while they are in the US resettlement process. So they can continue
sorry.
that pathway.
Thank you. I appreciate that, but I'm sorry. I just know we're short of time. I'm specifically asking about any commitments given by the Papua New Guinea government to the Australian government, and your evidence is that there are none. Is that right?
Not commitments to the Australian government, no, Senator.
So, in other words, the Australian government has sought no commitments whatsoever from the Papua New Guinea government in terms of the ongoing treatment of these people. Is that right?
Well, the ongoing treatment of these individuals, the treatment of these individuals since 2012 has always been the responsibility of the Papua New Guinean government.
Well, I don't accept that and I never have. So let's just park that for a minute. That's not the question I asked. So I'm just after confirmation that the Australian government has sought no commitments at all from the Papua New Guinea government in terms of the ongoing treatment of these people. Is that right?
That's a factually correct statement, Senator.
Wow, okay. So we really are just washing our hands of them. All right. So Australia, can I ask then, the Australian government presumably would have no problem if the Papua New Guinea government then decided to accept the offer from New Zealand to resettle these people? That would not be a matter that the Australian government would have an interest in?
Senator, the Papua New Guinean government has been working with UNHCR and other authorities about resettlement options for the cohort that include UNHCR processes and others. Were the Papua New Guinea government to approach the New Zealand government, that would be entirely within, the ambit of the Papua New Guinean government.
Okay, thanks very much for that. And last question on this topic. So just to be clear, there'll be no ongoing funding committed by the Australian government to support the 121 people who remain in Papua New Guinea?
Well, Senator, post the 1st of January, the Australian government will be providing no funding, that's correct, but that doesn't mean that there will be 121 people in Papua New Guinea as of the 1st of January of 2022. The US resettlement agreement is still accepting people from Papua New Guinea, and people continue to leave for the United States from Papua New Guinea. The transferees, should they wish to remain a part of the regional reprocessing capability, being offered the opportunity to transfer to Nauru, which is, as you'd be aware, the Australian government has signed an agreement with the government of Nauru for an enduring regional processing capability there, so they can take advantage of that, and some of them have said that they will transfer to Nauru. And the rest will be offered either a permanent pathway to settlement in Papua New Guinea, and many of the transferees have families in PNG now and have set up businesses, so the settlement in PNG can be an attractive option for them, or other third country resettlement activities.
All right, thank you. And in terms of the US arrangement, can you provide us with an update on how many people have been accepted but are yet to be transferred, and whether there is a time frame in terms of an expectation of when the final transfers will take place?
So since the last time we talked about this, Senator, at the May budget estimates, 46 additional individuals have resettled in the United States. Approximately 225 individuals have received a notification of provisional approval from the United States, including 145 individuals who've disengaged after receiving that provisional positive outcome. So that, I think, answers your question.
So, sorry, do you have a time frame for final
yes, sorry, Senator. So the United States has said that it will, recognising the COVID complications, will continue to support resettlement. We were expecting the program to end this year, but it is highly likely that the resettlements will continue into 2022. Given that the US resettlement agencies have not been able to make it to this part of the world to conduct the normal processes that they go through.
All right, thank you. And I just have a couple of final questions on a different topic.
You just need to make this very quick, Senator McKim.
Yes, I will. Thank you, Chair, and hopefully the answers can be quick too. And these are in regards to a commitment that, or evidence that the department's previously given to various committees, that the government is considering the extension or reinstatement of visas for temporary visa holders that are stranded overseas due to the pandemic. And I just wonder, in very brief terms, whether Mr. Pizzolo or someone else there could update the committee on the work that they've done in this area, whether that has been presented to government, and I'm particularly keen to hear about visa subclasses like 485s, 476s, 500s, 489s, 491s, 482s and bridging visa Bs who've been stuck overseas for over a year and a half now and are desperate for either extensions or reinstatements.
Well, some evidence was provided earlier in respect of prospective marriage, but as to the broader suite of visas, I'll ask Ms Moy and Mr Willard to come forward.
Thank you.
So, Mr Willard, without rehearsing the prospective marriage category, is there anything that you can add to your earlier evidence about other classes of visas?
Michael Willard, Immigration Programs Division. Senator, there's a large number of concessions in place for the cohorts you just described. I won't go over those, but we could provide that or point those out to you. We've continued to provide advice to government in respect of COVID concessions generally and their application.
All right, so have you, just last question, have you provided advice to government in regards to those visa subclasses, specifically around the potential for extending or restoring lost time or reinstating lost visas in those subclasses?
I'm just trying to recall all of the subclasses that you mentioned. We've provided advice.
Oh, perhaps I could just ask you to take that on notice, and that would save time if you're able to take that on notice.
All right, thank you very much. Thank you, Senator McKim. And we are now going to move to outcome 3. We are running a bit behind time, so the objective is to finish by 11 o'clock. And I will move straight to Senator Keneally.
Chair, as is your practice, could I just ask if Mr Outram's got an opportunity to make a brief opening statement?
Oh, I apologise.
He hasn't had a chance to do so. And I'm cognisant of the lateness of the hour,
yes.
But his matters normally come up under 3. So. And it may be that the Commissioner has nothing by way of an opening statement.
Commissioner, welcome to the table.
I didn't check.
You do have an opening statement? Fabulous, thank you.
Chair, Senators.
Welcome. Over to you, Mr Radford.
Thank you, Chair. Since I last appeared before the committee, Australia's international border landscape has evolved, and with the pace of vaccinations, of course, Australia is a very different place in the pandemic. And since well before that last appearance, in fact, the Australian Border Force and our colleagues in Home Affairs have begun lifting our gaze to the reopening of Australia's border. And the ABF is poised for international travel to recommence at scale starting on the 1st of November, while, of course, continuing to keep essential goods crossing our border. Reopening the border will be complex, subject to unexpected changes, as international travel systems attempt to reconnect from the fragmented picture that we see today, and it requires continuous engagement with airlines, airports, international partners, Commonwealth agencies and the states and territories, and there is no standardised process for restarting international travel and reaching the sort of pre-pandemic volumes and service levels. But the national plan provides the guide rails, and never before have we had to validate travellers' vaccination or infection status at the scale needed from now on. International travel is, of course, more difficult. There are more approvals to obtain, more rules to follow, and these can differ from country to country, affecting passengers, airlines, airports, and, of course, border agencies like our own. And whilst international traveller numbers have been obliterated by COVID-19, processing times have in fact increased with the added health and biosecurity requirements, and it takes around 1 hour 22 minutes to process a passenger arriving on a red flight compared to 20 to 25 minutes for green flights. And wherever we can, we must adopt simplicity as the first principle and not make coming to Australia unattractive to tourists and business travellers. And while supporting Australia's COVID-19 response, the ABF continues its work in Australia surrounding maritime domain and overseas to facilitate trade, travel and protect our borders. And we're proud of our officers and those in Home Affairs who deployed to Kabul and Dubai in support of the whole of government operation to evacuate people from Afghanistan, one of the largest humanitarian airlifts in our history. And the ABF has successfully continued the ongoing work of ensuring our nation's maritime security, despite real difficulties in moving our crews across domestic borders to support those operations. And with our partner agencies, of course, we use a range of surveillance and response capabilities deploying air and maritime assets across our surrounding oceans and seas. And to this end, I am pleased that the Department of Home Affairs has extended by 6 years its existing contract for civil maritime surveillance services, which are critical to our mission and the nation's border security. These services help maintain our operational awareness of Australia's vast maritime domain, enabling the disruption of drug smuggling ventures, illegal fishing, deterring people smuggling and detection and removal of maritime pollutants and hazards. Our management of these services moving forward will reflect the ANO's 4 recommendations in its report on the initial maritime surveillance contract, as well as the range of contract management improvements implemented since 2017. Given the complex environment in which we operate, it's understandable that our demands on these services will continue to evolve over time, as they have done since the original contract commenced in 2008. But I expect the outcomes delivered in the next 6 years will be as successful operationally as the last 6, and these services will remain a vital part of our border security arrangements. The ABF secures Australia's principal connections to the world through the movement of goods and people, a fundamental economic role. We facilitate the flow of goods that almost every Australian business, family and individual relies on. And Australians are buying goods in different ways. For many individuals and businesses, online purchases have been the most viable option during extensive lockdowns. And volumes continue to rise. In 2020-21, the ABF facilitated and processed 26.9% more sea cargo consignments and 20.1% more air cargo consignments than in 1920. The downturn in international travel during COVID-19 has been overlaid with increased and more complex goods movements, and the ABF has responded by redeploying some officers from our airports to international mail and cargo screening and intervention, which we were able to do thanks to the agility of our workforce, and such agility will remain essential as we face unprecedented demands. Pivoting these resources enabled a 48.3% increase in air cargo examinations in 2020-21, resulting in a 168.9% increase in detections of illicit goods, including increases in tobacco and drugs. And for sea cargo, there was a 173.4% increase in the number of detections. And in the mail stream, the additional resources also meant more examinations and detections increased by 50% in 2020-21. Redeploying ABF staff from mail and cargo operations back to airports, as we must do from the 1st of November, will inevitably see a reduction in cargo detections and increased processing times. And as always, with finite human resources, our operational footprint will be guided by the threat environment and our ability to balance facilitation with intelligence-informed risk assessments. The global border environment from a threat perspective is characterised by increasingly sophisticated organised criminal entities who infiltrate borders and circumvent migration, visa, trade and customs laws. In light of the AFP's Operation Ironside, viewing the Australian border as a system, where illegal movements of goods have offshore origin and transshipment points, and where criminals seek to corrupt processes at our ports, airports and logistics nodes, this reveals the scale and sophistication of the criminal threats that are manifesting at and across our border. In 2020-21, the ABF detected over 23 tonnes of illicit drugs, 1,059 consignments of illegal firearms and over $1.9 billion worth of illicit tobacco at the border. This is an outstanding achievement by our frontline officers, but we know criminal entities continue to try to exploit vulnerabilities, including legitimate businesses, to move illicit goods into the country. The United Nations Office of Drugs on Crime data for 2020 showed 57% of significant global cocaine detections in sea cargo utilised the RIP methodology of concealment, with trusted insiders in the supply chain placing and retrieving consignments without the genuine importer's knowledge. The ABF is reprioritising its work to allow us to focus on strengthening border integrity and making Australia's supply chain more hostile to this form of criminal infiltration. And we will seek to fully leverage our legislative powers and capabilities, working closely with our partner agencies in the Home Affairs portfolio, to discover, disrupt, dismantle serious organised crime actors seeking to circumvent border processes. Not far, Chair. Tackling criminal threats while still facing trade means we must also build the future systems and processes that will continue to meet our responsibilities as an integrated border agencies. And as an integrated border agency and close partner of Home Affairs portfolio agencies, the ABF has many opportunities to prevent harmful goods from reaching our shores, to make our border a hostile place for criminals and cheats, and to ensure our migration system isn't used to exploit foreign workers. Notwithstanding that opportunities are sometimes missed due to statutory limitations on our ability to act or that our functions are not explicitly defined. As Australia moves into the COVID-19 recovery phase and we face up to the current and emerging threats at our border, we are taking stock of the challenges facing our frontline officers. We're shifting to a different operating model that will drive rational prioritisation, empowering decision-making as close to the front line as possible, and simplifying our overall approach. And we must ensure the ABF is agile, responsive and capable of keeping pace. And never has this been more critical as we look to support economic recovery and keep our communities safe. Thank you.
Commissioner, thank you so much. I will now hand over to Senator Keneally.
Thank you, Commissioner, for your opening statement and for your officers for their work in Afghanistan. And may I also take this moment to publicly thank Minister Alex Hawke for the work he did with my office and many officers to secure safe passage for many people who are seeking to get out of Afghanistan. Thank you. I have some questions about a contract between the Department of Home Affairs and DPG Advisory Solutions, which I think will ultimately relate to Quarantine Services Australia. So I flag that. On tenders.com.au, the Oz Tender Contract Notice lists a contract with DPG Advisory Services for Management Advisory Services worth $79,950 to start 27 August 2021 and to end 27 October 2021. Specifically, for which projects or services is DPV Advisory Solutions providing management advisory services to the Department of Home Affairs?
I'll ask Deputy Commissioner Saunders to join us at the table. The Deputy Commissioner has been seconded to the department for a period of time to work on border measures related to reopening the border in detail, and the Deputy Commissioner can speak to that.
Thank you.
Thank you, Senator, for the question.
Hello, Ms. Saunders.
So as you've indicated, yes, we did engage DPG Services in August of this year. The purpose of doing so, probably context is important here, Senator, is that certainly in assuming this role in July of this year, certainly an observation made very early in the piece was that there was a significant demand for skilled labour across the country, and there'd been a series of ad hoc and small pilots undertaken by industry engaging with states and territories in terms of establishing alternative quarantine arrangements that did not have an impost on states and territories and ensured that Australians could return to Australia within the arrangements that exist, both within passenger caps and quarantine capacity. So noting that there was this significant demand, obviously we were interested to explore what might be possible insofar as a more sustainable alternative quarantine arrangement. And DPG was engaged with the view to really catalysing the discussions into a tangible actions, because whilst there'd been many conversations across industry, business, service providers, there hadn't been a tangible action or plan established. So on that basis, DPG was engaged to a limited tender process based on their government and business advisory services and a requirement to act very quickly. And so DPG was engaged for that purpose, and as a result, DPG established a framework which actually engaged industry on a national level, service providers to inform what was to become a company which you've referred to as Quarantine Services Australia.
Okay, so can we just break that down, and thank you for that answer. How was the contract awarded? Was it an open tender or was it an invitation to DPG, or did they approach government?
It was a limited tender, Senator.
Limited tender?
And sole source.
Sorry?
Sole source.
Sole source, limited
That's right.
tender. So you didn't invite anyone else?
That's correct.
Besides DPG to tender?
That's correct.
And so what will be the deliverables from this work?
So the deliverable was the development of a model that may be considered by industry to actually establish a user pay model that would deliver services for industry, that being an alternative quarantine arrangement, which they did deliver.
They've delivered it already?
So they delivered a model which they have then used to then engage across industry nationally to get appropriate funding to support the establishment of the Quarantine Services Australia company, engage service providers. And I understand, whilst, as I said, if you've got particular questions of Quarantine Services Australia, obviously it's a company, so I obviously encourage engaging with QSA directly. But I understand they've come up with a model, as I said, which was the task that we allocated. They've engaged stakeholders and they're in the process of developing plans in consultation with states and territories, noting the state and territory responsibilities for quarantine.
Now, the head of DPG Advisory Solutions, Mr. David Gizzard, who's a former advisor to John Howard and Peter Costello, told a media outlet that this project is a 100% industry-funded initiative. So what roles...
Senator Keneally, do you have the report to which you refer that can be tabled?
I do, but I also have note that I'm happy to table a whole lot of reports, but I also note I have advice from the clerk that I'm not required to table any document in particular. However...
Can you just provide
I will.
the Deputy Commissioner with
Well,
more
let me ask
information?
this. Is this a 100%, is Quarantine Services Australia a 100% industry-funded initiative?
Yes, it is.
So why does the Department of Home Affairs need to be provided $10,000 a week or $80,000 in total of taxpayer funds so that industry can put this proposal together?
So, Senator, as I indicated, what we were proposing to broker through engagement with stakeholders was an industry-led solution to solve an industry problem.
But why do they need $80,000 of taxpayer dollars to do that?
Well, because we didn't have the capacity to undertake that activity and develop the model, which is why we went out to those that had the expertise, and DPG had that expertise.
So this is an industry problem for industry to solve.
That's correct. Well, of course, as a Commonwealth, we had a keen interest, noting that there were significant workforce pressures. Just earlier, we've heard evidence from my colleagues in regards to pressures to bring in people under the Pacific Workers Program, for example. So from Commonwealth level, we were very supportive of the development of alternative models which allowed to address those workforce pressures within the framework that currently exists in response to COVID-19.
And so you handpicked DPG Advisory Services through as a sole source limited tender, and gave them $80,000 of taxpayer money to put together an industry proposal that's going to be that they claim is 100% industry funded.
We did enter into contact with DPG to develop a model, and the cost of that contract was $80,000.
Let's understand a bit more about DPG. This is how they describe their staff, and I want to ask a question about this. Here's how they describe their staff on their website. Founder and director, Mr. David Gizzard, is a former ministerial advisor, journalist, and named as one of the 10 most powerful people in Australia. He's joined by Scott Briggs, a former lawyer, investment banker, considered to be part of Scott Morrison's inner circle, Sasha Grebe, a senior advisor to both Joe Hockey and Scott Morrison in their roles as treasurer, and Alistair Coe, a former leader of the opposition in the ACT. Which of those staff are working on the DPG $80,000 contract with the Department of Home Affairs?
I've directly engaged with Mr. Gizzard and Mr. Briggs.
Mr. Gizzard and Mr. Briggs. Okay, thank you. Let's understand Mr. Briggs and Mr. Gizzard's role a bit better, please. The DPG website features a media section clipping from August 2020 that claims that Scott Briggs and David Gizzard are about as close to the Prime Minister's inner circle as you can get. The DPG website also states Mr. Briggs is currently a director of the Sharks NRL team. I understand Mr. Morrison's the Sharks' #1 ticket holder. The DPG website also states that Mr. Briggs is president of the Cook Federal Electorate Conference of the Liberal Party. Mr. Morrison, of course, is a member for Cook. Am I correct in understanding that this Mr. Briggs was previously heading the bid by Australian Visa Consortium for the $1 billion project to outsource visa processing before he left that role?
Senator, I couldn't comment on that. I don't have visibility on that issue.
Mr. Pizzullo, surely you can confirm that this is the same Mr. Briggs who was heading the bid by Australian Visa Consortium?
Well, I'm not sure that he headed the bid and the extent to which that consortium put out public notices. I'm just trying to remember the difference between public statements of an official character versus speculation in the financial press. But certainly he was known to us as being associated with that tender, yes.
Well, if it is
what role he played in AVP, I just can't quite recall to mind.
If it assists you, I'm happy to table this article from the Sydney Morning Herald. Mr Briggs quietly vacated his role with one of the bidders earlier this year amid ongoing scrutiny of the costly tender. Mr Briggs was heading the bid by Australian Visa Processing.
Well, as I said, what's been stated in financial and other press is distinct.
But it's the same Mr Briggs, whether he was heading it or not. We're talking about the same person.
I'm not speaking to the veracity of the Herald story. What I'm saying is we had contact with Mr Briggs in the context of that tender, yes.
Yep. Am I correct in understanding that Mr Morrison and then Immigration Minister Coleman recused themselves from Cabinet discussions on the issue because of their long personal and professional relationship with Mr Briggs?
We've given evidence previously in relation to what was known as the Global Digital Platform, or GDP, that the Prime Minister and a minister, other ministers, recused themselves. I don't recall giving evidence as to the particulars of their perceived conflict or why they chose to take that action, but they certainly, as I've given evidence before, indeed as the department's given evidence before, the Prime Minister and other ministers did absent themselves from those discussions, yes.
I note that the Australian Financial Review says few people have as much access to the Morrison government as David Gazard, and that he speaks to the PM daily. Did Mr Morrison or the current Minister for Home Affairs, Karen Andrews, or the current Minister for Immigration, Alex Hawke, or their offices have any role in the awarding of this $80,000 contract to
No, they were
DPG
told about
Advisory
it.
Service? Sorry,
No,
Mr.
no, they were told about it. I made it very clear to Ms Saunders that this was a matter for the department. It had nothing to do with ministers, their staff, or ministerial officers.
And so can you confirm that the department and the department alone made the decision
Yes.
to award this
Yes,
$80,000
it's something
contract?
that I personally oversaw and managed and ensured that
You
Ms
personally
Saunders,
oversaw
yes, I gave very explicit instructions to Ms Saunders that this was a matter for the department. And as a courtesy, once decisions had been taken, I told Minister Andrews that we'd done it. She had no foreknowledge at all, and nor did the Prime Minister nor staff. It had, frankly,
And
well, A, it's a procurement, it's nothing to do with them. B, it's a very technical procurement. I understand the profile and I understand why you're raising it, but it had really nothing to do with
I have many
ministers.
questions. I just flag. If I could finish on this section with another maybe 2 minutes, Chair.
All right, 2 more minutes and then we'll share the call around. Thank you.
Yes, okay. So, Ms Saunders, you said you'd met with Mr Gazard and Mr Briggs. Was to discuss the contract?
My discussion with them was not to do with the contract specifically. That was undertaken by First Assistant Secretary of the COVID Border Measures Group. My conversation with them was in regards to the problem state that we were seeking to address, i.e. the workforce pressures that I've touched on.
Yep.
And our observations in regards to pilot activities around the country that had been effective, from which they could learn, the Australian Open, for example,
Right.
and to hear from them about what their thoughts might be in terms of industry options.
Could I just take on notice if you could provide, or could I ask you to take on notice and provide the dates that you met with them?
I can provide those to you now, Senator, if that would be of interest to you.
Sure. Just noting, I do have 2 more questions.
Sure.
They should be short.
So according to my records, I met with Mr Gazard and Mr Briggs on the 17th of August, on the 19th of August, the 23rd of August. I met with Mr Briggs on the 24th. So did I say that? 23rd of August, Mr Gazard and Mr Briggs. The 24th of August, I met with Mr Briggs. The 26th of August, I met with Mr Gazard and Mr Briggs. On the 30th of August, I had a further conversation with Mr Briggs and Mr Gazard. The 1st of August, the
1st of August or 1st of?
1st of September,
Yep.
Mr Briggs and Mr Gazard. 2nd of September, Mr Briggs and Mr Gazard. 6th of September, Mr Briggs. 15th of September, Mr Briggs, Mr Gazard. 15th of September, Mr Briggs, Mr Gazard.
Okay, thank you very much. It's very helpful. Mr Pizzillo, do you happen to know the address for DPG Advisory Solutions?
Its physical location? No.
It's level 1, The Realm, 18 National Circuit, Barton. We might come back to that.
I'm I'm certainly familiar with that building, but I didn't know that they were based there. No.
Thank you. I feel like I do have more questions on this matter, but I'm happy to share the call around.
Thank you very much, Senator Keneally. We are going to go to Senator Patrick, and then Senator Van is also seeking the call. I think around about 5 minutes.
Yeah, thank you. Just a
Senator
couple
Patrick,
of
because we are
just a-
needing to finish at 11.
Just a couple of supplementaries
Senator
on that.
Patrick, thank you.
Thank you. Just a supplementary on that. Having been a contractor to Defence, similar and aware of the Commonwealth procurement rules, $79,500 sounds like the number that you commence a contract for which there is no requirement to go to tender because of the Commonwealth procurement rules. Then, of course, you can extend, and there are no limitations on the extension. So the question I have is that contract, has that contract been extended? Is there some plan to extend that contract?
No, Senator.
Okay, thank you. All right, I'll leave that alone then. I'll go to illicit tobacco, and I might just ask, I note that on page 119 of the annual report, and you mentioned in your opening statement that illicit tobacco detected at the border basically tripled from all of the previous years. Now, you mentioned perhaps greater inspections. I just want to understand the cause of that. Not a criticism, obviously, you're doing better. I'm just trying to understand how you achieve that.
There's a couple of explanations, Senator. We've, of course, got the Illicit Tobacco Task Force that was a government-funded initiative that's still running, and that's increasing in size still year on year, and there's about 89 FTE in that task force, the majority of them from the Australian Border Force, a number from ACIC, ATO and the DPP. So the task force is a constant, and its sole focus is illicit tobacco.
And so when did that start, that task force? Does that explain the...
I might just need to get somebody with a back pocket brief for me on the illicit tobacco, if that's okay, in terms of...
1st of July 2018.
There you go, 1st of July 2018.
So why the latency? If you're attributing that to the success, there's clearly some latency between that task force commencing...
Well, I haven't finished the answer to the question yet, Senator, because there's a whole range of initiatives in place in relation to illicit tobacco.
Okay.
Secondly, in terms of the our staff being moved out of airports, not all of them, but a fairly small number, but into screening means we've been screening more air cargo, sea cargo and international mail. And so we've got more screening going on, and the volume of screening has led to a higher number of detections, including of drugs, by the way, not just of tobacco. And then thirdly, we've been doing a lot of work with Home Affairs Intelligence in relation to the performance of our targeting on cargo, and our strike rate has gone up quite significantly in the same period as well. So if you look at those three factors, we've got the task force dedicated every year. Of course, these officers are learning, getting more experience. We've got improved strike rate in terms of our targeting of mail and cargo, and we've got more officers doing it. So those three things are the factors I would bring to the table in terms of improved performance. Of course, whether there are other factors at play in terms of what criminals are doing, I can't tell you that. I've got no intelligence to suggest that. But our performance has been outstanding in terms of detections of drugs and tobacco at the border over the last year.
Okay, my job as a crossbencher is to always say you need to do better, but I'll acknowledge you've done extremely well. Have you bought additional detection equipment? Has that also contributed to the success? Screening equipment, for example?
No, we've been replacing equipment as it's becoming to end of life, so we're probably improving the quality of the technology, but there's been no specific program in terms of more container examination facilities or anything like that. So we're still using pretty much the same facilities and the same capabilities.
And so KPMG have done some studies in relation to the amount of illicit tobacco that's making it into the country, and there's some estimates from in relation to loss of excise. In terms of Let's move from the previous year where we had how many tonnes?
So in 1920...
Yeah, it was 484.
I'm sorry?
484 tonnes, and then you've now done 12 1,048 tonnes in this year. So is that, what's that as a portion of what you estimate is actually in the market? I mean, have you basically closed down illicit tobacco? Because I'm not hearing that. I'm just trying to understand.
No, I wouldn't go so far as to say we've closed it down, Senator, and there are challenges in terms of some of the modelling that's done in terms of trying to gauge with accuracy the size of the illicit market, and that's because, of course, of changes in terms of duty, the amount of people who are smoking, etc. So it's very difficult to actually gauge with precision, and we leave that really to the ATO to try and gauge that. But what I would say is the fact that there's been actually more detections in the last year of domestic production, illicit production, suggests to me that the effect we're having at the border is making the, if you like, the organised criminals here rethink their business model to some extent. So I'm going to claim success again.
Sure.
But no, I would never claim similarly for drugs.
No, I was just trying to understand how much of the chunk of illicit tobacco you are now capturing.
Well, let me give you a sense of the duty evaded. In 2021, it was $1.9 billion, and in 1920, $611 million. So the revenue evaded, assuming though again, like for like, people who we take tobacco out of the system, people would have bought legitimate. That's the sort of dollar numbers you're talking about.
So I'll say congratulations, but I hope to see better next year.
I always aim for perfection, Senator. Thank you.
Thank you, Senator Patrick. Senator Van.
Commissioner, you answered most of my questions about seizures in your opening statement, so thank you and congratulations on that. I do think it's a great job, and so congratulations. Keep up the good work.
And on the illicit drug as well. That's a good result from that too.
That's
Thank
what I
you.
was talking about, yeah.
Our frontline officers are doing an outstanding job in the last 12 months.
Hear, hear.
Thank you very much. Thanks, Senator Van. I'll now go back to Senator Keneally.
Thank you very much, Chair. So we've now established the Department of Home Affairs is paying about $80,000 to DPG Advisory for tangible actions or a plan for alternate plans for quarantine on a fee-for-service basis, and to engage with industry to develop that. It's not going to be extended. The staff working on it are Mr. Gizzard and Mr. Briggs, and that Mr. Pizzullo personally oversaw the contract through a sole source.
I personally oversaw the directions that I gave Ms Saunders, yes.
Okay, well, you did say, I wrote it down.
Which was to ensure that there was absolutely no connection to government. It's got nothing to do with the government.
Okay, so let's turn to the possible outcomes of what might occur as a result of this contract. On the same day this contract commenced, the 27th of August, a web page was registered under the name Quarantine Services Australia, and 3 days after DPG was awarded the contract by Home Affairs, a company called Quarantine Services Australia is registered with ASIC. Mr. Pizzullo, do you know who the sole shareholder of Quarantine Services Australia is?
No.
It's DPG Advisory Services.
Well, there you go. That's news to me.
Do you know who the director, the sole director and the company secretary of Quarantine Services Australia is?
I'll see if Ms Saunders has knowledge on behalf of the department corporately, but no, I'm not aware. I do understand that it's a mutual as opposed to a profit
And I'm
arrangement, but Ms Saunders?
That's correct.
Since it's news to the secretary, I will table the company details in terms of shareholders as well. But yes, sorry. Do you know who the secretary and the sole company director and the secretary?
No, I don't, Secretary. And you know, the department had no role to play in the establishment of the company and the actual filling of key roles within that company. That was done entirely independent of us.
Well, according to ASIC, it's Mr. Scott Briggs. Do you know if the directors or employees of Quarantine Services Australia receive a fee or a salary?
No, I don't.
Do you know so you can't guarantee that none of the $80,000 of taxpayer money is going to pay employees or directors of Quarantine Services Australia?
Senator, we paid DPG under the contract for the development of a model.
And DPG is the sole shareholder of Quarantine Services Australia, which they registered on the day they got the contract. They set them up as the sole shareholder, and Mr. Briggs is the sole director and the company secretary. Are you telling me you can't tell me whether or not any of that $80,000 is going to Mr. Briggs as a director or anyone who's employed by Quarantine Services Australia?
Well, we can answer the question because the monies were for advisory services from
correct,
DPG,
from DPG.
and I assume that they've provided invoices that have been acquitted.
That's correct.
I'm assuming.
Well, I'm asking the question. Has any of the money, taxpayer money provided, gone to Quarantine Services Australia to pay remuneration to either directors or employees?
The officers just answered it.
Well, no, actually, I don't think they have. It's a yes or no question.
And they just said that invoices were provided and they were acquitted in the proper way.
But are any of
They've
those
answered your
invoices
question.
for remuneration for staff? And are you sure that it's not remuneration for staff for Quarantine Services Australia?
Secretary, Senator, as I said, we paid DPG Services for the advice they provided in the development of the model.
Have you asked them if any of this money is going to Quarantine Services Australia?
No, I haven't, Senator.
You didn't even know until a few moments ago that they were the sole shareholder of this company.
Correct. Not on the basis that this was an industry solution for an industry problem, the establishment of the company and the fulfilling of key positions and the like were not matters for the department.
But you can't tell us today for sure that none of this money has gone to Quarantine Services
I've
Australia.
had no direct role in the establishment of the company, Senator.
Do you know what the registered address is for Quarantine Services Australia?
No, I don't, Senator.
Well, it's exactly the same as
surprise,
DPG Advisory Services, Level 1, The Realm, 18 National Circuit, Barton. So just so we're clear, the same day DPG gets a contract without tender, a sole source, and $80,000 to scope out an industry-led quarantine program, they register a website for Quarantine Services Australia. 3 days later, they register a company called Quarantine Services Australia, which is the sole shareholder. Isn't it fair to say that DPG Advisory Services and Quarantine Services Australia are essentially one and the same thing? Hasn't the Department of Home Affairs just handed $80,000 of startup capital to a bunch of the Prime Minister's closest mates so they can start up a private company to run a fee-for-service quarantine facility?
No. No, it doesn't follow at all. We provided payments for services rendered, which, again, Ms Saunders can speak to the detail, which were invoiced, and that related to advisory services to the department on the establishment of a scheme, which I have to say...
Why does the department need advice on the establishment of a scheme that's going to be set up by industry?
I was just about to say, when did we engage? Was it August?
I'll confirm the 17th of August.
So as we were,
27th of August is when the contract
So
started.
as we were approaching the resumption of travel at scale, it was of particular concern to the department, to members of the Board of Measures Task Force and to others that there was a lot of discussion. I couldn't avoid turning on the TV and in between political interviews seeing a whole lot of worthy people speaking about skill shortages, accommodation for students, accommodation for agricultural workers, some of which were mentioned earlier. But there was no momentum or motivation that I could discern or that my officers could discern from either the industry associations or from industry. I'm using air quotes around that. And so as a catalysing force to ensure that we weren't, as a default, saddled with a quarantine scheme over and above state-managed hotel arrangements for things like students, skilled workers and others, the invisible hand of the market needed a bit of a nudge. Sometimes it's not so it's not so active, the invisible hand.
Was the nudge from Mr. Gizzard and Mr. Briggs to you, or did you go find them?
No, we went looking for an advisory option.
Did you speak to anyone else?
I'm not sure that we spoke to anyone else, but it was apparent to us that the people with the focus, the energy and the drive who could get this done by way of an initial advisory piece to us was DPG. But
that's correct. That's correct, Secretary, if I can add to that. Though, I mean, we did engage other stakeholders as well. So we did engage Business Council Australia to see what thoughts they had about what might be possible. So they were
When did you do that?
Engaged.
What was that
I
date?
actually don't have that date, Senator, but certainly And prior to, from my recollection, Senator, prior to engaging DPG, we'd spoken to BCA in light of the, as I said, the problems that we had identified. And we also had around that time, prior to that time, engaged KPMG to do market testing on service offerings for quarantine services as well. So yes, we had engaged other stakeholders, but that work was discontinued when DPG Advisory Solutions were engaged.
So it's your evidence, Mr. Pizzullo, to this committee that the lobbying advisory firm DPG, led by two people in the Prime Minister's inner circle, just happened to be the only proponents the Department of Home Affairs approached to develop a private sector fee-for-service quarantine facility.
Well, I'm not sure with whom else we spoke, but the net outcome was that, yes.
And that firm got $80,000 of taxpayer money to build the business case for a private sector fee-for-service quarantine facility. And 3 days later, that firm just happened to register a company called Quarantine Services Australia, where they are the sole shareholder, and Mr. Briggs is the sole director and company secretary. So this all seems very convenient and cozy, and yet your evidence...
Sorry, the first part of your question referred to the development of a business case. I don't think that was within the contract scope. I'm not sure.
That's correct.
Okay, that is shorthand for the tangible actions to plan for quarantine framework to engage industry.
Understood.
Well, they certainly seem to be building a business case. They've registered a company.
One more minute, Senator Keneally.
Okay, so let me ask you this, Mr. Pizzullo.
Senator Keneally.
Minister?
Well, I have a number of questions for Mr. Pizzullo, but I'm happy if the minister wants to try and jump in.
Yes, Minister.
Senator Keneally, I know you're trying to paint a particular picture here, but we do need to be precise given the seriousness of what you're trying to allege, and there's no evidence to suggest that the remuneration provided by the department to DPG Advisory was for the purpose that you have stated. Now, I think we owe it to everybody to be precise when we're dealing with what I think you are trying to suggest is a serious matter.
Mr. Pizzullo, I note in an article in the media on the 13th of September where the Prime Minister's office told Samantha Maiden that the Prime Minister had, quote, no involvement with Quarantine Services Australia, and that the, quote, the proposal is being handled entirely by the Department of Home Affairs.
Yes.
Mr. Pizzullo, did you attend and speak at a Business Council of Australia event on 17 September 21st?
I'd have to check my diary, but there's something ringing. There's a bell of recall ringing around that time, yes.
Did you tell attendees at this event that, quote, Quarantine Services Australia is very important to the Prime Minister?
No, I don't recall saying that at all.
Mr. Pizzullo, let's just assume that I
Senator
have confirmation
Keneally,
from
we are
people
at
in the
time.
room who told me that those were your words.
I doubt very much I would have said that because I have no view about the Prime Minister's attitude to QSA any more than I have the view of any minister. This is an industry solution for what is going to be, as states bring their hotel quarantine program to an end, and you wait and see what happens when that tide goes out, to a industry-funded scheme to the extent that quarantine is going to be required to deal with the inevitable take-off in arrival of students, skilled workers and the like.
Did you discuss Quarantine Services Australia at that BCA event?
That will be the last question, Senator Keneally.
I just have to remember, I think we discussed the importance of an industry-funded scheme to pick up any gap left by the retirement of states from hotel quarantine, yes. But whether we spoke about QSA, I just can't remember.
Thank you very much, Senator Keneally. Obviously, we are getting very close to the end of this evening's program.
I flagged here that I do have two more sections, please. And
Well, we might
Senator
need to discuss
Grogan.
that because we are going to need to finish as close to 11 o'clock as we can. Senator Betts, could you just indicate how much time you're seeking?
2 minutes.
Senator Betts, you have the call.
Thank
We'll
you.
go to Senator McKim.
Can Border Force tell us how many seizures of nicotine and nicotine vaping products have been intercepted at the border since the 1st of October?
In terms of vaping products, Senator, I need to take that on notice.
All right, thank you.
You'd be aware that they're not prohibited under the Customs Act, but they are of interest to the TGA, and if we find them, we refer them to the TGA, but I need to take on notice the number.
Thank you. And what additional enforcement measures have been put in place to detect and seize nicotine vaping products imported without a doctor's prescription?
Again, that would relate to how many profiles or you would put into the system to look for them. I need to take that on notice.
All right, thank you very much. As promised.
Thank you.
Even less than 2 minutes.
Senator Betts, I'm very impressed. Thank you. We'll now go to Senator McKim.
Thank you. Can you provide the committee, please, with an update on how many of the detainees at the Park Hotel have tested positive with COVID? I understand it was 20 as of yesterday. Is there any update?
Senator, it's Michael Outram here, Commissioner of the Border Force. I do have my Deputy Commissioner, Dwayne Freeman, who's unfortunately having to join us remotely as well from Brisbane, because he would have had to go into a hotel for 2 weeks on return if he didn't. So I'll ask if Deputy Commissioner Freeman can firstly introduce himself to the committee and answer your question.
Thanks, Commissioner.
Thank you, Commissioner. Can you hear me there, Chair?
Yes, we can.
Thank you, Chair. Yes, it's Dwayne Freeman, Deputy Commissioner, Maritime and Detention, Australian Border Force. Of the 45 detainees at the Melbourne APOD, there are 21 who are COVID positive.
All right, so nearly half of the detainees there are COVID positive. And for scale, can I just say that if that was reflected through the broader Victorian community, we would be talking about millions of people with COVID. How could this possibly have been allowed to happen?
Well, Senator, we haven't been advised yet about how the virus got into the facility by Victorian Health, so I can't answer that question. In terms of broadly speaking, our performance across the immigration detention network, for nearly 2 years, we've kept COVID-19 out of our detention facilities. We've done very well in applying the CDNA guidelines for managing the disease. But of course, the Delta variant was a game changer, and that came to our country in mid to late June, and unfortunately, as you know, it's somehow got into our facility in Melbourne. So I can't say how, though, because we haven't been given that advice by Victorian Health.
All right. Why are these people still in detention, given that so many of this cohort have been released from hotel detention into the community? Why are the 45 people in the Park Hotel still in detention?
From the Border Force point of view, I can't really answer that question. We undertake obviously the operational activity of detaining people where they need to be detained under the Migration Act, and that's what we're doing.
Can I ask the department then why these people are still in detention? And the department's previously given evidence to the COVID committee that tranches of recommendations were being made to the minister. So can I ask the department, please, why are these people still in detention, particularly given the obvious danger that they're facing from COVID at the moment?
Well, Senator, it would turn on the circumstances of each individual, of the status resolution that relates to each individual detainee. But I'm joined at the table. We're sort of technically drifting back into outcome 2, but they are interdependent. Ms. Jones, Justine Jones, the First Assistant Secretary of the Division that handles status resolution, can address your question.
Thank you.
Justine Jones, First Assistant Secretary, Status Resolution and Visa Cancellation Division. I'll take my mask off, that's a bit easier. So the people in the APOD are unlawful non-citizens and they remain in detention for that purpose. The vast majority, I think 43 of them, are transitory persons who were brought to Australia for a temporary purpose, being medical treatment from a regional processing country.
Thank you, Ms Jones, but there are plenty of people that fit both of those descriptions that are in community detention now, not in hotel detention. Why are these specific people still in hotel detention despite the obvious danger to them from the COVID virus?
So I can't talk to the health aspects of it, but in terms of transitory people and decision making in relation to where they are placed outside of detention, either in community detention or on final departure bridging visas, those decisions are made using ministerial intervention.
No, I do understand that, but the department's previously given evidence that there have been tranches of recommendations put up to the minister, which have actually been signed by the minister, that has resulted in quite a large number of people in this cohort being released from hotel detention into community detention. Has the department put up advice of that nature, specifically relating to these people?
Not at this point in time for this group
Why
of people.
not? Why not?
Because generally speaking, transitory people do not meet ministerial intervention guidelines.
Well, there are plenty of transitory people, Ms Jones. I'm sorry to interrupt, but it's very short of time.
Yep.
There are plenty of transitory people who, in the last 18 months, have been released from immigration detention. Some of them are my friends, and I celebrated when they got out. Why is the department not putting up advice relating to these specific people?
No, I understand, Senator. If I could just finish what I was saying, is that the department, because they generally don't meet ministerial intervention guidelines, transitory people, we, ministers, of course, because of the nature of their personal non-compellable power, can request particular cases to go up outside of the department's guidelines assessment process. And the previous cases from this cohort who have been granted visas or moved into community detention have had those considerations and decisions made outside of the department-initiated process.
So they were requested by the minister, is that right?
That is correct.
All right, thank you. And my last question is, I believe, back to the Commissioner. Commissioner, can you confirm that ambulances that were called for detainees at the Park Hotel suffering from COVID were turned away?
That's absolutely false. We actually have, Senator, on shift through the day, 3 nurses at the site. There's one there right now through the night. There's access by telephone to a doctor who can attend the site as required. So we're being very attentive to the medical needs of this group of people. Moreover, Victorian Health have visited the facility several times, including as recently as last week, and we're certainly not in the habit of turning away ambulances, far from it.
All right, well, you know, there were plenty of people, including me, who warned that this would happen, and it's come to pass, and these people have been brutalised for 8.5 years, and I think it's time that this terrible chapter in our country's story came to an end. Thank you, Chair.
Thank you very much, Senator McKim. I will now give the call to Senator Grogan.
Senator Keneally first.
All right, well, so I've just been, just for time management purposes, it is right on 11 o'clock. I have given Labor senators a 10-minute grace. We will need to finish at 11:10, and then it may be necessary to go to a spillover if we can't finish by then. So I will leave it up to Labor senators as to who wants to take the call.
Yeah, I flagged that Senator Grogan did attempt to ask questions earlier today and was told to wait to outcome 3. I do have some more questions on this in outcome 3 as well.
Senator Grogan's got about 5.
Yes, and
5
I have.
minutes.
Yes, but I have additional questions, so I think we are heading for a spillover unless we finish tonight. So that's fine by me.
Yeah. All right. So why don't we just move to Senator Grogan?
No, actually, Chair, I am seeking.
You would
the
like the call? All right, Senator Keneally. Yes, Minister. Would you like to make some comment?
If we're headed for a spillover anyway, then as a matter of fairness to officers who have been here for 14 hours, including our hardworking secretariat, we can just go to a spillover if we don't think it's going to
I feel
work.
quite guilty because Senator Grogan, I did indicate to her many hours ago that she would be able to ask questions now, but if we're going to go to a spillover, do you think one will be necessary?
Oh, I think it will be. I do have one time critical question I would like to ask before we close tonight.
All right, well, why don't we will finish with your final question and then we will finish for this evening and then we'll need to resolve to go to a spillover. Senator Keneally.
Thank you very much. Mr. Pizzullo, I have heard through several sources that the government is going to make an announcement this week that it's going to take over quarantine for the return of international students. Can you confirm that?
You've heard it said to you by sources a rumour that the government's going to take over quarantine for international students.
Yes.
I've-
That's going to be announced this week by the government.
I have no knowledge of any such matter at all.
Mr.
All right,
Pizzullo,
so
just
Senator
to
Keneally,
follow
we-
up on that.
we- No, Senator Keneally, there was
Chair,
an
with
agreement.
greatest of respect.
No,
just to
I've been
follow
very
up on
respectful. It is, you just asked for one question. It is now 2 minutes past 11.
that. Chair.
So we will
with
need-
the greatest of respect, one follow-up, please.
It's not about
Labour
respect.
Senate-
It's not about respect, but I
Labor
would be...
senators have had,
All day.
well, in fact, if we want to do a time count, I don't think it would show that.
Labor senators have had the far bulk of the time post-dinner. I've been very generous with Labor senators.
You have, I just have one more question.
All right,
Is it
a very
Mr.
quick
Pizzullo's
one.
understanding that this industry-led fee-for-service quarantine facility would actually be primarily would be where international students would likely go for their quarantine?
Possibly, as I've been advised, the sort of umbrella not-for-profit mutual, which is known as QSA, would have a number of limbs, one of which would deal with companies in need of bringing skilled labour here. Another limb might well involve engagements with tertiary institutions to arrange a different standard of bulk, if you will, student accommodation. And then I think at one point when I was briefed on the establishment of QSA, I mean, leaving aside the sort of company arrangements, which...
When were you briefed on the establishment of
Through the
QSA?
course.
Keneally, there is
He
no
raised
more...
it, I apologise.
Senator Keneally, there is no more liberties. So please, Mr. Pizzullo, finish your answer and then we will have to finish up.
You could tell me.
And then it had a third limb or area of interest which might have been related to accommodation more suitable to agricultural workers on farms. So it's
All
got
right,
different components.
Mr. Pizzullo, thank you very much. Senator Keneally, thank you. I'd like to thank all senators. That concludes today's proceedings. I want to thank the Minister and the departmental officers for their attendance, along with Hansard Broadcasting and the wonderful Secretariat staff.
Hear, hear.
Here. To Sophie and her team. Can I just move that all that the committee accept table documents received during the day? All those in favour? Against? That's carried. Senators are reminded that written questions on notice should be provided to the Secretariat by 5 p.m. on Friday, the 5th of November 2021. The hearing is adjourned. Good evening.